take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Like to with the facts, pretty brown girl with the sass. Morelia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight.
Mic check, 1, 2, 1, 2. Can you hear me now? Can you hear me now? Good. Okay, you can hear me now? Thank you. Okay, good. Oh my goodness. I'm sorry, guys. I'll just sit up here talking and talking and talking. Oh my goodness. And Jason was like, he put something in the chat like, Sweet Pea not ready either. And I'm like, what do you mean? I'm right here. What you mean? I'm so silly. I apologize. Wait a minute. The reason why you couldn't hear me before because I was trying to talk. Yeah, I know. I was just yapping. I was trying to talk to y'all and explain to y'all this chart that I got behind us. So I'm gonna start over. So y'all will have to hear my thing once again. I mean, I was yapping away, Lynn. Oh gosh. Oh gosh. Let me see. Okay, so I don't want to be that big. Okay. Well, I'm gonna try to do this the best way I can because I see my thing is like covering people up. Okay. So okay, so y'all know when we covered the Alicia Andrews trial, y'all know we were in Judge Cisco's courtroom. If y'all don't remember, the trial is actually on our channel. This is involving the redrum of Julio Foolio. He is a rapper that was in Florida, that based out of Florida. Now, in total, there were a total of 5 defendants. She was the first one to go to trial. The reason why she was the first one to go to trial is because she was only being charged with conspiracy of redrum and also voluntary manslaughter. Now, we seen how Judge Cisco was in the courtroom when we watched the Alicia Andrews case. And you know, there were a lot of things that transpired from that case. First of all, she had a lot of action. Let's put it that way. But Judge Cisco is also over all of the other defendants. So that's not the last that we will see of Judge Cisco, but it was the last that Alicia Andrews will see of Judge Cisco because regardless of the fact that Judge Cisco did not want to disqualify herself, Alicia Andrews' defense team, they actually took it to the Supreme Court and they actually were able to get the judge removed off the rest of the proceedings on the case. So in regards to her sentencing, that's why we have not had that in Alicia Andrews' case because they could put the judge off. So it's a new judge on the case. So the new judge right now, last thing that I seen, she was reviewing all the transcripts, things like that, in order to get herself caught up. Now, the next real big thing that happened in that case, and I'll do another. Well, maybe I don't have to do another little video, but the next big thing that happened in that case is that the defense was like, well, hey, this judge was legally required to disqualify herself, and we can see all the things that she did wrong, and she limited us from providing a jury instruction that we wanted to give to the jury prior to them deliberating. How about we overturn the entire conviction? And I was like, oh wow. And honestly, like in some ways, I feel like that may be fair, like because the judge determines what comes in, what goes out, what is heard, what is not heard, how the case will be structured. And it was enough, they had enough documentation and enough evidence to submit to the appeals court that the appeals court agreed. Right? So now they're trying to see if they can just get her whole conviction kicked out. And I think they have some very good points in regards to that. And we'll touch base on that. Monday the 10th, they do have another hearing where the judge is going to be doing like a status hearing. It shouldn't be a whole bunch, but it's going to be some. So what makes this really even more spicier is because, okay, our Judge Cisco is back and she's presiding over other defendants. But in my mind, I'm thinking, well, how could she not be biased? I mean, we seen how she was in the Alicia Andrews case. Like she just couldn't, and we got the same prosecutors. Everything's the same except for the defendants. So, they buddy. Now we got some new lawyers, but we got the same defendants, we got the same prosecutors. So if things look familiar and y'all think we in Alicia Andrews' case, nope. Today we are going to be looking at different hearings in regards to them getting everything set up. The case is supposed to begin in April. I'm not sure if it's going to begin in April. It is a DP case. So from the last thing that I heard, they are seeking a DP against Isaiah Chance, which is Alicia Andrews' boyfriend / baby daddy. They are seeking a DP against Davon Murphy, Rashad Murphy. These two are cousins, just so y'all know. And then we have Sean Gaffright. And if anybody remembers from when we watched the last trial, Sean Gaffright, his mom testified in the last case. You remember his grandma testified in the last case. He is the one that Chance went over his house and went and got all the weapons, and he was considered the weapons man. So let me see if I can move myself to the other side just so y'all can see who these players are in this game. And I'm gonna try to keep us like up to date because like this can get kind of confusing. So so that's I got right. Okay. And that's the weapons man. And these three, so him and Alicia, Isaiah Chance and Alicia Andrews, they are allegedly responsible for being the lookout, being the setup people, kind of letting Davon Murphy, Rashad Murphy, and Sean Gaffright know where Julio Foolio was, right? So these were the stalkers. These was the ones in the parking lot. These were the ones kind of like texting and letting these guys know where he was at. Now, when you look at the video, because remember, this pew-pewing is caught on video because they were at the hotel, motel, Holiday Inn. So these three, Davon Murphy, Rashad Murphy, and Sean Gaffright, they're all on camera, like with the right. That's what they were doing, allegedly. So we got them all on camera. Now, Isaiah Chance, guys, like, I don't know if he can be considered just as, will he be considered like, because he didn't actually do the pew-pewing, but then we had this thing like, even if you didn't rob the bank, you were in the car, you knew about the bank robbery. I mean, you may not have done anything, so you stand the same charges as everybody else. Well, guys, they asking for the cases to be severed. So they want separate trials because they're seeing evidence that goes towards one person does not go towards the other person, and it will be biased for the jury. So we are going to go into the proceedings that they had over the last couple. Dying, Jason. Well, they didn't even do opening statements. We don't have no opening statements today. You ain't got to worry about that. But today we're gonna go into finding out some and Liam right. Y'all must have been typing up y'all guilties together. So we are going to some hearings that are very important in regards to this case and how this case is going to be tried. And remember, we are still in Miss Cisco's courtroom. So I wonder, like, what is her demeanor towards the rest of the defendants? I mean, they caught on camera, but you don't know if it's them. I mean, it's dark outside. You can just assume it's them. It was dark. It wasn't me. My Shaggy. So what we're gonna do is we're gonna go in and look at some of these hearings. And the reason why I like looking at pretrial hearings and hopefully y'all find it interesting too is because we actually get to see how they decide evidence, right? Or I guess our YouTube blog degree. We get to see how they decide evidence, what evidence comes in, what evidence does not come in. And if it doesn't come in, then that's stuff that the jury don't hear. But guess what? We get to hear it. And that I think that's what kind of cloud my judgment in a lot of these cases because I hear all the pretrial stuff in most cases that we're following, especially if they doing pretrial hearings and stuff. So with that being said, we're gonna go ahead and get into it because I don't want to keep you guys all Saturday. Y'all don't want to be here all Saturday, right? I'll probably fast forward through some parts and we may watch it on a different speed and stuff. But the most important thing is that I want to understand exactly what we're looking at and what we're going into when we start covering the trial, hopefully sometime in April. Okay, guys.
Along that same line, I was a little brief for purposes of brevity with regard to the state's response to the motion to sever yesterday.
Judge, I'm going to have to take issue with his definition of brevity.
You
did speak for over almost 2 hours initially.
In the eye of the beholder.
Yeah, exactly.
But to that extent, when I am doing a short written argument to provide to the court with regard to conspiracy, I'd like to also be allowed, if the court would do so, to just address a couple of the issues in closing as part of that same file.
That's fine. The state can follow a reply.
And Judge, we also, in the same token, I think Ms. Ismer also would like, because some of the pieces of evidence that have been qualified as statements, we actually would like the court to see, because there is an argument that they are not statements. They actually are photographs and postings that are recovered from iCloud accounts and stuff of that nature. So we would like the opportunity to submit that as well. And it's just the statements that have been identified and listed in defense counsel's motions.
Okay, very good. We'll figure out a timeline, but I'm thinking, since I'm probably going to hear the gang evidence motions next Friday, that I will probably give you all until the following, maybe Tuesday, to submit whatever you're going to submit. Okay?
And as I understand it going forward today, Judge, we're going to put some witnesses on, particularly from Jacksonville today, just in terms of qualification as it relates to the motion that's going to be heard next week.
Yeah.
I just want to make sure I have it all straight.
Yeah. And so for today, as I indicated yesterday, because I think you do have out-of-state witnesses, correct, as well?
Not out of state, Judge. We just had from Jacksonville.
Okay. I'm going to, with regards to all of the pending motions to suppress where evidence is going to be taken, we can line them up however you all want to do them. I don't know if you have a preferred schedule, but I'm going to hear the evidence as to all of the motions, and then we will have argument after that. So, and I am going to limit you all to 30 minutes argument on your motions. If you need more time, if you're in the middle of something and it's an important point and you want additional time, that's fine. Just ask me. But we're going to start off with a 30-minute time limit for argument. Okay, so do you all have a proposed schedule on the motions, or do you care?
I believe yesterday we concluded that Mr. Gonzalez would go first. So I was going to start off with, based on the witnesses I asked to be here first, was the motion to suppress statements on defendant Rashad Murphy.
Okay, very good.
Judge, by stipulation, the state's going to be entering a audio of Mr. Murphy's statement without objection, and I'm going to be entering as defense number one for purposes of this motion, the actual transcript.
Okay, very good. Okay, so if we're ready to go, let's go ahead and call your witness.
Remember, the state would call Detective Ramos.
All right.
So guys, the detective that's coming to the stand, he is the same.
Okay, the rule of sequestration.
He is the same detective that testified in Alicia Andrews' case. He is the same detective that we seen on direct and cross-examination. We have seen Detective Ramos a couple times. So he should look very familiar to you guys, and let's see what his testimony is going to be in regards to Rashad Murphy. I believe this is who we're dealing with first, and just to kind of show you, this is what Rashad Murphy looks like. I gotta figure out how to do this where this is not like. I can't figure out. Maybe I have to put my thing up there a different way because I do want to keep like referencing you guys to that. So you know who the defendants are. But okay, I'm gonna take us back into court. Let's see what Detective Ramos is gonna be testifying to, because remember he has to testify specific information to each defendant, because the defense right now for Rashad Murphy is saying, well, hey, we're trying to get this interrogation video out. Like, no, 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 no. We don't want this in there. We don't want this information in there. So that's the first thing that we're looking at today, the motion to suppress this interrogation video. Now, does it come in? Does it not? I don't know. But the good thing is about it is that we're going to see it. So let's see.
Has been invoked. If there are any other witnesses here to testify in any of the motions, you are to remain outside, and you're not to discuss your testimony with any other witness until the hearings are concluded.
Do you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is possibly the truth, the whole truth, and nothing but the truth?
Good morning. All right, you may proceed.
Thank you, Your Honor. Please state your full name for the record.
My name is Juan Ramos,
How are you employed?
as a detective for the Tampa Police Department
And how long have you been with the Tampa Police Department?
since October 13, 2015.
And where were you assigned in June of 2024?
Homicide.
Were you assigned as the lead investigator into the homicide of Charles Jones and the attempted homicide of 3 other members of his party?
I was.
And as the lead detective in this case, did you respond to Georgia on June 26th of 2024?
I did.
Why did you respond to that location?
We had probable cause for 2 vehicles, suspect vehicles that were used in the homicide, and I was notified that one of those vehicles was captured in Gwinnett County, Georgia, so I responded out there for that.
And this is 3 days after the homicide had occurred, is that correct?
Correct.
And you said at this point it was probable cause just for the vehicles involved, is that correct?
Correct.
At this point in your investigation, had you developed probable cause for any suspects?
No.
Had you at that point already viewed and obtained video footage from the crime scene as well as the 2 other locations the victim had been prior to his homicide?
Yes.
And is that what let me ask you this, what was the basis for the probable cause for the 2 vehicles, and what were the 2 vehicles?
Yeah. The 2 vehicles were a silver Chevy Cruze and a black Impala. And the basis for the probable cause was video collected at multiple scenes that the victim was seen at throughout the night right before he was murdered, and license plate readers and stuff like that.
And so had you at that point identified the license plates both for a silver Chevy Cruze as well as a black Chevy Impala?
Correct.
Did you run the tags on both of those vehicles?
Yes.
And those had been identified as the 2 vehicles involved in the offense, is that correct?
Yes.
Now, you had been contacted by Gwinnett County Police in Georgia on June 26th of 2024. Who contacted you?
Lieutenant Christopher Cheeks.
And what did he brief you as to that particular vehicle?
He briefed me that the Silver Cruze was hitting off of license plate readers in their area, and that he was closing in on where he believed the vehicle was. And then he kept me updated and eventually told me that he found the vehicle.
And when approximately did you get alerted that the vehicle had been located?
Between 5 and 7 a.m. on the morning of June 26, 2024.
And when you got that information, were you given details as to whether or not any people or persons were located within the vehicle at the time the vehicle was located?
Yes, I was told that the defendant, Rashad Murphy, was driving the vehicle when they attempted to take it into custody, and then he resisted by trying to run away from it.
Was he taken in custody and arrested by Gwinnett County Police Department?
Yes.
And that was based on unrelated charges, is that correct?
Correct.
Has nothing to do with the homicide here in Tampa?
No.
And based on that, what did you do?
My second lead, Detective Campbell, and I drove out to Gwinnett.
Now, you said that you had PC for that vehicle involving your case, is that correct?
Correct.
Had a search warrant been obtained prior to that?
No.
Did you know where the vehicle was?
No.
And after you found out the location of your vehicle, did you get a search warrant, a joint search warrant for that vehicle in Georgia through Gwinnett Police Department?
Yes.
Now, you said you and your partner at the time, Detective Campbell, went up to Georgia, is that correct?
Correct.
For what purpose?
To facilitate the capture of the vehicle and the process of the vehicle, and then to attempt to interview defendant Rashad Murphy.
Was there additional investigation done by Gwinnett County Police Department into who owned that vehicle or who may have been with Rashad Murphy at the time?
Yes.
And who was that?
The person with the defendant was Charmaine Steiger.
Okay. Were you briefed as to whether or not she was in the vehicle at the time Mr. Murphy was pulled over, or was she located somewhere else?
Yeah, I was told that she was in a hotel room, inside of a hotel room in the parking, the hotel that the vehicle was captured in.
When the vehicle was captured, was there a cell phone that was located within the vehicle, the silver Chevy Cruze that Rashad Murphy was driving?
Correct.
Was that cell phone, was it seized?
Yes.
And was that part of an investigation that Gwinnett County did prior to you getting up to that location in Georgia?
Yes.
Was that phone searched by anyone in Gwinnett County prior to you getting there?
No.
And when you got to Gwinnett County, did you speak with or did you ask to interview the defendant, Rashad Murphy?
Yes.
And is Mr. Murphy, is he present in the courtroom today?
He is somewhere. I saw him. Behind you.
I'm sorry, I'm blocking you.
Yeah, no, it's okay.
Oh, he do the highway. All right,
The record
cool.
should so reflect.
And
Let
where
me
did
show
that
y'all
interview take place?
So I'm gonna stop right there. I'm gonna show y'all something because we got the actual footage from that, and I figured y'all may. I'm just trying to make this like very it's to show you as much as I can, because I mean you can watch the court hearing if you can't, if you want to, But I want to show y'all some stuff as we doing this, because remember, I watched a lot of this stuff as it was kind of like unfolding. So it's like video footage of every doggone thing out here. So just in case y'all didn't see this part, I'm gonna show this to you guys. Let me see if I can rewind it. Wait a minute.
No.
So this is who they talking about right now. They got arrested, but let me show y'all let me see if I can get the entire thing to come back up. I don't know how to, I'm trying to figure out how to rewind it. I don't know. So they got the audio cut down, but this is him getting arrested. Let me see if I can start it over, because it was like the funniest arrest. Oh, here we go. Okay, here we go. Look at this mess. You see this big gun? Oh my goodness. So this is going to be our guy, Rashad Murphy, back here in the background. But this is like the funniest stuff. So I'm assuming he's at a hotel. He's over there in Georgia, guys. He's over there in Georgia. So let's look at this thing. So this is him coming out of the room. Wait a minute. And he got the little puppy.
He's compliant. Crawl towards me. Crawl. Come on. Keep crawling. Keep crawling. Crawl towards me.
Drop that book now.
Drop the book.
He say, please. The dog say he don't know what is going on. Dog running from one ear to the other ear like a dog. Like, he say, please. Oh gosh, these people, like, and if this is him right here. This is the same guy, guys. So that was funny, because I'm like, oh my goodness, the polo puppy. I feel bad for the puppy. The puppy, like, I don't know which way to go. I don't know to go here or go there. I don't know, but these guns are too big. I'm going back over here where these guns at. So let's go ahead and finish listening to what Detective Ramos has to say in regards to that, how he got arrested and why he got arrested and the things. So here we go.
In an interview room at the Gwinnett County Police Department facility.
And at some point, do they have audio? Do they have recording ability or capabilities there?
I can't recall there. I know that I had an audio device and I recorded it.
And
yes.
you did it yourself, is that correct?
Correct.
He was not under arrest at the time for the charges here in Hillsborough County, is that correct?
Correct.
And prior to coming to court, did I ask you to look at and listen to or look at a DVD marked States Exhibit 1 that contains your audio recording, and then initial it so you can recognize it later.
Yes.
At this time, we introduce into evidence States Exhibit number 1.
Any objection?
No objection.
Okay, admitted.
Detective Ramos, is this a fair and accurate audio recording of the interview that you attempted to conduct with the defendant, Rashad Murphy?
Correct.
Who was present in the room?
Myself, Detective Campbell, and Rashad Murphy.
And did you introduce yourself and explain who you were?
Yes.
And did you read to him what is known as Miranda rights?
Yes.
And did he understand and appear to understand what you said when you went through his Miranda rights with him?
Yes.
And during the course of reading the Miranda rights, did he indicate to you that he wanted to talk to you?
He said he wanted to talk to a lawyer.
And after he informed you that he wanted to talk to a lawyer, what did you do?
I made no further attempts to interview him on this offense.
So you terminated the interview, is that correct?
Yes, we spoke for a couple minutes after, but it was just preliminary information and I was giving him.
Your Honor, may we publish the State's Exhibit 1?
Yes.
And Detective Ramos, was that the entirety of the interview that you had was captured on this audio?
Correct.
Less than 5 minutes?
Around there, correct.
How you doing, man? How you doing, sir? My name is Detective Juan Ramos. I am with the Tampa Police Department Homicide Unit. This is my partner, Detective Aaron Campbell. Also, you all right now? Okay. All right, cool. Listen, we apologize, one, about, whatever's been going on. I don't know what's going on with Grant right now. They have that thing going on, but we're here about something completely different, okay? Obviously, because you are under arrest, I have to afford you the opportunity to be informed of your rights. You guys say you don't have to talk to us if you don't want to. That's totally up to you. You get to make that choice, all right? Yeah. I think you got to resist charges and they'll do it. Can't speak for fucking, you know, I don't go to them like, we are talking to you right now, we just talk about you do your rights. Okay, before, I promise you, I'm gonna have all the answers. I'm gonna have all the answers for you, okay? But I have, you know the game, okay? I legally have to explain this to you, and then I'll feel free to ask any questions you have if I can, okay? Just so you know, you have the right to remain silent. If you give up right to remain silent, anything you say can be used against you in court. You have the right to consult an attorney before you make a statement or answer any question, and the right to have an attorney present during question. If you want an attorney, you cannot afford to hire an attorney. One will be appointed to represent you before and during question free of charge. You have the right to use any of these rights at any time you want during the interview. You may stop this interview at any time. And you understand those rights? Okay. Can you spell out your name for me? And then the last name? Okay, and then this would just say, you have these rights read to you and you understand them, and then if you want to make the choice to talk to us, you would just initial here and then print and sign here, okay? It's up to you, all right? I really don't know. Okay. Okay, so just so you understand, this is not about what they did to you, okay? We are with the Tampa Police Homicide Unit, okay? We want to talk to you about something that happened in Tampa.
Just for the confusion.
Yeah, just so that, yeah.
About this, we're not.
Yeah.
We're to talk to you about campus stuff.
Okay.
And you want to talk to us, you have to let us know.
Yeah. At the end of the day, we wouldn't be doing our jobs if we didn't afford you the opportunity, okay, to have this, this is an opportunity that has to be afforded to you, okay? If you want to talk to us and we can talk out a little bit what's going on in Tampa, we can talk that. That's why we're here. We're here to give you an opportunity to talk about what's going on in Tampa. And that may or may not include, to give you the opportunity to say, hey, if you have no involvement, you have no knowledge, but in order for you to tell us that, we have to, agree to talk to us. You know what I'm saying? It's up to you.
How about your shoulder? Oh, shoot. That look right. Yeah.
Is it still dislocated or they put it back in?
You got, oh, you got rib.
Oh,
Yeah,
wow.
I got rib.
Okay, well, what side of that happened to you?
Hey, it's a short shoulder. My right hand.
Listen, okay, just for the report, just verify something. That's fine. Do you want my card? Okay. I'm gonna put my cell phone number on the back of it, okay? That's my direct line. You can call or text or, at any time, all right? And then my email and desk number is at the front, all right? If you're gonna consult with a lawyer and your lawyer wants to reach out to me and talk to me, you're saying, or you wanna reach out to me and talk to me, I'm available 24/7. Okay.
Can you get a phone number for you?
Yes. I'm sorry, 904-327-6899, okay? Okay. 092. And who's your wife? Sherman. Are you guys legally married? Okay.
We've been together since we're 13.
Oh, wow, wow, okay.
Oh, you? Okay, you got to get her.
Okay. Yeah. Okay, all right, all right, well, since, you've asked for your lawyer, we're gonna terminate this interview, okay? I'm gonna turn this recorder off, all right?
Detective Ramos, after that interview, after the recorder was shut off, did you make any other attempts to interview the defendant, Rashad Murphy?
No.
And did you at some point, after you left Georgia and conducted the investigation, that portion of it, did you at some point contact Detective Christopher Drabeck with the Jacksonville Sheriff's Office?
Yes.
Who is Detective Drabeck in relation to this particular investigation? What was his role?
He was assisting me in Jacksonville. He was essentially the lead detective in Jacksonville, my second in Jacksonville.
Was a lot of the investigation in this particular case done in Jacksonville and some of the evidence and search warrants conducted there?
Yes.
And was he the person that you would go to whenever you needed assistance or any of the searches done in Jacksonville?
Correct.
At some point during a briefing with Detective Drabeck, did you brief him as to what occurred in Georgia?
Yes.
And did that include the fact that the defendant that you attempted an interview and that he invoked and requested an attorney?
Yes.
Was the defendant arrested on that day for any charges related to the homicide and related offenses that occurred here in Tampa on June 23rd of 2024?
No.
Was he in custody and was he arrested for separate charges that occurred in Georgia during the stop of that vehicle?
Yes.
Eventually, was he released from Georgia on that charge?
Correct.
When was the arrest warrant issued for the arrest of Rashad Murphy related to these charges?
Saturday morning, July 27th, 2024.
And so approximately a month after you had that interview with him in Georgia?
A little over a month, yeah.
A little over a month.
Day or two over a month.
And where was he arrested?
He was arrested in Jacksonville, Florida.
Where were you at the time?
In Tampa.
And at that point, how were you alerted to the defendant's arrest?
He was arrested, I think, 3 days after on July 30th, and I was called by Drabeck in Jacksonville.
And at some point, was there a request made by the Jacksonville Sheriff's Office to conduct another interview of him regarding this particular case?
Yes.
Were you available to do it at the time?
At the time, no.
And so who did you request do that?
Again, who would have been the lead in Jacksonville, Christopher Drabeck.
And then at some point, were you then briefed by Detective Drabeck that he was able to conduct a recorded Mirandized interview with the defendant?
Yes.
Your Honor, at this time we pass the witness.
Okay, Cross.
Good morning, Detective Ramos.
Morning, sir.
So, Detective Ramos, the interview that took place in Gwinnett County was on June 26, 2024, correct?
Correct.
And during the course of your initial interaction with Mr. Murphy, you read him Miranda in its entirety, correct?
Correct.
Did you do that by memory? Did you do it by a card or a piece of paper that you carry with you on a regular basis?
I believe that specific incident, sometimes it's a card, sometimes it's the 310 form, the Tampa police form. I think that form that time we had the 310 form.
Okay. And that 310 form gives Mr. Murphy the entirety of his Miranda rights in every respect, correct?
Correct. Typically, I'll read it and then I'll have them review it as well and look at it and then initial and sign if they agree.
And you explained it to him, correct?
Correct.
You asked him whether or not he understood Miranda, correct?
Correct.
And you asked him specifically if he wanted to exercise the right to speak to you, correct?
Correct.
During the course of the inception of this investigation, you were coordinating with Jacksonville because at that particular time, you had made a determination that the vehicles that were involved in the surveillance had Jacksonville plates or plates and owners that resided in Jacksonville, correct?
That was one of the pieces, yes.
And you were in communication with the Jacksonville detectives, specifically Detective Drabeck, on a regular basis throughout the investigation, and certainly in its inception when you were attempting to try to put things together.
Yes, correct.
And after the interview with Mr. Murphy, you communicated on a regular basis with Detective Drabeck. He knew you went to Gwinnett County.
Correct.
You told him that you had exercised or you had read Mr. Murphy Miranda, and he had exercised his right to not speak to you, correct?
Yeah, I told Drabeck that he invoked and we got no statement from Rashad.
Okay. And he was not arrested on that day because you didn't have any probable cause to arrest him, correct?
Correct.
And it's also a fact that you went there because you were going to interview him about this particular murder, not the resisting arrest without violence that he was actually arrested for in Gwinnett.
I was there for the murder in Tampa, yes.
You told him that, didn't you?
I told him that I was with homicide and I was from Tampa, correct?
Right. And you were investigating an incident in Tampa. Detective Campbell told him, look, we're here because of Tampa.
Correct.
Detective Drabeck also knew that Charmaine Steiger, Mr. Murphy's girlfriend, was also detained in Gwinnett County, correct?
She wasn't detained, but he knew that she was present.
Well, when she was being interviewed, was she free to leave, to your knowledge?
To my knowledge, yes. Gwinnett had explained to her that they had no reason to hold her. She elected to wait there for the vehicle.
I don't have anything further.
Okay, redirect?
No redirect, Your Honor.
Okay, thank you. Thank you, Detective Raymond. You can step back outside. Any other witnesses?
Yes, the state calls Detective Christopher Drabeck. Oh, I gotta show it.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may proceed.
Thank you, Your Honor. Please state your full name for the record.
My name is Christopher Drabeck
How are you employed?
with the Jacksonville Sheriff's Office.
And were you employed with the Jacksonville Sheriff's Office in June of 2024?
Yes, ma'am.
What unit were you assigned to at that time?
I was assigned to the gang unit.
During June of 2024, at some point, did law enforcement officers from the Tampa Police Department contact you with regards to the homicide of Charles Jones?
Yes,
What day did that occur?
it was in the morning of the incident.
And as that investigation was unfolding in Tampa, were you assigned a particular role to assist the Tampa Police Department?
Specifically that day, I was the on-call detective with the gang investigations unit. My supervisor reached out to me and informed me that Tampa Police Department was inquiring information relative to the death of Charles Jones. So I reached out to Tampa Police Department and began assisting in whatever way I could.
And how are you familiar with that name, Charles Jones?
He is a prominent member of the criminal gang 6 Block in Jacksonville.
During the course of the investigation by the Tampa Police Department, did you routinely get phone calls from Detective Juan Ramos, the lead homicide investigator assigned to the case?
Yes,
And did he often brief you with updates and seek intelligence based on your knowledge in Jacksonville gangs during the course of this investigation?
yes.
At some point on June 26th of 2024 or after, did he contact you and give you an update as to the investigation that he did in Gwinnett County, Georgia?
He was routinely updating me in reference to his efforts as it related to that case.
Did he update you and brief you as to the locating the silver Chevy Cruze and coming in contact with a person by the name of Rashad Murphy?
Yes, ma'am.
Did he indicate to you, or what did he tell you with regards to his interaction with Mr. Murphy while he was in Gwinnett County, Georgia?
He advised that he attempted to interview Rashad Murphy, and it was a very short interview, and it concluded with Mr. Murphy invoking his rights.
And at some point, did you, even after that point, did you continue to assist Detective Ramos with different parts and aspects of this investigation, including the execution of search warrants and any other assistance that he needed done in Jacksonville, Florida?
Yes.
At some point, were you alerted that there were arrest warrants that were done for all of the defendants in this case, including Rashad Murphy?
Yes.
When did that happen?
Sometime in July, approximately a month later after the incident.
And you said, so July of 2024, is that correct?
Yes, ma'am.
Okay. Was there who were the first individuals that were located and arrested?
There were 3 defendants arrested initially. It was Isaiah Chance, Alicia Andrews, and Sean Gathright.
And was there a period of time that elapsed before Rashad Murphy was able to be located and arrested?
Yes.
When did that happen?
I believe it was a period of less than a week, a few days after the first 3 were arrested.
Do you remember the date that he was arrested on?
I believe it was July 29th or July 30th.
When he was arrested, were you present during the arrest of Rashad Murphy, or were you alerted by other gang members in your unit?
I was informed that he had been arrested.
At some point, did Detective Ramos ask or request of you to conduct a Mirandized interview of Rashad Murphy after he was arrested?
Yes, ma'am.
And when did that take place?
The evening he was arrested.
And was that on July 30th of 2024?
Yes.
And was it kind of in the early morning hours?
Yes, ma'am.
Where did the interview take place?
It took place at our Crime Gun Intelligence Center in Jacksonville, Florida.
And he had been arrested for the homicide and all of the related charges that occurred here in Tampa. Is that correct?
That's correct.
Who was present when you did the interview of the defendants?
It was myself and Detective Craig Griffin.
Was that interview audio and video recorded?
Yes,
Did you read the defendant his constitutional Miranda rights?
I did.
Did you actually ask him to read some of that form himself, just so you could ascertain his ability to read and write?
I did.
Did he have any did he have any problem or any issue understanding when you were going over the Miranda rights with him?
No.
Prior to conducting the interview, were you aware, prior to conducting that, you said it had already been indicated to you that he had previously invoked, is that correct, and requested an attorney?
Yes.
But how long had that been when that occurred?
Approximately 1 month.
And after you went over the Miranda form with his rights on it, did you ask him to sign and date it and acknowledge that he understood all of those rights?
I did.
Is there also some preliminary background questions that you go over with him just to make sure or ensure that he is cognizant and he can comprehend everything that is going on?
Yes.
Prior to coming here today, did I show you what's been marked State's Exhibit number 2 and ask you to view it so that you could recognize this particular DVD as the video that you had done with the defendant Rashad Murphy on July 30th of 2024?
Yes,
And did you initial and date it?
I did. And I see them at the top of the disc.
Your Honor, at this time we'd introduce into evidence State's Exhibit number 2.
Any objection? Okay, admitted.
And the room that he is placed in while he's waiting to be interviewed, is the video recording going the entire time that he is in there?
Yes.
At some point, is he provided a blanket?
Yes.
All right, go sit down. As soon as I find some scissors, I'll send someone that I'll get in here to get those off you, all right? So just sit down and come.
And for the record, you're publishing the exhibit. It looks like you're fast forwarding to a certain section, correct?
Yes, Judge, and I've already discussed it with defense counsel that there's about an hour of dead space, so we're going to fast forward it to when the detective actually comes
Which
in.
for the record is at what point in time?
It's like at 1 minute, Judge. I'm sorry, 1 hour.
I had to get one of these in the car. You want one? You take these? You have?
I lay it off the road.
Bad for you? I hear that too. But I used to do this thing called chewing like tobacco, and it's pretty bad for you as well. So I'm happy I'm not doing that anymore. Chew tobacco?
Yeah.
Well, I used to rip 6, but then I kind of started chewing. Anywho, before I can speak to you about obviously whatever conversations we have, I just have to do this first. If you have any questions at all about it, just let me know and I'll be happy to explain it, okay? Are you able to read?
Yes.
You are? Okay,
I got
sure.
yeah, I know how everybody should do on YouTube, but.
Yeah. Well, let me tell you something. All the things you've ever watched on YouTube, right? Hear me out, because I understand your question. Listen to me. I've been doing this job for a hot minute, so I understand your question. But your question is in reference to Jacksonville videos. We have probably different record request laws than what maybe Tampa might have, right? This isn't a Jacksonville case. You feel me?
Yeah.
So the conversation we have is important, but I do understand your concern. And I can promise you that what your concern is directed to like crime circus and all that shit you see on YouTube, that's Jacksonville related. We don't have control of that in Jacksonville. Tampa's a different story. Does that make sense? Can you demonstrate you're able to read by reading that first line for me? Perfect. I'm going to read the rest. And if you have any other questions, Rashad, do people like Rashad? Just let me know. You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before you make a statement or before any questions are asked of you, and to have a lawyer with you during any questioning. If you cannot afford to hire a lawyer, one will be appointed for you before any questioning if you wish. And if you do answer questions without a lawyer present, you will still have the right to stop answering questions at any time and consult with a lawyer. Do you understand all that? Okay. Do you know how to sign your name? Okay. If you could print your first and last name on that line, and then sign your name on that line, and then once you do that, I'm gonna write my information just above yours. You're fine, man. It's like creeping up on 3 in the morning. Don't blame you.
That blanket help you out in it?
Yes, sir. Holy smokes.
Can I get some?
Hold on. Piece of paper.
No, I just.
Oh, that's fine, buddy. I mean, if you're, yeah, just, look, that's fine. I'm good with that. Just sign your name and I'll sign right above it. Mine's not a hell of a lot better anyway, so. My name is Chris. I don't know if I introduced myself when we were talking the first time, but this is my ID number. It's 78576. Some people call it a badge number, but that's mine. There's a couple questions down here. I'm just going to go through real quick. Sir, what's your date of birth? Damn, you almost got 420. So you get to celebrate 2 days in a row. Okay. So how old does that make you? You probably 30? Big 30. Congrats. What's your highest level of education?
My highest level of education, like 12, but really 11. I just got stuff on it.
Did you graduate high school? What was the last high school you went to? Okay. So you were a, was it a Stingray?
Yes, sir.
Nice. You can read, sir. You can also write. Is that correct?
Yeah, correct.
Okay. It's just a question I'm gonna ask. Have you had any alcohol today? Mm-hmm.
That was earlier.
What time was that?
Like 12 afternoon, going on like 11 hours.
11 a.m., 12 p.m. What were you drinking? Just a beer?
Drinking it's like a wine cooler.
Okay, like a little White Claw?
You know, with the
High noon?
you know, tourniquets, like the little orange.
I don't think I've ever heard of that.
The tourniquet, it's like a shot, like a healthy shot.
Okay. I haven't.
Tourniquet mixed with, it's like, it's a tourniquet you drink.
It sounds like something I would probably like.
It make you wake up. Get your energy and anything like that. I don't know. Okay.
Just get you in the mood. Have you had any drugs today?
I just want to be out on the drugs.
Have you smoked any, I'm sorry, have you smoked any marijuana today?
Around the same time.
Around the same time?
Yes, sir.
Have you smoked weed? You rip GDs or you blunts?
No, I heard black probably. I don't like smoking because I don't like how harsh it is.
Rashad, do you wear any glasses?
You know, wear glasses. I used to wear glasses. I don't know.
So no.
I wear glasses like since my list, when I was on the training, my brother's like smoking.
Do you wear contacts?
Contacts.
No, no. Do you have any mental health conditions? You said physical health?
Like I hurt my shoulder on that one.
Shoulder?
Yeah.
Did you have any injuries?
Shoulder injuries. You talk about? Georgia, like, I've been going to the doctor, going on shoulder, but Georgia, like, I'm at the Georgia, my shoulder, and I feel like they really, like, broke. I've been like that.
Do you play football? What high school you play at?
Coach Jackson,
What position you play?
running back, receiver.
Okay. I used to, so I'm around the same age as you. I used to play at Lights. Maybe we,
So you know, person that works, Montgomery.
Casey Turner, Kevin Parker, Kevin
I
House.
played with like Steph Durham and Preston Edwards. Steph
Where
Durham.
they play at?
Steph Durham, he's a coach for Wilson now. Lewis High School.
Okay,
And he used to go on Jefferson Tech.
okay. So you were playing when like Lewis Nix was playing, when he was at Reigns. He was the big defensive lineman at
I went
Reigns.
to that coach 2012, like second year.
Okay. Damn, so you was in there when it was
Yeah, like
fresh off. Yeah. So today is July 30th, 2024, and the current time is 0304. This is 311 West Monroe Street. You mentioned watching YouTube videos. I'm sure you've seen this room many times, right? This is my office. This is at the state attorney's office. This is what we call a satellite.
Like, when David wanted to talk to me, like, he'll like probably take me outside room and get like, you know what I'm saying?
Yeah, that's a little different.
But you said it's not y'all.
It's not. No, it's not. You know that. And yeah, no, I'm being a man telling you that. However, I will tell you that this is Tampa's investigation, and you're probably confused why they're not in here, right?
I really want, like, I don't want to talk to them because, like,
They're nasty.
Nah, they don't know me. You know what I'm saying?
They don't know
Like,
Jacksonville shit.
They don't know. They don't know. So like,
I agree.
trying to like talk to them and help me.
Chop it up, you can't.
Because it's like, you know what I'm saying? Because I don't. It's like 7 minutes is good. Like, if somebody put me on game about something, they're not know how to.
Sure.
But like, ain't nobody like put me on. You know what I'm saying? They really left me in the line. So like, if I
Okay.
was in the line, I would got in the car, and I wouldn't let nobody.
Well, in their defense, I think it's also fair to say that whenever you did talk to them that first time, they were probably really overwhelmed with a lot.
Which
Which
they
I
had
think,
to travel. They had to travel 8 hours and all that. To come see me. So like,
Yeah.
I respect it.
true. I think that's everything for me. Just send that.
I gave my family my Jesus College book.
Your what book?
My Jesus College.
Jesus Caller?
Jesus College. Like the book I had before I walked out the door.
Did you have it? And
Yeah, I had it.
or is it still in the apartment?
No, I bring it out.
Okay. Did you ask someone to do that?
What? Oh, yeah, I told them to get.
I can promise you if you-
I read it with my kids every day.
How many kids you got?
I got 4, and I'm raising my son and sister, so like 6, because I'm most left, so I got like 6 kids.
You've got 6 children.
4 of my
And but 4 of them are yours. How old is your oldest?
My oldest is 11. My second child is 8. Prosper, he just turned 7 June 23rd.
Okay.
Gabrielle, she is 26, November 1st.
Wow, you got a little army, dude. You get to see them every day? Are they always with you?
Yeah, my kids live in
Okay, that's fantastic. I'm sure you really appreciate that.
I don't even, like, I don't even spend no more than a week for my kids.
Yeah. So I think it's fair to say there's probably no secret why you're here. Ultimately, what I was getting at, the reason Tampa isn't here, they've got a lot going on. So they asked us to step in. Unfortunately, what that means for us is since we didn't do the investigation ourselves, I can't really, because I used to work in the homicide unit before Jacksonville, I don't anymore. But unfortunately, what that means for us is if you were to lie about anything, I probably wouldn't be able to call you out on it. That's what I like to do for my cases. This isn't my case. But I say that to say, let's be honest as we can. Does that make sense?
Yeah.
So I'm sure you have a lot of questions. I know I have probably a few, but I'll let you have the room and you can start off wherever you'd like. How do you feel like you ended up here?
I ended up there about like not about like people hold stuff and put stuff in my name. Like that's just like, you know, it's the typical thing, you know, when people can get Airbnbs and all that.
Your Honor,
stuff.
I'm going to stop it at 1 hour and 11 minutes and 36 seconds into it. I know that Mr. Gonzalez and I agreed that the entirety is on this recording, I'm sorry, on this DVD, as well as you have a transcript of it.
Okay, very good.
And Judge, just to supplement that, I will be arguing and giving the court some context about specific statements made that are not going to be testified to under oath, but stipulated to by way of the video being the best evidence of what was said.
Sure. Okay.
Detective Drabeck, during the course of that interview that you just watched, when you were going over his Miranda rights, you explained to him that this was specifically in regards to the Tampa homicide. Is that correct?
Yes.
Did he ever indicate to you after you read those Miranda rights or during the entirety of the interview that he wanted a lawyer or state that he did not want to talk to you about this incident?
No.
Your Honor, at this time we pass the witness.
Okay, Cross.
Morning, Detective.
Morning.
So just to give some context in regards to what we doing here and why we looking at this video. The defense is trying to say because of the first initial contact that Mr. Murphy had with Detective Ramos maybe 2-3 weeks earlier, when he stated that he wanted to talk to an attorney, and they stopped the interview, right? They did let him go because they didn't have enough to charge him on, because he originally was in there regarding the arrest warrant in Georgia. The defense is trying to argue because he requested a lawyer at the first interview with Detective Ramos. When this detective came and this officer came to question him, it should have flowed over. Like it was a continuance of I want a lawyer. Like, I don't think that works like that. Like, but they're trying to say it's a continuation of I need a lawyer, or I want a lawyer, or I don't want to talk to you. I plead, I invoke, my Fifth Amendment, whatever they're doing. But they're acting like it rolls over. So in this portion, the reason why they showed that video is because during that period of time when he was read his Miranda rights or anything like that, he did not ask for a lawyer this time, right? And his attorney is saying, well, he didn't ask for a lawyer because he asked for a lawyer the last time, so it rolls over. It's a rolling objection. Yeah, and I guess that's the same thing that they're trying to say, Drunky, is that he only has to ask for a lawyer once. But this is like an arrest. The detective comes in, Detective Ramos comes in and talks to him. He asks for a lawyer. He is released at that point in time because they were only looking into his crimes that he committed in regards to a Georgia case. Then they collected enough evidence to charge him in the Julio redrum case. So they arrested him again. And this time when he's read his Miranda rights, he doesn't answer. So is it a rolling thing? No, it's not in the same. Yeah, like he left and came back. Like, is this just because it's the same issue? And that's what the defense is trying to say. The defense is trying to say, look, it's a continuing request for a lawyer. Just because you change detectives and you arrest me and rearrest me, it doesn't change anything. So that's what they're arguing. That's why they want to try to get this interview thrown out, because this is the interview where he must say some stuff or do some stuff that the lawyer don't want coming in just talking too much. All right, for life, right? Like nobody can talk to me about any crimes that I've committed, because I am requesting a lawyer no matter when you read me my Miranda rights. And I don't think it's like a broad-based cover, and that's what they're trying to say. But let's listen to the arguments.
So, Detective, just so I'm sure I understand the chronology here, in communication with Detective Ramos during the inception of this investigation, you were aware that approximately a month prior, Mr. Murphy had invoked when Detective Ramos traveled to Gwinnett County, correct?
Yes, sir.
And throughout that process, you...
See, y'all heard it? So he invoked. Okay, that's the word I was looking for. He invoked for an attorney a month prior to Detective Ramos. I knew. Chris up here like, look, I don't know what he did. I ain't got nothing to do with that. We arrested him on this day here. And I asked the same questions. He didn't invoke with me. I think he had every right to kind of keep going at it, right? They be trying to pull any move that they can. Remember, these guys are facing the DP. So, I mean, I guess you got to pull it out of the bucket. You got to figure out which way to try to make this seem like there was some flawed investigation. I guess you got to do whatever you can, huh?
Continued on kind of a live basis, on a regular basis, to collaborate with each other as it relates to the investigation going on in Tampa and the investigation side that was in Jacksonville, correct?
Yes, sir.
And the precipice for the interview that occurred on July 30th was Mr. Murphy's arrest in Jacksonville for that murder.
Yes.
And that was the same murder or the same set of facts that Detective Ramos went to Gwinnett County to interview him for a month earlier.
As far as I'm aware, yes.
And you would agree with me that although you may not recollect verbatim every word that occurred during your portion of Mr. Murphy's interview on that date and his responses on that date, that the video and the audio and the transcript of the interview would be correct as to what was said between you.
Yes, sir.
The July 30th interview was not initiated by Mr. Murphy, correct?
Correct.
And was it Detective Ramos that contacted you, or vice versa, you contacting him saying, hey, Murphy's in custody?
Yes.
That would be you to him?
Yes.
And his response was, go ahead, I would like you to interview him.
Yes.
Did you all discuss his prior invocation?
At that time, no.
And is there any reason why you attempted to interview him knowing that he had previously asked for counsel and invoked his rights as it relates to this same and particular incident?
Yes.
Why?
Because I wanted to obtain his statements that he was willing to provide in reference to this investigation.
After he had previously invoked?
Yes.
Did you talk to him about his previous invocation?
No.
And did you consider this to be a separate interview?
Yes.
And you were aware, obviously, that the arrest in Jacksonville was an arrest for the murder in Tampa?
Yes.
Do you recall why Detective Ramos was not able to come to Jacksonville and conduct that interview on the Tampa murder?
I don't recall.
During the course of your initial interaction with Mr. Murphy, after you read him the advisements, you essentially just say, hey, if you have any questions, let me know. Is that a fair statement generally?
At the conclusion of reading his rights, I did ask him if he understood. His response was yes, and then I followed up with that with what you just said.
Okay. Do you recall whether you ever asked him whether or not he wished to waive those rights?
I believe that's included with read to him.
Okay. And so your commentary or your questioning of Mr. Murphy and his responses would be in the transcript, the video, the audio, correct?
Yes, sir.
And it's your testimony that you believe that you asked him whether or not he wished to waive those rights after the advisement was read? And if you don't have any independent recollection, I understand.
My understanding that the rights that are read to him, that's included.
Okay.
I didn't provide any additional follow-up to that.
You didn't ask for an acknowledgement from him after he read it as to whether or not he wanted to waive it.
I feel like that would be a bit redundant, so no.
Okay. And you proceeded then to ask him, hey, look, just print your first name and your last name on that line and we'll get going.
Yes.
Give or take a word here or there.
Yes.
And during the course of the form and the instruction on the form, you talked about the absence of the Tampa detectives being there on that particular day for the interview, correct?
Yes, sir.
And he indicated to you that he didn't want to speak to the Tampa detectives.
He makes a comment alluding to that, yes.
Yeah, I mean, pretty much said verbatim, I don't want to talk to them.
I don't know what the quote was, but yes.
That's fine. And certainly that you remember that type of a dialogue happening with regard to you explaining to him, you're Jacksonville, they're Tampa.
Yes.
Homicide, but you used to. You
Yes.
recall that line of questioning?
That's how I positioned it, yes.
Okay. And you went on to ask him and tell him, well, you know, even if you lied, I probably wouldn't be able to call you out because I don't really know anything about this.
Correct.
Initially, Mr. Murphy denied being in Tampa, did he?
He did.
And you began a series of kind of warnings to him where you were telling him, hey, look, your co-defendants are painting you as a mastermind. And, you know, this is going to be the most important conversation of your life. And that these are the kind of things where lives change. And again, I'm not talking about specific language, but in general, do you recall that line of questioning?
Yes, sir.
And then you went on to discuss with him at length the strength of the investigation in Tampa and how good they are down there and what great investigations they do, and that you wouldn't be messing around if you were him. Do you recall that line of questioning?
Yes.
At that particular time or somewhere near it, Mr. Murphy then made an admission to you that he had been in Tampa, but he did not have anything to do with any shooting or any murder.
Yes.
Did you indicate to him that he's never seen anything like what a Tampa interview would be like, and that you're not bluffing about what that would be for him?
I don't understand.
Do you ever recall telling him that, hey, look, this is a Tampa investigation, right? Not Jacksonville. I'm not bluffing you because you've never seen anything that takes place in Tampa and the way they do their investigations and their interview.
I suppose you could phrase it that way, yes.
Okay. And again, listen, I'm not trying to put you on the spot. There's no way for you to know exactly what you said verbatim. Do you recall that general line of questioning, and would you defer to the transcript?
Yes, sir.
And Mr. Murphy told you he didn't want to talk to any Tampa detectives, correct?
Yes.
Because they don't do things like things are done in Jacksonville.
Mr. Murphy was expressing that Tampa wouldn't have the knowledge base of Jacksonville stuff.
And at one point in time, you told him, yeah, they're nasty. Are they nasty? Talking about Tampa detectives.
I said that, yes.
I don't have any further questions. Thank you.
Okay, redirect.
Just briefly, Detective Draybeck, when he said he didn't want to talk to any Tampa police detectives, there were no Tampa law enforcement officers in the room. Is that correct?
Correct.
And during the course of your interview, you're allowed to use strategic tactics when questioning suspects. Is that correct?
Yes.
Was it made clear to him that you were speaking to him about the Tampa homicide?
Yes.
Was that the only reason he was arrested, was for the Tampa charges?
Yes.
And during the course of that entire interview, did you make him any sort of promises of any kind during that interview in order to get him to talk to you?
No.
I have nothing further, Judge.
Okay, thank you. May this witness be excused.
Yes, Your Honor.
Okay, you can remain outside. I don't know if you're needed for any other motions today.
He is.
Okay, then don't go anywhere. Okay, any additional witnesses?
No additional witnesses, Your Honor.
Okay, so defense, do you have any additional witnesses?
I do not, Your Honor.
Okay, very good. Okay, so I'm gonna, as I indicated, I'm gonna hear argument later on. All right. Okay, so that is the testimony in total for Rashad Murphy's motion to suppress statements. All right, are we going to stay with, let's see, Mr. Gathright has, looks like 2 motions. Mr. Murphy, Davion Murphy has 1, and Rashad Murphy has 1 additional defendant's motion to suppress cell phone. So which motion do you all want to take testimony on next?
What were they again? I'm sorry.
This is what I show. So this is what I show we've got as far as motions to suppress. Rashad Murphy has a motion to suppress cell phone. Davion Murphy has a motion to suppress search and seizure of Davion Murphy. Sean Gathright has a motion to suppress evidence obtained following the warrantless search of the defendant's vehicle. And Sean Gathright has a motion to suppress evidence illegally obtained from the defendant's iCloud accounts. Is there any other motion to suppress that's going to require testimony that I have overlooked?
Not a motion to suppress yet. I do. Judge, we do also think that there's testimony required for the motion to limit gang charge, but we can do that in the afternoon as well.
Okay.
Well, Judge, I'm sorry, I didn't recognize, it looks like, I mean, I have on my schedule 3/6 of 2029, the motions are limited.
Right, but I think that that the state wants to put on some evidence.
Testimony? I'm
Yes,
sorry.
and
I'm
so,
sorry.
okay, so I tell you what I'm gonna do. I'm just gonna take a quick 10-minute break. You guys figure out the schedule for the testimony for the remaining witnesses, and then I'll come back and we'll proceed, okay?
Okay.
All right, thanks.
Or somebody else?
So of course we're not gonna go to a break. They're gonna I'm gonna pull us forward, but So they're moving on to the next person, the next defendant. And it's, let me turn this booster down because it seems like it's just giving them like a lot of feedback.
What motion do you all want to take testimony for next?
I believe we're going to stick with Rashad Murphy and do his motion to suppress cell phone.
Okay, very good.
And
who's going to be your witness?
Detective Reynolds again.
Okay.
Yeah. So we just heard from Rashad Murphy's attorney. They were trying to get his interrogation video to say that it's a blanket effect. No, the judge has not ruled on it. We will hear her rulings soon, but they all have different issues. So now they are about to argue, call witnesses in regards to his cell phone. So I think it's going to be his cell phone, and I think somebody else wants their cell phone, iCloud or something, to be suppressed. So let's listen in.
Sure. All right, so we'll have Detective Ramos back on the stand. Oh, and we don't have a court reporter, so we can't do anything. Never mind. I can't see you, so I need to remember to look before I start talking. Okay, yes, come on up, Detective Ramos. You remain under oath from your previous testimony. We're now moving on to Rashad Murphy's motion to suppress cell phone. Okay, you may proceed.
Again, please state your name for the record.
Juan Ramos.
Detective Ramos, I'm going to go back to your time in Gwinnett County when you were there investigating Rashad Murphy. At some point, was there another detective with Gwinnett County Police Department that was assisted you in the investigation?
Yes.
Who was that?
Detective Angela Carter.
Were you alerted that there was a cell phone in the silver Chevy Cruze when the defendant Rashad Murphy was stopped by Gwinnett County Police Department?
Yes.
And based on that, was there the detective Angela Carter, did she reach out to you during the course of the investigation prior to you getting to Gwinnett County?
Yes.
At some point, do you know, were you alerted or were you briefed that she had conducted a consensual interview with Charmaine Steiger?
Yes.
And during the course of that, that Ms. Steiger had consented to her, Detective Carter, looking at the phone.
Yes.
At some point during that interview, was the consent withdrawn?
Yes.
Based on that interview, did Detective Carter learn that who that phone belonged to?
Yes.
And what was your understanding of the information that Detective Carter got from Ms. Steiger?
That it was a phone mutually owned by Charmaine Steiger and Rashad Murphy.
And after the consent was withdrawn, was it at that point determined to get a search warrant for that particular phone?
Yes.
Was there a joint search warrant done as you as the joint affiant with Detective Carter because you were located in the jurisdiction of Gwinnett County?
Yes.
Did you assist and provide Detective Carter with the probable cause to get the phone?
Yes.
I'm going to show you State's Exhibit number 3. Are you familiar with this?
Yes.
Is that a copy of the search warrant as well as the affidavit that is the support that lists the probable cause to search that phone belonging to Charmaine Steiger and Rashad Murphy that was taken from the silver Chevy Cruze back in July of 2024?
June 2024.
Sorry, June of 2024.
Yeah. Yes.
Your Honor, this time we introduce into evidence State's Exhibit number 3.
No objection.
Okay, admitted.
I'm gonna ask you to take a look at that.
Sure.
You're familiar with the PC, is that correct?
Correct.
You assisted in the drafting and provided the basis for all of the probable cause, is that correct?
Correct.
Is there anything that was in the search warrant that was incorrect or misleading for the application of the search warrant?
No.
At the time, I believe you've already testified that there was probable cause to seize the silver Chevy Cruze, is that correct?
Correct.
You did not have probable cause at that time to make an arrest of the defendant on that day, did you?
No.
Was he considered a person of interest based on the investigation that you had done to date?
Yes.
Is that the reason why you wanted to interview him on that day?
Correct.
Specifically asking you about the facts and the circumstances, I believe on the affidavit, the first page of the affidavit and application, where it says, based on the facts and circumstances. Did you read that paragraph for the forensic download of the iPhone and what was given for as the reason?
Yes.
Is there anything that is deceptive or inaccurate in that account?
No.
And specifically, you list in there, you want the location data to clarify the timeline of her, and you're referring to Charmaine Steiger and Murphy's trip to Gwinnett County from Jacksonville, Florida, and because GPS application was displayed at the time the phone was retrieved from the Chevy Cruze. Is that correct?
Correct.
And it does make a reference that originally with Steiger's consent.
Correct.
And does the, at some point, did you conduct an interview with Charmaine Steiger?
Yes.
And did Detective Angela Carter conduct an interview of Charmaine Steiger prior to seeking this search warrant for that cell phone?
Yes.
And based on those interviews, was she asked about her whereabouts as well as the defendant's whereabouts, and in particular, the silver Chevy Cruze?
Yes.
And does the search warrant and the affidavit for probable cause outline all of that?
Yes.
Okay, Your Honor, this time we pass the witness.
Okay, Cross.
Detective, to back up just a little bit and set the stage here.
Sure.
This was the infancy of this investigation, correct?
Day 3.
And during the course of day 1 through 3, you were able to seek and review video surveillance from various locations that identified this silver Chevy Cruze, correct?
Correct.
And certainly you had no way of knowing who the occupants were or why it was involved or any backdrop other than that is the make, model, and color of this car. We know who the registered owner is, correct?
Yes.
And you haven't developed at that stage of the game any additional information relating to the registered owner. You hadn't spoke to them yet. You had determined whether anybody else could be developed as a result of simply the ownership of the car.
Yeah, I hadn't spoken to the registered owner.
And so what you did do, though, is you did an alert on the vehicle so that if it was found anywhere through any means, that it would be stopped and secured and held for further investigation, correct?
Correct.
Okay. And this had no evidentiary basis or no person or persons attached. It was the vehicle and the vehicle itself and the vehicle alone.
Correct.
And when the license plate readers determined that the Chevy Cruze was in Gwinnett County, you were alerted that there were individuals being detained and the vehicle had been secured, correct?
I was alerted that one individual was detained and the vehicle was secured, yes.
Okay. Were you aware or made aware that there was another individual in the hotel at that time that might have had some involvement with the car?
Yeah, but I don't believe she was arrested or anything. Yeah.
Okay. But she was detained to the extent that she was taken to the police headquarters and there was a request made from her for an interview, correct?
We talked to her, yes. Again, my understanding of that was that she went willingly with the police department and agreed to stay there.
Okay. And the way that it was determined or the way the car was found was through license plate readers.
Correct.
You talked to Ms. Doherty about the search warrant.
Yes.
And so you kind of used a fellow officer type of situation in this regard. You were working with Detective Carter as a fellow law enforcement officer from another jurisdiction, and you had made a determination that you wanted to search his phone, correct?
Yes, a co-affidavit search warrant. I was working with Carter, correct.
Okay. And certainly Detective Carter wouldn't have had any information about any of the evidentiary backdrop or the probable cause for the search warrant. That would have been supplied by you.
I wouldn't agree to that. We spoke about, I briefed her on what we had on the case at that point, and so she had some knowledge going into the interview of what was going on, and then obviously she's developing new information with her interview with Charmaine Steiger, so we're working together as a team.
So the part of it that she would have direct knowledge about would be what happened with that vehicle once it got to Gwinnett County.
Correct.
Essentially, the portion of the affidavit all the way up to that point, which is toward the end, would have been information you developed in the investigation prior to that.
Yes.
And it's fair to say that the one portion or the one part of the affidavit that involved or where Mr. Murphy was mentioned was that Jacksonville had provided you some general intelligence from their sources that revealed that Mr. Chance and Mr. Murphy could be people of interest in this murder, correct?
Prior to the capture of the Cruze, yeah, correct. That was the one piece of information that Jacksonville had obtained.
Right. And what other additional information you might have had at the time that the affidavit was done is that Mr. Murphy was in custody because he was in possession of the Cruze.
Yeah, that added to the probable cause, him being in possession of the cruise and fleeing from it when they tried to stop him.
Okay. And relating on your reliance in that affidavit to produce probable cause, Jacksonville never gave you any evidentiary basis whatsoever for their opinion that Mr. Murphy could be a person of interest, correct?
Direct evidence? No. I mean, again, they were sourcing information from multiple sources. So
Sources that you weren't aware of, correct?
I was not notified what the sources were, correct?
Sources that they didn't tell you who the sources were, correct?
Correct.
You're not aware if there's any witness that provided any information that might indicate that Mr. Murphy was involved, correct?
Witness, no.
There were no forensic evidence that had been developed that would implicate or cause Mr. Murphy to be a person of interest, correct?
Physical forensic, no. I was aware that they were monitoring his Instagram account, and they were extracting some of the information from there as well to verify what the intelligence that they were getting.
You are not suggesting under oath to the court today that your probable cause affidavit for this phone would have included any information regarding Mr. Murphy, an alleged Instagram account, or anything in that Instagram account that would implicate him, correct?
I don't believe I mentioned the Instagram account up to this point, no.
And there were no forensics, obviously, that would cause him to be a person of interest. Would you agree?
Yeah, correct.
No video other than a vehicle that we've been able to identify, correct?
He wasn't identifiable in any video at this point, yeah.
So it was based on this information that we've just discussed that was generally given to you by the Jacksonville detectives that created this portion of the probable cause affidavit for you.
It's not just the information, it's also what happens when the car is captured. It's the totality. So the PC isn't based solely off of what Jacksonville says. It's also his capture, the fact that he's in the car and in possession of the vehicle that we did have probable cause for.
Okay, so you already felt like you had probable cause to do a search warrant for the vehicle, correct?
Correct.
Okay, and that was your intent to do that.
Correct.
And you're not suggesting that the fact that he was an occupant of that vehicle days after the murder would be evidence that he committed this murder, correct? You agree?
I would think that it's definitely important, in the investigation, or it's it's definitely part of the probable cause, the totality of circumstances, him being in possession of the vehicle that was used in the murder.
And you weren't aware at this particular time that the owner of the murder was related to him, correct?
At this point, no.
So your rationale in then seeking a search warrant for the phone was that you had a search warrant for the car. Mr. Murphy was in the car, so he possessed the car. And when he ran from the car, ultimately a phone was found in the car, correct?
The phone was found inside of the car,
Okay.
correct?
And that phone becomes an extension of the car.
The phone was definitely part of the car, correct?
Well, essentially, your admission when you authored the factual basis for the probable cause for the phone was that the phone was an extension of a car, correct?
The phone was a part of the car, yes.
Okay. Prior to your seeking the affidavit and the warrant for the phone, you didn't, between that time frame, come into or become aware of any additional information as it relates to Rashad Murphy being a suspect in this murder than what we've already discussed, correct?
No.
Nothing further.
Okay, redirect.
Just briefly, Your Honor. Detective Ramos, this, even though that there was a search warrant done on that vehicle and that it was contained in the vehicle, you did a separate search warrant to actually and approved and authorized you and Detective Carter to go into that phone. Is that correct?
Correct.
And you said that there was, it wasn't just the basis of the information from Jacksonville, but you did include the intel from Jacksonville. Is that correct? As part of the basis for the search warrant?
Correct.
And you just referred to it as intel. You didn't list or try to say that this was based on any sort of eyewitness testimony or anything. You specifically put in there, honestly, that it was intel derived from the gang detectives who work in Jacksonville. Is that correct?
Correct.
Listed them by name.
Correct.
And then did you then go in and detail the two names that they had come and provided to you as suspects in this case prior to the defendant being found in the suspect vehicle?
Yes.
And who were the two suspects that they believed, based on their intel, had something to do with this homicide?
Isaiah Chance and Rashad Murphy.
And then Rashad Murphy is found in that vehicle within how many days of the homicide?
3 days.
All of that part of the facts and basis of the search warrant?
Yes.
And then I want to go specifically to the phone. The phone at first was utilized and given to Charmaine Steiger, who said that she also shared use of that phone. Is that correct?
Correct.
She was willing to open that phone and talk to Detective Carter about the phone.
Yes.
All of those facts are contained in the search warrant. Is that correct?
Yes.
And during that interview with Detective Carter, she was questioned as to her whereabouts and the defendant's whereabouts during the time frame of the homicide. Is that correct?
Correct.
As well as that silver Chevy Cruze.
Correct.
And during the course of Detective Carter's interview, did Ms. Steiger, when she was alerted that that car was down in Tampa for homicide, did she start to change the information she was provided about providing Detective Carter about her and her knowledge as to the defendant's whereabouts that weekend?
Yes.
And is that part of the basis why at that point and included in the search warrant that the phone was then seized and a search warrant was going to be secured? Because at some point, Ms. Steiger did not want her looking at that phone anymore. Is that correct?
Correct.
All of that disclosed and part of the search warrant.
Yes.
All right, I have nothing further, Judge.
Okay, thank you. May this witness step down?
Yes, ma'am.
Okay, thank you. Any additional witnesses from the state?
No, Your Honor.
Any witnesses from the defense on this motion, Mr. Gonzalez? Okay, very good. Okay, next will be,
Judge, I know that Mr. Wise had to step out and he has a couple of them that will have to wait, but I do think there is one for Mr. Damian Murphy.
correct? All right, so we'll move on to Davion Murphy, motion to suppress search and seizure of Davion Murphy. All right, and state who's going to be your witness or witnesses for this one.
Detective Nieder.
Detective Nieder,
Nieder, yes, Your Honor.
okay, and that's N-E-D-E-R?
Yes, Your Honor.
Okay.
N-E-A-D-E-R.
N-E-A-D-E-R. Davion Murphy's motion to suppress search and seizure. Okay, detective, raise your right hand. The clerk's gonna swear you in.
Yes.
All right, Ms. Ismer, you may proceed.
Sir, would you state your name for the record?
Detective Richard Nieder,
Where are you currently employed?
Jacksonville Sheriff's Office.
And how long have you been employed with the Sheriff's Office?
Be 10 years in September.
What is your role with the Sheriff's Office at this time?
I'm a detective in the Gang Investigations Unit.
And how were you employed in June of 2024?
I was employed by the Sheriff's Office as a detective in the Gang Investigations Unit.
Did a part of your duties include following or monitoring one specific gang?
Yes,
Did your duties also include making sure that you maintain some level of knowledge as it related to the other relevant gangs in Jacksonville as well?
yes,
Did you ultimately have an opportunity to assist in the investigation into the homicide of Charles Jones?
I did.
And as a part of your role in that case, did you in part conduct or participate in an interview of an individual by the name of Davion Murphy?
Yes.
And do you recall when that interview occurred?
It was, I don't remember the exact date and time, but it was after his arrest in Jacksonville for the warrant that he had.
Would that have been subsequent to the homicide of Charles Jones?
Yes, it was many months after.
And did it take some time for law enforcement to actually locate and arrest Davion Murphy on the homicide warrant?
It did.
Once he was subsequently arrested, were you aware or notified by the arresting unit that arrested Mr. Murphy that he was in custody?
Yes, our unit assisted our SWAT team in arresting him, along with our U.S. Marshals team.
At the time of Mr. Davion Murphy's arrest, was there a photograph produced to you of him at the location of his arrest?
Yes,
Were you able to ascertain what he was wearing at that time?
He was wearing a tan jacket and pants is what I recall.
And had you received that before you actually completed the interview with Mr. Murphy?
Yes, I saw that prior to interviewing him.
Did a formal interview actually take place?
Yes.
Where did that occur?
At our CJIC office, which is located inside of our state attorney's office in Jacksonville.
And was that interview recorded in some way?
It was.
When you had an opportunity to actually speak with him, did you read him Miranda and go through the full formal process of an interview?
Yes, we did.
During the course of that interview, does his clothing or attire change in some way?
Yes.
How is that?
I believe the jacket came off and he was wearing a tank top, like a wife beater, white style tank top.
Was the clothing that he was wearing at that point, could you see more of his body?
Yes.
What parts of his body were exposed to you visually?
After the jacket was off, was
Yes.
his arms.
His arms?
And his neck.
And was there anything that you annotated or marked down, took note of, that was of importance or potential value to your assistance in the investigation?
Yes. Prior to him taking his jacket off, I could see the tattoo 1200 block on the back of his neck. And then after he took his jacket off, I observed several other 1200 gang tattoos.
At the conclusion of the interview that you conducted, or towards the end of that interview, did you have an opportunity to ask Mr. Damian Murphy if you could photograph those tattoos?
I did.
And tell me how that came about.
I asked him, JSO procedures, if you have tattoos on your body, they photograph them at the jail. I asked him if I could take pictures of them inside of the room. And I believe his response was like something like facts or like for sure. I took that as like a consent to photograph his body. Also advised him that they were going to be doing it at the jail as well.
When you spoke to him or asked him about the taking of the photographs, was it a situation where you believed you even needed consent to take photographs?
I don't believe so, because I was either going to take them myself or they were going to be taken at the jail, and I would just pull them from our jail inmate photos.
Is it standard process or procedure for your agency in working with the jail that you will assist the jail in taking photos? Is that typical? Or
I don't assist the corrections officers take the photos, but yes, if you go through processing into our jailhouse, the corrections officers will photograph the tattoos that are on your body that is within reason, like legs, body, neck, face, arms. They don't do like private areas tattoos.
would the
So this is the memo to all people that want to commit crime. The only place that they're not going to they're not going to take pictures of is your private areas, right? So if you want to get 1200 block or ATK or any of these other things, KFC, UFC, NBC, ABC, if you want to get any of this stuff tattooed on you and it can be correlated with some type of boom boom activity, you probably want to get it on in your private areas, is what he basically saying. Because I know we are not here today in court arguing a motion in regards to them taking pictures of his person, which included his tattoos. That's what we doing. All right. Denied.
photos include chest and back? Is
Yes,
that an open
yes, it
area?
would. That would be an area that they would take photographs of the tattoos.
Did you take photos of the tattoos that you saw visually while you were in the course of your interview,
Yes, I did.
and ultimately submitted those photographs as well?
Yes.
When you indicated that you took photographs of pertinent items, you said you saw a tattoo of 1200. What is that, if any, significance to you?
1200 is the name of a gang on our city's east side. It stands for the 1200 block of East First Street, and it's the gang that Davion Murphy is associated to.
Were there other tattoos that you photographed that you recognize as having been related to what has now in court been this ongoing rivalry?
Yes, ma'am.
And would that have also represented people who have died as a result of the violence back and forth?
Yes.
For purposes of documenting those things, did you also make a note or write a supplement which indicated that you took those photographs, which could be used by you or other officers in your agency?
Yes.
And are you familiar with the statutory criteria for determining whether someone meets gang eligibility requirements?
Yes, ma'am. And tattoos is one of them.
Pass the witness, Your Honor.
Okay, cross.
Good morning.
Hey, how are you?
How are you doing?
Good.
All right, so I want to just start off with this interview with Davion Murphy was recorded, correct?
Yes, ma'am.
And have you watched it?
I have not.
You have not watched?
I've watched like bits and pieces of it, but I've not fully watched the whole thing over again.
Okay, so if it was yourself and who else was in that?
I believe it was Detective Drabeck.
All right.
Detective Drabeck would have been like the lead on the interview, and I would have been like a second chair, like helping him.
If I were to show you portions of that interview with Davion Murphy, would you recognize them?
Yes, ma'am.
You recognize it? Detective, I want to show you just portions of that
Okay.
interview.
I tell y'all guys, these Murphy
Is
boys,
it, are you,
I'm looking at these Murphy boys, these cousins, they look rough. Golly, I don't know. It can't, I mean, I know that being in custody, being incarcerated can do some strange things to you. But gosh, just looking at them, they look rough. I hope they get haircuts before the trial. Because if I was a juror, I would be scared of you just because of your hair. You have to get this together. Like this hair game, you're gonna have to let it go, sir. Y'all look scary as hell to me, right? Oh my goodness. I'm like, go put them in jail because of they appearance. Like they look scary. They look rough. Oh, please. Attorneys, please have your clients get their hair cut before we go to trial. I'm telling you, next month I cannot see this because I'm gonna convict them because of their hair. All right. Oh my goodness, darn, look at that face. Don't he look scary? Oh, could you imagine waking up to that mother every day? Me personally, like that's just way too rough for me. Darn. Like you ain't got nobody to braid it or twist it. You gotta let it go. You know, like Teddy Pendergrass is another TKO. Let that go. Especially when we go to trial. I hope they look different when they go to trial. If not, just I'm gonna convict them just because of their hair. All right.
going to be introducing the interview into evidence, or?
I am, Judge, and I have it on a thumb drive, and I wasn't expecting to go up this soon, but I do have it on a thumb drive as well as the photographs. So it will be defense, it will be the entire interview, but I'm just going to play portions for the court and for the detective.
Okay, so for the record, this would be what, defense exhibit? I thought we had 3 that was entered though. That was okay. All right. Okay, so we're going to preliminarily, this will be introduced as defense exhibit 2, which would be the recorded interview, I guess in its totality, of Davion Murphy.
Judge, did you say it was defense number 2?
Well, that's what the clerk said.
Yeah, I already have 1. I just wasn't working on yet, but it's already labeled 1 for defense. It's transcript.
But is that for this defendant?
Does it not say 1? Exhibit number 1?
It says 1.
1 as it relates to
Also,
trial.
Murphy, I'm sorry.
This is
So this will be 1 for.
Yes. Okay. All right. This will be exhibit 1 for defendant Davion Murphy. Okay.
Whatever that is on your laptop. Yes.
All right, can you see that?
Yes, ma'am.
All right, perfect, thank you. So, for this portion of it, which is offense for Davion Murphy Exhibit
1.
1, thank you. Do you see, and I have it stopped, but the beginning of this video appears to be Davion Murphy walking into the interrogation room, and in front of them, there's someone that's standing in a black t-shirt. Is that?
That would be Detective Drabeck.
And then you would be?
I believe I'm behind him, maybe walking in behind the patrol officer or the transport officer that's there also.
Who pulled his jacket down?
Was not me, so I'm not sure. It could have fell based on the angle of his arms. With your hands behind your back, your shoulders really aren't providing much support of clothing.
I didn't mean to interrupt you. All right, so let me just kind of sort of play. So then behind him would have been.
Yeah, I haven't entered the room yet.
Okay.
That's me in the green hat.
Yes. And do you see Mr. Murphy kind of pulling up his shoulder and putting his jacket further to cover himself?
I wasn't paying attention to that point, but I can't really see what he's doing up there.
All right, let me rewind it for you. Let's watch it again. You see the kind of the top of the screen there?
Mm-hmm.
Top left?
Yes.
You'll see his shoulder, his body kind of move where he is repositioning his jacket.
Yeah, I saw that. Let's see that. I don't know if he was doing that for his jacket or the fact that his shoulder may have been uncomfortable by him being in handcuffs. He could have been stretching her. I don't know what his actions were at that time.
If he wanted to stretch, surely after his handcuffs were off, he would have stretched and probably waited, right?
Yeah, you could. I mean, rolling your shoulder would be a form of stretch.
Okay, but it's your testimony that you nor anyone that you saw or you were present with pulled his jacket down, meaning Davion Murphy's jacket down.
I did not.
All right, so let me kind of stop it there. You had indicated that Mr. Murphy, Davion Murphy, had consented? You had read him Miranda and then he consented to these photographs?
Towards the end of the interview, I asked him about his. I asked him if I could photograph them. I let him know they're going to do it at the jail, and I believe his response was something along the lines of like "for sure," which implemented to me that I could photograph them.
So it's your testimony that you asked Davion Murphy?
We were speaking about his tattoos, and I asked if I could photograph them, and he responded with facts for sure.
All right, so then I'm going to speed this interview up, and hopefully I have my times correct. And I'm going to stop. I'll stop at 2:01:01. Wait. Should be 25. We'll stop at 2:01:20.
And is there audio?
No, you're good. He is finishing it up.
You don't look like that.
About the same time. Yeah. He is.
Should I stop?
Sure, I just didn't know if there was audio. So
There is audio. I just didn't think the first part was
Yeah, that's
relevant,
fine.
but okay.
Finishing it up. It just takes long because we got to get the info from Tampa to here. But what I want to do is I'm going to take some pictures of your tattoos. That way it kind of speeds it up at the gym.
Okay, so at that point, you're telling Mr. Murphy, Davion Murphy, that you're going to take photographs of his tattoos. You're not asking him. Would you agree?
And he agreed with me.
Okay, let me back that up.
All right, one last thing we got. No, you're good. I don't have yet. He is finishing it up.
You don't look like that.
About the same time. Yeah. He is finishing it up. It just takes a while because we got to get the info from Tampa to here. But what I want to do is I'm going to take some pictures of your tattoos. That way it kind of speeds it up at the jail.
I'm saying all of them are still current though. Ain't getting nothing.
They don't have them at the jail.
Oh, in prison. Y'all got them. Y'all can get them from prison.
So did you ask him or did you tell him? Because it appears from this interview that you're actually telling Mr. Murphy, Davion Murphy, that you're taking photos. You're going to take photographs of them.
Yes, I said I'm going to take photographs of your tattoos, and he responded with facts for sure, and then undressed himself giving consent to photograph his body.
Facts for sure. What does that mean?
Facts for sure, it would be like a yes. Like, and then with the fact that he took his jacket off, I mean that he was allowing me to photograph him.
Well, didn't he ask you before he started unzipping his jacket, don't you have these photographs from DOC? The jury had these photographs and you didn't get no, they didn't have them.
And I answered that our jail did not have photographs of his tattoos.
Okay. So at your direction, Mr. Murphy, Davion Murphy begins to unzip his jacket.
No, ma'am.
Agreed?
I would
No?
not agree with you. I didn't tell him to take his jacket off.
All right. Would you agree that he's in a confined interrogation room, right?
Correct.
With yourself and Detective Drayback, right?
That right there is Detective Matthew Jones. That's not Treybeck, but yes, ma'am. He was at one point.
Thank you for that correction. He's in a small space, right?
Yes,
With two
reasonable.
detectives.
Yes.
He's just been, and during that interview, would you agree with me that Mr. Murphy, Davion Murphy, indicates to you that he's been drinking and smoking marijuana really the entirety of that day?
I don't recall what he said his plans for that day, what he did that day.
All right, fair enough. Would you agree with me that he really didn't have much of a choice, if that's what you're indicating to the court, is that he agreed or he consented to these photographs?
No, I wouldn't agree with you on that.
All right, so let's kind of play the remainder of this, okay?
Okay.
And I'm at 2:01:53 seconds.
Did you get him in prison? Yeah, I always came in prison. These are all prison tattoos. All right. Soldier. Yeah. Did you join in prison? Soldier. No. I don't know what that is. It's just a Buddha man. What's KD? Roll it. You can roll it. KD, that's my little sister. That's my little sister. You say KD Cosmetics. Okay. Makeup. That's her lips. Yeah. Her lip gloss brand. She start a makeup company. 187. Nice. What's 490? What's 490? Time. There's no 90-minute time. Loan bags. Where's the free case badge tattoo at? Free case badge? Yeah. I don't know, fool. I don't know who that is. Who's case badge? Oh, man. Is that like a Celtic thing? No, same something. I just remixed it in my own way. It'd be different. Okay. You said Saint? Yeah, the same something. You talking about middle of my neck? New Orleans Saints? No, yeah, New Orleans Saints. New Orleans Saints, yeah. I just mixed it up in my own way, try to be different. Yeah, that's my favorite player though.
How many photographs did you take?
All the time.
I don't know the exact amount.
Right. Who's Jacoby Wright? My brother. How many brothers you got? No, I know that's the picture you wanted to get. No,
At that point, the photograph that he moved here behind Mr. Davion Murphy, and he's got the red tank top on, you're actually pulling his tank top down, right?
No.
No? Okay.
that's the picture you want to get. No, that's the picture you want to get. What's the belly looking like? What you got there? You been on Ozempic? No. Holy cow. Let me get this. I've been coming back. Let me get this Avery one. There's K4 on you. Well, you look.
All right, so that is in fact you in that interview room taking those photographs, right?
Yes, ma'am.
All right. I want to show you where I'm going to mark this defense exhibit 2 for identification. So the composite of second first witness. Let's see, mark first.
It's a composite?
It's a composite.
Do you have them marked to A, B, C, D?
I don't have a mark,
So-
but I would say there's a composite of 1, 2, 3, 4, 5.
Well, do me a favor. Do you have a pencil or pen on the back of them as you're showing the witness? Just put to A, B, C, D, so the record's clear what photo is being shown, okay? So just mark them as you go. Do you have something to write?
All right, so
Is there going to be any objection to these being admitted?
No, Your Honor.
Okay, so
it's going to show
do we have
you
an
this.
Elmo? Can you show them? What are you going to do?
I was going to identify them if you want.
Yeah, the state is conceding that they can be admitted, so you don't need to lay the predicate.
It doesn't matter one way or another. I don't mind.
All right, so then I'm going to, this is going to switch to the Elmo, right?
The tech guru needs to intervene.
So this is gonna be,
So you're showing him, what is this?
this is gonna be 2A.
Okay, very good.
Did you take that photograph?
Yes, ma'am.
Okay, so this is gonna be 2B. Did you also take that photograph?
Yes, ma'am.
This is gonna be defense 2C. You took that photograph as well?
Yes, ma'am.
And those are the same photographs that we were watching you take in the interview.
Yes.
And this photograph as well, which is gonna be 2B. Zoom out. 2D.
Yes, ma'am.
All right. And 2E. Oh.
I thought she's on E.
E.
Yeah. Yes. Yes, ma'am.
And then 2F.
Yes.
All right, you would agree with me that all of these photographs thus far are of Mr. Murphy, Davion Murphy, in just a red tank top, right?
Yes.
Jacket has been removed that he had on.
Yes.
This is going to be G, 2G.
Yes.
You took that one as well. And 2H, that one as well.
Yes.
And 2I.
Yes.
And then 2J.
Yes.
And in 2J, would you agree with me that that would be your hand that you're pulling down the back of Mr. Davion Murphy's?
Yes. It appears I'm pulling it down to obtain the full photograph, so you can see the entirety of the tattoo.
So your testimony earlier, when you had indicated to us.
Yes, I must have mistaken about pulling it down. I couldn't see it in the video, and I didn't recall it. But seeing this photograph refreshes that I did pull it down to view the entire tattoo.
All right, fair enough. And then K, that's a photograph of Mr. Davion Murphy's stomach.
Torso area, yes, ma'am.
Torso area, thank you. And he's pulling up his shirt, right?
Yes, he did.
At your direction?
I don't know if we exactly told him to pull his shirt up. We asked him if he had body tats, and he showed him off.
And then 2K.
Yes,
That one as well.
that one. Yes, ma'am.
And would you agree with me that Mr. Murphy during that interview and during that last portion, he had indicated to you that the tattoos that you had just taken of his body, right?
Yes.
Were obtained while he was incarcerated in prison.
Yeah, he did say that he got some of them while he was in prison. Yes.
And do you know the time frame? Do you know when Mr. Davion Murphy was released from prison?
I don't know the exact date that he was released, but if I recall correctly, it wasn't very long before he was back in our custody.
Do you know how long he was in prison?
I do not.
But it was more than a couple years, right?
I don't know his exact prison time.
Did you ever obtain a search warrant or, now it's compound, but because we're here at a hearing, did you or anyone from the Tampa Police Department obtain a search warrant for Mr. Davion Murphy's body?
No, I did. I'm not sure about Tampa. I can only speak for myself. I did not.
Well, they did. So would that have changed your position as to whether or not you felt that you could direct Davion Murphy to lift his shirt up or you pull his shirt down in the back, etc.?
No.
Would you have waited?
No.
Is there a reason why you did not obtain a search warrant first?
He was under arrest, and I didn't forcefully take his clothing off to photograph him. I asked him, or I didn't ask him, I said, I'm gonna take photographs of you. And he took his clothing off by himself. And at our jail, they were going to photograph him regardless. So I would have obtained those photographs, whether I did them myself or if I went to the jailhouse and had them printed off.
So it's your testimony that when Mr. Davion Murphy went to the jail, they would have photographed both the front and the back.
All of his tattoos. Yes, they would have photographed his tattoos.
Did the jail in fact do that?
I'm not exactly sure. I'd have to go back and look.
Did you obtain any of those photographs?
No, because I took them myself.
Okay, so if the jail had taken additional photographs of Davion Murphy's tattoos,
I wouldn't have got them because I wouldn't have needed them because I already had them.
Okay, do you know if they, but you, as you sit here, you don't know if they took them?
They should have, but I did not go back and double check because, like I said, I did not need them anymore.
Do you know if the Tampa Police Department took them when he was transported to Tampa?
I'm not sure how Tampa and Hillsborough County works now.
Is it something that, is that something that a trained detective, either in a gang unit or homicide unit, would want to obtain?
I already obtained them, so I had no reason to figure out if they photographed their inmates or not.
Do you know if Mr. Murphy, Davion Murphy, had any tattoos below his waist?
That, like I said, we don't photograph in those areas. We only photograph the body.
So if the below his waist would have been photographed either by Jacksonville at the detention facility or in Tampa regarding potential gang affiliated tattoos, you wouldn't know.
His lower half would not be photographed by the Jacksonville Sheriff's Office.
What if there was gang tattoos that were affiliated with the tattoos that you had taken?
That's not, our jail doesn't photograph below the waist. It's your body, your neck, your face, and your arms.
What if the individual did have tattoos above the waist and had tattoos that were affiliated with the gang below?
I'm not sure. I don't know how to answer that because that's not what our policies and procedures are.
Would you, if you knew, if you had either on Instagram, what have you, that someone had a tattoo below the waist, either on their thigh, their ankle, what have you, is that something that you would have sought a search warrant for?
I would think it would depend on the circumstances of the photograph.
Well, I'm telling you what the circumstances are, because you indicated that Jacksonville jail does not take photographs of anything below the waist, right? That's what you testified to.
Correct.
Okay. So if an individual had gang tattoos that you were aware of as a detective, right, you would have sought a search warrant in order to obtain photographs of those tattoos below the waist?
I can't speak on what I could have or should have done or would have done.
Hypothetically,
If he would have had tattoos below his waist, I would have addressed that situation at that time. But based on my investigation, that the tattoos that I photographed were on his body, and I did not photograph anything below his waist. So I can't tell you if I would have done something or I would have done something. At the end of it, I didn't, because I didn't photograph below his waist or anything.
All right. So hypothetically, with your training and experience, right? You're a gang detective at Jacksonville.
Correct.
In Jacksonville. Hypothetically, if you had an individual, person of interest that had tattoos that you know of, that had tattoos below the waist, what would you have done?
I mean, I don't like speaking on hypothetically. I work off facts.
Factually, I'm giving you a factual hypothetical. I'm giving you that factual hypothetical. Let's just pretend they are the facts. What would you have done? Would you have?
Ma'am, I can't answer that. We're talking about pretending and hypotheticals. That's not realistic to me. I work off facts and things that are happening.
Answer the question. I'm
going to sustain the objection.
Do you know if the Tampa Police Department obtained any photographs of Davion Murphy from the waist down?
I do not. I would have to ask Tampa that.
You already testified that Mr. Murphy received these. You admitted that he received the majority of the tattoos that, or actually, he said all of the tattoos that you had taken, right, of him in prison.
I don't know if he said all of them or some of them, but he said he did receive some of the tattoos in prison.
Fair enough. And because you did not attempt to or believe that Mr. Murphy consented to any photographing of below the waist, or check with Jacksonville Police Department or Jacksonville Police Department as to whether or not he had any tattoos that were gang related that perhaps he didn't receive in prison? You can't testify to that.
Yeah, I'm not, that you kind of lost me on that question. I'm sorry.
I know it's kind of complicated. Do you know whether or not Davion Murphy has any tattoos below the waist that he did not receive in prison?
Oh, I do not. I don't know what tattoos he had prior to prison or the ones he got in prison. We didn't discuss that.
Did you have the tattoos that he allegedly, photographs of the tattoos that allegedly are from when he was in prison? Because you had indicated to Mr. Murphy that you had those or could get those.
Yeah, I could reach out to the Department of Corrections and ask them. They would have like photos as he went along his time in prison. If they noticed more tattoos, I would imagine that the Department of Corrections would photograph them. I've never worked for the Department of Corrections, so I don't know how they operate or what they do. But if he says that they got him in the prison, will have documentations, that would make me feel like that Mr. Murphy has noticed that corrections officers have photographed his body over time.
All right. Those are all the questions I have for you. I just wanted to make sure that this was good for the clerk. Thank you, sir.
Yes, ma'am.
When you entered the interview room where Mr. Murphy was located, were the tattoos on his neck visible without any questions or follow-up whatsoever?
Yes.
Were the tattoos on his hands visible without any questions or follow-up whatsoever?
Yes.
Did you have an opportunity to ask him, not command or demand, but to photograph his tattoos?
Yes.
Regardless of whatever his response would have been, would you have still photographed his tattoos based on the observations you made?
Personally, I would not have, if he would have said no, I would not have taken his jacket off of him. I would have just waited and got the jail photos.
Okay. Well, you know that the jail is going to take photographs of his tattoos at that point.
Correct.
And you also know that you could, or that the photos exist in the Department of Corrections records, because the defendant not only admitted it, but you're familiar with their processing of inmates.
Yes, that would have just taken a lengthy amount of time to obtain them dealing with those guys.
But they are in existence and also available.
Yes, they should be.
So inevitably, you would have had them from the Department of Corrections based on the defendant's statements and your knowledge of how the Department of Corrections photographs inmates.
Yes.
And their tattoos during the course of their stay in Department of Corrections custody, correct?
Yes.
And inevitably also would have received them from the jail.
Yes.
There's a lot of conversation or questions that you were asked about above the waist and below the waist. When you're talking about below the waist, are you talking about private areas? For example, a tattoo on someone's genitals would not be something you standard or typically would have taken.
Correct.
Without something else.
Correct.
Now, you were asked about what is visible. If you saw a gang tattoo on an ankle during the course of your interview, is that something you would have photographed?
Yeah, if I could see it.
Now, when you said to the defendant, what's the belly look like? Obviously, you were referencing his stomach.
Yes.
But you didn't make any other kind of command, demand, instruction beyond that, correct?
I did not.
No further questions, Your Honor.
Okay, thank you. May this witness step outside.
Yes.
Okay, thank you, Detective. Any additional witnesses from the state?
No, Your Honor.
Okay, any witnesses for the defense? Okay, all right, very good. That concludes evidentiary portion of Davion Murphy's motion to suppress. So want to move on to Sean Gathright?
Yes, Judge, I believe Mr. Wise is back.
Yes, he is. Okay, all right, you ready to go?
Yes.
Okay, state, do you care which one we start with?
Judge, I know the search of the traffic stop and house, we have 5 witnesses, but not, I mean, if you want to do a couple and we go to lunch, it's up to you, Judge.
Okay, let's go ahead and get started at least. Are there any witnesses that you would call initially that will be done completely as far as testifying goes?
Barry, I don't think we'll need it yet, but I was going to call him Bird in the.
That's fine. I'm just asking the question. Well,
I would rather just go chronologically.
that's fine. Just call a witness.
Detective Juan Ramos.
We're doing the, I believe, the motion to suppress evidence obtained following the warrantless search of the defendant's vehicle.
Yes, Your Honor.
Okay, Detective Ramos, welcome back. You remain under oath, and we're now proceeding forward with testimony for Sean Gathwright's motion to suppress evidence obtained following the warrantless search of the defendant's vehicle. Okay?
And Judge, can I go background because
That's
it's
fine.
already taken it?
Yep.
Detective Ramos, I'm going to ask you with regards again to the homicide investigation of Charles Jones. You had developed a probable cause for the black Chevy Impala, is that correct?
Correct.
Can you tell the court how it is that you came to identify the black Chevy Impala?
The Impala was identified through a mixture of video surveillance footage that was obtained from the homicide scene and at least 2 other locations where the victim was tracked. And then ultimately that was compared to images from license plate readers, and the license plate readers gave us the identity of the vehicle, specifically the license plate number.
And did you run the registration of the black Chevy Impala?
Yes.
And who did that come back to?
Damali Lyle in Jacksonville, Florida, defendant Sean Gathwright's mother.
And is that near or close in time to when you were able to identify the silver Chevy Cruze?
Yes, the way we identified them is they were traveling in tandem at some of these readers.
And you were able to also identify a license plate for the silver Chevy Cruze?
Yes.
Did you run the license plate, the tag for that particular vehicle as well?
Yes.
After you had, and who was the registered owner of the silver Chevy Cruze?
And Jasmine Glennon.
After you had identified both of the suspect vehicles from the video surveillance by running them through the license plate readers, what did you do with that information?
I put them into the state and national databases of felony wanted vehicles.
Now, I want to ask you about both the silver Chevy Cruze and the black Chevy Impala. When you ran the registered owners, were any of them, did they live in Tampa?
No.
So there was no indication and you did not have any reason to believe they were within your jurisdiction of Hillsborough County, is that correct?
Correct.
And so what type of BOLO did you put out for those vehicles?
FCIC is a statewide database and NCIC a national database.
What does that do?
That puts the vehicle information, license plate, VIN number, all the descriptors and case number into a database. So if any law enforcement runs that plate, they can see the hit and know that the vehicle is wanted in Tampa.
Okay. And after you are alerted, what is your intent at that point?
To seize that vehicle for evidence.
During the course of your investigation, did you get alerted to a hit by another law enforcement agency of the black Chevy Impala?
Yes, Polk County.
When did that occur?
June 26th as well, June 26, 2024.
A couple of days, 3 days after the homicide, is that correct?
Correct.
Were you at any point during the investigation, were you in a position at that time of hearing that alert to respond to Polk County?
No, I was on the way to Georgia.
To conduct the interview of Rashad Murphy, is that correct?
Correct.
Did you request for other detectives at the Tampa Police Department to respond to Polk County where the Chevy Impala had been located?
Yes.
And who was that?
Detectives David Alverson and Matthew Kirkpatrick.
And after they responded to that area and made contact with the Polk County Sheriff's Office, did they relay back to you what had occurred during their part of the investigation?
Yes.
And what were you briefed as to that?
That the black Impala was located and taken into custody. That at the time that it was located and taken into custody was being driven by defendant Sean Gathwright's grandmother, and that the detectives obtained a statement from Sean's grandmother and viewed some footage from her home in relation to this homicide.
And since Sean Gathwright was not with the vehicle at that point, did you know where he was?
No.
And had there been, you said that there was some video footage that was recovered, that included Mr. Gathwright, the date and time when he arrived at his grandmother's house in the black Chevy Impala.
Correct.
And were you briefed as to what he did when he got there?
Yes.
And is that based both on the detectives Alverson and Kirkpatrick viewing the video footage themselves, as well as conducting an interview with defendant Sean Gathwright's grandmother?
Correct.
And based on that information, did you receive any information about any sort of other vehicle that was now at play in your investigation?
Yes.
What was that?
A gold 4Runner. I was told that Sean Gathwright arrived to his grandmother's house, swapped out things that were in the black Impala, put them into a gold 4Runner, and left in that gold 4Runner.
Based on the information from the grandmother, was there any indication at that time from the grandmother that she saw any sort of firearms or weapons?
No.
But you were given a description of what he was driving, is that correct?
Correct.
And were you also given information that he had removed any sort of items that were in the black Chevy Impala and placed them into the Toyota 4Runner?
Correct.
After you received that information, did you then brief Detective Draybeck as to the information that you had received from Detective Alberson?
Yes.
When did that occur?
The same day, the 26th.
Were you, did you provide Detective Draybeck with a description of that Toyota 4Runner?
Yes.
What sort of information were you able to give him?
So I was able to find out that that vehicle was registered to Damali Lyle as well. So I was able to give him the license plate number, make, model, year, color, full description on the vehicle.
And after you did that, did you also tell him or ever direct him to stop that vehicle or any orders in relation to that?
Yes, I asked him to see if they can put some resources into looking for that vehicle because I believe that Sean Gaithright was in that vehicle and items might have been taken out of the Impala and put into that vehicle. So they started searching for that vehicle and they found it.
And was that to conduct surveillance of the video? I'm sorry, surveillance of that particular car?
The ultimate goal was to get it stopped and try to establish probable cause to search it.
And all of that was conveyed to Detective Draybeck with the Jacksonville Sheriff's Office. Is that correct?
Correct.
And now I want to ask you, I know that you were not there when that vehicle was stopped or searched. Is that correct?
Correct.
There were items later that were searched based on whatever Jacksonville Sheriff's Office authority was to search it. Is that correct?
Correct.
Everything that was later done, were you briefed as to that?
Yes.
And included in there, were you later learned that there were firearms as well as cell phones and laptops and stuff of that nature that were recovered from the vehicle?
Yes.
And before looking at any sort of cell phone, would you have obtained a search warrant to do that?
I would have, yes.
Were you alerted that the cell phones that were obtained in this case, that they were new phones?
Yes.
And based on that, did you then decide to do a search warrant for the defendant's iCloud account instead?
Correct.
Did you ever search or seize the defendant's phone?
No.
And as far as the search warrant, again, for the house that was later done on Sean Gaithright's house, did you participate in that search warrant or execute that search warrant on behalf of the homicide case here?
No.
What is your understanding as to how they did the search for Sean Gaithright's house?
Jacksonville had their own probable cause for Sean Gaithright's house, and within that search warrant for their probable cause, the scope included firearms and firearm components.
And so was that a probable cause search warrant that was done for a homicide investigation that occurred in Jacksonville and had nothing to do with the homicide that occurred here in Tampa? Is that correct?
Correct.
So they had executed a search warrant and it was authorized by a judge, and they did that on their own for their own case. Is that correct?
Correct.
And during the course and execution of that search warrant, they received and within the purview of the search warrant were authorized to take firearms and ammunition. Is that correct?
Correct.
And they processed it and they seized it for their case. Is that correct?
Correct.
And they ran NIBIN and conducted testing on those items pursuant to their investigation. Is that correct?
Correct.
And you were relayed information after those items were processed for their case that it was connected to your case. Is that correct?
Yes.
Your Honor, we pass the witness.
Okay, Cross, Wise.
Your Honor, I know the iCloud warrant came up, but so we're going to do that motion separately.
That is correct, Judge. Because you had also brought up the phone, I just wanted to touch upon it.
Morning, Detective.
Morning, sir.
Detective Ramos, you first learned of Sean Gaithright's name, correct me if I'm wrong, after you connect the Chevy Impala to his mother and then learn that his mother, Molly Lyle, has two children, including Mr. Gaithright, correct?
Correct.
And when you come upon that information, you contact, I believe it's Detective Draybeck in Jacksonville and ask him about this Chevy Impala that you've now seen on the license plate readers. Is that correct?
We spoke about it, yes.
And he wasn't familiar with that particular car, correct?
No.
And when you, and at that point, had you developed the Sean Gaithright name, or does that come at a different time?
The very first time that I know of the Sean Gaithright name is when I ran the license plate registration to the Black Impala and saw that the registered owner was Damali Lyle, and then I did some research into her and saw that she had two children that lived at the same address.
And so when you come upon Sean Gaithright and you believe he may have maybe a person of interest to you at that point, you asked Detective Draybeck about Sean Gaithright as well, correct?
There wasn't much at that point. We had not located the vehicle yet, so I did not have the information from grandmother or the video footage of him driving the vehicle to the house after the murder. So there wasn't much discussion prior to the capture of the Impala about Sean Gathright.
Okay, but at some point prior to the traffic stop, ultimately in Jacksonville, you have asked Detective Drabeck about Sean Gathright, correct?
Well, I believe we spoke about him, yes.
And Detective Drabeck didn't know who Sean Gathright was.
They didn't have any real history on him at that point.
I mean, he wasn't even familiar with the name, right?
From what I can recall, yeah.
Now, by the time you have connected the Impala and the Gold 4Runner, and you relay that to Jacksonville detectives, I think Detective Drabeck, that is on or about June 26th at noon. Does that sound right?
About that, yes.
Okay. And you have said that the ultimate goal was to have that 4Runner stopped and develop PC to search it, correct?
Correct.
I mean, but you agree with me, you've got to have legal basis, number one, to stop the car, and number two, to search the car, right?
As the Supreme Court ruled, the pretextual traffic stops are perfectly legal. So
But, sure.
they had to develop their own PC. But yes, it's a pretextual stop.
Pretextual stops are legal, but
Yeah.
you've got to have cause to stop the car first, right?
I believe they developed their own cause, yes.
And you would agree with me, based on what you had seen to that point, you don't have enough to conduct a traffic stop of this 4Runner.
At that point, the decision was made prior to that there wasn't enough probable cause to seize the vehicle itself for this investigation, yes.
And you're aware, even if a traffic stop is made, then you have to have probable cause to search the car for some reason, correct?
Because we had the information that items were removed from the car and placed into that car. So again, there was some evidence that car was in play in relation to our murder, but there wasn't a warrant that we were seeking for that.
And just to clarify for the record, we're talking about the 4Runner, right?
Yes.
Okay,
And
thank you.
to ask again, my question is, for the 4Runner, you recognize you're a seasoned detective. If you pull it over for a traffic stop, an alleged traffic infraction, you got to have some probable cause to search the car. You can't just go in and search the car.
Correct.
Right?
Correct.
And at that point, even with your suspicions, was not enough to justify a seizure and search of the car.
On its own, no.
And you said about noon on the 26th, you're notifying Jacksonville basically that you're hoping to be able to search this car.
I told them that a suspect in this homicide, was likely traveling in this vehicle, and I asked them to look for it, yes.
And then within approximately 2.5 hours of that time, the car has been stopped and searched. Does that sound about right?
It was that same day in the afternoon, yes.
With about 2:30 that afternoon?
I can't recall the exact time that they stopped the vehicle, but it was somewhere in that afternoon.
Approximately 2.5 hours after you contacted them. Does that sound about right, that they would have stopped and searched it by that point?
I can't recall it.
Okay. And I think you covered this, but you don't have any part in the stop and search of the car in Jacksonville.
Correct.
Well, are you in Georgia at that point or in Tampa?
I'm either traveling to Georgia or in Georgia.
Okay. You mentioned the knowledge you had of Jacksonville, then obtaining a search warrant from Mr. Gathwright's house later.
Correct.
But you were aware that they were relying on evidence that was obtained from that traffic stop to get the search warrant for the house in Jacksonville.
Correct.
And you also mentioned that evidence is taken from the house that is being investigated in connection with the case in Jacksonville. But there's also evidence taken from that house that you ultimately rely on in your investigation, correct?
Correct.
That's all. Thank you.
Okay, redirect?
No, Your Honor.
Okay. Okay, Detective, that's it for this motion. So, all right, so it's 12:02. Is the next witness lengthy or
No, Judge.
short? Okay, let's go ahead and call the next witness.
Okay. Second call is Christopher Drabeck.
This is Sean Gathwright's motion to suppress evidence obtained following the warrantless search. It's the same one. Yeah, we're not done yet. Okay, welcome back, Detective. You remain under oath. We've moved on to Sean Gathwright's motion to suppress evidence obtained from the warrantless search of the defendant's vehicle. You may proceed.
Detective Drabeck, on June 26th of 2024, again, were you contacted by Detective Ramos from Tampa Police Department in reference to a gold Toyota 4Runner?
Yes.
And were you given details as to the make and model and the connection to the black Chevy Impala and Sean Gathwright by Detective Ramos?
Yes.
Was there a request from Detective Ramos to conduct surveillance on that vehicle and see whether or not probable cause could be ascertained or developed in order to do a search of that vehicle?
Yes.
Who were the two detectives who were assigned to surveil the vehicle?
I know ultimately Detective Chris Berry and Detective Craig Griffin took on that role.
And and you were aware that that was being done, is that correct?
Yes.
And did you participate in the surveillance of of those vehicles?
No.
Okay. Your Honor, that's all I have for Detective Drabeck.
Okay, Cross.
Good afternoon.
Detective Drabeck, you're in the gang unit in Jacksonville?
Yes.
You're contacted by Detective Ramos at some point back in June of 24 and asked about a Chevy Impala with a certain license plate number. Correct? Does that sound familiar?
Yes.
You didn't, that Impala and license plate number was not familiar to you, correct?
It was not.
All right. And then you're asked, I don't know if it was the same time or sometime, within a day of that, maybe you're asked about a guy named Sean Gathright as well, right?
I don't recall if he specifically asked about Mr. Gathright, but I do recall him inquiring about the vehicle.
Okay. And you recall him telling you that he found the name of a woman, Damali Lyle, that the vehicle was registered to, and she had 2 children. One of them was Sean Gathright. Does that sound familiar?
Yes, I do remember him mentioning Miss Lyle.
And I guess what I'm ultimately getting at is before the name Sean Gathright is relayed to you from Tampa Police, however it may come, that was not a name you were familiar with at all.
No.
Correct. You're not present when the car is searched, the 4Runner, is that right?
Correct.
But am I correct? You author the search warrant for Mr. Gathright's residence later on?
No.
Okay. Do you have any part in providing any of the information that's going to be relayed in that search warrant affidavit?
No, sir.
And am I correct? You're present when that warrant is executed, but you don't actually go in the house?
I was present at the point of the residence being secured and the search warrant being read to the occupants of the residence. At that point, I left.
Okay. And did you have any communication with Detective Ramos at any point after that regarding the search of the house?
As it relates to Sean Gathright's residence, no, because I was not there.
Thank you.
Okay, redirect.
No redirect.
Okay, thank you. You're done as far as this motion goes. All right,
you.
is the next witness lengthier?
No.
Let's go ahead and call the
Well,
next.
maybe just a little bit.
That's fine.
Okay. Detective Berry.
And is that the witness that will be done after he testifies?
Yes.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may proceed.
Thank you, Your Honor. Please state your full name for the record, spelling your last name for the court reporter.
Christopher Berry, Berry,
How are you employed?
Jacksonville Sheriff's Office.
How long have you been with the Jacksonville Sheriff's Office?
10 years and a couple months.
Were you working on June 26th of 2024?
Yes,
On that date, what unit were you assigned to?
I was assigned to the criminal apprehension unit.
Were you tasked with conducting surveillance on a gold Toyota 4Runner involved in an investigation, a homicide investigation for Tampa?
Yes,
Who were you assigned to do that with?
I was working with the gang unit.
And on that date, June 26th of 2024, were you given some information about
Hold
where
on.
to look?
Mr. Harmon, Ms. Ismer, you all need to whisper. Go ahead.
On that date in conducting surveillance, where did you go? What area of town?
It was the north side by the airport.
Why did you go to that location?
That's where we were told. I come in to work a shift with them, and that's where I was told they were.
And approximately what time did you go to that location?
It was in the afternoon. I don't recall. It wasn't dark, and I know it wasn't early in the morning.
Who were you working with?
The gang unit.
Was Detective Griffin one of the detectives that you were working with that day?
Yes.
And what sort of vehicle were you in?
If I recall in the time, I think it was an F-150.
At some point, did you observe or see or come into contact with that gold SUV?
I did.
And can you explain where that happened?
It was the 2700 block of New Berlin Road. I can't remember the cross street. It's in between Dunn Creek and Yellow Bluff.
And what were your observations at the time?
It was driving above the posted speed limit and that they had dark window tint, so a traffic stop was conducted.
What sort of area were you in at the time?
It's mostly a residential area.
And do you recall what the speed limit was?
I don't recall off the top of my head, somewhere between, it'd be 35 or 45.
And you said that there were 2 reasons the vehicle was stopped. Is that correct? You said
That's
the
correct. The tent, yep.
And what else? Speeding?
It would have been above the posted speed limit, but I didn't have an actual, basically I was just doing off the visual estimation.
Visual estimation.
Yep.
Do you receive training in order to be able to make visual estimates of speeding?
Yes,
Can you tell the court what sort of training you receive in this area?
it's a state accredited class through the state of Florida.
And do you receive a certificate after you complete that course?
Yes,
How long is that course?
40 hours.
40 hours. And can you tell the court what sort of training that certification class, that week-long class entails?
Basically, you go out and do, the class as a whole will go out and do traffic enforcement, but it's more or less training as in visual estimation of how fast the car is going, and then you would, verify it with a laser or radar.
At the end of that week-long class, are you actually tested to see if your visualization of the speed, estimate of the speed is accurate and tested against an actual radar recorded reflection of the speed?
Yes,
And is there a requirement in order to get that certificate? Is there any sort of requirement as to your accuracy to the actual reflected speed on the radar?
yes.
And what is that?
It's between 3 and 5
And were you able to pass, and were you, when you say 3 or 5 what?
miles per hour. So
3 or
your
5.
estimation has to be when the actual, what was captured on radar laser.
So that's how you're tested and that's how you are certified. You actually give an estimate and it has to be within 3 to 5 miles of the actual reported speed by radar.
That's correct.
And did you pass that and were you certified with that estimation?
Yes.
And so after you did that, do you still, in the course of being in the gang unit, do you still actively do that on a regular basis?
During patrols, yes, you could.
Approximately how many times would you say you have to do that in any given month?
It just depends. That's not my on-view activity is not my normal course of duty.
But it is something that you have done more than once, is that correct?
Oh, absolutely.
And that was something that you were certified and trained to do?
Yes,
And back on June 26th of 2024, you did a estimation as to speed on that Toyota 4Runner, is that correct?
that's correct.
And was that over the speed limit?
Yes.
And do you recall at this time whether or not you can remember how fast he was going over the speed
I
limit?
don't recall exactly. It was, based off of the tent and then that also second violation.
So you had a second reason to stop that vehicle, is that correct?
Correct.
And how was the Toyota 4Runner violating the tint requirement?
Based on the visual estimation of how much you could see into the car, the tent looked darker than what it was supposed to be. Once the traffic stop was done, a gang detective had a tent meter and they measured the tent, which showed above or below, however you look at it, above or below the allowed amount.
It was in violation, is that correct?
Correct,
Of
yep.
the legal amount of tint that could
That
be
is
on the
correct.
car.
And then I wrote a citation for that.
You actually gave him a ticket, correct?
Yes.
And when you stopped him, was Detective Griffin, was he present as well when the vehicle was stopped?
He was right behind me. Yes,
Did you ask for the defendant's license?
I did.
And at some point after receiving that license, you stepped away from the vehicle, is that correct?
That's correct.
And then there was interaction with Detective Griffin.
That's correct.
Your Honor, at this time, we pass the witness.
Okay, Cross.
How are you?
Doing well. How are you?
Good.
All right. So, Detective, you weren't familiar with Sean Gathright before this traffic stop was conducted.
No, sir.
And this is happening about 2 in the afternoon ballpark, is that right?
It would be, if I had referred to the arrest report, then I'd be able to tell you the exact time, but it was in the afternoon.
Okay. And you are a member of the Criminal Apprehension Unit.
That's correct.
So you're not a traffic officer at this time.
That is
right?
correct.
Criminal apprehension, you're trying to apprehend
Criminals.
potential criminals, right?
Yep.
Okay. So you're, in this kind of situation, you're going to be looking for a reason to try to stop a target vehicle. Is that fair?
Yeah.
And that's ultimately what Jacksonville is trying to do at this point, right? Trying to find some reason to stop this 4Runner.
Correct.
And you're primarily working, I think you said, with Detective Griffin, correct?
He was, so it just, I went out to help them during this incident, and it's just kind of with a vehicle moving, traffic. It's just how it ended up. I was the first one in line.
Gotcha. But you, at that point, you and Detective Griffin are more or less in the same area of, I think it's New Berlin and Dun Creek roads.
Right. We passed that going, I could call it westbound, but past Dun Creek going west on New Berlin.
Okay. You're in separate vehicles, though.
Yes, sir.
And I think when the 4Runner is first spotted, you're basically, you're closer to it than Detective Griffin, correct?
It was at the River City Marketplace. I don't remember our exact route. I remember being at the River City Marketplace, which is farther away from where the traffic stop was conducted. I don't remember the route of how we got there, how it made it to Dun Creek or to New Berlin passing Dun Creek.
At some point, though, before the traffic stop's conducted, you and Detective Griffin received information from other law enforcement that this target Forerunner has left the residence that it was parked at, right?
So I don't know that I was out there if it was at a residence and as it left the residence, they followed it. I remember being out there and becoming a part of this investigation when it was at River City Marketplace.
Okay. All right. Well, ultimately, when you first spot the Forerunner, you're maybe 50 yards away from it at that point. Is that correct?
I don't remember exactly. Maybe a car length or two from what I recall on Dunn Creek.
Let me ask this. When you first spot the car, where is Detective Griffin in relation to you?
He would have been behind me.
Okay. How far behind?
Well, when you say first spot, when we were traveling on Dunn Creek, I wouldn't call that the first time I spotted it because it was at River City Marketplace and we'd already seen it.
Right.
When we were traveling on Dunn Creek, it would have been target vehicle, me, and then Detective Griffin was behind me.
Okay. And before the traffic stop is initiated, because I think it's Detective Griffin who actually initiates the stop, am I correct?
So he was behind me. I was the one that initiated the defendant would have saw my lights first. When you work in a shift like this with a larger unit, somebody that gets on the radio and calls out the traffic stop, I don't even know who that was that would have done that. Anybody could do it. So I could do the traffic stop with another officer, like another detective behind me. A third detective could pull up and they say, hey, did y'all call this out? Basically get on the radio and say, hey, traffic stop this place this time, blah, 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 and read it out. That could be, so who's saying that called it on the radio may not be, it could have been, I don't know if Detective Griffin did that or who.
Fair enough. But in any event, when you're observing the traffic infraction and then initiating the stop, you and Detective Griffin are in close proximity.
Absolutely, right? Yes.
And you pursue the car for about a quarter of a mile before you initiate the traffic stop. Is that right?
It would have, anywhere from the traffic stop was done in between Dunn Creek and Yellow Bluff. That's a 2-lane road. So there's not, usually if I'm conducting a traffic stop, I'm finding a place where I can conduct it and there's a safe place to pull over, which there was because we were at that convenient store.
You didn't prepare a report in connection with the case, correct?
No, I did not.
But you were Detective Griffin did?
I wrote a uniform traffic citation.
The citation, right?
Correct.
Not a separate police report.
That is correct.
Detective Griffin did or
I believe so. So from this incident, I was a part of it. I had to leave and go do something and then I come back. So I wasn't a part of the search of the car or any of that stuff.
And you wouldn't have any reason to think that whatever Detective Griffin documents in his report or what he recalls would be incorrect, right?
I don't think so. No.
If he said that it was followed for about a quarter of a mile, would you have any reason?
I would agree. Yeah. From the River City Marketplace at the time where the traffic stop, that's more than a quarter of a mile. But from the time that it was, I guess you could say, decided to do a traffic stop, Dunn Creek to the stop location, that's probably about right.
Okay. And the sole bases for the traffic stop are speeding and window tint.
Correct.
You don't recall what the speed limit was in the area where you pulled him over?
So it's going to be anywhere from 35 to 45. I don't recall off the top of my head. But it's a residential area. It's somewhere in between 35 and 45.
Okay. And you didn't issue a citation for speeding, correct?
That's correct.
You didn't write a report, right?
That's correct.
You didn't document anywhere what the estimated alleged speed was the Forerunner was driving?
No, sir.
And you don't remember what you think the speed was?
It's somewhere between 35 and 45. I don't know the exact speed on that road.
But I think you testified on direct. You don't remember how fast you thought the Forerunner was going either.
I don't recall offhand. Go ahead. Sorry.
You don't recall how fast the Forerunner was going? I didn't mean to cut you off.
Not offhand.
So we just have to take your word for it now, a couple years later, that Forerunner must have been speeding.
I remember it above the speed limit. I don't recall. And I know that we wrote a citation for the tent violation under Florida statute. And
I'll ask you about that. But as far as the speeding goes, we've got to rely on what you tell us now a couple years later that it must have been speeding.
That's yes, sir.
Okay. And I don't remember if this was covered on direct, and it's probably clear now, but no one clocked the Forerunner on a radar gun, right?
That's correct.
Let me ask about the window tint now.
Yes, sir.
The windows that you believe were in violation were rear windows in the vehicle?
Yes, sir.
And the citation you ultimately issue was for the tint being less than 15%?
Yes, sir.
You didn't measure the window tint yourself, correct?
I think it was Detective Bias that did the violation.
And you don't know what the results were of his testing?
On there, it should be possibly on the comment, should be in the comment section of this uniform traffic citation. Okay. But offhand right now, I do not remember what he said it was. And it would be recorded on body cam as well.
Yeah, that was one thing actually I forgot to ask about. Neither you or Detective Griffin had dash cams when the traffic stop was conducted, right?
No dash cams.
And did you have a body cam? I
did.
recall. You did, but it wasn't activated until after the search begins. Is that right?
Well, I was never part of the search. It should have been from the time I did the traffic stop until I was never part of the search. So real quick, I did the traffic stop, went back to my car to run the license and then ultimately write the citation. More detectives showed up. They were a part of the search of the car. I never searched the car, never was a part of any of that.
Yeah, and that was probably, a misleading question I asked. before the traffic stop is conducted, you don't have the body camera. Is that right?
It should have been on, from what I recall. Time I do the traffic stop, turn the lights on, I shouldn't have my first interaction with him and then go back to my car to write the citation.
Okay. With the body cam, as you recall, would have captured the visual speed.
I don't know, based on where my camera is on my vest or was at the time, I don't know if it picks up how fast I was traveling.
Okay. Mr. Gathrigh's cooperative with you. Would you agree?
For me, yes.
And when the traffic stop's conducted, he gives you his driver's license.
That's correct.
You run the license. There are no issues with the license, right?
Not that I recall offhand. I mean, if there was a suspension or something like that, then I would have probably wrote a citation for a suspension. Or if he was on an ID card, he would have got no driver's license, ever had one or something to that effect.
Okay. And you also ran the license plate, right? For the 4Runner?
You could go back and pull the records. Probably I did, more than likely. I don't recall. At this moment, I don't remember typing it in, but I know for a fact it was done because when the traffic stop was called out, it would have been ran by dispatch.
Okay. And whether you ran the plate or not, you at least get the license, run the license. And while you're doing that, you have contact with Mr. Gathright, get the license, go back to your car and run it. Detective Griffin stays with Mr. Gathright at the car.
Correct.
And it's not until you come back to the car that Detective Griffin tells you that he has believed to smell a faint odor of marijuana. Is that right?
I don't remember having any, from what I recall from my body camera, I do the traffic stop, go back to my car, and then I never leave my car and go back up for the search or when he was pulled out. I was never up there for that.
Right.
There was other detectives that arrived, but it wasn't just me and Detective Griffin the whole time.
So Detective Griffin doesn't even tell you then that he's detected marijuana.
I don't recall being told that by.
And you never smelled the odor of marijuana either, correct?
I was with him for a couple seconds to get the license and go back to the car.
But at that time, I mean, you're in close proximity. You're right at the driver's side window.
I never smelled it, no sir.
That was my point. But
yeah,
you're right next to the car, right? At some point, like.
I walk up, tell him the reason for the stop, get his license, and go back. I did not stand there for a decent amount of time.
But you're right at the driver's window. You're right there to where he can hand you the license without reaching.
That's correct.
Far out, and you don't smell marijuana.
Not that I recall.
No other questions. Thank you.
Okay, redirect.
Just briefly, Your Honor. Detective, you did these visual estimation while you were in your vehicle, is that correct?
That's correct.
And you were able to discern that he indeed was speeding, is that correct?
He appeared to be driving above the push speed limit.
And that was the basis why you pulled him over, as well as,
the 10th. That is correct. 2 violations.
and even though you're not the one that actually measured, you were there present when another detective from the gang unit came out and measured the actual tint, is that correct?
That's correct.
And based on that, based on your observations, as well as the confirmation, you issued a citation.
That is correct.
I have nothing further, Judge.
Okay, all right. May this witness be excused? Excused.
Excuse, yes, Judge.
Okay, thank you. You are free to go. All right. Okay, very good. We are ready to continue on with Mr. Gathwright's motion to suppress the search of the vehicle. State who's going to be your next witness.
Detective Griffin.
For the record, defendants are all present with counsel, states present.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, you may proceed.
Thank you, Your Honor. Please state your full name for the record, spelling your last name.
Detective Craig M. Griffin, Griffin.
How are you employed?
Currently with the Jacksonville Sheriff's Office,
How long have you been with the Jacksonville Sheriff's Office?
almost 17 years.
What unit are you currently assigned to?
Currently assigned to the Gang Investigative Unit,
How long have you been in the gang investigative unit?
a little over 5 years now.
And were you working on June 26th of 2024?
Yes, ma'am.
On that day, were you tasked and assigned with conducting surveillance on a gold Toyota 4Runner?
Yes, ma'am.
And was that part of an investigation that was jointly being done with the Tampa Police Department for a homicide that occurred down here in Tampa?
Yes, ma'am, it was.
Who were you working with on that particular day?
Other members of the gang unit,
And what was your assignment?
more or less assigned to the outer perimeter of the neighborhood.
And you were conducting surveillance on that gold Toyota 4Runner, is that correct?
That's correct.
And was the purpose to see whether or not you could see a traffic infraction?
Yes, ma'am.
And where were you, do you remember where you were stationed at when you first saw the Toyota 4Runner?
I was on New Berlin Road.
that located in Jacksonville, Florida?
Yes, ma'am.
Did you have any information as to where to set up in order to put eyes on that Toyota 4Runner?
No, ma'am, just in the general area.
And did you at some point while you were stationed there see the Toyota 4Runner?
Yes, ma'am, I did.
Did you also have like a tag information as well as the description and make and model?
We had a description, make and model. I don't recall if we had the tag or not, but I believe we did.
And at some point you said that you saw that. Do you remember approximately what time it was when you came into contact and made visual observation of that vehicle?
Roughly around 1400 hours, 2 o'clock.
2 o'clock in the afternoon?
Yes, ma'am.
And can you tell the court exactly what you observed?
I observed the vehicle traveling south on New Berlin Road. Observed it for a little while. I've seen that it was traveling at a high rate of speed. Got up closer to guesstimate the estimated speed in which it was traveling, seen that it was traveling faster than the posted speed, and also observed the dark tinted windows on the vehicle, and then decided to do a traffic stop.
Was there another detective, Detective Barry, that was also working and in a different vehicle?
Yes, ma'am. He was with me.
And you said that you made a visual observation that was speeding over the posted limit. Is that correct?
That's correct.
Do you have any sort of training or certification in being able to visualize and estimate speeds of moving vehicles?
Yes, ma'am. FDLE offers a course in speed and radar measurement, in which is a week-long course that I took and passed in early 2019, 2020.
And do you become certified after you take that class?
Yes, ma'am.
Can you tell the court what that entails, that sort of training that you did?
So that training is in large part of you all going out and observing vehicles traveling. You match their speed with what you estimate they to be, and then you verify it being using either your speedometer, a laser, or radar.
So there's something to measure what your estimation is. Is that correct?
Yes, ma'am.
Okay. And at the end of that week-long course, are you then tested to see your accuracy in your ability to be able to estimate the visualization or visualize the actual speed?
Yes, ma'am. There's actually 2 exams. One is strictly based off the estimation of speed. It's approximately 50 cars in which you have to estimate the speed. And then another was an actual written exam at the end.
Okay. And when you are looking at these 50 different cars and estimating speed, is there a score that is considered acceptable for you to be certified in this area?
Yes, ma'am.
And what is that?
You had to be 50. Oh, you had to be 100% correct.
You had to guess the speed of all 50 cars 100% correct.
Yes, ma'am. Within 5 miles per hour, plus or minus.
And you were able to do that, sir?
Yes, ma'am.
And you became certified in this area?
Yes, ma'am.
And during the course of your work in the gang unit, is that a skill that you continue to utilize in your work?
Yes, ma'am, I do.
Approximately how many times would you say that you'd have to visualize and make those speed estimates?
Once to twice a week.
So that's something that you have regularly kept practice at, is that correct?
Yes, ma'am.
And going back to June 26th of 2024, did you have any sort of radar gun with you or anything other than your ability to visualize the speed?
No, ma'am. Just the my speedometer in my car, which is regulated through our city department.
And so you were in a moving vehicle at the time when you are surveilling the Toyota 4Runner involved in this case?
Yes, ma'am.
So you have that visualization as well?
Yes, ma'am.
And was the car going greater than the speed that you were going?
Yes, ma'am.
And you said that it was going greater, it was speeding over the speed limit, is that correct?
That's correct.
Was there another basis to pull over the vehicle?
There was.
And what was that?
The dark window tint.
And what, did you have emergency lights on your vehicle?
Yes, ma'am.
When did you initiate those?
Shortly near New Berlin and Sap Road.
And was your intent to conduct a traffic stop at that time based on your observations?
Yes, ma'am.
And did you and the detective Barry do that?
Yes, ma'am.
And it's who received who received Sean Gathrigh's license?
Detective Barry was the first to make contact with him, and then I walked up and made contact as well.
Okay. And what did Detective Barry do when he first made contact with the person in the Toyota 4Runner?
He identified who he was and then asked for his driver's license, I believe.
What happened at that point?
Mr. Gathright handed him his Mississippi driver's license, and Detective Barry then went back to his vehicle.
Did you remain at the driver's side door of the vehicle?
I did, yes, ma'am.
Was there one or more occupants in the vehicle?
No, ma'am, just one.
And you said that you guys received a license, and who did that belong to?
Mr. Gathright.
And is Mr. Gathright, is he present in the courtroom today?
Yes, ma'am.
I'm sorry, sir. Can you please point him out and describe what he's wearing?
The light-skinned gentleman in the orange jumpsuit.
We're approximately in the lineup because we have.
Oh, I'm sorry. He has on a red. He'll be the one in the middle from where I'm looking at. I only see 3. I can't see the other one.
Okay.
Next to the lady in the pink.
Okay.
To the left of her.
All right. Very good. Thank you. The record should still reflect that he's been identified.
So after Detective Barry received his license, did you remain at the driver's side door with the defendant?
I did, yes, ma'am.
And what happened while you were at the driver's side door?
We engaged in a conversation.
And when you were engaging in a conversation with the defendant, did you make any other observations?
I did, yes, ma'am.
And what was that?
Detected an odor of marijuana.
Okay. At that time, was the window up or the window down?
The window was down.
And you said, how long had you been with the Jacksonville Sheriff's Office?
Going on 17 years.
And during your 17 years with the Jacksonville Sheriff's Office, have you had occasion to come into contact with cannabis or otherwise known as marijuana?
Yes, ma'am.
And do you recognize the smell or odor of marijuana, both burnt or in raw form?
Yes, ma'am.
And is that what you detected back on June 26th of 2024?
Yes, ma'am.
And besides your on-the-job training, your lengthy experience at the Jacksonville Sheriff's Office, did you receive any sort of courses or additional training in that area, being able to detect the odor of marijuana and other narcotics?
I've taken courses in the past put on through HIDA in reference to drug recognition.
And how often would you say during the course of your employment with the Jacksonville Sheriff's Office that you had occasion to come into contact with cannabis, also known as marijuana?
Several times throughout the month.
After you detected the odor, what did you do?
I asked questions in reference to the odor that was coming from the vehicle.
Can you tell the court what specifically did you ask of the defendant?
I believe I asked Mr. Gathright if he had smoked today or if he was in possession of any marijuana.
And what was his responses to those questions?
He said no.
And after you asked him those questions, what did you do?
I asked him to step out the vehicle.
Why did you do that?
So do a probable cause search of the vehicle in order to locate the marijuana.
And did you then proceed? Did you yourself conduct the search?
Yes.
Were there other detectives from the Jacksonville Sheriff's Office, the gang unit, present during that time?
Yes, ma'am.
But you are the one that searched the vehicle, is that correct?
That's correct. Yes, ma'am.
Can you tell the judge what happened during the search of your vehicle?
Mr. Gathright stepped out. I asked him to step to the back of the vehicle. When he did that, he did. I then began the search of the vehicle. Observed a black backpack in the passenger seat. Inside that bag, located I believe a grinder or a mason jar that had marijuana residue. I also located a plastic bag of what appeared to be mushrooms. Continued searching, found a firearm in the center console. And then at that point, we stopped and I told them to detain Mr. Gathright.
So when you are searching the vehicle, are you searching for marijuana during the entire search of the vehicle?
Yes.
And during the course of conducting that search for marijuana, you came across a firearm, is that correct?
Yes, ma'am.
What type of firearm was it?
It was a Glock handgun
Where was it located?
in the center console.
And you said at that point you stopped the search?
Yes, ma'am.
Why did you do that?
Just to have Mr. Gathright detained,
And why did you detain him at that point?
because at that point I had probable cause to place Mr. Gathright under arrest
For what?
for armed possession of a controlled substance along with drug paraphernalia.
And is there also a violation with the defendant's age and possession of a handgun?
Yes, ma'am. At the time, he was 18,
And what age do you have to be to own the handgun?
21.
And there was no one else in the vehicle, is that correct?
No, ma'am, there wasn't.
Did you then have a inventory search done on the vehicle?
We did. Yes, ma'am.
And was the vehicle inventoried for all of the contents?
That's correct. Yes, ma'am.
What was located other than you had testified to the drug paraphernalia as well as the drugs, is that correct?
That's correct.
Did you do any sort of presumptive tests on the cannabis that was collected?
Other than based off of odor, no, ma'am.
And you said that he was placed under arrest for that, is that correct?
Correct. Yes, ma'am.
As well as for the handgun.
Correct.
And the inventory search of the vehicle, were there additional firearms or parts associated with firearms that was recovered during the inventory search of that vehicle?
Yes, ma'am. If I recall correctly, there were firearm parts and accessories along with shell casings, cell phones, and live ammo, I believe.
All of that was inventoried, is that correct?
Yes, ma'am.
And is that standard procedure when a person is arrested and a vehicle is taken into custody?
That's correct. Yes, ma'am.
Also, part of the standard procedure and protocol when conducting an inventory search, what happens when there is ammunition and firearms that are recovered in any sort of search?
They go through a process called NIBIN.
And that is done in every single case when there are firearms and ammunition, regardless of it's an inventory search or a search warrant. Is that correct?
That's correct. Yes, ma'am.
And that is standard procedure?
Yes, ma'am.
And you said that he was placed under arrest. Is that correct?
Yes, ma'am, he was.
I want to ask you about, and what were the charges again?
Armed possession of a controlled substance along with drug paraphernalia, and then he received a citation for the dark window tint.
And I want to ask you about the speeding. You did your own independent estimation of the speeding based on your training and qualifications. Is that correct?
That's correct. Yes, ma'am.
Did you cite or give him a traffic ticket for the speeding?
No, he's only issued a warning.
And why not? And why issued only a warning?
it was convenient at the time to issue a warning. He had already read the citation for the dark window too.
And after all of the search and surveillance of that vehicle was completed, did you report your results to Detective Drabeck or officers from the Tampa Police Department?
Yes, ma'am.
May I have one moment?
Yes.
Where do we pass the witness?
Okay, Cross.
Oh, sir.
Detective, you were familiar with Sean Gathright prior to the day you conducted a traffic stop, right?
I was not, no, sir.
And when you conduct a traffic stop, there's basically somewhat of a concerted effort amongst Jacksonville gang unit detectives to try to find a reason to stop this forerunner. Is that
Yes.
fair to say? And when you were in the area of
You know the amazing part about all of this, or not so amazing, depending on what end of the spectrum you're on, and depending on your opinion. What I would like to say is that this guy Sean had everything in the damn vehicle. That's what I would like to let y'all know. And I'm getting it pulled up so we can watch the actual arrest video, but he had everything in there.
I think it was New Berlin Road and Dunn Creek Road. You had gotten word from another officer sometime around that point that the target forerunner had left the residence.
That's correct. Yes, sir.
And was it believed to be heading in the direction where you were positioned?
I don't remember where it was headed to. It was more or less they notified us that the vehicle had left.
Okay. And it's about 5 to 10 minutes later that you actually see this gold forerunner. Is that
Correct.
right?
Yes, sir.
And at that point, you're with Detective Barry as well?
That's correct. Yes, sir.
Separate cars, but you guys are kind of in the same general area?
Yes, sir.
And when you first see the forerunner, am I correct? You're about 50 yards away from it approximately?
Yes, sir.
And you don't have a dash cam in your car?
No, sir, I don't.
And I think you're wearing a body cam, but you don't activate that until the traffic stop is actually beginning, right?
Correct. Yes, sir.
You follow the forerunner for about a quarter of a mile
Yes, sir.
before you stop it, right?
Mm-hmm.
Okay. And the sole basis for the stop, just so we're clear, is the speeding and the window tint violation.
That's correct. Yes, sir.
If you recall, when we had the deposition, you may recall this, you didn't recall what the speed limit was on that road where he was stopped. Do you know now? Do you remember what it was?
I didn't go and check. It's either 35 or 45.
Okay.
I can't remember.
And you didn't use any kind of, I think it's covered, right? But you didn't use any kind of radar gun, laser, or anything to clock how fast the forerunner is.
No, just my odometer itself.
Okay. Well, was it were you pacing it with your odometer, or were you visualizing it as you described?
So the way it works is you visualize and you guesstimate the estimated speed, and then what you do is you get close to the car and you start speed matching, and then at that point you verify through your speedometer how fast the vehicle was going.
Okay. And you did all that in that quarter mile distance that you were following?
Yes, sir.
The class that you told us about on direct that you took that taught you how to estimate speed.
Yes, sir.
That was in 2020?
2019, 2020.
So 4 to 5 years before this took place.
Yes, sir.
Did you have any kind of follow-up class since that time?
No, sir.
You wrote a report in the case, correct?
Yes, sir.
And I know you didn't issue a citation for speeding.
No, sir, I did not.
You didn't listen to report what you believe the speed that the forerunner was going might have been.
No, sir, I did not.
The tint, you did not measure the window tint on the truck, correct?
I didn't. Somebody else on scene did.
And just for the record, I'm sure we all know, but a forerunner, by the way, that's a sport utility vehicle, right?
That's correct.
And you don't know what the readings were on the tint meter, whoever may have done that. You don't know what the results were.
No, they should be on the citation.
The citation that was issued by a different officer.
Correct. Yes, sir.
All right, when you initiate the traffic stop, Mr. Gathright pulls over at basically the nearest safe location he sees, right?
That's correct. Yes, sir.
And he's cooperating with you.
He is. Yes, sir.
He provides his driver's license to Detective Barry.
Yes, sir.
And I don't know, do you or Detective Barry, somebody runs the plate, right? The license plate?
Yes, sir.
And there's no issues with that, right?
None at all.
No issues as far as you know with the driver's license either, correct?
None that I know of.
And you're at the side of the car for some period, several minutes, right? While Detective Barry's running the license and all that.
Yes, sir.
You're talking with Mr. Gathright.
That's correct.
You don't see any signs of impairment or anything to suggest he's under the influence, right?
No, sir.
And at some point, you smell this odor of marijuana.
That's correct. Yes, sir.
You're not able to distinguish whether it might be burnt or fresh marijuana.
That's correct.
And you describe it, I think, in your own words, as a faint smell.
Correct.
When you go on to conduct a search, am I correct? The marijuana or suspected marijuana is inside a mason jar.
Mason jar or grinder? I believe it was a mason jar.
All right. And I was going to say, would looking at something help refresh a recollection of whether it was a grinder or a mason jar, specifically your depot transfer?
Yeah, that's fine.
Okay.
I want to say mason jar.
Okay. I think this came up, so maybe this will refresh your recollection. May I approach?
Sure.
This is a portion of, the definitely isn't a long binder over there, but
No, I got you.
that page probably would be right.
Okay.
Let's take a look at it and let us know if that refreshes your recollection.
Mason jar with marijuana residue. Yes, sir.
Did I refresh your recollection as to what was in?
Yes, sir.
Am I correct? It was a mason jar.
That's correct.
And the mason jar had a lid on it?
Yes.
And then that mason jar was inside another bag, correct?
It was inside a backpack.
A backpack. Okay.
Yes.
And the backpack, it wasn't one of the transparent backpacks that someone like carries into a football.
No, no, sir.
What I'm getting at is you can't see what's inside the backpack until you open it up.
That's correct.
And the marijuana that's inside is what you might describe as a residue.
Correct. Yes, sir.
A small amount.
Correct.
In fact, it's such a small amount that you can't even weigh it.
That's correct.
So obviously it's not weighed. Is there a presumptive test done on marijuana?
No, sir. Just the odor based off of after you open the mason jar.
Okay. And to get to the mason jar, you got to unzip the backpack too.
Yes, sir.
As far as everything else that's found in the car, basically the guns, the firearm parts, the ammunition, they're basically in two separate sealed bags, correct?
Correct.
So really, when you're stepping outside the car, and before you actually start the search, you don't see anything in the car that's suspected contraband.
No, sir. Not off plain view. No, sir.
And the sole basis for the search is the faint smell of marijuana.
That's correct. Yes, sir.
That's all I have. Thank you, sir.
Okay, redirect.
Yes, Your Honor. Detective, you observed the faint odor of marijuana and your search revealed marijuana, is that correct?
Yes, ma'am.
You said that there was also mushrooms, is that correct?
Yes, ma'am.
And the firearm.
In the center console. Yes, ma'am.
All that basis of the arrest, is that correct?
Yes, ma'am.
As far as having another officer come and actually write up the citation, is that usual practice?
Yes, ma'am. We work as a unit.
Nothing wrong with that?
No, ma'am.
Nothing unusual about having another detective with the unit actually do the measurement of the Toyota 4Runner SUV?
No, ma'am. Not at all.
And just the fact that it's a sport SUV utility vehicle, that does not exempt it from the laws concerning window tints. Is that correct?
No, ma'am.
Nothing further, Judge.
Okay, very good. Is this witness done, or does he need to?
He does need to stay.
Okay, very good. You're done for now. Remain outside. Okay, and who's your next witness?
One more witness for this motion, Detective William Parker.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, shall be God? I do.
Okay, you may proceed.
Please state your full name for the record.
My name is William Parker.
How are you employed?
I'm employed as a detective with the Jacksonville Sheriff's Office.
What unit are you assigned to?
I'm assigned to the homicide unit.
How long have you been with the homicide unit with the Jacksonville Sheriff's Office?
Almost 2 years.
And back in June of 2024, did you become aware of a search that was done on a Toyota 4Runner on June 26th of 2024?
I did.
And was that as a result of a search of that vehicle and some NIBIN results?
Yes.
How did you become aware of those results?
I received a report from our firearms laboratory stating that there was a match to a shell casing that was found in the vehicle to a murder I was investigating.
And is that still an open and pending investigation?
It is.
So no arrests have been made on that case, is that correct?
That's correct.
But you are the lead detective assigned to that particular case.
Yes.
And as part of Jacksonville Sheriff's Office policy, any sort of firearm or ammunition or rifle, any sort of firearm and related type of parts, that would be sent to NIBIN if it was taken in an inventory search or any sort of other search warrant. Is that correct?
That's correct.
And you just happened to get those NIBIN results after the search was conducted. Is that correct?
Yes.
Prior to that, had you had any knowledge or had you heard of the name Sean Gathright before?
No, I haven't.
And during the course of your investigation of the unrelated homicide that occurred in Jacksonville within your jurisdiction, after you received those NIGAN results, what did you do?
I drafted a search warrant for SeanGathright's residence.
So you offered a search warrant for the residence, is that correct?
Yes.
And that was related to your investigation that occurred in Jacksonville?
Yes.
And did you take that search warrant to a judge in that within your jurisdiction in Duval County?
Yes.
And did that judge approve that search warrant?
Yes.
And was there a search warrant that was as a result of that approval by the judge then conducted on Sean Gathright's house?
Yes.
When did that occur?
On the 27th of June.
And without going into the facts of your case, when talking about the search warrant, what was the scope of the search warrant? What were you looking for based on the probable cause to search that residence?
It was firearms, accessories, cellular devices, and any other evidence that we found relevant to my investigation.
And is that what was done when the search was executed, items located pursuant to that search warrant that you found within the scope of that search warrant?
Yes.
And all of those items were taken and collected as evidence in your case based on probable cause for your investigation, is that correct?
Correct.
Your Honor, may I have one moment?
Yes.
And we pass the witness.
Okay, Cross.
Good afternoon.
So the case that you're investigating, unrelated homicide, I believe it was called, or separate homicide, Mr. Gathright's name did not surface in that investigation in any way until you hear about the knife and hits that ultimately are derived from the evidence found during the search of the forerunner.
That's correct.
And you rely on that evidence ultimately to obtain the search warrant from Mr. Gathright's house.
Yes.
Correct? When you conduct a search of the house, I mean, obviously you're looking for evidence, I assume, that might be relevant to your homicide. But ultimately, you also find evidence that you learned has since become relevant in the case we're hearing today, correct?
Correct.
That includes, I think, 2 rifles that were found within the house.
Yes, sir.
There were quite a few rifles found within the house, right?
There were several guns.
And they were in, I believe, a locked safe, correct?
That's my recollection.
And that safe was in the master bedroom of the house.
Yes.
There are also, I think, 9mm casings found in the house that ultimately become evidence in the case we're talking about here.
Yes.
I think that's all I have. Thank you.
Sir.
Okay, redirect.
Just briefly, that was the property, the type of items of evidence that was specifically listed within your search warrant, is that correct?
Yes, firearms and firearms accessories, ammunition.
Nothing taken except what was authorized by the court, is that correct?
Yes.
Nothing further, Judge.
Okay, very good. May this witness be excused, or do you have to stick around?
Please excuse.
Okay, you're done.
Thank you, Your Honor.
Okay. All right. Any additional witnesses on this motion?
No, Your Honor.
Okay. And defense, do you have any witnesses you wish to call?
No.
Okay, very good. Okay, so next up, I believe, we've got Mr. Gathright's motion to suppress evidence illegally obtained from the defendant's iCloud accounts.
I spoke with Mr. Wise before, Your Honor, just to confirm, it is not based on the content of the motion that was filed by defense, an argument other than anything legal. So there's no objection. If I'm mistaken, please let me know, Mr. Wise, but there's no objection to the actual substantive probable cause. They're just arguing correct. So it'll just be legal argument. We do not need to make that a priority today.
Is that correct, Mr. Wise?
Well, I'm sorry, I may have misunderstood. It is legal, well, but I think Detective Ramos would testify. I recognize there's a search warrant in this one, so I might arguably need to call Detective Ramos, but I would like to take some testimony from Detective Ramos. I'm sorry. I'm not suggesting it was not probable cause, but I think his testimony will be relevant to the oath.
Okay. Does somebody want to call a witness for Sean Gathright's motion? I don't care who or what, just a witness. So Ms. Ismer, you're gonna, all right, she's gonna call Detective Ramos.
I would also ask just now, Your Honor, that the court take judicial notice of the preliminary responses that were given for the predicates for the detective.
As far as his training experience? Yes, that's fine. Okay, Detective Ramos, back again. You remain under oath, and this time you're testifying regarding Sean Gathright's motion to suppress illegally obtained evidence from the defendant's iCloud accounts.
Yes, Your Honor.
Okay, very good. You remain, go ahead.
Detective Ramos, did you have an opportunity to coordinate with the Jacksonville Sheriff's Office regarding the evidence seized from the Forerunner that was searched on June 26th of 2024?
Yes.
Did the evidence include cellular devices?
Yes.
Were those items, to your knowledge and based on your communications with Jacksonville, seized from the possession of or at the time of the contact with Mr. Sean Gaffray?
Yes.
And as a result of your information regarding some evidence and cell phones being collected, was a search warrant also conducted on Mr. Gaffray's residence the following day, June 27th of 2024?
Yes.
Ultimately, did you also, in this case, prepare a search warrant for a return on an iCloud as it related to both of the devices that were seized from that vehicle stop on June 26th of 2024?
Yes.
And did you, in submitting that search warrant, obtain a signed copy of that warrant that was approved by a judge?
Yes.
What did you do with that warrant once that was approved?
I served it to Apple.
And based on what you served to Apple, how many returns did you expect? How many accounts were there?
It was, I think there was multiple accounts. Yes.
Did one or was one account accurately reflected as redman5x@icloud.com?
Correct.
And was a secondary account rockoutsean at icloud.com?
Correct.
Having served those warrants upon Apple, did you actually include in the probable cause section or in the search warrant itself a period of time for reference for Apple to return the information?
Yes.
And why did you elect to include from June 1st of 2024 to July 12th of 2024?
So I was asking Apple for any backups that were done during that period, specifically because that period covered the entirety of the planning phase of the murder and then up to the point where I was drafting it where the suspect was still outstanding.
At the time that you drafted the warrant and included in your probable cause for the warrant, did you have confirmation that the Chevy Impala connected to Mr. Gaffright had been identified as having been used in the homicide?
Yes.
Did you include in the warrant or the application the identification or preliminary identification of a Rashad Murphy and Isaiah Chance as potential suspects?
Yes.
Did you have the information that Mr. Gaffright's vehicle had been linked in some way to Mr. Chance at that point?
Yes.
And how was that vehicle linked?
I'm sorry, which vehicle?
The black Impala, I apologize.
Yeah, so the information that we had linking Isaiah Chance and Isaiah Chance and Sean Gaffright is that Isaiah Chance's personally owned vehicle was caught photographed at Sean Gaffright's house. So we knew that they had been at the same house at the same time.
Did you also include the license plate reader information that you had about both vehicles that were leaving from Tampa driving in tandem in the application?
Yes.
Did you include in the application as well the identified suspect vehicle having been in Tampa at the time of the homicide?
Yes.
Did you include information about your conversations or confirmations of Sean Gaffright's location and subsequent acts after the homicide with his grandmother
Yes.
and with the video evidence subsequently obtained?
Yes.
Did you have an opportunity also to confirm the use of the defendant's phone in the video footage that you recovered from the Ring doorbell camera from the Airbnb residence?
Yes.
And did you have an opportunity to confirm with the Jacksonville detectives over the course of the investigation that there had been an ongoing or long-standing back and forth between some rival gangs in Jacksonville?
Yes.
At the time that you made the application, and did you include in your application portions of those conversations leading to relevant information about a planning or a motive to having committed a homicide in the Tampa area?
Yes.
And did you have that information during the course of your investigation in order to determine how far back you would seek the information to be produced by Apple?
Yes.
Included in your standard search warrant, what is the language that you previously referred to in your testimony as a backup mean?
An Apple device will back up all of its data, or at least with whatever the customer elects.
So wait a minute. I see some confusion in the chat room, and I know that this is a whole lot to take in. Okay, Isaiah Chance and Sean Gaffright are two different people. Okay, that's the first thing. So let me show y'all so y'all can kind of picture who they are as we are going along in our trial. This is Sean Gaffright. He's going to be the lightest of the crew. I guess that's the easiest way for me to explain that. Chance is going to be, so they're two different people. So we got four individuals that's still on. Devon Murphy, Rashad Murphy, Sean Gaffright, and Isaiah Chance. Isaiah Chance is who Alicia Andrews is involved with, okay? Good question. So this is Isaiah Chance. And as they show him again, I will point him out just so we can kind of like be correct. But it's four people, Isaiah Chance, Sean Gaffright, two different people. But Isaiah Chance Alicia Andrews. They both went to Sean Gaffright's house. And that's where they were loading up all the weapons. And that's the vehicle that they drove in the Impala up to the area where Foolio was unalive. And guys, I'm not sure if, I don't know if she had the Glock or not. I don't know about that. I don't know. I haven't seen anything saying she had evidence, but who knows? Who knows what that girl. That's what I can tell you. Like, who knows at all?
To be backed up into the cloud. So the way Apple stores it is as a complete backup, which would be similar to like a phone extraction, a copy of all the data on that phone.
Did you include in your request information regarding requests to Apple for photos, messages, videos, etc.?
Yeah, the common stuff you would find in a iCloud backup, yes.
Is that standard procedure for your law enforcement agency?
Yes.
Are you trained as a law enforcement officer to include that information because you don't know where relevant information will be located?
Correct.
Did you receive a return on both of the accounts previously mentioned, Redman5X and RockOutSean at iCloud.com from Apple?
Yes.
Did you have an opportunity to review the content of those extractions?
Yes.
In your review of the content of those extractions, were there images or contents between the dates of 6/1/2024 and 7/12/2024 which related to or referred to your investigation?
Yes.
Were there contents from that same time frame which also connected or in some way or included backups outside of that time frame?
Yes.
Is that to be expected when you request the actual backup from the device?
Yeah, so the time period that I'm requesting, I'm asking for a backup that was done during that time period. They have no way of separating stuff that would have been outside of that time period. That's the backup done at that time period, which could include items from before that time period.
So for example, when you receive an extraction, if we go off of Cellbrite, does each image, for an example, have a created date, modified date, access date?
Correct.
If you subsequently access a photo you took a week ago and text it to a friend, are there multiple dates attached to that photograph?
Yes.
Is that why you are requesting not only time frame for the backup itself, but also from the content before that?
Yes.
Specifically as it relates to the dates that you requested in this case, you're indicating that you only intended to include those times for the backup.
For backups done during that period.
Is there any way for you to determine without actually contacting Apple or having the information that was provided to you from Apple to the device when a device had actually been previously backed up?
No.
Is there any way for you to know that without having personal knowledge of it?
No.
And is that also a part of the basis for why you request such a time frame?
Correct.
May I have one moment, Your Honor?
Yes.
I will pass the witness.
Okay, Mr. Wise.
All right. Ramos, when you authored the search warrant affidavit for this iCloud, you set a date range for information that you would be searching. Is that correct?
No.
You do not?
It's not a date range for information that I'm searching. It's a date range for backups within that date range. So that's what I was asking for.
So you listed that you were seeking specific technical data information pertaining to the use of the Apple accounts with the below list information. And you list the Rockout, Sean, Apple ID, and the Redman Apple ID.
Correct.
And then you list for the dates of 6/1/24 through 7/12/24, correct?
Correct.
Where in that is it a limitation to only information that's backed up?
Apple has no way of parsing out or giving you certain context for a date range. For when it comes to iCloud accounts, when you back your phone up, that entire backup is in the cloud. So the date range, is specifying the iCloud backup date. So if the account was backed up within this date range, then the expectation would be that backup would have some content that might be relevant to the investigation.
Well, when you ultimately get the Apple iCloud, I mean, you're able to sort all the information by date. Even you can sort files by date created, date modified, or date accessed. Would you not agree?
Yes, the viewer that we use, so they give it to you as raw data, and then it gets parsed out in either a viewer called Cellbrite or Axiom. And there's a ton of ways you can search. You can search by keywords, by date ranges, by specific files, JPEG, videos, messages. So there's a bunch of different ways to sift through the information.
Is your testimony that Apple cannot limit the data that it provides to certain dates?
I'm not aware of what Apple is capable of doing. What I'm testifying to is what the typical procedure is when you request an iCloud backup, that they're not going to separate. They're just going to give you the whole backup, whatever's been backed up to the cloud on that date.
I guess what I'm asking, and what I guess I'm not understanding is, what is the point of even putting this date range in the search warrant? 6/1/24 through 7/12.
So that specific search warrant template is an electronic communications, or some of the warrants, depending on what you're looking for, have a pre-fill for date range. That one comes with a pre-fill for date range, and so I mean, in theory, I could just say I'm going to do any iCloud backup that you have for this, but that one required a date range, so I chose that date range.
So you had no intention then of only looking through the iCloud material for the dates of 6/1/24 through 7/12.
I'm going to look through whatever they send me in good faith. If they do limit it to that, then that's what it's limited to. But again, I'm asking for an iCloud backup within that date range.
Okay, so if they send you, and for instance, in this case, they did send you data, they went back at least as far as May 12th of 2021. Does that sound right?
I believe so, yes.
Yeah. I mean, clearly they sent you years worth of data from the Rockout Sean iCloud account, right?
It would be whatever was in the backup, yes.
Okay. Well, do you want to look at it to refresh your recollection as to how far it could have gone back?
No, I'm aware that it went back years.
At least 2021. Right? So you didn't limit. So you looked through all that.
If they send it to me, yes, I would look at it.
Okay. And when you prepared the search warrant affidavit, you also listed categories of specific technical data information requested, right?
Yes.
And that was also, and I assume you drafted the warrant as well.
Yes.
And you parceled out various categories. Would you agree that you're basically asking for everything that's in there?
Correct.
Including, you had listed you're requesting device registration info, including name, address, email address, and telephone numbers associated with the account, right?
Yes.
And that you wanted the contents of all emails associated with the listed account, including stored, preserved copies of emails. Basically, you wanted all emails linked to this account, right?
I wanted all the data they had linked to that account.
Yeah, I mean, well, I'm going to still go through it all, but basically these categories are written in a way to encompass everything that's going to be in the iCloud.
Yeah, because again, the way that you back up your iCloud, okay, you can elect to only back up photos or only back up videos or only back up text messages, or you get, so I don't know what the individual customer has elected to back up. So as a cover, we just asked for all the topics that I know that are optionable to back up.
So then going back to the categories, you requested and was ultimately listed in the search warrant, the contents of all instant messages associated with the above listed account.
Correct.
And FaceTime call invitation logs.
Yes.
Were also requested.
Yes.
All iCloud data associated with any backups of iPhones associated with this account.
Correct. Yes.
Contact data for all contacts, including names, addresses, dates of birth, and email addresses and phone numbers. Correct.
Yes.
And you requested and were given access in the search warrant to log in IP addresses with port IDs.
Yes.
And you were requested access and given permission in the search warrant to search all records and information regarding locations where the account was accessed, including all data stored in connection with location services.
Yes.
And then goes on to state contents of all files, including photographs, videos stored in iCloud or other server or Apple facilitated format, including all iOS device backups.
Yes.
You jump into one other category. You request and you're granted permission to search records of games, videos, or other remotely accessible data and the associated IP address from which the remote access was made, correct?
Yes.
And again, you request and are granted permission in the search warrant to search all files, keys, or other information necessary to decrypt any data produced in an encrypted form when available to Apple.
Correct.
For the record, I'd like to show you a copy of the search warrant attached to the motion. I'll show you what's marked as a one. Take a look at that.
Yes, sir.
You recognize that?
Yes, this is the search warrant for Sean Gaithwaite's iCloud account.
And that's the one that we've just been discussing that you drafted.
Correct.
So, okay. I'd move at this time into evidence defense exhibit 1.
Okay, defense exhibit 1 as to Sean Gaithwaite, he'll be admitted.
Now, as to the information you included in the search warrant affidavit, I mean, you include several pages of information in the affidavit, right?
For the probable cause?
Yes, sir.
Yes.
And it spans dates, I believe, of June 22nd, 2024 to about June 28th, 2024. Is that right?
But majority of the activity occurred in those dates, yes.
And I mean, and your you do more investigation after, but basically what I'm getting at is the alleged acts that you're saying constitute probable cause, those basically transpired during those dates of 6/22 and 6/28. Does that sound right?
The majority of it, I mean, we had information that there was a planning phase that, you know, or at least the victim started advertising a couple weeks in advance.
Well, that was, you got to my next question.
Yeah.
There's ultimately a flyer posted by Charles Jones, Julio Foolio.
Correct.
That he's going to be having a show in Tampa.
Correct.
Right? And you believe that's where this conspiracy basically begins, right? Because the plot is to go to Tampa and commit these crimes in Tampa while he's there for the show.
Correct.
And that flyer is first posted on June 14th, correct?
Correct.
So before June 14th, these people involved in the case, as far as you know, would have no idea that Charles Jones, Julio Foolio, was going to be in Tampa until June 14th. I
wouldn't testify to that. I don't know if they have insider information.
Sure.
Yeah.
But looking from the outside in, the only evidence you see, or the earliest you see any indication that Charles Jones is announcing the show comes June 14th.
Correct.
You recall your deposition, we were discussing this, and you testified that you in the iCloud search came upon some photos that you believed were depicting Sean Gathright making what you thought might be gang signs. You recall that?
I'm aware of them, yes.
And at the time, you didn't recall which photographs we were talking about, what dates they would have been, or what gang signs you're seeing.
Off the top of my head, I mean, I can't quote specific dates that they were taken.
Well, I mean, since that, because I asked about it for several questions, right? I mean, have you gone back and looked to see which photos you were talking about?
I have reviewed the photos. I mean, I don't have off the top of my head, I don't have a memory of how many photos we've set aside or what dates they were taken. I'd have to review, the files.
And you agree with me that whatever photos it would have been you're talking about, they would have been created and last accessed sometime prior to June 1st, 2020.
If you're referring to the photo specifically where he's throwing up what we believe to be gang signs, yes, those photos were, the dates on them were prior to June 1st.
I mean, long prior to June 1st.
Yeah.
Like not even in 2020.
I can't recall the exact dates, but yes, it was way before June 1st.
That's one question. Thank you.
Okay, redirect.
You also had information in your investigation that in the month of June, obviously long before that, but certainly in the weeks leading up to Mr. Jones's death, Mr. Jones was on social media or prominently in disagreements or disputes with rival gang members. Is that correct?
Correct.
In the weeks leading up to the offense.
Correct.
And when we talk about the dates encompassed in the backup that you actually received, do you recall specifically a photo that was retrieved from the extraction from Rashad Murphy's device of firearms on the ground?
Yes.
And the information or data attributable to that photograph, that would have been within the time frame of June 1st and July 12th that you retrieved, correct?
Correct.
Now, in the extraction or the data that actually comes from Mr. Gathwright's device, that photograph originated or was present on Mr. Gathwright's device in advance of that, before that.
Correct.
And that is a way in which the data or the information for when that photograph would first appear on Mr. Murphy's device in one time frame, but backed up on another device before that would make it relevant to have that information as a backup, correct?
Yes.
The timeframes that we're talking about are specifically for information that would have been at least preserved for that user's account at that time, correct?
Correct.
Are you ultimately trained with your agency to only look at times by sorting by date created or date modified?
Under certain circumstances, but no, I mean, are you asking if I get a whole download or?
Well, when you are taught to utilize or trained in utilizing Cellbrite Axiom, do you oftentimes find files that don't have a date created, date modified?
Correct.
Specifically, look to, or let's reference the information that you obtained from the new device that Ms. Andrews had when you investigated her cell phone device. Did all of that backup information include the date by which Apple provided it to you, or were there certain specific dates actually annotated for each item?
They had different dates. It could be a date that the phone is being set up, and those files are going onto that phone, and then there could also be a date of the actual capture date. So they're different dates.
And have you received downloads before where the dates and time for each of the items that you're actually looking at are the same? Meaning it would be impossible that all these pictures were taken at the same time, that the same date and time is reflected.
Yeah, there are times where, especially when you set up a new device, where a file could be 4 years old, and the only date you're going to see in Cellbrite is the date that it was put onto that device, which is not the same date that it was captured, and we would have no way of knowing when that image was captured.
Is that why you cannot strictly rely upon date created, date modified timeframes?
Correct.
Are you, as a part of your just standard operating procedures as a detective within the agency, trained to utilize or to view items of evidence on these extractions, even when they do not have a date or time attached to them?
Correct.
Is it unusual to not have a date or time attached to an item of evidence on a cell phone extraction?
It's not unusual at all.
In fact, if an item has been deleted or removed from a device itself, but you're able to at least recover the quote deleted file, are there oftentimes you have no trace of date, time, created, modified, any of that information?
That is correct.
is that information, if that item was backed up in some way by Apple or had not been written over, still available to you to at least open or view,
Yes,
even though the software provides you that it has been deleted from the device?
correct.
Can you specifically say with any certainty, unless essentially you're a member of a conspiracy itself, where items of potential evidence will be located on these cellular devices?
No.
And is the language that was included of backup of the iPhone or iOS device backups in the search warrant that you provided all standard within your agency as required by Apple for this particular cloud return?
Yes.
I have no further questions here.
Okay, very good. Thank you, Detective. Any additional witnesses from the state on this motion?
No, Your Honor.
Defense, any additional witnesses? Okay. Are there additional motions that we need to take testimony on?
Judge, not additional motions. We just wanted to make sure that we called the detectives that we listed as gang experts just to, I know that motion's gonna be a little later, but because they're here, we wanted to go ahead and call them. There are 4 of them just to go through their expertise credentials.
Okay, very good. All right, who's going to be first up?
Detective Richard Meager.
Okay, very good.
Meager, Richard Meager.
Just for the record, Your Honor, because I know that this kind of incorporates a couple of motions. This is specifically as to what was filed on February 7th as the defendant's second motion in limine for Rashad Murphy, the Dauber challenge. What about that?
I do, go ahead and have a seat, Detective. What date were we supposed to hear that?
We are making a record of which ones we're having under to provide for.
Sure. When was this one supposed to be heard?
This one was filed February 7th of 2026. We have it on our list for. We have it on our list for the 27th, the AM session.
Okay, and tell me again, the
Number 9 it should be.
Rashad Murphy defendant's first motion in limine testimony regarding Ghost 187.
My number 9 is second motion in limine and Dauber challenge.
Okay. I have it as number 10 on my list. It's okay. Let me find it real quick on my card, and then we'll get going here. Okay, I have it. All right, and Detective, you remain under oath, and I think now the state's going to be going into your training experience. So you may proceed.
Sir, would you please reiterate for us the amount of time that you've been with the Jacksonville Sheriff's Office?
I'll be 10 years in September.
And what is your current title?
I'm a detective.
What is your current assignment?
I'm on the gang investigations unit.
How long have you been in the gang investigations unit?
I'll be 4 years this fall.
What are your day-to-day activities in the gang investigations unit?
My day-to-day activities deal with monitoring social media, documenting gangs, gang members, also purging gangs and gang members.
When you indicated that you had some service with the sheriff's office in advance of your time in the gang unit, talk to me a little bit about what your day-to-day duties were then.
So I started off in patrol, and I rode the city's east side. In patrol, you answer calls for service. So anybody who calls a non-emergency or 911, you're the first one. You're the first uniformed officer there to handle that. After that, I moved on to a community problem response unit, which is a citywide task force that deals with assisting other detective units, whether it's serving subpoenas, arrest warrants, locating victims. We also do social media investigations there, where we have done like Instagram live takedowns and things of that nature, like Instagram and social media investigations dealing with firearms and drugs.
And does that somewhat encompass a large part of what you still do today?
Yes, ma'am.
In your time with the sheriff's office in Jacksonville, was the gang rivalry, at least between ATK, 1200, 6 Block, prevalent or known to you and the other officers and detectives?
Yes, it was known to me. Yes.
Did you have an opportunity to investigate gang-related or gang-motivated crimes or offenses that occurred even before you were in the gang unit?
I wouldn't say that I investigated them personally. I was a part of the investigation, but I was never the lead investigator on any of those things until I became into the gang unit.
Well, I mean, in a way that, did you respond to these offenses, whether you took over the investigation for the latent investigation thereafter or not? I'm not asking. I'm just asking whether you responded to the offenses.
Yes, I responded to, like the city's east side is a heavy gang territory. I responded to many shootings, homicides, and stuff of that nature in that area. Also, the community problem response unit had the opportunity to apprehend multiple victims and suspects and witnesses of the gang shootings and wars and stuff.
Do you have a significant amount of contact with the members of the community that are either witnesses, victims, members, etc.?
I would say yes.
Now, as it relates to your time specifically in the gang unit itself, how do your day-to-day duties now differ?
My day-to-day duties now is strictly towards gang activity rather than the wide variety of everybody in Jacksonville that's committing crimes.
So on any given work week for you, is your ultimate job or responsibility to follow up, study, or investigate gang crimes?
Yes.
And are you assigned specifically to do those tasks for one specific group?
Yes.
And what is the group that you are assigned to?
I'm assigned to ATK.
What does ATK stand for, if you know, based on the information you've been able to collect in your time with the gang unit in Jacksonville?
What I've been told that it stands for, and it's ACE's Top Killers.
Now, when you talk about investigating these groups, is it only that you respond to crime scenes, or are there other types of investigations that you do behind the scenes, office work almost?
We do all sorts of investigations, not just respond to the scenes.
And what are those all sorts of investigations including?
We've done like shooting investigations, we've done drug investigations, firearms related investigations, fraud investigations.
When you say you monitor social media, what does that include?
I monitor the social media accounts of the members and associates of ATK along with their associated groups, which would be like their ally groups. I monitor those accounts as well, see their posts and their stories and kind of see what's going on in their world.
When you say ally groups, are those also groups that are associated to or associated with ATK?
Yes.
When we talk about allied, is that groups that get along with ATK?
Yes, they would get along.
What, if anything, is their commonality versus 6 Block?
The one thing that all the ATK's allied groups have is a common enemy, and it is like the 6 Block bully gang. We got like the north side of Jacksonville.
And as a part of your role in taking ATK or being the primary detective for that group, are you also investigating and studying and focusing on the associated and allied groups?
I do, but just not as much as my time towards ATK.
Does your role in the gang unit include you responding or providing information about ATK or that you might have about those allied groups to other detectives to further their investigations?
Yes.
And do you work with other detectives in the gang investigations unit?
Yes.
Do you become a part of that unit? Do you have to be a detective before you go there?
Not necessarily.
And do you have any kind of specialized training in gangs or their investigations?
You do once you get there. You attend trainings and conferences and stuff of that nature that teach you how to handle and operate a drug or a gang investigation.
Did you specifically attend those trainings?
I have.
And tell me about the trainings that you have received or attended.
I've received classes through HIDA, which is a federal agency, courses about gangs. I've received training through the Florida Gang Investigations Association. It's a week-long conference where they teach classes about gang investigations, and not just that, but how to dissect cell phone downloads and stuff like that. I've taken a technology conference that has taught how to read towers and do cell phone downloads and what to look for and how to get into the weeds of a cell phone download. I've also taken it's a REOC course on robberies that occur within gangs.
Do the conferences and trainings that you attend help to advance your investigative techniques when you're looking at these cases and investigating them?
It does. It teaches us what other agencies are doing throughout the country and how it may apply to us, to where we can go back and use their techniques to help solve ours, and they may use some of our techniques to help solve their crimes.
Do you share some of the things that you're seeing with your location, area, jurisdictional specific gangs?
Yes.
When you attend these types of conference, are they more generalized for the bigger or more well-known gangs like Bloods versus Crips or things like that when they're giving you examples? They're not focused on Jacksonville gangs, correct?
Generally, they are to what we would call a national gang, which would simply mean that it's everywhere across the nation. Most people would know Bloods and Crips and stuff, but that's generally what these conferences are focused on.
And while you're learning the investigative techniques that are used, are you also sharing the new information or ways that crimes are happening in Jacksonville related to your specific gangs
Yes.
with other detectives?
Yes.
And in your role with the Jacksonville Sheriff's Office, do you not only provide information about ATK or ATK's affiliates to other officers in your agency, but also across the state?
Yes, if they call with questions, all of those questions would come to me.
Specifically as if it's ATK related.
Yes.
Are you also in your role familiar with the other prominent or more prominent gangs or groups in Jacksonville?
Yes, I'm familiar with the other, I would say, stronger groups in Jacksonville, which would be the 6 Block, Bully Gang, we got Northside area, as well as like the 1200 out east area.
While you're investigating offenses that you believe to be related to ATK or in some way linked to ATK, do you work with the detectives for 1200, 6 Block, or whatever the affiliated or related groups are?
Yes.
And do you all share information about those offenses?
Yes, we do.
Do you utilize the information that you have to help other detectives, whether in your jurisdiction or outside of your jurisdiction, to establish motive for cases? So if you have specific information about ATK and their rivals at the time, do you share that?
Yes.
Do you also monitor, in addition to social media accounts, YouTube or music video sharing applications?
I'm sorry, say that again.
Do you monitor music videos? Do you watch music videos in addition to looking at social media accounts?
Yes.
Included in the social media accounts that you're familiar with, do you monitor or are you familiar with YouTube,
Yes.
with Twitter, or now X?
More familiar with YouTube than X.
What about, well, have you viewed posts on X or Spaces as a part of your job duties?
Yes.
What about Instagram
Yes.
and Facebook? Is that something that's utilized?
By some, but it's not real common.
What, if any, is the methodology or the way that you go about looking into these accounts when a crime is reported? How do you know where to go or what to look for?
Generally, if there's a shooting, something like that, and your victim is going to be on one side, you would go to the other side, which would be the opposition's. That's a good place to start and figure out who's dissing him and talking about the crime.
Is it common that when you are able to identify a victim at a scene, pretty quickly thereafter, a rival group is taking credit for that?
Yes.
And do you utilize whoever is at least the most vocal about taking credit for those offenses as a part of your investigation and trying to work back from that to ascertain whether there's evidence at all relevant to your case?
Yes.
So if there is a crime and you respond and the victim is present, you work back from the identity of the victim to determine potential suspects by looking at other gangs.
Yes.
And do you know, for example, if you respond to a location and an ATK member is the victim, what rival gangs to start looking at first?
I would start with the North Side groups.
And is that just based on your experience and having investigated these cases?
Yes, that would be you would go to the opposition, would be the first people talking about it, at least.
Were you familiar, although not a member of ATK, with an individual by the name of Charles Jones at the time of his homicide?
Yes.
And was that just as a part of having a peripheral investigation to your work with ATK, or was that something well known in Jacksonville?
I was well known in Jacksonville of who Charles. I would take that back. I wouldn't say well known because Jacksonville is very large, but if you lived in those neighborhoods, you knew who Charles Jones was.
And how long would you say the ongoing rivalry between ATK and 1200 and 6 Block has been going on?
Well, I can only speak for 2017 and on because that's when I officially became a police officer and was on my own on the street, and that was about the time that I realized how dangerous they were.
Back in 2017 and thereafter, were there some shifts in the names that were utilized for some of these groups?
Yes.
When ATK started to become more popular, was that as a result of one of their primary members, Kenyatta or Young Bullard or Young and Ace, becoming more popular with his music career?
Yes.
And 1200 itself, was that a group that you were familiar with, having been growing in size when 187 kind of dissipated in Jacksonville?
I'm not familiar with 187. I think that was before my time as being the police. It's always been 1200 for as long as I've been on.
When you make contact with members from 1200, is it uncommon for you to see markings which indicate 187 or posts which also indicate 187 in them?
Yes, based on my understanding now and what I've learned through my experience in being law enforcement, 187 is more of the older crowd of 1200, and they have rolled into 1200 now. It's not really one. They don't call themselves 187 anymore.
Did you have a similar experience in your role with investigating, or at least your contacts with 6 Block members, and that being the younger generation of what was formerly known as a PCE?
Yeah, PCE would be also a little bit older crowd. PCE got RICO'd in Jacksonville, and they kind of changed their name after that and became 6 Block.
based on some of the conferences that you go to, based on your experience, or have you noticed a trend in that if a group gets smaller or changes, a new group develops?
Yes, usually happens after like a mass arrest or something. It's kind of, you take down a good bit of them that somebody else starts it with the same group and they just kind of change the name.
Does your involvement or your role as a detective with the gang unit include actually documenting gang members?
Yes.
Is that a standard procedure with Jacksonville Sheriff's Office, at least now?
Yes.
And how do you go about documenting a gang member?
Follows Florida State Statute 874.
What does that process actually look like? Are you writing a report? Are you saving that information?
Yes, we do field investigative reports that it lays out all the information on how they meet the state statute. We submit that report. Once it gets approved, we put it into databases, and now appears on like NCIC and FCIC databases that they're a gang member in Jacksonville, Florida.
Is that for purposes of you utilizing that information to notify other officers or detectives in Jacksonville?
Yeah, and across the nation.
And how often is that report actually updated?
We have to update them every 5 years. So within the time that they're documented to the 5 years, they're still meeting state statutes. You redocument them with the new ways on how they're meeting the state statute still.
So in your role, you have to be familiar with the state statute.
Yes.
And when you say every 5 years, what happens if you have contact with a documented member or an associate within that time frame?
You just document it in a field investigative report, which can be pulled from the system. And then once you get all those compiled and the 5 years is coming around, you write a big master field investigative report that shows all of the contacts and the criteria that they meet in that field investigative report.
And is that just for information for you or other investigating agencies as it relates to potential gang affiliation or association, documenting whenever you've had contact, et cetera?
Yeah, I think it's more it's a Jacksonville Sheriff's Office based database that houses the reports. So I don't think everybody across the nation can access them, but it appears when you run somebody's name that they're a documented gang member in Jacksonville, Florida, and it'll give a case number, and that allows them to reach out to us if they need the documentation.
It is not all-inclusive or all-encompassing of every gang member, is that correct?
What do you mean by that? I'm sorry.
The documentation that you have, it's not all-encompassing of every member of 1200.
I can only speak for ATK. I'm not.
Well, let's talk about ATK.
Each person that is a member of ATK has their own documentation, and then there's a documentation that actually documents the gang.
But what happens if there is a new member that you've not had contact with?
They wouldn't be considered a member until they're documented. So they would just be an associate. And if I haven't had contact with them, they're simply just an associate or somebody that, like a person of interest that we can be looking into to if they reach the documentation status that we would need to document.
And by document, you are talking about the reports that we've discussed, which is actually compile that information into a report and ensure that other agencies are aware of it.
Yes, ma'am.
That being said, if you made a stop tomorrow and made contact with an individual that met several of the factors to be considered under statute, do they qualify as meeting the statutory criteria, whether you completed your report or not?
Yes.
In this particular case, did you provide assistance to the Tampa Police Department by way of interviewing some individuals in this case and providing intel regarding the gang rivalries?
Yes.
Were you, at the time that you received information that Charles Jones had been killed, familiar with several music videos that had been published by Charles Jones and or 6 Block members?
Yes.
Were you also familiar with several music videos that had been posted or published by ATK members?
Yes.
And is that review or familiarity with those music videos a part of the social media review that you previously talked about doing?
Yes.
When you review those videos, what do you actually do when you're watching them?
Everybody does it differently. The way I do it is the first time I usually watch it all the way through with no interruptions. The second time I usually try to break down the lyrics, see what they're saying, whether it's closed captions or just keep rewinding and listening to it. And then the third time I watch it through, I notate everybody that I can identify in the music video if there's multiple people, and firearms, any type of evidence or stuff like that. And then if I can't identify who they are, I will take a screenshot of the video and I'll send it to our crime analysis unit, who will then attempt to identify who's in the videos.
And ultimately, do you document that in some way, particularly if gang signs, weapons, or gang-related activity is documented in those videos?
Yes, because that would go towards the documentation on becoming a member. If you're in a music video with a known gang member and you're throwing hand signs and you have a style of dress and you have tattoos visible or necklaces or stuff like that, that's part of being associated to that gang. So that goes towards their documentation.
And at the end of essentially the next 5-year period, would that report that you've documented those things, for example, be utilized in either reestablishing that person as a documented gang member or changing that status?
Yes, but I wouldn't use that same music video or the same big picture. So it'd have to be new stuff that happened within those 5 years. So they're continuing that lifestyle, they're continuing their association. I'll document that as the 5 years comes along.
And it's a part of your regular practice to watch these music videos every time they come out.
Yes.
Would you consider or define those music videos as popular?
Well,
let me re-ask the question. In your review of those music videos, is it uncommon to see tens of millions of views as to each of them?
Yeah, they get lots of views.
Did you work with Detectives Griffin and Drabick in this particular case in discussing the rivalry amongst these gangs, as well as Detective McCullough?
Yes.
And the potential motive behind the homicide of Charles Jones or any of the offenses essentially around the time frame that were committed for it?
Yes.
Did you have an opportunity to specifically review and document a music video titled Who I Smoke?
Yes.
Did you do the same for When I See You?
Yes.
Are those two songs posted or provided by rival groups?
Yes.
Who was Who I Smoke created by or published by?
Who I Smoke is going to be ATK and 1200. It's got the rappers and artists of Young and Ace, Fast Money Goon, Wappa with the Choppa, and Spin Events.
And When I See You?
When I See You is a song that was posted by Foolio, also known as Charles Jones, who is a part of a member of 6 Block.
Is it uncommon to see these music videos from rival groups posted back to back with each other?
Yes.
It's uncommon or it's common?
Oh, I'm sorry. I thought you said it was common. It is common. That is a response video.
Is there a specific name that's utilized when you all talk about these types of music videos?
It's often called drill rap.
And what does that mean?
Drill rap is a form of music that simply disses the opposition or talks about crimes that have occurred, whether it's deceased or stuff like that.
How are you able to decipher the language that's actually being utilized in these music videos?
So there's multiple different ways. A lot of these, some of these rappers and artists have become well announced, and they're on platforms such as Apple Music and Spotify. Apple Music will provide the lyrics to the songs along with who the song was written by. And then there's also closed captions on YouTube. There's also websites out there that will post the lyrics, like I think it's like lyrics.com or something like that, will take the song and actually post the lyrics that they hear.
When you utilize or see those services being offered, do you then still yourself take an opportunity to review the songs to make sure it's accurate?
Yes, I generally will read it on Apple Music and see if I hear the same things that Apple Music is given.
Separate and apart from the transcripts that are provided for these songs, do you also document any kind of significance for the locations at which the videos are taken?
If we can determine where they were taken at, yes.
So for example, in the When I See You music video, was there any significance to the fact that it was filmed or recorded at what appeared to be a cemetery?
Yes, it was reported at a cemetery, and the song is focused on people who are now deceased. So we notate that, but we are unable to notate which cemetery that is at.
When you investigate these types of cases, the information about maybe significance of where the video is published or the posters or visuals that are used in those videos, is that information that you specifically know is relevant just based on your training and experience with these gangs?
Yes.
Are you familiar with the summary exhibits that were created in this particular case for ATK, 6 Block, and 1200?
Yes.
And did you have an opportunity to work with Detective Nieder in at least giving your input or insight in some of the members or associates depicted in those images?
Yeah, I hate to correct. I worked with Detective Drabick.
I'm sorry.
That's okay.
You all work together, though, with other members of the gang unit?
Yes, ma'am. I think Drabick was the ultimate compiler of the photographs and information, and then Detective McCullough and Griffin both did it for their respective gangs, and I did it for ATK, of saying that's an approved list.
Because that is your assigned group.
Correct.
And can you state whether this summary exhibit is all inclusive of every member of ATK that you have knowledge of?
No, it is not.
Your Honor, can I have 1 moment?
Yes. I will pass the witness, Your Honor.
Okay, Mr. Gonzalez.
Afternoon, Detective.
How are you?
So I think you indicated to us that you have been a member of the gang unit for 4 years, and that's inclusive of today, correct?
I'll be coming up on 4 years in a couple months.
And prior to you being in the gang unit, you went through the ranks. You were in a patrol situation. You were in other departments, and then you ended up here sometime close to 4 years ago, correct?
Yes, sir.
And you said you responded to crimes that may or may not have been gang-related crimes based on what people told you or witnesses told you as you responded, correct?
Yes, sir.
And you never actually investigated until you became a member of the gang unit, a gang crime.
Yes, sir.
I think Ms. Isber was asking you early on about the origin or the name ATK.
Yes, sir.
And as I wrote down your response, you indicated that I'd been told. And that's correct, right?
Yes, sir.
And so would it be fair to say that the majority of information you get in this realm are from people on the street?
Yes, sir.
And these are either people that you know or have you come across in other investigations, people that other people tell you about. And when you confront them, whether it be during the course of a crime or whether it be in the course of a field interview or whether it be in the course of someone else giving you their name, your source of information is primarily gathered by and through people on the street, correct?
I would say it's probably half of it. The other half would be like social media and cell phone downloads.
Okay, so social media are people talking on their platforms, depending on what that platform is, about doing this, doing that, so-and-so did this, so-and-so is who, so-and-so is somebody, correct?
Yes, sir.
Okay, and you have no way of confirming what those people are saying other than what comes out of their mouth, correct?
No, I would say that's correct.
And that would essentially compile the bulk of the percentage of what you would call gang intelligence, correct?
Yes, sir.
And that type of intelligence you do not document. You do not write reports on.
Not all of it, no, sir.
Well, any of it. Do you ever write a report that says so-and-so told me so-and-so is a gang member?
It depends on the situation.
If I were to ask you how you know Charles Jones was either the face or a very prominent member of 6 Block, what would you say?
I would say you're correct.
No, you would say people told you that?
No, sir.
You
I
would say
I would say Charles Jones himself portrays that.
Portrays it in music videos?
Music and on his own personal, on his Instagram.
And that is because he reps 6 Block?
I think he calls himself Mr. Six.
Right? That's where he grew up, right? That's his neighborhood.
To an extent.
That's where his friends are. That's where he congregates. That's where he does a lot of his music. All those correct?
I can't tell you exactly where he makes his videos, but he has made videos there.
Okay. And many of the people he grew up with live there. He lived there, correct?
At the time of his death, he did not live there.
Has Charles Jones ever stated or ever said in a music video that he killed somebody?
I don't think he's ever talked about himself killing anybody.
Has anyone in any rap video you've ever seen said I killed somebody?
No, I don't think they say those exact words.
Well, they disrespect people that have been killed, correct?
Yes.
Okay. They might even laud or are in the video happy somebody's dead, correct?
Yes.
Okay. But you wouldn't have any means to determine, nor has anyone said in a video that you've seen, I or we killed somebody.
Not using those exact words, no.
Okay. Well, when you say not using those exact words, you're talking about describing how somebody died, right?
Well, I'm saying that I've never listened, me myself, have never listened to a music video where somebody has said, I killed John Doe.
Be really stupid, right? I would assume, and there are stupid people out there, but
Yes.
Nonetheless, the videos that you look at will tell you who is disrespecting who.
Yes, sir, in a very cryptic way.
And that would be cryptic way based on maybe the kind of person that person was that was deceased, correct?
Yes, sir.
Or how that person died, correct?
Yes, sir.
And people on the street, everybody knows how a particular person died. No secret, is it?
You just wait for the news.
Wait for the news. Doesn't take long. And in fact, once the news hits, or even before the news hits, people in the street know what happened and how it happened. And they also talk about who they think did it
Yes.
and for what reason.
So,
And also for what reason they did it.
like the motive behind it?
Yes.
Yes, sir.
And you utilize that information to determine whether or not a person or a group committed a crime unless that person was actually arrested and charged with that crime, correct?
We utilize.
You utilize that information in order to make determinations as to who you think committed a crime, even if there's not enough evidence to support an arrest.
We utilize, I think the second half was right. We utilize that information to guide us in the right direction. And then the evidence that we obtain and the facts of the case is what ultimately leads to probable cause for the arrest.
Well, in probably 75% of the incidents that we've talked about that would comprise the historical nature of this gang war, nobody's ever been arrested for hardly any of it. Isn't that fair?
No.
70%?
I don't know the exact percentages, but there's definitely been a significant amount of arrests in this war.
And listen, I don't want you for 1 minute to think that I'm disrespecting your work or suggesting to you that you guys don't get things done. I don't mean that. What I'm suggesting to you is that for you to think something occurred, for you to have somebody on the street say something happened, for somebody to diss somebody or to talk negatively about their death.
I'm just asking if there's a question that be asked.
I think he's getting there. What's the next question?
The question would be, that doesn't mean somebody did it, and that doesn't mean you can arrest them for it.
Based on like the social medias and stuff.
Based on them saying they were happy about it? Correct?
Yes,
Doesn't
sir.
mean somebody can be arrested.
Yeah, that's right.
Based on them disrespecting that person in general and being happy they're dead, not sufficient for an arrest, correct?
Yes, sir. Correct.
Based on them talking about the graphic nature about how that person died, not sufficient for somebody to be arrested, correct?
Yes, sir.
So you can only presume by this bravado or this disrespect that that person or that group of people might have had something to do with that death, correct?
Yes, sir. Like I said, that kind of leads us into the direction. We take that information and couple it with the evidence, and that leads to probable cause for the arrest. It's not just strictly the social media and the disrespect and stuff. There's evidence and other things that go along with it that lead to the arrest.
As it relates, strike that. You utilize the criteria of the gang statute in order to document someone as a gang member, correct?
Yes, sir.
And in the daily course of your work, you look through social media to see if you can find something that is deemed relevant, correct?
Yes, sir.
You look at open cases to determine whether or not there's sufficient evidence to determine that a particular person or persons committed the crime, correct?
Yes, sir.
You determine and you look to see whether those people might be related with one alleged gang or even more than one alleged gang, correct?
Yes, sir.
Because these are what we call hybrid gangs.
The ones we're speaking about today, yes, sir, they're hybrid.
And that means there's no hierarchy in these gangs, correct?
No, sir, there's not.
There's no rules. There's nobody telling someone else what to do, correct?
Correct.
And in fact, they can do their own thing. They can get mad at somebody, whether it be a regular person or a person that exists in another gang, and they can go kill them, correct?
Yes, sir.
Doesn't have to be related to the gang for them to do that, right?
Right.
They can have their own motivation to kill someone outside of any association that they may have with other people that are alleged to be in a gang, correct?
Yes, sir.
Okay? And nobody has to make a collective decision in any one of these groups to kill someone else. You would agree?
Yes, sir, I would agree with you.
And nobody tells somebody else what to do, when to do it, or what they can or can't do, correct?
Yes, sir, I would agree with you.
And they can come and they can go as they please.
Yes.
And they can associate with a different gang if they want to.
Yeah.
And the information that you would get about these things would come either, as you testified to, from social media monitoring or talking to people in the streets.
Yes, sir, generally.
Okay.
And
I'm sorry, Mr. Gonzalez, I hate to interrupt you, but I think one of the defendants needs to use the restroom. So we're just going to take a quick 10-minute recess, okay?
Thank you.
Sure. So Detective, you are welcome to remain seated or you can step down, but since you're under cross-examination, you can't talk to anybody, including the state, about anything related to your testimony. Okay?
Now that's the first. We see him actually like running to the restroom. That is too funny. I cannot deal. I've never seen that before. Have you ever seen that before? He's like running to the restroom. They had to take a restroom break because he had to go to the bathroom.
etc. Correct?
Yes, sir.
I guess
Correct?
I
Yes,
go,
sir.
gotta go. That is funny.
Etc. Correct?
Yes, sir.
And the videos that you talked about, Who I Smoke, When I See You, the third being, I can't remember right this very moment. That would be List of Dead Ops. So most of these videos are old, correct? They're back from early 2021, 2020, thereabouts, give or take, right?
Yeah, give or take maybe a year or two around that time.
And there are sometimes large numbers of individuals in these videos, correct?
Yes, sir.
Sometimes there's 4 or 5, sometimes there's 10, sometimes there's 15, 20.
Yes, sir.
Okay. And some of these people you may recognize as people you either have documented or you believe might belong to, be associated with, or documented gang members, correct?
Yes, sir.
And there are also several other people in there that A, you may not know. Is that fair to say?
Yes, sir.
And also that you would have no idea if they are in fact gang members.
I would say that just because they're in the video, they're not members, but it definitely meets the criteria of associates.
So if you appear with a gang member in a rap video, that gets you one step closer, criteria-wise, to being documented as a gang member.
Yes, sir.
Fair to say, pursuant to the statute.
Yes, sir.
And when you look at these rap videos, they're not coded. They're not word coded so that when people talk about them, you don't know what they're saying. Are they?
I don't think I understand that.
It's not coded language. I mean, they're talking. You may understand it. You may not understand it, depending on who you are and how often you listen to their work. But they're not coded with special words, are they?
Not the ones that I've heard, but I would agree with you on that if you live it and you are a fan of it, you understand it more than somebody who doesn't.
And when you do it, and the more you listen to it, you are interpreting those lyrics yourself, correct?
Yes, sir.
You would agree with me that whatever you say under oath is going to be your interpretation of that song or that word or that line.
Yes, sir.
Talking about training and experience, and I'm almost finished. You talked about HIDA, that's North Florida HIDA, correct?
Yes, sir.
That's a general conference. It has a gang component, but when you go to HIDA, you're learning about a lot of different things, whether it be racketeering, whether it be cell towers, whether it be global, entry of drugs. It's a generalized course that detectives take that has a gang component within it.
The HIDA classes that I've taken were strictly gang 8-hour gang classes. Now they do HIDA is a drug-based agency, and so they do put on cartel and drug classes and interdiction classes and stuff like that.
So part of it is this is HIDA's gang involvement or gang preparatory course for you.
Yes, sir.
And you've done that at a beginner's level, correct?
I've taken one or two of the 8-hour HIDA classes.
Okay. And I think you also took a class by the Florida Gang Investigators Association, correct?
Yes, sir.
And I think you also took a class from, and I may be mispronouncing it, ROKIC.
RIOC, something along those lines. It's a combination of word or letters.
Right. And that also gives you a general understanding of a lot of different subjects, including gangs.
Yes, sir. That one is a robbery gang conference.
Detective, you have never been qualified as a gang expert, have you?
I wouldn't know how to answer. I've testified in gang trials before.
Okay, you've testified in gang trials. You testified in a lot of trials as it relates to what you did in the investigation, as it relates to how you were involved in an arrest, whether you were involved in a search warrant. What I'm asking you is, has a judge ever qualified you in a trial to testify as an expert in gangs? The answer is no, correct?
I'm not sure that's done at the judge level or what. I would say that an expert is somebody who has more knowledge about something that the general public wouldn't. And I would say I have more knowledge about gangs and ATK than general public.
I would tentatively agree with you with regard to what you believe, your knowledge and experience is. But I would also suggest to you that you never recall having anyone in a trial say, Detective Nieder is an expert in gangs, and we're going to take his testimony as an expert. You don't recall that happening with a judge being able to say, yes, we're going to treat Detective Nieder as a gang expert.
I think that happened in the last trial. The state deemed me an expert, and I don't remember any objections to it.
Okay, so you believe you were qualified as a gang expert in the trial that was related to this case?
I'm not sure about the qualifications and how that's done at the court level. I do recall that the state said that I was an expert witness for them, and there was no objections to it.
Okay.
Based on my memory.
Understand your answer. Thank you. I don't have anything further.
Yes, sir.
Okay, redirect.
Your Honor, I believe several other attorneys have adopted this, the court should have them.
Yes, I'm sorry. Any additional cross from counsel for Davion Murphy?
Yes, if I may quickly, Your Honor.
Okay.
Good afternoon, Detective. My name is Nick Shinardi. I represent Davion Murphy. Do you recognize Mr. Murphy in the courtroom?
Yes, sir.
Prior to today, have you had any prior contact with Davion Murphy?
Just the date of his arrest.
That was it?
Yes, sir.
All right. Now, you've indicated that you have been a member of the gang unit of the Jacksonville Sheriff's Office since approximately 2021. Is that
22?
22.
Yes, sir. Be coming up on 4 years and maybe 4 or 5 months.
All right. In your employment with the Jacksonville Sheriff's Office in their gang unit prior to the arrest that you've referenced of Mr. Davion Murphy. I'm going to keep repeating Davion because there were two Murphys.
Yes, sir.
Had you had any direct contact with Davion Murphy?
No, sir, I have not.
All right. So that was the first contact, correct?
First one ever.
And did I understand you correctly when you indicated that your primary focus as a gang detective was the which gang was that?
ATK.
ATK.
Yes, sir.
All right. And I'm assuming, and you correct me if I'm wrong, at some points in time, there's an overlap between ATK and possibly 1200 or 6 blocks, et cetera.
ATK and 1200 would be like allied together. They post on social media together. They've hung out together. They make music together, but they are two separate gangs in themselves. And 6 Block is a separate gang in itself.
All right. Can you testify specifically what criteria under Florida Statute 874 that qualifies 1200 as a gang?
I do not have 1200. That would be a question for another detective.
So you don't know then individually how it is that 1200 qualifies as a gang as opposed to an association of individuals that live in the same neighborhood, correct?
Yes, sir, that would be correct. Name would come up due to his family ties.
All right. Are you aware or have you checked the prior history of Mr. Davion Murphy?
Like since his arrest or like prior to his arrest? No, sir.
Do you realize that he was incarcerated until 2023?
That I learned that earlier. I knew he was incarcerated, but I don't know the extent of time he spent in prison.
All right. Thank you, Detective.
Yes, sir.
Okay. Does counsel for Mr. Gathright have any? Are you done?
Yes, I am.
Okay. Very good. Do you have any questions? Okay.
How are you?
Doing well.
Good, thank you.
Detective Sean Gathright, I think we may have covered this actually this morning, but you didn't know his name until it surfaced in connection with the case we're discussing today, right?
That's correct.
You've never documented him as a gang member, correct?
I have not.
Or a gang associate?
Based on this, he's not documented as associate, no, but based on this case and his connection to Isaiah Chance, he would meet one of the criteria that's outlined in 874.
And that's all information that you learned
after
from Tampa PD, basically.
Yes, sir. After the homicide.
Thank you, sir.
Yes, sir.
Okay. And finally, counsel for Isaiah Chance, do you have questions? Okay.
Afternoon, Detective.
Hey, how are you?
You testified that you get a lot of information from social media.
Yes, sir.
Another way, do you do interviews with gang members?
Yes, sir.
Would you say that they are unwilling to provide you specific information, though?
It depends on the circumstances of the interview. If generally, there's some of them that are really cool, that have outgrown that lifestyle that will talk to you just man to man or outside of the walls. There's some that are still in the lifestyle and they'll give you little bits and pieces here and there. And then there's some that face significant charges and they are willing to help themselves that give them information.
Okay. If they're not helping themselves a lot of times, or they're no longer in the gang world anymore, they're giving you more generic information. They're not telling you what.
Yeah, it's kind of just basic stuff that everybody will tell you.
And as far as Isaiah Chance, you documented him based on 5 reasons.
Yes, sir.
Do you remember those?
I do not have it right here in front of me. I need to refresh my memory. It's,
Well, if I run through them very briefly, you can be able to tell me if you remember those?
yes, sir, I would.
One of those was a 23 necklace he wore on 2 occasions.
Yes, sir.
You remember how you saw that? If you saw it in person? Or?
Yeah, he posted them on his social media, and one of them was in a music video.
Okay. And then 2 and 4 were one was associated with 1 or more gang members. One was associated with 1 or more gang members 4 or more times.
Yes, sir.
Do you know how you were able to see those? Did you see those in person?
Yeah, that's also on social media. Just he's posting up with ATK gang members. I don't remember exactly all of them, but I can remember a few of them, like Tayshawn Thomas, Antonio Tilley, like those guys, Raymond Lakes, Raheem West.
Okay.
And then another one was there's it was called like a day in the life of ATK YouTube vlog that Malquise Worthen posted on YouTube. And in that video, you can see Mr. Chance sitting on the tailgate of a truck with a bunch of ATK gang members.
Okay. So you're getting all that from social media.
Generally, yes, sir.
And then another one was physical evidence that you referred to as an Instagram post.
Yes, sir. So physical evidence is I treat it as like if I can physically hand it to you and stuff like that. That would be physical evidence. So the post I printed out and it's in his case file and it's talking about the ATK.
And the last one was a confidential informant.
Yes, sir.
Now, are you able to talk more about that confidential informant here today? Or is that still someone you are unwilling to release the name of?
I'm not willing to talk about it.
Without asking questions about that, is that be able to verify the information this person told you?
Yes, based on the other evidence that I've outlined in the document with all the other criteria.
The one we just talked about.
Yes, sir.
Did this person give you any specific information other than just the simple fact that Mr. Chance was an ATK member?
They gave his nickname as well.
Which is?
He has several. Some people call him Double G. They call him Gutta Man or Gutta Zay or just Gutta.
Do you remember what this confidential informant referred to him as?
Gutta Zay.
Okay, that's all I have now.
Okay, thank you. All right, redirect.
We're asked by Mr. Gonzalez about the statements that are made on social media posts and in music videos not being direct statements of any crimes that have been committed. So you didn't hear any statements of "I killed someone," correct?
Not to my knowledge. I don't remember hearing that.
But there are direct statements or admissions that are frequently posted by gang members. For example, Hakeem Robinson or Queso. Mr. Robinson recently convicted of a crime.
Yes, he was 2 or 3 days ago.
Is he a member of ATK?
Yes, he is.
Was he in the last several months also convicted of another homicide of a Lil Buck?
Yes.
Is Lil Buck actually Charles McCormick and a member of 6 Block?
I don't know about Lil Buck's document, his status, but he was definitely an associate and artist of 6 Block.
Are you familiar with an admission posted by Hakeem Robinson, aka Queso, in the case in which he was convicted? That was a direct admission. I killed an N-word and then I got my toes done.
Yeah, but it wasn't necessarily, that doesn't like imply. It
Doesn't
doesn't
say
say
I
who he
killed
killed.
someone.
Yeah.
Does it?
No, it doesn't.
But that would have been a useful piece of information and ultimately was a useful piece of information utilized in the trial where he was ultimately convicted.
Yeah, I believe so. I didn't have to partake in that trial with the evidence.
So when you're responding about questions of direct statements of admission, your responses were limited to not seeing gang members say, "I killed so-and-so on X, Y, and Z date."
Correct.
But the other statements that you utilize to essentially develop leads on cases lead you in your investigation to potential items of evidentiary value to help solve those crimes.
Yes, they lead us in the right direction, and then we take that with the evidence that we obtain.
The same thing occurs when music videos are posted back to back. Is that correct?
Yes.
Did you have an opportunity in 2023 to respond to the murder of 6 Block member Jake Jett?
Jaquan Pickens, yes, I did.
And that's his legal name is Jaquan Pickens.
Yes.
And were there several social media images or postings that took place immediately thereafter from a rival gang taking credit for that?
Yes.
That cannot serve, at least by itself, as evidence.
By itself, no. Yes, you're
But
correct.
after the social media images that you directly observed, did you, within 5 hours, subsequently respond to the attempted murder of Charles Jones, which occurred?
I think you got the timeline mixed up.
I'm sorry, Lil Kobe. It's an attempted murder for Lil Kobe.
Yeah. So I don't know the exact time of the in between Jake Jett and Labobi, but it was somewhere around maybe like 10 or 12 hours, I would think.
But you're responding to a homicide scene, just like we previously discussed, and identifying the victim, correct?
For Jake Jett, yes.
And determining what group they're associated with.
Yes, he was a part of the bully gang 6 Block.
And you ultimately determine who is posting on social media taking credit for those acts.
ATK.
And is there a shooting of a then ATK member within hours?
The shooting would have been a 1200 Lavovi.
So an affiliate or associate to ATK?
Yes, ma'am.
Same scenario when we're talking about the attempted murder of Charles Jones. Was there an attempted murder or a murder of a rival gang member that occurred hours before that?
Yes, ma'am. That would have been the murder of Antonio Tilly.
And did 6 Block members take credit for that on social media?
Yes, by trolling.
And did Charles Jones then become the victim of an attempted murder hours later?
Yes, approximately maybe like 4 or 5 hours later, Charles Jones had an attempt on his life where he was struck in the foot.
So despite not having these direct statements of I killed X, Y, or Z, as you're watching these music videos or watching these social media posts, are the investigations that you're conducted ultimately often confirmed because there is a shooting or another homicide of the individuals who posted those drill rap videos or posts to their rival gangs?
Yes, ma'am. We call it retaliation shootings.
As it related to your discussion regarding gang criteria, in addition to the tattoos, as you previously mentioned, or the type of dress that was depicted, are there necklaces that are depicted by ATK members or worn by ATK members?
Yes, they wear the number 23 as he was a victim of this town center homicide, triple homicide in 2018. They also wear a necklace that has an ace of spade and it says ATK.
Without your specific knowledge of the gangs, ATK specifically or generally as it relates to 6 Block and 1200 in Jacksonville, would you know the importance of the nicknames that are being said in these music videos or in these postings?
Yes, I know the most of the members and associates' nicknames.
As a result of your work with the Jacksonville Sheriff's Department?
Yeah, just based on my knowledge and experience of doing this line of work.
You were asked about your familiarity with having met several of the defendants in this case in person. Is it common for you to become familiar with members of the gangs that you're investigating by way of seeing them on social media, even if you've never had personal contact with them?
Yes.
And are you able to identify several members of even just ATK without ever having contact with them based on the observations you make on social media?
Yes.
May I have a moment, Your Honor?
Yes.
When we're asking about your familiarity with the defendants specifically, we'll ask in your review of social media, have you had an opportunity to see the defendants either live or actively posting in real time on social media?
Of the one sitting in here, two of the 4.
Which 2 of the 4 have you actively seen in real time posting or on live?
Rashad Murphy and Isaiah Chance.
Did you have an opportunity to observe Rashad Murphy via Instagram or another means?
Instagram.
And how is it that you were able to observe Mr. Murphy?
He's utilizing the Instagram Ghost 187,
And was that a live video or an active post?
a live video.
Could you see the defendant, Rashad Murphy's face in the live video?
Briefly.
Do you, when you're reviewing social media just day to day, actually record or preserve those videos when you're just doing general intelligence gathering?
No.
If there's evidence of a crime, do you then document that?
Yes,
Okay, so if it's just day to day activity, it's not necessarily something you make a note of.
that would be correct.
And as it relates to Isaiah Chance, you indicated you also saw activity of Mr. Chance. Where was he active?
On his Instagram.
And is that the Gutta Zay Instagram account?
Yes, ma'am.
Did you document interactions between the Gutta Zay account and the Ghost 187 account on Instagram?
They would tag each other in post.
Even to this day, there are active posts with tags, correct? I didn't ask you to check today, but within the duration of this case, as it's been ongoing, there's still active posts.
Somebody's had access to their accounts.
And these are posts as well as the stories that kind of disappear after a certain amount of time. Is that correct?
Yes.
When you saw the post from Mr. Chance's accounts, is he posting images or videos of himself?
Like since his arrest?
No, I apologize. During your investigation of the case.
Yes, he has. He has posted pictures and images of himself.
And your familiarity as it relates to qualifying Mr. Chance based on his clothing and his music video, is that from Mr. Chance's music video of Blood on My Prada's video?
Yes.
And is he depicted wearing some type of gang depiction or symbol in that video?
In that video alone, he's wearing the 23 necklace, and he's also with another ATK gang member who is his name is Xavier Harrison. He goes by the name of Fat Zay.
So in 2 places, you would have documented that.
Yes.
No further questions, Your Honor?
Joe, only as it relates to the visual.
Okay, quickly.
So Ms. Ismer asked you about taking credit. Again, taking credit means somebody is on a video talking about a murder that was occurred or somebody who died. That's taking credit, correct?
Yeah, I would think like taking credit when they talk about it in music videos is just kind of like a disrespect thing. They never necessarily did it, but they're going to disrespect it by saying they did it.
Well, they're not saying they did it. Did anybody say they did it? Didn't you answer Ms. Ismer by saying by trolling? Isn't that what I heard you say?
Trolling, yes, sir.
Yeah, trolling means that you are attempting to get under the skin of somebody else. You're trolling them.
I would agree with you.
And you would also agree that when the state uses over and over the word taking credit for, you mean they're on Instagram Live or they're doing a video or they're communicating and they're disrespecting the person that died. That's what you mean by taking credit, correct?
Yes, sir.
Okay. And as it relates to Jaquan Pickens, the case that Ms. Isra brought up, that's an unsolved murder, correct?
Correct.
Okay. And when you talk about Jacoby Beals, who was shot the next day, essentially, you believe that was retaliation. You don't have any evidence to show it was retaliation, do you?
It was based on the time frame and the social media posts afterwards that was a retaliation for Jake Jett.
Trolling, right? Discrediting and dissing.
Yes, sir. That would lead us to believe that it was a retaliation shooting.
And essentially, that would be from unconfirmed hearsay of other people talking on video and from sources that you can't tell me who they were.
Correct.
And one last thing, when it relates to Mr. Murphy, I know you talked to about Mr. Murphy. When did you see Mr. Murphy on Instagram?
I don't recall the exact time.
Okay, and who else was on there, you said, other than Mr. Chance? Anybody else on that feed? Did you take down other people's handles or other people that were involved in that conversation?
What do you mean by feed? Like as far as
you said you saw them live, right?
Mr. Murphy, I've seen live.
Okay, and when you saw him live, can you tell me when that happened?
No, sir, I cannot.
Can you tell me who Mr. Murphy was speaking with?
No, sir.
Can you tell me what was being said?
No, sir.
I don't have anything further.
Okay, very good. All right, may this witness now be excused.
Yes, Your Honor.
Okay, all right, thank you.
I have a quick question. Is that for good or
I
go
think
away
you're,
outside?
is he done?
All
You're
right.
done.
Thank you.
Okay, who's your next witness?
They say you done. All they do is they do stuff, do these crimes, and then they go rap about them.
Judge, are you ready for us to call the witness?
I am.
That's why they're starting to bring all these lyrics in.
Okay, we can call Craig Griffin, Your Honor. I apologize for the delay.
Okay, and is this still in relation to the defendant Rashad Murphy's second motion in limine, or is this?
Yes.
Okay.
Yes, Your Honor.
Okay, very good.
I don't even know how to judge people on this straight. Like, it's just way too much going on. That's why we got to take it in pieces and parts, and that's why I also put up that chart so we can have some kind of idea. I mean, I know a lot of it because for the fact that I did look at it.
All right, Detective, you remain under oath. All right, you may proceed.
Detective Griffin, how long have you been with the Jacksonville Sheriff's Office?
Going on 17 years.
And what were your prior assignments before the gang unit with the Sheriff's Office?
Prior assignments, I worked in patrol on the north side of Jacksonville. I was assigned to the narcotics unit. I also worked in internal affairs. I worked in sex offender registration and also assignments inside the jail.
In addition to those assignments, did you play some role in community-based outreach as well?
Yes, ma'am.
And what does that involve?
Involves reaching out to prospective gang members, trying to get those out of that type of life to give them an opportunity, job, schooling with pastors and local community leaders.
You also have the opportunity as in the community outreach to make contact with active gang members or associates.
Yes, ma'am.
And do you have an opportunity in that role to also develop relationships or at least some semblance of a trusting relationship with those individuals?
Yes, ma'am.
Is that through that outreach itself?
A little bit, yes, ma'am.
What are some of the day-to-day activities that you engage in as a gang detective?
We monitor social media. We monitor reports that we receive from officers that make contact with individuals through patrol. We actually go and do in-field interviews. We do nightly deployments. We do the community outreach as well. We document gang members. We undocument them as well once they reach the 5-year period if they don't meet the qualifications anymore.
And is that by utilizing the gang statute to ensure that they either meet or do not meet those qualifications?
Yes, ma'am.
Is that the same operating procedure that would have been used by the other gang unit detectives in evaluating at the end of that 5-year period whether they still meet the criteria?
Yes, ma'am.
And that's applied uniformly whether it be yourself, Detective Nieder, et cetera?
Yes, ma'am.
You all employ the same day-to-day activities as well, maybe different for your specific gang, but same day-to-day outreach, investigations, et cetera.
Yes, ma'am.
So I'm not going to dig too deep into that with you, but I want to ask you whether you also attend the gang conferences
Yes, ma'am.
and do any kind of follow-up work as it relates to staying educated on your particular gang.
Yes, ma'am.
What gang are you assigned at the Jacksonville Sheriff's Office?
Out East 1200.
And how long have you had that assignment?
Almost a little over 2 years now. I was working in conjunction with the prior detective as well.
Explain to me the difference between or the relationship between Out East and 1200.
So Out East, 1200 is a subset of the overall gang Out East. Out East is the main area. 1200 is a group in which follows up under Out East.
And is that a location or an area of Jacksonville as well?
Yes, ma'am.
Is it typical for members of those gangs to have resided at some time in that area?
Yes, ma'am.
And are you at least starting to see now members of each of these gangs that don't necessarily still live in those areas but are still members?
Yes, ma'am.
Did you have an opportunity in attending the gang conferences to also learn about the mechanisms utilized on a national level with the gang investigations and updated techniques with investigating gang activity?
Yes, ma'am, I have.
Have you shared your knowledge or expertise about Out East, 1200, or Jacksonville gangs locally or statewide or nationally with other gang detectives?
Yes, ma'am.
And have you had an opportunity to review, research, and look at the chart that was created? In this case, is a demonstrative for the group 1200.
Yes, ma'am.
Did the chart accurately reflect at least a portion or some of the individuals affiliated to the group 1200?
Yes, ma'am, it did.
Before you reached before a 5-year mark was reached, I know you did not have Isaiah Chance assigned to you, but you said every 5 years that determination as to what gang you're affiliated with and whether you meet that criteria is reassessed.
Yes, ma'am.
Had you had an opportunity to come to that time frame with defendant Isaiah Chance in this case?
I have not, no, ma'am.
Was there some information or evidence that at some point Mr. Chance was transitioning from ATK to 1200?
Yes, ma'am, there was talks.
And was that also supported by Mr. Chance's social media posts about switching to 1200 as well?
Correct, yes, ma'am.
In your review of the social media posts that you have, are you able to monitor live videos with gang members associated to those accounts as well?
Yes, ma'am.
And are you always documenting your day-to-day observations, or do you document what you would deem could be useful information in the future?
We document what would deem to be useful in the future.
As a part of the criteria that you mentioned that's statutory, did you have an opportunity to, in looking at the demonstrative aid, confirm each of the individuals depicted met or meets that criteria?
Yes, ma'am.
As it refers to the met that criteria, are some of the individuals depicted no longer living? Were they victims of the back and forth?
They were victims of gang violence, yes, ma'am.
Did you learn of their relationship to the motive for these deaths as in your role as a detective in gang unit?
Yes, ma'am.
Okay, I know that Lynn is Lynn trying to figure out if she can see Goddess in the chat. Yeah, sometimes I accidentally, y'all know I'm real bootleg, and I be clicking on block people all day. I be blocking people. I'm a bad mod. I just wanted to stop for a minute and say something in regards to like what we hearing and how things are going. You know, the funny part, well, I ain't gonna say funny. I should stop saying funny. The sad part about all of this is that when I look at, we just went through a trial with Alicia Andrews, correct? And from all her testimony, not to say that the jurors are going to hear the same thing, but even from her motions and her filings, like she's basically, like, at least in my opinion only, all her filings and everything basically say these guys did it. They did it. They did the shooting, they did the unaliving, they did the planning, they did everything, and she didn't know anything about it. So they did it. So when we hear and we like listening to this stuff, I guess I'm kind of biased because I'm kind of like, well, Isaiah probably should have took a plea deal and, you know, blame the other two people. Or maybe it was too late for him to even try to take a plea deal. You know, I don't know. Maybe because they got so much overwhelming evidence, but they are going for the DP for this case. So I'm not sure if they offer anybody any plea deals or if there's even a reason to offer a plea deal because the evidence is so overwhelming. I mean, it's like so overwhelming with a lot of the things. But yeah, I am not sure why, how we got here, if they're even able to get a plea deal once they go for DP. I have to look that up in Florida to see how that works because I'm assuming if they're going for the DP, they have so much hardcore evidence that they don't need a plea deal for these last 4 defendants. And we're not just talking about one defendant, we're talking about 4 defendants. And remember, for Alicia, they did not. They did not go for DP. Goddess says no because of prior cases of shootings. Most of them were involved in before the unaliving of Julio. But yeah, well, you know, and even if that's the case, I don't. If you they're not on trial for the prior things, and I know that, you know, sometimes they get off on one thing and then they like, okay, we're gonna get you on everything, which, you know, whatever. But you know, when people are convicted of crimes, I want them to be convicted for exactly what they're on trial for, not for all the past things or inner things. But, you know, and I don't know if now, if these wars are going on still in Florida, but guys, it's like terrible. Like we watched the Queso trial where his own daddy got up there and testified against him. Like, this is all in this same circle. This same circle. So this circle is very, very, very large. In regards to all the people that are involved. So it definitely gets kind of confusing. And then I know at points in times they were trying to bring Young and Ace, and he's a well-known, prominent rapper. And his name was actually brought up in the last trial that we watched, where they were trying to say Young and Ace, you know, hired, I don't know, with these people to do this thing to Foolio, because Foolio and Young and Ace were both in the same background, same hood, rapping in the same area. It's just that Young and Ace had a bigger audience and was more mainstream than maybe a Julio Foolio was, in my opinion. But you know, sometimes when these guys, they make it and they get big out here in these streets, they are unable to leave their street life alone. And not to say that Young and Ace had anything to do with any of this stuff, but I don't know. That's where they getting the ATK from. That's where that's part of. But I'll put us back into the courtroom, of course. But just to kind of give y'all some thoughts. And I mean, it can be real confusing when you're looking at this. Yeah. I don't know. I can't recall if I heard that testimony, Goddess, but I can believe it. In some ways, I don't know. I don't think they have any money transactions. But, you know, at the end of the day, it just seems like it's all about streets that we don't own, hoods that we don't own, neighborhoods that we don't own. And it's like really, really sad. Like, just because you and some people, y'all create a brotherhood and y'all down for each other, does not mean that y'all got to go unalive other people that decided to create a brotherhood and be down with each other. I never understood the whole thing about gangs. Me personally, like, I understand being down for the cause, but I mean, nobody owns not one of these streets. None of these streets. None of these hoods don't own nothing on it. We from Marcy Projects and you from Hoodwink Projects. And because we stay over here and you stay over there, we all cool over here. So now we gotta be unaliving you guys over there. We gotta be getting into it with you guys over there. It just seems very, very stupid to me. But that's just my opinion. I it's so, after the movie, what was it? They had brought that movie out, and I don't know if you guys, I'm probably about to show my age. Y'all remember Colors? And I was like, gosh, but that was in California. So I thought only gangs were in California, and that's just how I guess sheltered my life was, because I thought that it was just California, and then as I got older, I'm like, okay, gangs is played out. Because it wasn't like people were running around here talking about, I got a red flag, I got a blue flag, I got a green flag, I got a purple flag. Like, it became like it was played out. So just to hear about these 18, 19, and 20-year-olds actually talking about they still out here doing this stuff, but stuff that they don't own, that don't really make sense. I can't wrap my head around it. But, teach his own in regards to it. Yeah, I really thought this shit was played out, but apparently it's not. I don't know if it's played out now. Hopefully, and in Florida is like real bad, and Chicago. So, and those is places that I wouldn't even thought of. What's that? Tennessee? Is it Memphis? I think it's Memphis. Bad. I think that's another area that I heard that's real bad, that nobody even thinks about. And I guess they like, long as they offing each other and they not having no problems, let them do it. Because I promise you guys, in Chicago, like, they would literally unalive each other, go do a video, post it on social media, go to jail, get out of jail, and start the cycle all over again. The only time that I really heard that they really got involved, the police, I would say, per se, in the Chicago gang wars, is when somebody got shot in a very prominent neighborhood outside of, I believe it was a Gucci store or something. And that was Duck. Yeah, I said Duck. When he was like, that's the only time that they really got involved, is once it kind of came into an area where they didn't want that. But long as it happened in the hood, like, it just seemed like they just let them do it, post about it, and like, long as they was offing each other and not doing it where nobody else was at, they was good with it. Yeah, so I mean, it's really sad. It's like even hard to keep up with because it's just so much when we look at it at different points in time. So you got to kind of like take this stuff in baby steps. But I mean, I don't know if this is setting a narrative and a point for other people that are thinking about doing these things or getting involved with these things. But yeah, you can even tell from even a testimony that we heard when we was looking at Alicia Andrews' case what this is all about. But let's go back in. Yeah, rap word, streets, neighborhoods, all types of stuff. They smoking on each other. It ain't even pouring out a little liquor on nobody. Now we smoking on them. Like, dang. So disrespectful.
How about information that you had or information that you knew about the gang rivalries in Jacksonville before you were officially assigned to the unit?
I knew a little bit, having worked in the north side of Jacksonville. You knew certain names that jumped out at you. But once I was assigned to the gang unit, I've gained way more knowledge in reference to the murders.
As it relates to the surviving members of 1200, at least to this point, were there individuals that also rep or previously repped a group 187?
Yes, ma'am.
What is the relationship between 1200 and 187?
So it was like a transformation. 187 would also be considered a subset of Out East. Once 187 was almost like a record label group. Once that kind of went away, they all fell up under 1200.
And so is it unusual for you to see, when you're reviewing, for example, one of the criteria of tattoos, an individual that claims 1200 with a tattoo that says 187 or vice versa?
Correct.
And in your time investigating these types of cases and even attending the gang conference, were you able to determine what the reference 187 meant or was intended to reference?
Yes, ma'am, I did.
What is that?
So 187 is the California Penal Code for murder or homicide.
Do you also develop this information by way of either confidential or consensual proffers with gang members or former gang members?
That's correct. Yes, ma'am.
And does that also occur as a part of your duties in the gang unit?
Yes, ma'am.
In addition to your role in Jacksonville, did you provide information about this specific gang rivalry and your observations from social media to the detectives in your gang unit and the detectives in Tampa?
Yes, ma'am, I did.
Were you specifically able to identify Davion Murphy and Rashad Murphy as members of 1200?
Yes, ma'am.
And have you had an opportunity to review the tattoo images that were collected of defendant Davion Murphy
Yes, ma'am.
from this case?
Yes.
Were there depictions included on those tattoos which you documented or made note of for future documentation, which would have related back to either 187 or 1200 activities, including in the individuals who were killed in that rivalry?
Correct. Yes, ma'am.
Does that include Avery McKnight or Shug?
Yes.
How about Corbin Johnson or Corbin?
Yes, ma'am.
And Joe Rod Adams or Spaz?
Yes, ma'am.
Were those all in some way depicted and included on those tattoos?
Yes, ma'am, they were.
Is there some familial relationship between Rashad Murphy and Davion Murphy that you were able to ascertain?
I believe they're cousins.
And is there some familial relationship, either also a cousin or younger brother in some way, to deceased individual Joe Rod Adams, aka Spaz?
Correct.
Is that cousin or brother or something along those lines?
I believe they're brothers.
And is that information something that you're actually able to confirm, or is that just kind of intel that you have heard?
Just intel we received over the years.
Whose brother is Joe Rod Adams?
Be Davion.
But this is just intel from, outside witnesses of some kind.
That's correct. Yes,
There
ma'am.
has not been at least, or is there required for you when you're creating documentation to obtain birth certificates or like solidify familial relationships between the individuals
No, ma'am. Short of having both of them in a room and asking them.
and believing whatever the answer is?
Correct. Yes,
Okay.
ma'am.
And so that's part of the intel that you're kind of utilizing in some way over the years as you respond to these calls for service. You learn that there is a familial relationship of some kind between Joe Rod Adams, Davion Murphy, and Rashad Murphy.
Correct. Yes, ma'am.
Were you in charge of 1200 when Joe Rod Adams was killed?
No, ma'am.
And were you subsequently made aware of who had been convicted in that death?
Not till afterwards.
So subsequent to the homicide, of course.
Correct.
And was that Robert Howard?
That's correct.
When law enforcement in the Jacksonville area has a question, a concern, an interest in a 1200 gang member, are you the individual for whom they make contact with?
Yes, ma'am.
If there's an outside agency who needs information about 1200 or out east generally, so they're affiliates, I understand that there are several subsets to out east, do they contact you or
Yes,
attempt to
ma'am.
contact you for that information?
That's correct.
Are you the individual with the Jacksonville Sheriff's Department that's considered to hold the specialized knowledge about the out east gangs or 1200 specifically?
Yes, ma'am.
And is that to include the members of the gangs and their associates?
Yes, ma'am.
I'll pass the list, Your Honor.
Okay, Mr. Gonzalez? On behalf of Rashad Murphy?
Ted, you became assigned or started to become more intimately familiar with 1200 in the early part of 2024, correct?
Roughly, yes, sir.
And so that would have been just a number of months prior to Charles Jones' shooting in June of 24, correct?
Yes, sir.
And before that, you assisted in some of that particular gang activity, right?
Yes, sir.
And utilizing the intelligence for the day-to-day work that the state was asking you about, you monitor reports, meaning you monitor field interrogation reports, correct?
Yes, sir.
You monitor social media for what you can hear and what you can see and what you can develop, correct?
Correct.
And you also talk to people in the street.
That's correct.
And you would agree with me that the majority of the intelligence you get is either from monitoring social media or talking to people in the street, correct?
Well, the FIRs or field investigative reports are pretty important as well.
And when you do this documentation process, each detective utilizes their own means to do that, correct?
Yes, sir.
Granted, there's a statute that broadly tells you what you can document somebody by, correct?
That's correct.
But each detective decides when to document somebody, when they fulfill that that requirement, and when that happens.
Yes.
And you talked about 1200 being a subset of Out East.
Yes, sir.
Who are the prominent members of Out East?
So you got Spinner Benz, Whopper with the Chopper. You have Green Light.
Those are not members of 1200?
Those members 1200, yes.
Okay. So are you referring to 1200 and Out East being the same?
Yes,
You
they
said
all
one's
fall,
a subset of another.
correct. But they all fall up under Out East 1200. That's the way it's labeled.
And you said that you have either come in contact or you've had information with regard to Rashad Murphy, correct?
Correct.
And this would have happened during your time frame with the gang unit after you became strictly associated with 1200,
Correct.
which would have been in 2024, correct?
Correct. And not until till the murder happened.
And the criteria within which you documented Rashad Murphy came as a result of 2 contacts that you had in. They're asked, hey, listen, do you know gang members? Fair
Yes.
statement?
Yes, sir.
And you give them a list of people and they say, yeah, he's a gang member. No, he's not a gang member. He's a gang member. That's what happened in these 2 incidents, correct?
More or less.
Okay. So somebody in a car somewhere that has a misdemeanor amount of marijuana is asked whether or not Rashad Murphy is a gang member, and that meets the criteria for him being a gang member under the statute.
Meets one of the criteria.
Right. And the other criteria would be that he was in the association of an individual on at least 2 occasions by the name of Noah Williams, correct?
Correct.
And Noah Williams is a gang member, correct?
Correct.
And he's been documented as a gang member because other people have said he's a gang member, or he's been in the company of gang members. That's how he became a gang member.
And also his social media.
Okay. His social media doesn't tell you he's a gang member, does it?
It's certain stuff that they put on social media that we kind of use as information as well.
Okay. And you're aware that Noah Williams grew up with Rashad Murphy since they were babies. Did
Yes,
you know
sir.
that in intelligence?
Yes, sir.
Okay. Would that be a significant and reasonable enough circumstance for him to be around Noah Williams at least 2 times when you guys saw them?
Yes, sir.
That is the criteria that made Rashad Murphy a documented gang member, correct?
Yes, sir.
And it relates to 187. 187 was formed in order to promote rap music, correct?
That's correct.
And at one point in time, those people or those guys that were promoting that rap music or that were part of 187, it ended up dissipating or dissolving, correct?
That's correct.
Okay. And you're saying that some of those members became 1200.
Correct.
Okay. And they became 1200 from 187 because somebody told you that they did, right?
That along with field interviews, Instagram posts, social media posts.
Okay. You won't have any of those field interviews, would you? That have people's names on them and phone numbers and Twitter handles and Instagram handles?
No,
you
sir.
wouldn't have those for me to look at, would you?
No, sir.
You wouldn't be able to tell me when it occurred, would you?
I can tell you roughly around what year.
Okay. And it would have certainly had to occur after you came on board in 2024, correct?
What do you mean?
The field interviews that documented Mr. Murphy.
For Murphy or for the 187?
No, Murphy.
For Murphy?
We're talking about Mr. Murphy.
For Murphy, not till after I came on, yes.
Okay. And so you don't know what members of 187 that were promoting music and rap music turned into members of 1200, correct?
Well, we knew 2 of them for sure.
Okay. Who are the for sure's?
For, Noah Williams
Yeah.
and Whopper with the Chopper, which would be Reginald Williams.
And that's because they continued making music, right?
Correct.
And the music they made dissed other people
Correct.
and talked badly about people being murdered, correct?
Correct.
And gave intimate details of those murders, correct?
Correct.
Which you knew the details of those murders as well, right? As
Correct.
a law enforcement officer? Did you find out about the intimate details of those murders by people on the street?
What do you mean?
Well, did you find out about intimate details of particular murders by talking to people who said they knew about those murders?
Not necessarily, just through the homicide investigations themselves.
Okay. And so other people, lots of people, thousands of people knew about these murders and how they were committed.
If you're going off based off the music, yes.
Okay. And additionally, you can't eliminate that there weren't thousands of other people talking the same way about those murders on social media as the ones you were monitoring.
What do you mean? I don't quite understand your question.
Can you preclude that because lots of people knew about these murders, didn't they, when they happened?
I wouldn't say lots of people. What are you
Well-
saying? Just like based off of the amount of people that viewed the YouTube video?
No, I guess I'm just saying, when somebody gets murdered out in the street, people know about it real fast, don't
Yes,
they?
yes.
And they actually know how it happened real fast,
I mean, short of somebody being shot in the middle of the street, that's kind of all they know.
okay? And then people immediately start talking about it, rapping about it, having social media posts about it, and it goes crazy viral, right?
Yes,
And you guys are monitoring just certain ones that are doing that, correct?
correct.
And there may be 50 other similar videos, similar posts, similar conversations on social media that you're not monitoring that are saying the same thing.
That's correct.
When you talked about 187, and you talked about the statute, the murder statute, isn't it a fact that you are making an assumption, which you have every right to do? Don't disagree. I don't disagree with it. You're making an assumption that there could be a connection between 187 in Jacksonville, Florida, and the murder penal statute in California, right?
Yes.
Nobody told you that.
Field interviews.
Okay, so people out in the street, you wouldn't be able to tell me who told you that, right?
No.
Okay, but you're assuming that there's some connection without having an evidentiary foundation that there is, correct?
Correct.
So Detective Griffin, you've gone to HIDA conferences that include components of gang-related work, correct?
Correct.
And they include other types of law enforcement training and education as well.
Correct.
All right, and you've done that since you've been a member of the gang unit.
Yes, sir.
Okay? So that would put you at 4 years or so.
Yes, sir.
In addition to HIDA, was there any other conference that you attended?
What HIDA is just they offer courses. I believe what you're referring to is FGIA, which is
Okay.
the Florida Gang
Okay,
Conference.
I got it. So HIDA, you've had courses in social media, cell phone investigation, correct?
Correct.
And those can be applied in any area of law enforcement, right?
Yes, sir.
They just make cops better cops, detectives better detectives.
Yes, sir.
Okay. Detective Griffin, you have never been qualified as a gang expert, correct?
No, sir, I haven't.
Nothing further. Thank you.
Okay, Mr. Sonardi, on behalf of Davion Murphy.
Thank you. Good afternoon, Detective. My name is Nick Snarty. I'm an attorney. I represent Davion Murphy. Do you see Mr. Murphy present in the courtroom?
I do. Yes, sir.
Could you identify him, where he's sitting?
He's sitting between the gentleman with the blue jacket and the lady with the glasses on. He has an
All right.
orange jumpsuit
Let
on.
the record reflect he has identified Mr. Murphy. So that I'm clear, when was it that you actually became a member of the gang unit of the Jacksonville Sheriff's Office?
February of 21.
So at the time of the homicide involving Mr. Jones, you were then a member approximately 3 years. Is that correct?
Correct.
And I believe you've indicated that you were one of the ones during that period of time that assisted in documenting gang members. Is that accurate?
Yes, sir.
And I think we've gone over the method that you utilize in order to identify gang members. And a lot of that was interviews with people in the street, maybe looking at social media. What else?
Yes, sir. Interviews in the street, social media, jail phone calls, jail tablets, meetings just in general with the prospective gang members.
When, if ever, did the name Davion Murphy ever appear on your radar?
Not until this incident.
All right, which would have been in 2024, correct?
Correct.
So prior to between 2021 until 2024, the name Davion Murphy meant absolutely nothing to you, correct?
Correct.
You did not associate him with either Out East, 187, 1200, or any of the other gangs, correct?
It's my understanding he was in prison.
That is correct, until 2023.
Correct.
So the answer to the question is he was never associated with any gangs during that period of time.
Correct.
All right. Have you designated, or are you aware of any designation as we speak today that Mr. Davion Murphy is a member of a gang?
He meets the requirements to be documented as a gang member, but currently, as of today, he is not a documented gang member by myself.
Well, of anyone that you're aware of with the Jacksonville Sheriff's Office that has documented Mr. Davion Murphy as either a gang associate or a gang member?
Not that I'm aware of.
Okay. So as he sits there today, to your knowledge, as a member of the gang unit of the Jacksonville Sheriff's Office, Mr. Davion Murphy is not, nor has he been since commission of this offense, a member of any gang, correct?
Not with the Jacksonville Sheriff's Office, but with the Florida Department of Corrections might be a little bit different.
Are you talking about Florida State Prison?
Correct.
All right.
And are you aware of any designation by the Florida State Prison that Davion Murphy is a gang associate of any gang?
I believe they have him listed as a STG in there.
You have to help me. What is STG?
Security Threat Group. That's how they document gang members in the DOC.
That's your belief. Have you ever confirmed that?
With Davion, no, but that is how they do it in DOC. That's what it's referred to.
Well, that's what I'm asking you. As a Davion Murphy, have you ever documented whether or not he qualifies? I believe you're using it at STG. Is that correct?
I haven't reviewed DOC's record.
All right. So as we speak, you don't know if he was even documented by Florida State Prison as a gang member.
Correct, sir.
All right. Now let's see if I can clarify out east. What was out east?
What do you mean?
Is that is that a what is out east?
Out east is a portion of Jacksonville. It's an area town in Jacksonville.
Is that a designation for any kind of gang or assembly of individuals?
Where a lot of known out east gang members are born and raised. They reside at. A lot of violent crimes have occurred: robberies, murders, thefts, firearms.
Well, my
drug
question
sales.
is it a designation that is as is 1200 or 187? Is it the same type of designation, or is it simply a geographic area?
Geographic area up under that.
All right, so it's
title.
not a gang designation.
I don't think I understand what you're saying. That
Well, I'm
gang
trying to
designation.
determine, you've identified out east as being
area of town.
An area of town.
Yes.
All right, and my question is, out east also a designation for any type of gang?
Yes.
It is.
Yes.
All right, that was my question. Now, did out east at some point in time involved into 1200 or 187?
1200, 187 are subsets of out east.
Well, that's what I'm
So
asking.
They represent out east.
Okay. And is 1200 a part of out east, the geographical area of Jacksonville?
Yes.
And what about, you identified 187 as allegedly a penal code designation from California for murder, I guess.
Correct. It would be an area of town.
Okay. Since your time as a member of the gang unit of the Jacksonville Sheriff's Office, are you aware of Davion Murphy being a member of 1200?
No, but currently he does meet the requirements to be documented as a gang member.
All right. Prior to the homicide of Mr. Jones in 2024, were you aware that if Davion Murphy was a member of 1200?
No, sir.
All right. Subsequent to the homicide of Mr. Jones in 2024, are you aware whether or not Mr. Davion Murphy was a member of 1200?
No, sir.
Now, you indicated part of your criteria or methodology to determine whether or not an individual is a gang member is reviewing social media, correct?
Yes, sir.
And I guess we're talking about Instagram, X, YouTube. What other ones are there?
Facebook, Twitter.
All right. In your review of that social media, have you ever seen Davion Murphy?
No, sir.
What about the rap videos that you've described or talked about? Have you ever heard or identified Davion Murphy as either one, the individual doing the rap video, or being a part of the rap video?
No, sir.
Now, I believe there was some mention to tattoos of Mr. Murphy, Davion Murphy. I hate to keep repeating Davion, but we have two Murphys.
I got you.
So were you personally familiar with any tattoos on Davion Murphy?
Not till after the photos.
You saw the photos?
Correct.
Okay. And what are those photos? And they're in evidence. We can show them to you. What are those photos that you believe identified Davion Murphy as a member of 1200?
Correct. One of them. It says 1200 block.
1200 block. And that's, I believe, the big tattoo on the back of his neck and his back. Correct?
Yes, sir.
Is that what we're referring to?
Yes, sir.
All right. Do you know when that tattoo was applied?
No, sir, I don't.
Do you know whether or not it was applied in prison or not?
No, sir, I don't.
And is it fair to say that a gang member designation expires after 5 years?
That's correct. Yes, sir.
All right. And do you know whether or not Mr. Murphy, Davion Murphy, if he did in fact have a gang membership, whether or not it expired after 5 years in light of the fact that he was incarcerated?
I don't know.
Yeah. Thank you. I have any further questions?
Okay, thank you. All right, Mr. Wise, on behalf of, okay, very good. Mr. Petratus, on behalf of Isaiah Chance.
I'm going to go quickly, and then Mr. White's, with the court's permission, can cover for me. I have to we got my son and no one else can do it. I don't want to stop this from going because I know we have people from out of town.
Yes. How many more witnesses do you have?
Judge, we have two.
All right, very good.
Okay. Just a couple questions. Detective, what was the talk surrounding Mr. Chance moving from ATK to 1200 that you heard?
I believe it was an Instagram post. He was upset about one of his friends that died by way of gang violence and them not getting no retribution for it.
Now, so did you got that from an Instagram post or you were told that by somebody else?
I was told that by somebody else.
Did you ever see the Instagram post?
No, sir.
Who told you that?
It was another detective within the unit.
So would it have been Detective Nieder?
It possibly could have been.
Did you hear anything from anyone on the street about this supposed move?
No, sir.
Okay. So all you know is from Detective Nieder.
Correct.
Okay. That's all I have.
Okay, very good. All right, Mr. Weiss?
Hello. I know we covered this earlier. You didn't know Sean Gathright until the traffic stop that we talked about earlier.
That's correct.
You've never documented him as a gang member, correct?
No, sir.
And never documented him as a gang associate either.
No, sir.
Thank you, sir.
Okay, rebuttal, excuse me, redirect?
Detective, whether you have documented Sean Gathright or Davian Murphy or Rashad Murphy, whether you did it or did not, is that what's necessary to determine whether the defendants each meet the criteria for documenting them under Florida statutes or meet the criteria for being a gang member or gang associate under the statutes?
No, ma'am.
Is the documentation that you keep being asked about, whether they're documented gang members or documented associates, the reports that are utilized by your agency or cross jurisdictions to discuss or share information about gang members?
No, ma'am.
When you are talking about certified gang members or gang members that are listed by your agency, that is whatever report you all are utilizing and uploading.
That's correct. Yes, ma'am.
Does that have any correlation other than having used the statute to make those lists to the fact that in looking at the statute, the defendants still meet the criteria on that list?
Correct.
When you were asked specifically about Rashad Murphy, you indicated you had intel on the street, but also there were music videos, correct?
Correct.
Which depicted Mr. Murphy possessing firearms, correct?
Correct.
With that association member that he says is a brother, or that you were asked about being a close relative to him, Noah Williams.
Correct.
And in those videos, with a reference to F. Foolio attached to all of them, Mr. Murphy is depicted. Is that correct?
That's correct.
Mr. Murphy?
Rashad Murphy is depicted. Is that correct?
Yes, ma'am.
And Rashad Murphy is possessing firearms along with other gang members in those videos, correct?
Yes, ma'am.
You were able to identify specifically documented gang members in those videos and reviewing them.
Yes, ma'am.
Even though you were not assigned to 1200, when you actually got the 1200 assignment, basically, you had already been in the gang unit
Yes, ma'am.
and you had to essentially learn the history of 1200 and catch up.
Yes, ma'am.
Because these music videos that you were referencing with Rashad Murphy, some of them date back to 2020. Isn't that correct?
That's correct.
And in reference to those videos as well, are there several individuals to include Mr. Rashad Murphy utilizing gang signs as well?
Yes, ma'am.
How about clothing indicative of their membership?
That's correct.
And clothing directly related oftentimes to Charles Jones or the victim, Julio.
Yes, ma'am.
When the videos are reviewed by you or preserved by you, you educate yourself on the history of the gang despite only having been assigned to 1200 for half a year or so.
That's correct.
And did you have some knowledge at least of the inner workings of Out East and 1200 when you actually were transferred to that group?
Yes, ma'am.
When you discussed Mr. Davion Murphy, you don't recall which gang he was affiliated with in the Department of Corrections custody?
No, ma'am.
So that would have been another member of your agency that would have reviewed that information.
Correct. When it comes to DOC paperwork.
And you also were asked about whether you were aware whether Davion Murphy met or was a member of 1200 at the time of the homicide. When you obtain information, even if it is after the offenses that you arrived to investigate, are you still checking to see if at the time the crime was committed, each of the defendants meet the statutory criteria required to be considered a gang member or a gang associate?
Yes, ma'am.
I have no other questions, Your Honor.
Okay, may this witness be excused?
Yes, Your Honor.
Okay, you are free to go.
Thank you.
All right, who's the next witness?
Detective Trey McCullough.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Very good. You may proceed.
Please state your full name for the record and spell your last name for the court reporter.
It's Detective Trey McCullough, and it's MCCULLOUGH.
How are you employed?
I am employed at the Jacksonville Sheriff's Office.
How long have you been with the Jacksonville Sheriff's Office?
Roughly 10 and a half years.
Prior to becoming an officer with the Jacksonville Sheriff's Office, do you have any prior law enforcement experience?
I do.
What is that?
I started my career out in Bradford County, which is in Stark, Florida. I did a year and a half there. And then from there, I went to a different agency, Baker County Sheriff's Office. And I did 3.5 there. So roughly total of about 15, including JSO.
And before coming to Jacksonville Sheriff's Office, what sort of assignments did you have at those other 2 law enforcement agencies?
Well, I started out in patrol. And then from there, I went to like an investigation / like major crimes unit, narcotics unit.
And you, oh, did I interrupt you?
No, that's
okay. You said you were a detective with the Jacksonville Sheriff's Office, is that correct?
That's correct.
What unit are you currently assigned to?
I'm currently assigned to the gang investigations unit.
How long have you been in the gang investigation unit?
Coming up on 4.5 years.
4.5 years. Prior to coming to the gang unit, were you familiar in your position as a Jacksonville Sheriff's deputy with gang activity in Jacksonville before coming to the gang unit?
I was, yes.
And prior to coming to the gang unit, how long had you been familiar with the gang activity, specifically the rival gang war between ATK, 1200, and 6 Block, and some of the other groups that they were subsets of?
I started my career at JSO in it was 2016. So shortly after that, whenever I got released to patrol.
As a patrol officer, would there be more than a few occasions where you would become aware of those 2 groups and some sort of incident that occurred?
Yes.
And when you went specifically to the gang unit, did you have any specialized training in order to become a detective in that unit?
I had previously worked in the narcotics division at the Jacksonville Sheriff's Office. I did like a citywide task force type deal. And then obviously the gang unit.
And as a member of the gang unit, do you receive training that is specifically geared towards gang activity?
I do.
What sort of training did you receive?
So the very first training I received once I became once I was officially in the gang investigations unit was it was a 16-hour course. I believe it was labeled the beginner course, and then from there I did the intermediate training, which was like a year and a half, 2 years later, and that was a week-long course, like a 40-hour course. And then in between that, there's been numerous classes that I've attended, taken, like maybe they're like a one-day course here in Jacksonville, or depending on if it's a local training or something we can go to, and not travel out out of state or out of city.
And when you reference the beginner and intermediate courses and training that you have done, are those courses specifically focused on gang activity?
That's correct, yes.
Is there any sort of certification from going to those 2 courses?
You receive a certification with your name and the total number of hours of the course and the actual name of the course.
And you said that you had been in the gang unit for 4 years, is that correct?
Coming up on 4.5 years.
Coming up on 4.5. And as a member, as a detective in the gang unit, what are your daily activities that you do on a daily basis?
Just to monitor the gang activity in Duval County, which includes like assisting other units such as homicide, our RVCU unit, which is they investigate all shootings that don't result into a murder. We assist other units if they have questions about the gang activity and the current trends or beefs that who's going on and who's going back and forth, whatnot.
How many members are in your unit, the gang unit in Jacksonville Sheriff's Office?
There are currently 12 detectives and 2 supervisors.
And as part of the makeup of that specific unit, are there members within your unit that are assigned to specific gangs?
Yes,
Are you assigned to a specific gang or subset?
I am.
Who are you assigned to? What gang?
I'm currently assigned 6 Block along with Bully Gang.
And I want to ask you about that. You said 6 Block along with Bully Gang. Are they a related, or is one a subset of the other?
Bully Gang is a subset of 6 Block.
And can you explain what you mean by that it's a subset of 6 Block?
So essentially, 6 Block was a documented criminal gang prior to me coming to the gang unit. As the older, or I should say the younger guys were coming up, they kind of created this thing. It was, Bully Gang, but it was the same group of individuals that were associated with 6 Block, just a younger version, similar to how PCE was, the older version of 6 Block, and then 6 Block formed and so forth.
And is that kind of evolution in the gang in Jacksonville? Is that something kind of unique to Jacksonville in particular, where you have older members involved in a specific gang, and then younger generations or newer members then become that are a subset of that group?
Yes, ma'am. I would say that's accurate.
And that is based on your knowledge and training in this specific area in Jacksonville. Is that correct?
That's correct, with all the historical data and the same group of individuals, just maybe a different term or different name.
And you said specifically, you mentioned PCE, that was a much older group, and as a result of that, 6 Block became a subset of that. Is that correct?
6 Block essentially formed after PCE was dismantled in a RICO.
Was it a RICO? Is that correct?
That's correct.
And when 6 Block took over, was there a member that was a predominant member who was known for 6 Block?
Yes.
And who was that?
Charles Jones.
And was Charles Jones a documented member of 6 Block?
Yes, he was.
Was he the most predominant or well-known member of 6 Block?
I would say that's an accurate statement.
And when we go back to PCE, there would have been documentation. I know that you said you were just there for 4 years. When there is a gang that is evolving or becoming active in Jacksonville, is there a requirement that that be documented in a field incident report?
That's correct.
And that would have occurred prior to you being taken over. Is that correct?
That's correct.
Both for PCE and for 6 Block.
That's correct.
But as the current detective in 6 Block, would part of your job and duties of becoming the gang detective specifically covering 6 Block, would you go over and take a look at those certifications and that document and that history?
Yes.
And would members of the other members of the gang unit who are responsible for the other gangs, would they be responsible as well for taking a look at that prior documentation?
Looking at the prior documentation for 6 Block or their assigned?
For their assigned gang?
Yes.
I apologize. So going back to some of the daily responsibilities, now that you are the current person tasked with 6 Block, do you now document gang members and undocument them if necessary?
I do.
Counsel, can you all approach the bench real quick,
Yes.
attorneys?
Detective specifically assigned to 6 Block, and I believe I was asking you about your documentation. That is something you currently do, is that correct?
That's correct.
So you are responsible for that documentation.
That's correct.
How is a gang member undocumented?
Depending on their activity, after 5 years, we revisit their, what kind of investigate what they're currently doing. And if they have no specific gang ties or any activity or still, claiming or, repping the gang that they were associated or familiar with, then, there's a report written that basically, kind of eliminates them.
And that is required based by the Florida gang statute. Is that correct? 874, that documentation be kept. Is that correct?
That's correct.
And you said that you also monitor social media. Is that correct?
That's correct.
And are you familiar with the term drill rap videos?
I am.
And what does that mean to you in respect to the Jacksonville gang, rival gang war that's going on?
The drill rap in Jacksonville really took off quite a few years ago. And it's essentially music made by up and coming artists that's extremely vulgar, and they, diss or talk bad about, the opposing rival gang. If someone gets, shot and they're injured or murdered, they get on social media, they talk about it, they make specific details about their murder just to kind of throw a shot, if you say, or if you want to call it that, just basically throw shade at the other side, kind of diss the deceased of their rival gang.
Why do you monitor and track those drill rap videos?
Because from my training and experience, that usually draws a response,
Of
from
retaliation?
correct.
And I want to also ask you about your training and experience specifically with the drill rap videos. In these drill rap videos, are there nicknames that are utilized by the singers, the rappers who are making these drill rap videos?
Yes,
And based on your knowledge and training in the gang unit, do you recognize the nicknames that are being utilized in these drill rap videos?
I do.
And based on your knowledge and training as a gang detective, do you receive briefings and alerts when members of these gang members, 6 Block, as well as the rival gang members, when there is a shooting that occurs?
Yes,
And as a gang member detective, do you sometimes respond to those locations to assist in the investigation?
I do.
And does that include homicide cases,
Yes,
shootings that occur at high schools,
yes,
shootings where people survive their injuries?
yes,
And based on your specialized knowledge and training, the timing of those music videos, can that have a significance to an investigation?
yes, absolutely.
And that is all based on your specific knowledge and training in the gang unit, in Jacksonville, is that correct?
That's correct from the history that they have shown in the past. Yes,
And I know that we have shown you this chart for 6 Block, is that correct?
yes,
You did not make this chart, is that correct?
I did not.
That was a chart that was put together by other gang detectives in your unit, is that correct?
Yes,
I believe Detectives Draybeck and Detective Nieder.
yes,
But you yourself, since you were assigned to 6 Block, did you look at the people that are listed, the members and associates that have been put on this chart?
I have.
And could you confirm that these are members and associates of 6 Block?
Yes,
And you know that based on your time and experience as a gang detective, is that correct?
that's correct. Along with some of them I have, had interactions with.
So I want to specifically ask Charles Jones, he's on here. What was his nickname?
His Instagram handle was Julio Foolio, but people in Duval County just referred to him as Foolio or Lil Six.
And you said that you have, not only have you had interviews with people on the street, but you yourself, during your work in this specific unit, you have had contact with members. Is that correct?
Yes,
And that's live and in person?
that's correct.
And can you give us an example of some of the members of 6 Block that you have encountered and have met and have seen out in person when you are working in the field?
From that list or just in general?
In general.
It's kind of a long list, but obviously Charles Jones, Felix Pousse, Loreno Span, Therese Poe, Gary Davis, Alex Bass, Keon Newkirk. There's numerous. I don't.
Numerous. You've been in the gang unit for a very long time. Is that correct?
That's correct. 4.5 years. Yeah.
And you said that just on the list, there are other documented members of 6 Block and associates that are not on this list. Is that correct?
That's correct.
This chart in particular was put together based on some relevance to this case. Are you familiar with Adrian Gaynor Bibby?
I am.
And is he a documented member of 6 Block?
Yes.
And how are you familiar with Bibby?
He was murdered in Hilltop back in 2019, I believe.
And when you say Hilltop, what area of Jacksonville are you referring to?
It's on the northwest side of Jacksonville, Duval County. It's an apartment complex, Hilltop Village Apartments. It's right there on West 45th Street.
And what gang is associated with Hilltop, that area?
6 Block.
6 Block. So Charles Jones and Adrian Gaynor, that's kind of their area. Is that correct?
That's correct.
And did you know the relationship between Charles Jones and Adrian Gaynor?
Other than they were super close, very close friends.
And are you familiar with a rap video, Who I Smoke?
I am.
And in that rap video, and that is put on by the rival gang, 1200 and ATK, is that correct?
That's correct.
There are several refrains in that, or several lines in there, Who I Smoke, and then there is a specific name or a nickname that is given after Who I Smoke, is that correct?
That's correct.
Is one of those nicknames that is mentioned by ATK and 1200 in that song, Bibby?
Yes,
Were there other nicknames that were mentioned in that song after that sentence, Who I Smoke?
there were.
And are some of those other members that were specifically mentioned, those nicknames of gang members belonging to 6 Block or the subset Bully Gang, are they actually dead and deceased from that song?
Yes, every name mentioned in that song, Who I Smoke, is deceased.
And were nicknames utilized specifically in that video?
That's correct.
You're also familiar with a drill rap video that was created by Charles Jones that was called When I See You. Is that correct?
That's correct.
And therefore, there are specific individuals that Charles Jones referenced in that drill rap video that referred to people who were killed in the rival gangs.
That's correct.
Who was that?
I don't remember their actual, I want to say Jacoby Groover. He was 4. That's what he went by. And then 2 times, which was Kenyatta Buller's brother. And then 23, which was, I can't think of his legal name, but it was.
You know the nicknames, correct?
Correct, yeah.
And as a gang member in Jacksonville, part of that unit, even though you're just assigned to 6 block, do you also have familiarity and share information with the other gang detectives who are responsible for the rival gang?
That's correct. We share information. I'm extremely familiar with, the gang that I'm, specifically assigned to, as well as the other ones. I don't know like pertinent details to the other rival gangs as like I do at 6 block.
But you're familiar enough with the nicknames, is that correct?
Correct.
And you said Kenyatta Buller. Is that the person known as Young and Ace?
That's correct.
He was shot several times in that same shooting but survived. Is that correct?
That's correct.
As a detective specifically assigned to 6 block, are you familiar with the criteria that some gangs have hand signs or hand signals?
Yes.
Is there a hand sign or a signal that is particular to the gang 6 block?
There is.
And what is it?
There are several actually. There's one for 6 block, one for Bully Gang, and then there's another hand sign that they flash that we have determined to be as a hand sign associated to 6 block.
I'm going to show you just what's been marked for identification 6 block. I want to take you, some of these photographs are from social media. Is it common for members of the gangs in Jacksonville to post photographs, videos to social media, to various social medias?
Yes.
And in those photographs, can you recognize the hand signs that are specific to 6 block and specific to Bully Gang, as you have just described? And I know that some of them have more than one.
Yes.
And looking at that chart, are the photographs that are specifically utilized in this chart, do some of the photographs contain members that are flashing those hand signs?
Yes.
And can you kind of just describe, and I know it's sometimes hard to describe, what are some of the hand signs that are typical for 6 block?
So you want me to demonstrate them?
Yes.
So
Yes, sir.
So this would be the 6 block hand sign, and then this would be the Bully Gang hand sign, and then they'll flash the K for Kendra.
And they will post themselves doing this, is that correct?
That's correct.
And that can be sometimes part of the documentation of the certification, correct?
That's correct.
And you know that because you have specialized training for these specific groups, this gang and its subsets.
That's correct.
And the chart you just showed him, is that marked as an exhibit?
Judge, we're going to argue it later, but I just had them look at it marked for identification.
Okay.
And just for the record, it was a chart that was entitled 6 block members and associates. Is that correct, sir?
Yes.
Now, not only do you assist other gang detectives in your unit, do you also assist other law enforcement agencies if there is any sort of intel or information that is needed regarding your specific gang 6 block?
Yes.
And that would include Tampa Police Department for this investigation. Is that correct?
That's correct.
And along with the hand signs that you are familiar that are unique to 6 block and Bully Gang, are you also familiar with dress style and or any specific jewelry that might be unique to those groups?
Yes,
that gang?
I am. Yes.
And can you describe what sort of dress style or jewelry that may be specifically worn by members of that gang?
So oftentimes when a gang member is murdered or, deceased, they will, print out shirts with their face, or it's like a group picture. Like they'll do shirts, they'll do lanyards, they'll do little wristbands. And then obviously the jewelry and pendants and stuff like that with a picture of them, on them, hanging from the jewelry.
Worn in memory of their deceased member, is that correct, or friend?
That's correct.
And you said the certification for 6 block as a gang, that was done prior to you, is that correct?
That's correct.
And that would be kept in a field incident report, which would document how that gang qualified for the criteria per the statute, is that correct?
That's correct.
And there is a field incident report for 6 block in this particular case, is that correct?
That's correct.
And are there any tattoos that are common to 6 Block that you are aware of?
Yes, there are several tattoos.
And what are those?
There's anything from 8 ball, which is you referencing a deceased member. There's a 3-5, the number 3-5, which is referencing a deceased member. There's the name Bibby. There's a Kendra one. There's quite a few.
And we've talked about the drill rap videos and sometimes the timing of that. Is that why you monitor their social media?
Yes.
What other information do you get off social media? We've also saw photographs with gang signs, but can you tell us why it is so important to be monitoring this on a daily basis?
To monitor it on a daily basis, it assists me with, and I'm sure the other detectives as well, to keep up with the current trends. You know, the new, they might start flashing a new hand sign and we've never seen it. And then we start investigating that. Like, why do they keep doing this or why do they keep doing that? So social media is a tool that we just utilize for, you know, the criminal gangs in Jacksonville.
And we've already talked about the intel that you received when there is a shooting where there is a member of a gang who has been shot, and the timing of viewing social media. Is there, when that is done, do you specifically, does that also kind of tip you off to start looking at social media when an event like that happens?
Yes, as soon as a violent crime happens involving a gang member, most of the time we're monitoring social media.
Even if the homicide occurs at 4 a.m. in the morning, is that correct?
That's correct.
And can the timing and posting of certain pictures be relevant when it is occurring immediately after a shooting, before law enforcement officers have even responded or identified a victim?
I think that's an accurate statement, given that, like, some people might not even know who the victim is, just as you described. Yeah.
But somebody with your training and your experience, you would know where to look, what accounts, and what otherwise might not have significance. Is that correct?
That's correct.
Right. Ron, may I have one moment?
Yes.
Your Honor, we pass the witness.
Okay, Mr. Gonzalez.
Afternoon, Detective.
Good afternoon.
Detective, in talking about your training and experience, just briefly, I know you talked about having done a beginner's course for 16 hours and then the intermediate course for 40 hours, and that would have been in 2022, correct?
The 16-hour course would have been in 2022. There was the intermediate was 23, a year of 23, I believe.
Okay. And when you talked about a certification, correct me if I'm wrong, what you're talking about is a certificate of completion.
That's correct.
Okay, we're not talking about somebody as a result of you having that class certifying you as something.
That's correct.
Okay. And you talked about the evolution of gangs. And I think you told Ms. Doherty that you believe that the evolution of gangs is unique to Duval County.
Yes, I do.
Okay. And that's based on what?
Well, the reason I believe it's unique, you have your traditional gangs throughout this entire country, such as your Bloods, your Crips, your GDs, your Latin Kings, you know, so forth. Here in Duval County, they adopt a lot of the same styles that we have seen, but they're more of like a neighborhood hybrid gangs. Like you're not going to hear of 6 Block in, you know, let's just say California, in my opinion, because it's not a national, it's more of a like strictly like neighborhood specific group in Duval County.
And essentially, I understand they're the Crips and the Bloods, and they, you know, they have their nationwide appeal. But you're aware in Hillsborough County, there are hybrid gangs that are associated with neighborhoods all over the city, right?
You asked if I'm familiar with Hillsborough County
Yeah,
gangs, and I don't know anything about Hillsborough County gangs.
Then how would you tell me it's unique to Duval?
It's unique in a sense that it's different than your traditional gangs, such as your Bloods and your Crips. I don't know how the gang activity works down here.
I understand. So what you're saying is it's not a Bloods, Crips, Latin King situation. It's a hybrid situation, and those are unique to each other.
Yes, usually in those traditional gangs, the national gangs, you have like some type of like hierarchy, structure, order. What we have seen, and again, I don't know, I can't speak for Hillsborough County. What we have seen in Duval County, there is no structure, per se, or hierarchy.
Understood. And what I must have misunderstood you. You don't mean it's unique to Duval. You're just because you don't know how gangs are structured in other communities, in other cities, in other counties, in other states.
Sure. And maybe I didn't explain that well, and I apologize.
No, that's great.
We have the national gangs in Duval County. It's just the ones that we primarily investigate that with all the violent crime is usually stems from these, these neighborhood gangs.
And you talked about in listening to these rap videos and individuals' names being mentioned in them, whether it be their street names, whether it be their real names. There's a large cross-section of the community that would also know these people's names, correct? They don't have to be stated in this video in order for people to know that's their name or that's their street name. Agreed?
I guess it would depend on the audience who's reviewing it.
And it's a large audience that is reviewing it, sometimes millions and millions of people, correct?
I mean, that's fair to say, yeah.
Okay. And all of those people who see those videos being produced over and over again, they're going to get to know those names, and they're going to know those names. People on the street are going to know those names. They're going to tell other people who those names are, correct?
I can't speak for them, but I would assume.
The intelligence that you get is just that. It's intelligence, correct? Meaning, in talking to people on the street, in monitoring social media accounts, you would agree that a large percentage of it turns out to be hearsay in most circumstances. It's somebody saying something about somebody else, or somebody hearing something that somebody else did and telling somebody else, and that person telling you.
I mean, here you're referring to like intelligence from the documentation and stuff, or I'm confused. I'm sorry.
Intelligence in whatever information you get in furtherance of the activities that you do on a daily basis.
No, I would disagree. As far as the documentation and intelligence that we gather and we document, like as Ms. Doherty was saying on the FIRs, that is information that we have verified.
And maybe I misled you. I didn't mean as it relates to the documentation of a particular person as a gang member. I mean the information you gain in general as it relates to gang activity comes more often than not in a hearsay capacity. Somebody that you're not going to be able to write down a name. You don't know when it happened. You don't know who told who about it. It gets to you and you bank it.
I wouldn't say bank it. No, I mean, we oftentimes hear like very crazy, wild, outlandish stuff, on the internet when something happens, but no, like we don't bank it.
And the internet's alive when these things happen. I mean, it's plastered all over social media. It's getting millions of views. You are seeing it on different platforms, different people posting it, different people talking about it. And therefore, what you are looking at is a particular person or a particular group talking about it. You would agree with me?
Whatever the individual or the actual investigation it is that I'm investigating, I'm trying to determine facts and, that can assist and, whatever the lead detective is on that specific investigation and kind of, like cipher through the stuff that's not relevant or that, just some random person on social media saying that they heard this or this.
Okay. And in talking about Bibby Gaynor's death, for example, are you aware that there are members of the gang unit that believe that Bibby's death was a crime of opportunity and not a crime of retaliation and not a crime of revenge? Have you heard that?
I have not heard that. No.
Okay. And when Bibby died, there was a significant volume of music produced about it, whether it be people dissing him or people praising him, correct?
That's correct.
And that went over a large social media space.
Yes.
Not limited to simply ATK and 6 Block. It wasn't the social media coverage, the dissing, the praising, the memorials, the talking about wasn't just limited to these two gangs, allegedly, correct?
I mean, as far as social media of the individuals that were involved, and yes, it was directed back towards ATK,
but not limited to.
No, I mean anyone can have can go on social media and say what they want. I don't know if I'm answering your question correctly.
Okay. I don't have anything further. Thank you.
Okay, Mr. Sonardi.
I do have one more thing. Detective, have you ever been qualified by a judge as a gang expert?
I have never. I've had a state attorney back in Duval County list me as an expert witness, but I've never been qualified or by a judge saying that I'm an expert witness.
Yeah, never testified as such. You've testified a lot in a lot of different cases, a lot of investigation with what you did, with what you learned. But you would agree with me that a judge has never qualified you to a jury to say this person who's talking is an expert in gangs.
That's correct.
Thank you.
We don't do that anymore, Mr. Gonzalez. We used to. Okay. Mr. Sonardi.
Very briefly, Judge, let me here. Good afternoon, Detective. My name is Dick Sonardi. I represent Mr. David Murphy, sitting here to my left. prior to June of 2024? Did you ever have any contact directly with Davion Murphy?
No, I did not.
Was it after the homicide involving Mr. Jones that his name became aware to you?
Yes.
Did you have any involvement whatsoever in attempting to qualify Mr. Davion Murphy as a gang associate or a gang member?
No, I did not.
And as he sits there today, do you in fact know whether or not he is a gang member or gang associate?
I do not know that.
Thank you. I have no further questions.
Okay. Mr. Wise, on behalf of Mr. Gathright and Mr. Chance.
Good afternoon.
As to Sean Gathright, you didn't know him or even know of his name prior to the investigation that we've been discussing here today, correct?
That's correct.
And you've never documented him as a gang member
I have not.
or gang associate?
I have not.
Do you know anything about whether he would qualify as a gang member? Or
I do not.
Okay. Isaiah Chance, you've never had any contact with him either, is that correct?
I have not.
Never documented him as a gang member or associate?
No.
Thank you, sir.
Okay, very good. Redirect.
Yes, just briefly. Detective, you have been listed by the state in cases where you have testified as an expert in gang activity in Jacksonville. Is that correct?
That's correct.
Approximately how many times in Duval County have you been listed as an expert witness?
I couldn't tell you. I don't know. There's been numerous, I would say.
That you know that you were listed?
That I was listed, yes.
And in those cases where you were listed, did you come to court and testify in this area of gang activity?
There were a few times, yes.
And specifically, I think that you were asked about Adrian Gaynor, Bibby, and all of the internet activity that came forward. Is that correct?
That's correct.
Was there an arrest actually made for the death, the murder of Adrian Gaynor, known as Bibby?
There was.
Who was arrested and what was his gang affiliation?
His name was Hakeem Robinson, but by queso, and he was a member of ATK.
And has he recently pled guilty to that murder of killing the person who was a member of 6th Block, Adrian Bibby?
He did.
And he was a member, you said, of ATK?
Yes.
I have nothing further, Judge.
Okay, very good. May this witness be excused?
Yes.
Okay, very good. Thank you. There you go.
Thank you.
All right, who's your final witness for this evening?
Christopher Draybeck, Your Honor.
Okay.
Yes.
Okay, Detective, you remain under oath. From your previous testimony, state you may proceed.
Detective, how are you employed?
Jacksonville Sheriff's Office
And how long have you been with the Jacksonville Sheriff's Office?
since May of 2017.
And again, I guess I didn't get you to state your name for the record. Can you do that for me?
Yes, ma'am. My name is Christopher Draybeck.
And how, you said that you've been with the Jacksonville Sheriff's Office since 2017, is that correct?
Correct.
And what unit are you currently assigned to?
I am assigned to the Gang Investigations Unit
How long have you been with the Gang Investigations Unit at the Jacksonville Sheriff's Office?
since May of 2024.
And what specific gang are you assigned to as a member of that unit?
21st Street, Rack Chasing Family, Yo-Yo Entertainment.
And none of those gangs are involved in this particular case, is that correct?
Correct.
But as a member of the gang unit, you would assist other agencies with any sort of information or intel that was necessary for a Jacksonville gang unit, is that correct?
Yes.
And as a member of that unit, although you're assigned to another gang, you do have familiarity with 6th Block, ATK, and 1200, is that correct?
Yes, ma'am.
And you share information with the detectives that are responsible and assigned to those particular gangs, is that correct?
Yes.
And based on the investigation that occurred in Tampa, were you assigned as a person responsible to assist Tampa Police Department with the investigation, the gang component involving 6th Block, ATK, and 1200?
Yes.
What are your duties as a gang unit detective, your daily duties and responsibilities? What do you do?
I'm required to monitor members, associates, persons of interest relative to the gangs and groups that I'm assigned. I also assist other major case investigative units with intelligence sharing as it pertains to their investigations and as that relates to the gangs and groups that I monitor.
And as part of your duties and responsibilities, do you ever respond to investigations or shootings involving your particular gangs?
Yes.
What about other gangs involved in Jacksonville, specifically ATK, 1200, or 6 Block?
Yes.
Is it how many members are in the gang unit?
I believe there's 12.
And do you work as a unit and assist each other with investigations, even if it may be a gang not particular to your specific assigned gang?
Yes.
What sort of training did you receive in order to be a gang unit detective?
There's no preliminary required training leading up to the assignment of the gang investigations unit. However, the sheriff's office does fund for us to attend conferences, more specifically the FGIA, which stands for the Florida Gang Investigators Association, which is an annual training seminar that puts on basic, intermediate, and expert level training as it relates to gang investigations in the state of Florida.
And which ones did you go to?
I've so far completed the beginner.
And as part of your duties, and you said you monitor daily activities of gang members, how do you do that? How do you go about conducting your monitoring?
Jail calls, jail tablet calls, social media, device downloads, interviews, field investigative reports, and other various investigations.
There were some gang charts that were put together for this specific case, gang charts involving ATK, 1200, and 6 Block. Are you familiar with those?
Yes, ma'am.
Did you and Detective Nieder put those together with assistance of the other gang detectives in your unit?
Yes.
And as part of your duties as a gang detective, do you familiarize yourselves with the various different nicknames that the members of the gangs go by?
Yes.
Are you also monitoring and taking a look at social media of various members of different gang groups?
Yes.
And what about drill rap videos?
Yes.
What is the significance of drill rap videos to the rival gang war between ATK and 1200 versus 6 Block?
Can you ask that again?
Yes. Is there, what role does the drill rap videos play in the gang war between allied groups, ATK and 1200 against 6 Block?
We see it as an opportunity for the gangs and groups and the members that are within them to essentially disrespect the people that they're referencing in their music.
And with regards to the gangs in Jacksonville and general gang knowledge, do these different groups, do they have unique, whether it be tattoos or jewelry or style of dress, do the different various gangs in Jacksonville, do they have different modes of, different modes of dress that may be particular to a specific gang?
Yes.
And is that something that you learn as part of your training and experiencing monitoring these different gangs in Jacksonville?
Yes.
And the same question as to tattoos. Are there tattoos that are specific to a particular group and subset of a gang?
There can be, yes.
And what about hand signs and hand signals?
Yes.
Your Honor, may I have one moment?
Yes.
Your Honor, this time we pass the witness.
Okay, Mr. Gonzalez.
Afternoon, Detective.
Good afternoon.
So quickly, you became a member of the gang squad in 2024, correct?
Yes.
And that would have been approximately a month before the Charles Jones murder.
Yes.
And you didn't have any specific involvement in that particular murder. You have your own things that you handle.
Correct.
And when you talk to us about the drill rap videos, these are rap videos that get millions and millions of views across the country, across the world, correct?
Yes, sir.
And they are songs that are produced, not always, but many times by artists that are signed to record labels that produce music in studios and sell their work commercially, correct?
Yep.
And those videos, I think you described them as being disrespect.
They can be.
For the most part, is a drill rap video, a video where one group or one person disrespects another group or another person.
They can be, yes.
And we have used, strike that. And as I understand it, unless something's happened in the meantime, you have not testified as an expert in any legal proceeding, correct? And let me.
Was that a
rephrase it.
no?
I'm thinking.
Yeah, let me rephrase it. I know you have testified in your cases. I know you have testified in cases that are gang related or that you were part of in some form or respect. What I would like to know is, have you ever testified as an expert?
Aside from this case, no.
Aside from the state listing you as an expert in this case?
Yes.
Thank you.
Thank you. Mr. Sonardi?
Detective Nick Sonardi, I represent Mr. Davion Murphy. You recognize him?
I do.
How do you recognize Mr. Murphy?
I've met him personally.
Was that during an interview?
Yes.
Prior to that interview, had you had any prior contact with Davion Murphy?
No.
And as I understand it, as Mr. Gonzalez has indicated, you actually became a member of the gang unit a month or so prior to the homicide of Mr. Jones, correct?
Correct.
And did you have any involvement whatsoever either with the prosecuting authorities in Jacksonville or the prosecuting authorities in Hillsborough County designating Davion Murphy as an associate of a gang out of Jacksonville?
I have not, no.
Do you have any direct knowledge that Davion Murphy is in fact a member of any gang out of Duval County?
Not independently from the groups I'm assigned, no.
Thank you. I have no further questions.
Thank you, Mr. Sonardi. All right, Mr. Wise, on behalf of Mr. Gafford, Mr. Chance.
Good afternoon.
I think we covered this earlier today, but Sean Gathright, you didn't know him until you began working this investigation in connection with Tampa PD.
Correct.
How about Isaiah Chance? Is it the same situation for him?
No.
Okay. You learned of him from like a search in the internet at some point? Is that right?
Separate investigations pertaining to my other cases.
Okay. Prior to your work on the case we're talking about here?
Yes.
Okay. Well, let me talk about Mr. Gathright first. You ever documented him as a member of a gang
No.
or an associate?
Nope.
Okay. Do you have any information to suggest he's a member of a gang?
Not from any of my investigations, no.
How about Isaiah Chance? Have you ever documented him as a gang
I have not documented him.
or a gang associate?
I have not documented him as a gang associate.
Do you have any information to suggest he's either one?
I would, yes.
What would that be?
It pertains to ongoing investigations that are major case.
So it sounds like something that's unrelated to this case.
It is.
It sounds like something you're not prepared to discuss.
Correct.
Okay. That's all I have.
Laura, can I ask one more question?
Sure.
Detective, what is your understanding, if you have one, about what you'll be testifying to in this trial as an expert?
I would suggest it's predominantly, as it relates to an expert, my groups and gangs aren't involved in this investigation. So in my opinion, I believe the best way to describe it, my role in this investigation was facilitating investigative portions that occurred in Jacksonville and assisting Detective Ramos with various things.
Would it require expert testimony to discuss what you did in assistance to Detective Ramos?
I don't know.
Answer is no.
She's asking.
I know, just cutting to the chase. The answer is no. He's a fact witness. Okay, redirect.
Just right there, Your Honor. Detective, you know, the defense counsel asked you if you personally documented Isaiah Chance as a gang member. Is that correct?
Yes,
That's not part of your responsibility because you are assigned to another gang. Is that correct?
that's true.
And so there may be gang documentation, but that would have been done by somebody else in your unit. Is that correct?
That's true.
And as far as the documentation for Davion Murphy, any documentation that existed prior to you becoming a gang detective, you would not have done that documentation, obviously. Is that correct?
Correct.
And since you are not assigned to that particular gang to 1200, you would not be aware of that documentation. Is that correct?
Correct.
That doesn't mean that that doesn't exist. Is that correct?
Yes, ma'am.
Or that neither one of those are not gang members?
Correct.
I have nothing further, Judge.
Okay, may this witness be excused?
Yes.
Okay, you are free to go.
Thank you.
Okay, that's it for the witnesses today, correct?
Yes, Your Honor.
Okay. All right, so we're going to reconvene Tuesday. I'd like to start at 9 a.m. Okay. Again, I asked you all to meet tomorrow since we don't have court, at least penalty phase counsel, to go over all of the penalty phase motions to see if there's any agreement as to any of them. Also, then when we reconvene on Tuesday, I would like to, I know that we have penalty phase scheduled that day, but I would like to hear argument on the motions to suppress first, just because I've reviewed all the case law and I would prefer to hear those arguments when the case law is fresh in my mind. So I'd like to start off with that. And then the later morning or afternoon will be devoted to penalty phase motions. So, okay. Also, we discussed the Richardson Hayes cases out of Jacksonville. And I did note that those cases were tried together, but before two separate juries. Do either of you know why there were two separate juries? Did they have a Bruton problem?
Judge, I want to go back and look, but I do believe there was reference to statements, and I don't want to make a representation that it was specifically Bruton without further taking a look at it. But
Well,
I did notice there was mention of statements.
Okay, so I did review the cases and it wasn't clear to me why there were two separate juries. So if you all could find out definitively, that would be helpful.
And by the way, Judge, I did misspeak yesterday because I believe I said they were severed. And I didn't mean to say they were severed.
Right.
They were tied with two juries. I did try to look at some of the pleadings, and I'll get with Ms. Doherty. Maybe we can collaborate on that and give the.
Yeah, I'm just curious why there were two separate. Yeah, that'd be good. I just would like to know because the reported opinions are not clear as to why there were, from my reading, as far as why there were two separate juries. Okay, thank you all. We'll
Judge,
see.
I also want to tell the court for the record, Mr. Hernandez apparently will not be available tomorrow, so I suspect he will get with the state on Monday with regard to his penalty-based motions.
Yes, he needs to meet, confer before Tuesday. Okay, very good. Thank you all.
So if I may, there were two days decided, I discussed it with the state.
I was trying to figure out about that.
Second two pay that was identified by Mr. Jacob.
You think they cut it? Because we got, I didn't know if you might have been watching a different hearing because we got a couple of them that we watching. Give me a second. I'm gonna put up the next one, but just so we can kind of understand where we're at right now. So the reason why they present the evidence that they're presenting in regards to suppress the motion in limines, these are the things in the background. This is in order to make sure that the trial goes smoothly, you know, to be able to be able to not have all them sidebars and you know, different things like that to hold up a trial. So they try to hash all this stuff out before trial. And the other big thing in regards to this motion is that they were trying to get the cases severed. The motion for severance for separate trials, the defense was trying to argue that, you know, evidence against one defendant is prejudicial against the others, that the cases should be tried separately. I'm not sure if they should be tried separately because all of this stuff seems like it's all one in one and kind of weaves into the other. You know, the motion to suppress the phone data, that's the centerpiece of the prosecution case. Like, that's why the defense is trying to go against the search warrants, location tracking, how they got that information. And of course they want that stuff to be thrown out because remember, they track these guys' phones all the way up there. They have all the phone data from the text messages and things. And remember, they said that Chance used Alicia's phone to give them all the information. So that's very key. And so they want to get that out. And then we just heard from all the gang experts. The prosecution claims that the redrum was tied to a gang rivalry. The defense is trying to limit all of this information in regards to rap lyrics and all these gang detectives coming up and all the social media posts. Because boy, oh boy, if you talk about self-snitching, baby, they definitely do it in all which ways. You know, we do have the surveillance footage, the footage that shows the movement between all the cars. We have them going and checking into the Airbnb. We have them outside of the club. We even have the redrum on film. Like, if this is not, and I guess because they thought because they was traveling from one place in Florida to the next place in Florida, that they wouldn't be caught. But I mean, guys, like, it's cameras everywhere. Cameras tracked them all the way, the entire route. It's almost like sickening in a way. Like, I don't even know how they thought that they was gonna get away with this in any shape, way, or form or fashion. But regardless of the fact, they definitely tried it, right? It didn't work out so well, but let that be that. So what we're going to do is they did have a hearing on Tuesday as you heard the judge, they were coming back Tuesday, and I'm just trying to get us completely caught up. So we are going to go into Tuesday's hearing so we can see what happened. What did she, and I think that she ruled on a lot of the stuff on Friday. Y'all see me messing around with my camera. I'm just messing around with it. So let's do this. I am going to get us into our next hearing, and we'll see how much we can get through. Like I said, I am planning it on a faster speed, so y'all can let me know if we need to slow it down at any points in times. But I figure that's a good way for us to kind of get through all of this stuff, if possible, today. So, okay, here we go. Let me get that. Let me get it up for us.
Even offered him a Red Bull. He was covered in a blanket from head to toe.
And I'll keep having our chart up here in order for us to be able to reference in our chart. I'll probably make it more expansive if I can, to try to include some different figures as we head into trial next month. But you think it's Tuesday hearing? Well, I hope it is. I definitely hope it is. Because here's Tuesday's hearing. So we'll get that on. Let's get that up and run it for us. And let's see what we have here. I know we're going to have some arguments and some other stuff. So let me see if they got closed captioning.
Defense counsel's present. Are we ready to proceed?
Because before they did not in the last one, just so y'all know, it wasn't me not trying to play it. Sometimes they do closed caption and sometimes they don't. But they have it on this one. So I'm going to definitely get it up for us, okay? All right, guys, let's go in.
Judge, can I address the court just briefly on what's happening today, just so I can clarify it in mind? As I understand it, Judge, we are going to be arguing the motions to suppress.
Correct.
That were, testimony was taken last week.
Correct.
We're going to do all the capital and phase 2 motions.
Yes.
And then the balance of the motions in limine and those related to the gang history, they're going to be done in conjunction with each other on Friday.
That's my tentative plan.
Okay.
Does that work?
Yes, Judge, that would be my preference.
Okay. And all right, very good. So on the motions to suppress, do you all have a preferred lineup? Or you just want me to pick? Anybody? Okay. All right, Mr. Gonzalez, you're closest to the podium. So, all right, let me just take a look here.
Motion to suppress statements, Your Honor?
Sure. We've got the motion to suppress the cell phone and the motion to suppress statements. So why don't we kick off with the motion to suppress statements? And I'm going to give each side 30 minutes total. So, okay.
Judge, as it relates to Defendant Rashad Murphy's motion to suppress statements, we are seeking to suppress statements made incident to an unlawful interrogation that took place on July 30th, 2024. If the court might remember, this began with the silver Chevy Cruze having been found in Gwinnett County. Mr. Murphy was driving the Chevy Cruze. After he fled from the Chevy Cruze, he was tased and taken into custody. And again, this was in Gwinnett County. At that particular time, as the court will remember, the Chevy Cruze was the evidentiary basis at that particular time. There had been no additional evidence that had been determined relating to Rashad Murphy. And after his being detained in that particular case and arrested for a misdemeanor in Gwinnett County, Detective Ramos and Detective Campbell traveled from Tampa to attempt to take a post-Miranda statement from Mr. Murphy. He was given Miranda advisements as testified to by Detective Ramos, And essentially, he testified that there was no evidence at that particular time. They were in possession of no evidence at that particular time linking Mr. Murphy to the homicide. This was simply an alert on the car based on surveillance footage that had been obtained, as well as license plate reader information. During the course of that initial statement on June 26th of 2024, Mr. Murphy clearly and on multiple occasions invoked and requested to have a lawyer, went so far as to say, hey, look, when I get a lawyer later on, I'll reach out to you guys. But at that particular time, Detective Ramos ceased his questioning, and he and Detective Campbell left Jacksonville. It's important to note that during the course of the gathering of this evidence, Detective Drabick had assumed the role in Jacksonville of keeping in contact with Detective Ramos on a regular, I think they almost called it a live basis, updating each other on what was going on and what was happening as evidence was being developed. Detective Drabick also was made aware that Mr. Murphy had invoked in Gwinnett County. So move along to July 30th, which is approximately 30 some odd days later. And at 3 o'clock in the morning, Mr. Murphy was arrested on these charges, which had already been. I also want to note, Judge, that when Detective Ramos went to Gwinnett County, he made it very clear that he was speaking to Mr. Murphy about the homicide in Tampa. It wasn't as a result of the misdemeanor arrest that he had incurred when he was in Gwinnett County. So at 3 o'clock in the morning, and certainly in an interrogation not initiated by Mr. Murphy, Detective Drabick provided Mr. Murphy with acknowledgments or advisements as it relates to Miranda, and obviously at that time was fully aware that Mr. Murphy had previously invoked. And looking at Detective Drabick's deposition on 210, 211, I wanted certain times I want to phrase exactly what Detective Drabick told Mr. Murphy. I asked in the deposition, is there any reason why you attempted to interview him after you already knew he had asked for counsel and invoked? And he said it was because it was a separate incident. And I asked the question, a separate incident or a separate interview? Because you were inquiring about the same thing that Tampa Police was inquiring to, right? And he said a separate interview for sure. The first incident, I do know he was under arrest for charges in Georgia. I wasn't present for that interview. So I can't really say for certain what he had actually invoked to. Well, Detective Ramos made it very clear in his testimony that he had indicated to Detective Drabick that he invoked as it related to questions being asked about the Tampa homicide. Essentially, moving forward, Judge, I note that Detective Drabick's posture at that stage of the game was essentially to tell him, and this is our quotes from the interview itself, that, listen, before I can speak to you about obviously whatever conversations we have, I just have to read you this first. If you have any questions at all about it, just let me know and I'll be happy to explain it. But directly after making that statement and the defendant saying, yes, sir, he doesn't, Detective Drabick that is, indicate or ask Mr. Murphy whether he is willing to waive those rights and speak to him. He goes directly into, okay, print your name here, print your first and last name, sign your name on the line, and then once you do that, I'm going to write my information. At that stage of the game, Mr. Murphy says, I'm shaking, I'm cold as hell, and Drabick says, well, it's 3 o'clock in the morning, I get it. Detective Drabick then, during the course of the interview, as set forth with particularity on page 6 of my motion, says he raises the Tampa detective's absence from this interrogation and states, and the defendant clearly states that I don't want to talk to them. I don't want to speak with those Tampa detectives. And there's a dialogue between he and Detective Drabick about why. And Mr. Murphy is clear about that. And that is found at page 13 and through 15 of Detective Drabick's deposition. Detective Drabick then distances himself even further from the investigation and emphasizes that, listen, Jacksonville's got a limited role here, stating that, we just were asked to step in. We didn't do any investigation in this case. I used to, work homicides, but I don't do that anymore. And I probably wouldn't even be able to call you out on anything because I don't really know anything about this case. And that also is set forth on page 17 of Mr. Murphy's interview. Mr. Murphy goes on then to deny any involvement in being in Tampa, and Detective Drabick starts to take another tact by suggesting he's the mastermind of this and describing what other people are saying about him. and going on to say this is going to be the most important conversation of your life, and that others in these kinds of rooms with their life on the line, who knows what they're going to say. And again, that portion of the interview is set forth on pages 63 and 64 as set forth word for word in the motion. Then Drabick goes on to talk about the strength of this Tampa investigation in detail, talking about it being a fucking full meal deal, and that this is Tampa's investigation, not Jacksonville's. I'm not bluffing you because you've never seen an investigation and an interview being done in Tampa. I mean, you've never seen one of those. You've never been a party to one of those interviews. That Tampa has this thing and has done things that I don't even know existed with investigations. They're big wigs, and that, you know, it's like in the fucking movie. So he goes on to, again, distance himself from the Tampa detectives, distance himself from the interview. Mr. Murphy at that time thereafter admits that he was in Tampa, but arrived after the shooting and essentially states that he has no involvement in the shooting itself. Judge, suppression is required under the totality of the circumstances based on four, independent but interrelated reasons. Number one, law enforcement's minimization of the significance of Miranda, diluting what Miranda provides to a defendant when it's being administered. Number two, when officers fail to secure an express and affirmative waiver. Number three, when law enforcement employs a coordinated, like a multi-agency type of strategy that leverages.
So I'm just pausing right here because I want to make sure that you guys are catching this, guys. So the thing is that when I'm listening to the argument, he was read his Miranda rights when they first arrested him in Georgia, right? He invoked that he wanted to get an attorney. The big thing is they let him go. They rearrested Mr. Murphy. They brought him in. They did not read him his Miranda rights. So I'm gonna put out a poll because I'm curious to know what you guys think. Like, I mean, his Miranda rights were not read the second time. So just because they were read the first time, if there's a break in between this, you should be rereading these Miranda rights so he can have the opportunity to decide if he wants to get an attorney or not. So as I'm listening to this more and more, I'm finding out more information in regards to why the defense. Yeah, and it doesn't matter unless you're arrested, but the problem is that they were interrogating him. So, the rights include the right to remain silent, the right to attorney, anything said can be used against them, right? So if they said it to him the first time, he talked a little and then he was like, I want an attorney. They let him go because it wasn't on the same thing that he was rearrested for. Shouldn't that process start all over again? I don't know. I don't know if his interview gets put in. Let's finish listening to the argument. But I just wanted y'all to kind of listen to key things as we're going through this, because although we are courtroom law courtroom people, I mean, I do want to understand the process and understand why certain evidence is admitted and why it's not. So just thinking on those levels, because I'm like, well, yeah, that's a break in service. It's not a blanket saying, oh, my Miranda rights go down a list of things and I always want an attorney, but you are responsible to reading it to me every time you want to interrogate me, if it's on the same issue or another issue. Yeah, and they don't have to be read if you're not interrogating that person or arresting. But he's obviously in a room, interrogation room. He is obviously probably there up under his will. He's probably not able to go, guys. Remember, he's the one that they was arresting. They had the whole SWAT and he had the little doggy running away. So, I mean, like, you ain't going nowhere far. But let's see. Just some things to think about as we're going through this. And I'll put a survey in here just to see what you guys think, regardless of what they do. But do we feel like Miranda rights need to be read whenever you're about to be interrogating, even if it's an interrogation, even if there's a break in regard? Because it seemed like this was just really a break in regards to interrogation. in my opinion, because it seemed like they really wanted to interrogate him on this stuff the first time, but they just didn't have enough, and they let him go. But let's see.
The defendant and plays upon his mistrust of the agency doing the investigation, and finally, independently dispositive, but certainly I'm discussing these issues in an interrelated fashion, is that when the defendant previously unequivocally invoked his right to remain silent before substantive questioning happened on July 30th, that needs to be honored. And in this particular case, in addition to it not being honored, it actually was leveraged in order to get Mr. Murphy to talk. Judge Edwards versus Arizona, United States Supreme Court case talks about the two-part test to determine the admissibility of post-invocation statements. And those two-part test is first that the defendant must reinitiate with the police, which did not occur in this particular circumstance. And second, there must be a valid waiver of Miranda rights already invoked. And certainly that waiver can only be found if the individual is the one responsible for reinitiating, which is not the case in this circumstances. There's no question that Mr. Murphy previously invoked. There's no question that Detective Dreyfus was aware of that, and that Detective Ramos had indicated that happened. Understanding, Judge, and I can't say I'm oblivious to the fact that the Supreme Court has also talked about whether and when there's a sufficient break in custody that could permit a reapproach of the defendant if he has the opportunity to shake off the coercive effects of either a prior interrogation or the fact that there was an invocation. Here, there was about a 30-day period in the interim. Regardless of whether or not case law permits that renewed contact, the state still bears a really heavy burden to prove by the preponderance that the defendant's waiver was made voluntarily, it was made knowingly, and it was made intelligently. And I cite Hall at 248 Southern 3rd, 1227, which is a first district case, 2018. In this particular case, what occurs is that the interrogation shouldn't be considered as separate interrogations. They don't exist in a vacuum, especially in these circumstances. When we talk about what voluntariness there was in the waiver on the July 30th incident with Detective Dreybeck, it's my belief, and I think that the evidence would support, that Detective Dreybeck employed a coordinated multi-agency effort to distance himself and create a misconception in Mr. Murphy's mind that speaking with these Jacksonville officers was distinct and was distant from any cooperation or anything related to the Hillsborough County homicide, undermining his ability to make a free and deliberate choice. In this instant, Judge, there's a number of areas that I think need independent scrutiny. Number one, Miranda was minimized and phrased as a formality. As you look at the manner in which the transcript of the interview would suggest, Dreybeck didn't introduce Miranda as a constitutional decision type point. He minimized the entire process and essentially said, look, whatever conversations we may have, I just got to read this to you first. And once he did read the advisements, and I'm not suggesting he didn't read Miranda, he did read Miranda, but essentially he says, look, I'm going to make this short and sweet. As soon as the Miranda advisements were made, he quickly says, hey, look, you understand that? Yeah, here, sign this paper, put your first name, put your last name. Never asked whether or not Mr. Murphy wanted to exercise those rights, whether he was in a position to fully understand those rights, and then instructed him pretty much to sign his name and let's move on. He did as he was instructed. And at that particular time, Dreybeck also noted that Mr. Murphy appeared to be fatigued, even offered him a Red Bull. He was covered in a blanket from head to toe, including his face and his head. And you can see that in the video portion of the interview, which has been admitted into evidence, and asked him whether he was doing okay. And at that particular time, continued the interview process. And I believe that under Ross versus State at 45 Southern 3rd, Florida Supreme Court case in 2010, the court concluded that detectives improperly minimized and downplayed the significance of Miranda in almost an identical circumstance. In Ross, the defendant introduced the advisement by saying, there's a couple things I need to go over with you real quick. There's a couple things I discovered, and before we go any further, I want to cover this with you. It's just a matter of procedure based on everything we're talking about. The court held that language conveyed the impression that the warnings were clearly bureaucratic and a formality. And significantly, even though the detective in Ross requested an affirmative waiver of that right from the defendant, the court in Ross said that's still insufficient. We didn't even get that in this particular circumstance, which Ross got, and the court still ruled that in fact Miranda was undermined.
Well, the Ross case was pretty egregious, right? As far as
Yes,
the
ma'am.
conduct of law enforcement. I mean, in that case specifically, that the detective admitted that they violated their own policy at the direction of the sheriff.
And I agree, Judge, but I don't think it makes it more egregious, because I think regardless of the underlying reason why law enforcement did it, the pronouncements and the interaction between the defendant and law enforcement were the same, or in fact worse here than in Ross. I think clearly Ross confirms that where law enforcement conveys that Miranda's a routine procedural step rather than a substantial safeguard, that any ensuing waiver is constitutionally infirm and should in fact result in suppression. I did cite for the court, because I do acknowledge it, the Thomas case, which is at 351 Southern 3rd, 197, where in that case the court rejected a Miranda minimization claim. But the court there emphasized that the detective repeatedly referred to Miranda as a constitutional right. And he expressly informed Thomas that he was signing a form, meaning that means you're choosing to speak with law enforcement and ensure that he understood the gravity of those rights, and he was waiving them in exchange for conversation with the detective. The court also relied on the absence of any deception, any distancing between two agencies, any suggestion that Jacksonville's different from Tampa and we're not the same, and it's not really our investigation. We don't have much to do with this. And in this particular case, those circumstances that are set forth in Thomas are different. Drabik didn't describe Miranda as a safeguard. He didn't explain that signing the form constituted a choice to speak. And instead, what he did was he treated it simply as just a bing, bang, boom, let's get by this and move on. Secondly, Judge, and next, it's my belief that law enforcement, again, as I testified, or excuse me, argued earlier, he used this multi-agency interrogation strategy that exploited the trust that, or lack thereof, that Mr. Murphy had with Tampa, and attempted to utilize it in an attempt to gain trust without constitutional safeguards as it relates to Jacksonville. Before the substantive questioning and after getting the signature on the waiver, he starts, that's Drabik, deliberately distancing himself from the homicide detectives and telling Mr. Murphy that they're the decision makers here. You know, they're the ones, and it's their process and their case, and essentially pressing the defendant to cooperate after he initially denied being in Tampa. So I would suggest to the court that because the defendant had unequivocally expressed that he didn't want to talk to the Tampa agents as it relates to this homicide, that's critical in the court's assessment as to the voluntariness of his statements.
But doesn't it cut both ways for your client? If he is understanding enough of his Miranda rights to waive them the first go around, then doesn't that mean in the second go around that I can conclude that he understood what Miranda meant and what his rights were?
Under different circumstances. When Detective Ramos read advisements, he just didn't say, here you go, sign this. He told him, this is your constitutional right. Are you going to waive it? Are you going to waive it in order to continue to speak to me? Verbatim. Right? It wasn't simply bing, bang, boom, here you go, sign it, let's go. Whatever we're going to talk about, we're going to just start now. That is the distinct difference between the way Detective Ramos handled the advisements and the way Detective Drabik, with purpose, in my estimation, handled his portion of the interview. So no, I don't believe it cuts both ways, because I think it was done drastically differently. And not only, there was no underlying method of distancing that Detective Ramos used. He certainly wasn't talking about Jacksonville. He certainly wasn't talking about Gwinnett. It was very clear to him what was going on, and it was done, in my estimation, the right way. Without getting further into this
Just so you know, you're at 21 minutes.
That's
so
fine,
if you want any rebuttal time, then I'm just going to advise you.
That's fine, Judge. Your at the onset of the July 30th interrogation, when he told Drabik that he didn't want to talk to the detectives in Tampa, rather than honoring and clarifying the legal significance of continuing to speak, essentially what Drabik did was he exploited kind of this perceived division between Tampa and Jacksonville and distorted the defendant's understanding of the risks and the consequences of continuing to speak. And I believe if the court reviews the interview on pages 13 and 14, you'll see this dialogue clearly play out, and it is set forth with particularity in the motion. And I'll say again, Judge, because I think it's important. Drabick warned during the course of the interview, this is Tampa's investigation, not Jacksonville. I'm not bluffing you because you've never seen a Tampa interview, and there's a reason for that. He then emphasized the superior resources that Tampa has, that they are big wigs, they're like in the movies, and essentially to suggest that the cooperation through Jacksonville offered some safer or more advantageous alternative to Mr. Murphy at that time. And I believe that those coercive tactics parallel those types of circumstances that are condemned in the second district case of Bussey, which is at 184 Southern 3rd, 1138, 2015 second DCA case. In Bussey's, the officers repeatedly minimized the seriousness of the defendant's conduct, contrasting the outcomes to suggest that cooperation would avert harsher consequences and foster the belief that you could be saved from the worst case scenario, and that is being interviewed by Tampa or going with the bigwigs or the movie guys or the guys that you don't even understand how investigations go over there. Law enforcement distorted the defendant's understanding of the risk in order to overcome any resistance and secure a statement, which in this particular case is more important than Bussey because there had been a previous invocation, and Detective Drabick was aware of that. And again, suggesting that talking to Jacksonville was safer and more advantageous than dealing with the big Tampa machine, for lack of a better word. Judge, there's no dispute that Detective Drabick failed to honor the invocation because the substantive questioning commenced without interruption. We went straight full blast, 100 miles an hour from an advisement without the proper after statements by Detective Drabick that would ensure that Mr. Murphy fully understood and voluntarily and with knowledge waived his Miranda rights. Detective Drabick exploited it. He leveraged that refusal, and essentially he fostered trust in a subversive manner. I'm sure the state's going to suggest, and certainly the court has heard in the past, well, the government or police officers, detective can use lies. They can use methods in order to seek a statement. But in this particular case, it rises to the level of egregiousness based on the prior indication, based on the differences and the way that Mr. Murphy perceived the advisements and the statements given to him by Detective Ramos versus the type of atmosphere that Detective Drabick fostered, knowing that there was a prior indication. Under the totality of the circumstances, Judge, I don't believe the state can meet its burden to prove a voluntary, knowing, and intelligent waiver as it relates to the July 30th statement. Again, and in finality, Miranda was minimized, and it was framed as merely procedural. Number two, Detective Drabick failed to secure an affirmative waiver of those rights, which I believe incumbent on him to do, as Detective Ramos did during his interaction with Mr. Murphy. Third, that he exploited this artificial Jacksonville-Tampa divide in order to specifically distort Mr. Murphy's understanding of the consequences of speaking to him. And finally, he ignored and then leveraged a prior invocation to remain silent. And because those resulting statements were not freely and voluntarily given, we would suggest to the court that the July 30th statements must be suppressed.
Okay, thank you very much, Mr. Gonzalez. And state, did you provide me any case law ahead of time?
I did, Judge.
No, you did. I'm talking to the state.
Judge, we did not. We're relying on the same case law that Mr. Gonzalez relied on. We do not dispute that on June 26th of 2024, that first interview, that occurred in Georgia, that Detective Ramos was there specifically to question him about the homicide, but it's also undisputable that he was not arrested for the homicide in Tampa, that he did invoke for his right to request an attorney, and that was honored. That interview was immediately terminated. You heard the audio recording.
I'm sorry, I'm going to interrupt for 1 second. Mr. Sonardi, you have a very deep voice, and I can hear you talking to Mr. Hernandez. So I don't know if it's okay. I don't know if you're capable of whispering, but if you are, please. Okay. All right. Very good. All right. Continue.
Yes, Your Honor. It is also undisputable that that right was honored by Detective Ramos, that he terminated that interview. And what is also undisputed and what is fact is that he was arrested on Georgia-related charges and he was let go. So he was released, and that occurred in June 26th of 2024, and there was a break of over a month. And so I know that Mr. Gonzalez mentioned U.S. v. Edwards. That is a exception when a person has invoked his right to an attorney that is carved out by the U.S. Supreme Court. The other exception that is also carved out, which is applicable in this case, is Maryland v. Schatzer. And it is very clear in Maryland v. Schatzer, who a defendant who was in custody and was imprisoned was questioned, invoked his right to counsel, and the detectives in their investigation left the prison, and there was a break of 14 days. And after 14 days, those detectives reinitiated contact with the defendant. And the court, the U.S. Supreme Court and Maryland v. Schatzer found that that was a significant break, that 14-day, that 2-week period, that the defendant at that point could shake off the coercive nature of being imprisoned, could acclimate. That is a valid exception to when law enforcement can reinitiate contact. And that is what we have here, Judge. But we have a less coercive situation than Maryland v. Schatzer, where the defendant was serving a prison sentence. In this particular case, the defendant was arrested on Georgia charges. He then was released, and a month went by, over 4 weeks, not the 2-week period that was acceptable in Maryland v. Schatzer, but 4 weeks went by before law enforcement arrested him and developed probable cause to arrest him in this homicide related to Tampa. So that is what is significant, and that is what the law requires when somebody who has invoked their right to an attorney. So we have that break. And when we're talking about the totality of circumstances and that proving the defendant knowingly and voluntarily waived his rights to Miranda, certainly the first reading of Miranda that happened within a 2-month period, which was recorded on audio recording, that where his rights were fully read to him, we all heard it, and he acknowledged and he understood those rights, and so much so that he understood them that he actually exercised those rights by invoking an attorney. We have no reason to believe within a 2-month period that all of a sudden he no longer understands his constitutional Miranda rights. He definitely exercised them on June 26th of 2004. And so when we're looking at the Miranda on July 30th of 2024 with Detective Drabeck and looking at those totality of circumstances, all of the factors for the court to consider, Detective Drabeck, again, we have not just an audio version, we have an audio and recorded version. So they recorded their interaction with the defendant. There is a written form that was used, and clearly the detective, again, read all of the Miranda rights to the defendant. He made the defendant read the first sentence of the form to make sure the defendant could understand what he was reading. And then the defendant, again, acknowledged and signed off on his Miranda rights and continued to talk to the detective. There was no deception to the defendant trying to say that this wasn't related to the Tampa case. That was made clear to him that they were there to interview him for those specific purpose was to talk to him about the Tampa homicide. He never invoked his right to remain silent. He never asked for an attorney. He made one statement about not wanting to talk to Tampa detectives, and he clarified to the detectives why that was. It wasn't because he didn't want to talk about the Tampa case. He said because they don't know me. So there is nothing improper about Detective Drabeck trying to build a rapport and using strategic tactics to get the defendant to talk to him. So certainly if he wanted to play up that whatever and distinguish himself from Tampa, he still made it clear and was honest about what he was there to talk to the defendant about. And the defendant at that point never exercised his rights and never invoked his right to remain silent. That was a willing, knowingly, and voluntary waiver of Miranda that is recorded for all of us to hear. And it is definitely distinguishable against Ross, where they were looking at bad faith and bad actions by law enforcement. You do not have that here. That is a far distinction. You can't just qualify Detective Drabeck's interaction with the defendant and try to put it in a bad way. There was no promises that were made. There was nothing coercive about that interview that is on video. You could see there the manner in which it was taken. It was professional, and he was told. They were the ones that provided him with the blanket. So when you're looking at the totality of circumstances and what the law requires, there is nothing that is that needs to be suppressed in this particular case. There was enough of a break that occurred. He was no longer under the coercive nature of being in custody. He had been released from the Georgia authorities, and he had never been arrested for this Tampa homicide. 30 days had passed. That was sufficient of a break. And according to Marilyn B. Schatzer, that was sufficient for law enforcement to be able to reinitiate contact with the defendant and reread him his Miranda rights. And so we would ask that you deny the defendant's motion to suppress the statements and the recorded interview that he provided to Detective Drabick on July 30th of 2024.
Okay.
Judge, I would only add that, as the court knows, the video interview is in evidence, and I would urge the court to review it in order to make determinations that would be consistent with my argument.
Okay, very good. I'm going to take
no objection to that, Judge.
I'll take it under advisement. Okay, I'm going to do a written order on this one. Okay. All right. So, Mr. Gonzalez, you want to move on to your motion, Defendant Rashad Murphy's motion to suppress cell phone?
Judge, I am moving to suppress all evidence seized from the defendant's cell phone incident to an unlawful search warrant. Very quickly, court's aware, Gwinnett County, the LPR readers locate the silver Chevy Cruze, which is the subject, the vehicle is the subject of an alert put out by Detective Ramos based on surveillance video that was developed from various areas and specifically the scene of this particular crime. When Mr. Murphy is taken into custody, again, the court's aware that the cell phone was located in the vehicle, and it was open to show GPS directions back to the hotel. It was determined what the phone number was of that cell phone, and also that it was registered to Charmaine Steiger, who is Mr. Murphy's girlfriend, but that it was clear and unequivocal that both individuals utilized that phone. Detective Ramos authored an affidavit for a search warrant for that phone because he was aware of the evidence that had come to light at that particular time in the investigation, which was early on, within days. And certainly I have listed, or I have made that cell phone affidavit, Exhibit A, in the motion, and I would urge the court to read its probable cause. What happened in conjunction with that is that Detective Carter, who took upon herself the lead investigator in Gwinnett County based on the arrest, the subsequent statement of Ms. Steiger, and also all things forensics that occur in Gwinnett County, she included at the back end of that affidavit her additional statements or evidence as it relates to probable cause for that search warrant. And she and Detective Ramos are co-affiants to that search warrant. Judge, I have set forth in page 3 of my motion a synopsis of all of the evidence that provided alleged probable cause for this warrant. I would note to the court in subsection J, essentially the only thing that has any relationship, direct or indirect, well, certainly not direct, but indirect, is that Tampa police had initially contacted Jacksonville because of the vehicle being a Duval County plate. And at that particular time, I'm not even sure Detective Ramos, pursuant to his testimony, even had an registered owner, certainly had not contacted a registered owner, had no idea that Mr. Murphy had anything to do with that vehicle other than he was the driver of it in Gwinnett County when it was stopped. And essentially, that general information was that there was intelligence. And this, again, Judge, runs kind of dovetail into a lot of what we're talking about over the past week and now, where the Jacksonville detectives tell Ramos, hey, listen, we got intelligence which says that 2 out of the 3 shooters might be Isaiah Chance and Rashad Murphy. There are no witnesses to confirm this. There is no direct evidence of it. There is no forensics to support it. There are no videos to support it. There is no fingerprints to support it. There is no eyewitness or other direct witness testimony to support it whatsoever. It is a rogue statement by Jacksonville based on hearsay. And I think that's unequivocal. And I don't think anybody, inclusive of when Detective Ramos testified and then discussing it with Detective Drabick, ever suggested it was anything more than rank hearsay. So At this point in time, the only thing that is determined by that statement as probable cause in this affidavit is that Mr. Murphy might be a person of interest. So moving on, what ends up happening is Detective Carter, in her deposition on page 14, states that she had no idea who Rashad Murphy was. She wasn't provided any information with regard to Rashad Murphy. She wasn't told that Mr. Murphy had any connection or had any potential part in this particular murder. She thought, and she was told, it was the vehicle. It's the vehicle at issue here. So that is the premise under which Gwinnett County detectives are operating under, and it's the premise under which she's operating when she executes that probable cause affidavit for the cell phone search warrant. Detective Ramos, in turn, both in testimony last week and in his January 15th deposition on page 14, said, my original probable cause was for the car. So if the phone's in the car, then the phone becomes an extension of the car. Well, we all know that is not what the law is. That phone is not an extension of the car. And the only thing that Detective Ramos is operating under at that particular time is that there's an alert for this car and it's now in custody. And he goes on to testify in page 14 and 15 of his deposition that where Rashad Murphy was, that's where the phone was. It's a totality. So all of that information gets included. So again, that is what in his mind premised the probable cause for this affidavit. He goes on to testify on January 15th, and again last week, that he had not identified Rashad Murphy, that all he knew was based on Jacksonville intelligence, nothing more than that, the intelligence coming from Jacksonville. And then my question was, which was, we believe that for one reason or another, Rashad Murphy was involved? Answer, correct. And that's really as general as it got. There were no other additional information with any specificity about how, why, and what. His response, correct. So although Ramos identified the owner of the Cruze, he admitted that he had done no further investigation on that Cruze, Chevy Cruze whatsoever, and certainly could not connect it to Rashad Murphy as it relates to a crime, as it relates to a murder. Simply that days after the murder, he was in contact with it or he was the driver of it. Without having any context as to why that would even be the case, later to learn, obviously, it was a relative's vehicle, but certainly not being privy to that information at the time of the search warrant, at the time of the affidavit. So, Judge, in discussing those underlying facts, cellular phones are recognized as having very, very unique characteristics because of both the breadth and the depth of personal information that they have in them. And certainly that's buttressed by a number of federal court cases and Supreme Court cases, essentially saying that a cell phone collects in one place very distinct types of information that reveal much more in combination than any other isolated record. So to that extent, there is significant scrutiny when it comes to cell phones and what they contain. When determining the legality of a warrant, of course, the court's well aware that you look at the four corners of that affidavit. And I will not get into the four corners of the affidavit. They are set forth in the case law and in the motion with specificity. But I will say that certainly mere speculation as to whether or not there may be some evidence of criminal activity that might be found is wholly insufficient to support the issuance of a warrant. Additionally, Judge, even if that warrant on its face appears to have probable cause, I would suggest to the court that the case law is clear that the omission of material facts obviously render that warrant unlawful. And we'll talk about that. In this particular case, Judge, and with particularity as it relates to this particular case, the warrant lacked probable cause because the affidavit failed to establish that Mr. Murphy committed a crime, and it failed to establish a nexus between that cell phone and the evidence of any criminality. There is no nexus sufficient to authorize a search warrant in this case with regard to that cell phone based on the totality of circumstances. In particular with the cell phone, in order to search a digital device, it requires more than the possibility that that phone might have evidence of a crime. And when you talk about those things, as I set forth in the motion, you talk about the dichotomy between two particular cases that I would reference, Jefferson versus State, which is a second district case, a sixth district case, and also Torres-Carmona, which is a second district case. In Torres-Carmona, the second district upheld a warrant that was supported by a detailed multi-agency investigation establishing an evidentiary chain linking the defendant, linking his co-defendant, linking the victim, and linking the use of the cellular devices prior to and during the commission of the crime. None of that exists in this particular case. No mobile phones were located on Mr. Murphy's person. His phone does not travel to Tampa. Those are just a few of the things that certainly would not give rise to the same factual scenario in Torres Carmona. In that particular case, the victim's girlfriend told investigators that she provided those phone numbers. Detectives received cell tower information and call detail information on that phone. And critically, in Torres Carmona, the investigation demonstrated a coordinated pattern of travel for that phone. In short, essentially, the phone and the evidence of that phone was not speculative. When you contrast that with Jefferson, the court held there that officers lacked probable cause to search a defendant's phone, where they assumed that the defendant's phone would contain incriminating communications, but they didn't, importantly, establish a factual link between the device and the crime, which is a critical distinction in this particular case. The defendant in Jefferson, it was a first-degree murder case of the death of a female acquaintance, and although they could place the defendant near the victim, which can't be done here, they can connect him to the crime scene through physical evidence, which is not the case here. The affidavit relied on conjecture that communications likely existed on the defendant's phone. And the court noted that the facts which were known to the officers when they seized it is that there was a blood trail from the victim's body to the defendant's apartment. And this is where the court found a lack of probable cause.
You talking about the Jefferson case?
Jefferson case, Judge, at 363 Southern 2nd.
But there was not a warrant, excuse me. Yeah, there was not a warrant in that case, right?
No, Judge. The defendant was previously acquainted with the victim, and that 2 days before her body was located, they were seen together, and that the defendant had been less than forthcoming in prior interviews. So all of those things considered, the court still found that regardless of that circumstantial evidence, law enforcement did not establish probable cause to search the defendant's phone. It's not buttressed with anything of specificity that Mr. Murphy might be a person of interest. That is it. That is what is utilized in the entirety. If you look at the entirety of this 4 or 5 page probable cause affidavit, none of it would be something that a magistrate should be would find compelling to provide probable cause for this warrant. And the only time that Mr. Murphy is mentioned in that affidavit is when we talk about the fact that Jacksonville said, "Hey, look, he might be one of our guys." Mere association with that vehicle that was subject to involvement, without evidence linking the defendant to that vehicle during the course and scope of the crime, cannot support the issuance of this warrant, Judge. Third, the affidavit fails to establish a nexus between the cell phones and any evidence of criminality. And we discussed that, but I go into it in more sufficient detail in the motion on page 10 and 11. And I would point out to the court again that Detective Ramos is under the impression that simply because the phone was found in the vehicle, that makes the phone an extension of the vehicle. And the vehicle was the subject of the evidentiary inquiry, not the phone. None of which having direct relationship to Mr. Murphy and the crime. Not Mr. Murphy at the time the phone was found, Mr. Murphy and the crime, which is required under the law in order to seek and get this warrant. Judge, as it relates to omissions, I think the fact that the affidavit contained omissions would, had they been included, defeated probable cause is also an issue in this case. Detective Ramos admitted and testified that there was no evidence linking the defendant to the homicide. The affidavit, in a sense, misrepresented the intelligence that was received from Jacksonville. And if you look at the way that it's postured in the affidavit, compared to under oath, what Detective Ramos says, Detective Ramos had in-depth knowledge of the victim, the gang he affiliated with, and the gang rivalry he is feuding with, and Detective Drabick identified the defendant as a suspect. That is the premise by which Detective Drabick suggests that there should be some nexus or some linkage to this phone. And specifically in Detective Ramos's deposition, I again asked, had you at this time identified Murphy? I knew the name based on the intelligence, but I had nothing more than that, intel from Jacksonville. Question, which was, we believe for one reason or another that Rashad Murphy was involved? Correct. And that really is as general as it got. Correct. I highlighted that before, and I'm going to highlight it again because that is what Detective Ramos is operating under in truth, but that is not, in fact, the way that the affidavit is suggested when it's written. Despite admissions in sworn testimony by both Detective Carter in her deposition as set forth in the motion and Detective Ramos both in testimony before the court and in his deposition, that they had no evidentiary basis to connect Mr. Murphy with the homicide or even to place him in Tampa at that time, that fact is omitted from the affidavit. The affidavit also suggests that the homicide was motivated by ongoing gang activity, and it doesn't contain anything that would suggest at the time that the affidavit was written, the defendant was not a documented gang member when the warrant was issued. The defendant was never identified as a suspect in any ongoing gang investigations referenced in the affidavit, and the defendant and law enforcement had no evidence connecting defendant to any gang rivalry. What we had was that general statement given by Detective Draven, none of which was suggested to the magistrate in terms of specificity. Because if they had provided specificity, it would have indicated to the magistrate that there was no nexus that could be developed at that time, at the time in which the warrant was sought. Disclosure that they possessed no evidence linking Mr. Murphy to the homicide, and they believed that the probable cause was only extended to the cell phone from the vehicle itself, I believe would have defeated the application. Judge, at the end of the day, we always talk about good faith exceptions, and certainly when officers omit material facts or when they have no reasonable ground for believing that the warrant was properly issued, the good faith exception does not apply, and it doesn't apply here. At the end of the day, Judge, the affidavit does not link Rashad Murphy to the commission of any crime, does not establish a nexus between the cell phone and any evidence of criminality at all. And moreover, because there are omissions, as I've discussed, and have with more particularity citing deposition transcripts in the motion itself, those omissions could have altered a magistrate's finding of probable cause. And in that light, Judge, the evidence should be suppressed.
Okay, thank you. Story.
Yes, Your Honor. Judge, it's a
So before she comes up and gives her information, just some quick points in regards to what the defense is trying to say here. The defense attorneys, in regards to this, is in regards to the phone, the way it was seized, and what information they had at the time in order to actually get a search warrant for the phone. The motion is essentially asking the judge to throw all the phone evidence out, get rid of that stuff. That would include, all the text messages, the call logs, the location log, like get rid of it. It was no reason. They didn't have a reason to take the phone. The girlfriend, she was up under some different pretenses. But that's what they're trying to get out. And that's critical, right? Because if they can get some of this stuff out, then it doesn't point to a certain person that they were definitively there. And then they can make assumptions. Goddess, I will put his link in the chat, and I'll also put it in the description box for anybody who wants to check it out. If you want to go down a rabbit hole, I'm gonna send you down it, okay? Now, when you go down this rabbit hole and you get down there, don't be trying to come up for air. Let me know everything you got once you get finished. But I'm gonna send you down it, and if you don't even have to look up all of that. I'm gonna put you right in the place where the library at, and you probably gonna absolutely love it. Let me know if you ever check it out. Even if you're not chatting with us that day, just pop in the chat and let me know if you check it out. I'm gonna put his link in our description box. But yeah, that's why they're trying to get that information out of here, for that reason, to be able to, discredit this phone stuff. Phones mean a lot. They mean as much as somebody being there. And then in the same token, I wasn't there, but my phone was there, or it's my girlfriend's phone. We both share a phone. Like, she didn't give authorization for her to get the phone. Like, so it's gonna be all types of different things in regards to the warrant for this. But let's go in. Let's see what the prosecution team has to say in regards to the argument in regards to Mr. Murphy's phone.
State's position that law enforcement relied upon a properly executed search warrant. And what we want to make clear and make a proper distinction is there is a distinction between probable cause to arrest a defendant and probable cause to search a item of evidence that probable cause has been developed to search. I know that Mr. Gonzalez said that there was no evidence that defendant Murphy had committed the crime at that time. Judge, what is laid out in the search warrant is that a homicide had occurred in Tampa that involved 3 shooters, and all of the facts of the homicide have been laid out. So the crime that we are talking about is homicide, and there is PC that suggests that 3 shooters committed this homicide. There is nothing that requires or limits the state or law enforcement to only search items of evidence that belong to the suspects. We have to provide probable cause to search an item that may have evidence of the homicide. And so what is laid out in the search warrant, and we know that we are stuck by the 4 corners of this affidavit, and the reason that we provided testimony from Detective Ramos is to establish that there was no deception in the search warrant and there was no material omission. And we relied upon a properly exercised search warrant that was executed up in Duval County in Jacksonville. And there, when we talk about the probable cause for that phone, there was an executed search warrant for the car, and nobody searched that cell phone once it was located in the car. Nobody opened up that cell phone or searched it until there was a properly executed search warrant for that specific phone. And so when you're talking about the probable cause that is laid out by both the detectives who needed a co-affiant because this was done in a jurisdiction outside of Tampa, the detective is clearly laying out the probable cause to believe why there is evidence of the homicide in that phone. It includes all of the facts in Tampa that led to the crime and the murder of Charles Jones, but it also lays out and details the evidence of what occurs. This defendant is in the suspect vehicle within 3 days of this homicide occurring, and he immediately flees from law enforcement when he is apprehended in the very vehicle that they used to shoot and kill Charles Jones, the victim in this case. And when Mr. Gonzalez specifically refers to the statements that were provided by Jacksonville in the investigation where this defendant's name came up, they are using the exact accurate and honest depiction of what is going on. They label it as exactly what it is. It is just intel. And then they go beyond that and they tell the court, the magistrate, what that intel is. And then what is added about this particular phone is a part that Detective Carter with Gwinnett County Police Department in Georgia adds, that she actually had an interview with Charmaine Steiger, the defendant's girlfriend, and that involved the phone, and that Ms. Steiger let them look at the phone, withdrew consent, but she also gave a detailed interview after being confronted with the fact of this suspect vehicle and the whereabouts of her and the defendant during the time of the crime, and that she gave inconsistent statements. So all of that is woven into the probable cause. And so when we make a distinction about probable cause to arrest the defendant versus probable cause to search that particular phone because it has evidence related to a homicide case, that is clearly laid out in this search warrant. And based on Detective Ramos, there wasn't anything deceptive. There wasn't any omission that was given. He never tried to suggest that there was any evidence more than other than the defendant at that time was a person of interest, that they had an interview that of the girlfriend that claimed to be with the defendant the entire weekend and then changed her story once she was confronted, that the detectives absolutely knew that that car wasn't in Jacksonville when the homicide occurred, but was in Tampa. She then changed her story and said she didn't really know where he was. All of that is laid out in the search warrant. And so there is PC that a homicide had occurred in Tampa, that 3 shooters had participated in that shooting, and that there was evidence directly now related to a joint phone belonging to Charmaine Steiger and the victim in this case. And so there is no omission, there is no denial, and there's no sort of any additional facts to make it more suggestive than the defendant was involved that was actually in place at the time when the search warrant was executed. And so based on that, we would ask that you deny the defendant's motion to suppress, this was a good faith reliance upon a properly executed search warrant for that phone. That case law, that Jefferson case law is clearly, that was cited by defense, is clearly distinguishable. That's when they just went into the phone. That is not what happened here.
That was a warrantless search.
Correct, Judge. We have a warrant. We in good faith relied upon it, and there was nothing deceptive by either detective, and there was no material omission in that search warrant. Nobody suggested that there was PC to arrest the defendant at that time. Certainly, there were facts, even at this time when this search warrant was executed, that he certainly was a person of interest, but they accurately noted in that search warrant that they just had intel, and that hearsay that the defense attorney is suggesting that that intel is based on, that is laid out in the search warrant. They're not saying that this was provided by a reliable CI, or they're not trying to suggest they had any additional evidence. It is spelled out exactly with the sort of intel that they had from Jacksonville. And there is sufficient facts in there to believe that there is evidence related to the homicide that occurred in Tampa based on the interviews that were done prior to the execution of this search warrant.
Yep. Your Honor, the fact that the phone was not searched before a warrant was sought does not cure its illegality. Good for the police that they just didn't jump into the phone and start looking at it. That's not the issue. The issue is, did they have a sufficient nexus between the defendant and any act of criminality that would allow them to usurp the rights of privacy that he had in that phone when, and in fact, they knew that it was co-owned or belonged to him?
I understand the argument you're making regarding the nexus. I do. Okay. All right. Very good. I'm gonna take the matter under advisement. I will do a written order. Okay. So we've got two motions by Mr. Gathright and one by Davion Murphy. Davion Murphy, you want to go ahead, Ms. Toomey, on your motion to suppress? Okay. Very good.
Judge, this is a motion to suppress the search and seizure of Davion Murphy. There was, so let me just back up. Mr. Murphy was actually, Davion Murphy was arrested on January 6th of 2025. There was originally an arrest warrant that was put out on Mr. Murphy, Davion Murphy, on July 27th of 2024. That was recalled when an indictment was issued, and the KPS was issued on August 15th of 2024. So after Mr. Murphy, Davion Murphy was arrested by
So just so y'all know that this person that they're talking about, the Davion Murphy, guys, he was on the run for like 6 months. Like, he was out there, like they couldn't find him. They was looking up under bushes, trees. I mean, looking everywhere, they couldn't find him. For a whole 6 months, he was out here in these streets. I think this happened in July. They put out the warrant July 24th, and they did not find up and catch up with him until all the way in January. I don't know who was hiding them, who helped him or how it went, but baby, you talk about somebody being hidden. Now, in this regards, what she's about to be arguing, we heard they did file a motion in regards to Davion Murphy in regards to the search and seizure. How police kind of like obtained and searched evidence connected to Mr. Murphy. So let's see what she has to say in regards to this. But I think this may be our tattoo man. I know they wanted to talk about his cell phone, his text messages, his call logs. So kind of like back that way, but yeah, he definitely something else. He know how to get out here and run. But let's listen in.
Jackson County Sheriff's Office. He was initially read Miranda. He was brought into a room. He was handcuffed. He was still in street clothes. He had a red tank top on, a jacket. If I recall the weather during that time, I'm sure it was cold. The interview went on for a variety of hours. Mr. Davion Murphy cooperated with law enforcement, but then there was at the end, and I might note, and this is Defense Exhibit 1 during that motion, that during that time frame, Davion Murphy had his jacket zipped up all the way past up to his chest, almost up to his neck. Just for the record, I know I didn't play that portion, but it is on that interrogation video. Now, as I see it, without a warrant, there's about 3 exceptions that potentially the state could potentially argue. One, the photographs were taken incident to arrest. 2, Mr. Davion Murphy consented to being photographed. And then 3, we've got the plain view doctrine, whatever tattoos that were in plain view of law enforcement. So I just want to kind of briefly go through each one of those.
What
With
about
regard-
inevitable discovery?
Inevitable discovery, yes, which in my mind goes into the incident to arrest because, and I guess I'll take that one first. Incident to arrest, you have the purpose of that exception to the search warrant is for not only officer safety, one of the primary reasons is for officer safety, but when someone's arrested and they're booked into county jail, what have you, again, officer safety, inmate safety to make sure that individual's not bringing any contraband into the jail. There's a booking photo. They do not take photographs of any portions of your body other than to take a booking photo of you to document the identification of who they've been arrested. They take fingerprints. They ask you a myriad of questions, background information. These are purely administrative procedures and their routine when someone is booked into county jail. So I don't think that inevitable discovery without a warrant, if the Jacksonville or TPD, as indicated by Jacksonville Detective Drebeck, who said, we're just trying to speed things along, so that when you get to Tampa, things will go smoothly for you. And I quote
So
that.
let me ask you this question, and I don't
Yes,
know
sir.
if you know the answer, but the DOC records, would the DOC photographs have ultimately shown these tattoos on the body or person of Davion Murphy?
My experience is no. Now I can tell the court that I have photographs, not photographs, excuse me. I have records from a variety of clients of their DOC records. The only thing, just as a booking photo and the questions that are asked during the booking process at the jail is, are you having tattoos? They give maybe like a general description. If they have numerous tattoos, the booking officer will just put numerous tattoos, may go a little bit further, but
What about
you can
photos though? Are photos taken by DOC?
I have not seen photographs. I've seen where they've maybe described certain tattoos, but I haven't seen photographs. I have not.
Okay, I don't know. That's why I'm just asking the question.
Yes, Judge. So just because Mr. Davion Murphy was in custody, obviously, he was brought in under that arrest warrant. He was shackled and brought in an interrogation room in Jacksonville. Just because he was in custody and just because he was arrested does not give law enforcement full blanche to photograph any and every area of his body that they think is going to provide them what? Evidence, right? Because oddly enough, well, I'll get to that. So we have the incident to arrest. Also, part of the incident to arrest would be, well, potentially the individual is, the evidence might be lost in some fashion or another. We're talking about tattoos. So that's not applicable here. The second potential exception would be consent. And when determining consent, the court has to consider the totality of the circumstances. And I would submit to the court that Mr. Murphy, because he was in custody, he'd just been interrogated by Jacksonville Sheriff's Office, that he not only was he wasn't, in my opinion, was not asked. The officer told him that he wanted, but I'm going to quote, what I wanted to do is I'm going to take some pictures of your tattoos. That's what he told Davion Murphy. It's not a question. It's not asking him for consent. It's telling him what he is going to do. And mere acquiescence of authority is not enough. And the state has the burden to prove that there wasn't a mere acquiescence to the show of authority. In order to show that Davion Murphy consented, the state has the burden to show that his consent was free and unrestrained. It was an unrestrained choice that he had made. I haven't been provided anything wherein it was explained to Mr. Murphy that he's consenting, that he's signing, that he's got a right to not consent, right? That was never explained to Davion Murphy. So I think in the totality of the circumstances, there is no consent by Davian Murphy to the photographs, which, by the way, were personal in nature in that he lifted up his shirt. These are not portions of one body that are in plain view. And again, these are not photographs that are taken when someone is arrested. Yes, someone who is detained, a detainee in a jail, has less privacy rights than the average individual, and they do. But does that mean that the state and law enforcement get to trample on his constitutional rights as well, when they could have simply got a search warrant? I have other cases where they want to see my guy's tattoos. They obtained a search warrant and took photographs of the individual's tattoo that they thought had a nexus or were related to the crime involved. So looking at the totality of the circumstances, I don't believe that Mr. Davian Murphy gave consent. Now, plain view, obviously the stomach is not in plain view. One of those photographs, the detective admitted, and you can see in the photograph where he actually pulled back the back of his neck, the tank top pulled it down. So obviously those areas are not in plain view.
So you're saying the back of his neck is not in plain view?
No, that tattoo, specifically that tattoo, where he had a tank top on, right? After he took his jacket on.
It says, I think, 1200, right, on the back?
Yes, Your Honor. Okay. That was not in plain view because the officer or the detective actually had to pull his shirt down from his back in order to observe that and take photographs of it. And because there was no search warrant obtained by the state, the burden is on the state to prove that one of these exceptions apply. These motions, defense 2A through L, should be excluded, as well as the portion of the videotape where those pictures are being taken. And inevitable discovery, that's, yes, potentially, if the state had gone in the correct manner and getting a search warrant to begin with. Because, that's the whole idea of the exclusionary rule, right? Is not to reward misconduct or bad behavior by detectives and police department, right? So it would have been, they got all these other search warrants, it would have been that quick to get potentially, if they had probable cause, to get a search warrant for these tattoos that are on Davian Murphy's body, which they so desperately wanted to utilize in this case as evidence that he is part of this 1200 or the 187 gang or No Hospital gang or what have you. I might also note that the state, in providing the different groups, associates, members of ATK, members of 1200, one of the photographs that was used was from the interrogation room. And we'll get, I guess that's probably a subject of another motion, so I'll leave it at that. But I would request that those photographs be suppressed.
Okay, thank you. Ismer?
Good morning, Your Honor.
Morning.
I will address the specific exceptions. The state's position that a search warrant was not required in this case. If we are looking specifically first to the search incident to arrest, the defendant was lawfully arrested on a warrant. Law enforcement has the wide breadth in conducting a search of the defendant. By law, Florida statutes 901.21 conflict with the defense's argument that this was some kind of intimate or private search. The only description that's provided in that statute is going so far as to be a strip or a cavity search, something that's outside of the scope of the search of a person arrested lawfully, would mean the chest or breast of a female arrestee. So the defendant does not qualify. This is not some personal search or strip search or cavity search, nonetheless. That being said, the jail and law enforcement also have the ability to do so when the defendant has been lawfully arrested. So a strip search or cavity search, again, is conducted by the jail or law enforcement as long as it's done so in a manner and location that is reasonable. The defense would argue that the defendant had a right to privacy in the areas that were depicted, but as the defendant entered the interrogation room, his jacket was already off of his shoulders. The 1200 on the back of his neck was exposed. The block, so 1200 block is what the full tattoo is on the back, was not exposed, and that is what was covered. So the word block on the neck and the tattoo on the chest or stomach area are what really appear to be at issue. Other tattoos include those on the defendant's hands, which were obviously in plain view, and the side of the defendant's neck, as well as the upper chest area, also all in plain view, applying or meeting the standard for a plain view exception. Additionally, as it relates to the defendant's consent, when it comes to those areas, I think the question asked of the defendant was, what's that belly looking like at the time that the defendant lifted his shirt. Obviously, not necessarily needing to establish consent to prove that the law enforcement officers did not need a search warrant in order to obtain these photographs. The state would argue that that was consent to at least obtain the photographs on the stomach. But most importantly is inevitable discovery. The jail does in fact document the description of the tattoos, their location on each of these defendants' persons, but also these law enforcement officers are acting in a manner that is an extension of the jail. They are permitted to take photographs, even if they were roadside of an arrestee, when they see, for example, on someone who's been arrested for murder with a gang enhancement, tattoos indicative of being a gang member. That said, the Department of Corrections does in fact photograph gang members. So the records that Ms. Toomey may have been referencing for Department of Corrections records received for her by other cases or with other defendants referenced may be what's called a penitentiary pack, or referred to as a penitentiary pack. That commonly includes a photograph of the defendant, or the most recent photograph of the defendant that's been taken by the Florida Department of Corrections, their classifications and locations over the term of their time in the corrections department or prisons that they've been sent to, transfers, incidents, and fingerprints. That is the standard penitentiary pack. This particular defendant, though, has a designation, which means that he is on notice and noticing law enforcement agencies that he is in fact a gang member. That is a different document from the Department of Corrections. But each time the defendant would be transported, each time that the prison that he is located in would see additional tattoos or gang evidence, including his interactions or incident reports or having contact with the guards for gang activity, it's all documented, but thoroughly documented, as confirmed by the defendant in his interview, are his tattoos. So he specifically says to the detective, you already have those, the prison takes those, etc. Because in fact, what's called a STAR report from the Department of Corrections is specifically the Department of Corrections log of each inmate and every tattoo on that inmate's person. It's not only to keep track of the gang activity, involvement, developments, etc., but also to ensure that they are cracking down on the illegal tattooing in custody. There are several reasons for it, but they certainly monitor each defendant, not only at the time that they notice new tattoos, injuries, that type of thing, but also at the time that each of the defendants are transported. It would, I can only assume, appear from the defendant's interview that he acknowledges and admits to that, because he repeatedly says to the detective, oh, the prison already took them. Those are the most updated ones, and I received them all in prison.
I'm just curious, does every inmate get a STAR report in DOC, or just those that are suspected of gang affiliation?
Only those that are documented as having some involvement with a gang. So everyone gets a penitentiary pack. That's the basic information. And then if there is a gang attachment, that's a STAR report. That's the gang report, essentially. Okay. So at this time, Your Honor, the state's going to request that the court deny the defendant's motion as it relates to the defendant's tattoos having been taken by Detective Nieder. The Fourth Amendment certainly protects, just at a basic level, the search that was conducted. There was the scope of the intrusion that should be considered, the manner in which the search was conducted, the justification for initiating that, which of course is the charges in this case and the facts surrounding it, paired with Detective Nieder's knowledge of these gangs and the place that it occurred, which of course is in the privacy of a law enforcement district room, not on the roadside or something along those lines. So starting first with a Fourth Amendment analysis, law enforcement didn't violate any of the defendant's rights, but also in the event that the court believes that a search warrant would have been appropriate, the exceptions that the state would be relying upon are a search incident to arrest, plain view, consent, and obviously, most notably, the inevitable discovery of those records, which would have already been documented.
Okay, very good.
Thank you.
Okay, let's just go ahead and take our morning recess. It's 10:33. I'll be back at 10:45, and then we will proceed with Mr. Gathwright's motions. Under advisement.
Okay, so let's move on to our next one. That's the first half of it. And let me get that up. So guys, what do you think so far? I tell you. Lynn, did I miss the note yet? I hope I ain't missed the note by me sitting up here typing up some stuff. Oh, Goddess, you are going to love it over there. Okay, good. So it must be in the second part that we're gonna watch. Oh my goodness. That's how I got hooked on this stuff, Goddess. I was listening to him, and then he just doesn't cover Florida, he covers all of them. So if you into like the little dirt and all of that information, you are gonna really enjoy it over there. On some pastime and go down a long rabbit hole. Like I started getting stuff confused. That's how bad I was down that rabbit hole. I was like, what the heck? What? I'm like getting the names mixed up. ATK, CTK, NBA, ABC, KFC. I don't know what is going on here. I'm gonna have to rewind, go back. I'm like, oh my goodness, like who is all these people? But it looks like from what I did gather from what we did here in this conversation, guys, and I don't know if y'all caught on to it. So they say he pled, I think, in regards to the little bibby, because they seen a lot of this, it's just, oh gosh, it's just so deep. But the only people that I'm really like trying to bring to y'all attention is the people that's actually going to trial for these crimes. So just know that that's where we're at. But so I don't want to confuse anybody. But it is like, girl, I'm telling you, talk about a rabbit hole to go down and get stuck. You let me know if you ever need to come up for air. All right, let's go on to the second part of our hearing. I'm ready to see him put up his sign to his wife. I can't wait to see that. I hope I don't miss it.
Motion will be granted. Okay.
As to the state's second penalty, I have communicated several times in the last few days, so I can go quickly. As to the motion in limine regarding penalty phase, regarding a lingering doubt, I have no objection to that.
Okay,
I cannot argue that. However, I did want to point out that certainly that does not mean that I cannot tell the jury that despite all the weighing of aggravating and mitigating circumstances, they ultimately can vote to what they believe is the correct thing to do. But
And we're talking about, just for the record, so it's clear, the state's first penalty phase motion for order in limine, right?
Yes, ma'am.
Okay, I just want to make sure, because there were a number of states' motions, so. Correct. That doesn't impede your right to argue the balancing of aggravating and mitigating evidence. It just means no one can get it. Once, if the jury finds the defendants guilty of capital murder, then during the penalty phase, the parties may not relitigate that.
I agree.
Okay. All right. So I will, as to Mr. Rashad Murphy, that motion will be granted. Okay.
As to the state's second penalty motion, we do not object. I would not get into anything dealing with the details of the actual method of execution.
Okay. So as to Rashad Murphy, that's granted. State's third penalty phase motion.
The third one, Your Honor, the same, with no objection. I would not be getting into religious beliefs.
Okay. All right. As to Rashad Murphy, grant the state's third penalty phase motion for order in limine.
As to number 4, and tell me if I'm going too fast.
No.
A description of death, television shows, etc. I no objection to that.
Okay. As to Rashad Murphy, be granted.
As to number the 5th motion, I would not intend to, and this is something that I know the state's going to object because Mr. Harmon already told me he would, but I would not plan to get into details of other types of cases, such as mentioned Charles Manson, Ted Bundy, etc. However, when the state files a motion seeking or a notice seeking the death penalty, they are in effect telling the jury that they believe that this case qualifies as the worst of the worst because it deserves the death penalty. And I think that opens the door for me to be able to argue that this is not the worst of the worst if in fact we were in that situation. And I should be able to talk about comparing it to other capital cases to the extent that the death penalty in this case does not mean worst of the worst. I should be able to talk about torture and serial killing and things of that nature because I would need to separate the facts of this case from other cases that I would argue would be the worst of the worst.
So are you talking about just making a general argument at penalty phase as opposed to saying things like this is not Granville Ritchie, where a 9-year-old girl was raped and murdered. This is not Angel Kuzcho, where a 4-year-old girl was stabbed to death. Is that what you're talking about?
Yes, ma'am. I wouldn't be even mentioning other names, but I think that if the facts of this case do not have torture, if the facts of this case do not say serial killing, I should be able to make those distinctions.
Sure. Just generally speaking, that this is not the worst of the worst that would warrant a sentence of death, right?
Yes, ma'am.
Any objection to that, that general argument at penalty phase, assuming we get there?
Judge, I do object to that. If you look at the state's motion, and I cite the Rocket v. Ohio, Rocket holds that not only the sentences in other cases, but the circumstances of other cases, which would include torture or serial killers. There are many types of serial killers. There are many types of circumstances. There was a Timothy McVeigh bombing in Oklahoma that killed over 100 people. There was Al Donaldson, who recently killed 4 people here in Central Heights in Tampa. Ted Bundy, Oscar A. Baldwin, who was responsible for 3 young women here in the Tampa Bay area. They're all different. They're all distinct. All the defendants were of different ages. They have different circumstances. To simply say this isn't torture or this isn't a serial killer, it's even worse because you're leaving it up to the imagination of the jurors. And that's not what they're supposed to be doing. They're supposed to be assessing and conducting an individualized sentencing proceeding for this defendant to give him his due process rights. They're not supposed to be speculating about other cases and the relative proportional culpability or whether this is the worst of the worst or the least mitigated. That term is dicta from U.S. and Florida Supreme Court cases. That's not in the jury instructions. That's not for the jury's consideration. So we would object to that, Your Honor.
And my response, Your Honor, is in the end, they're instructed about weighing aggravating factors versus mitigating circumstances. But in the end, they have to decide what they feel is appropriate. And what I'm proposing, I would submit is a valid argument. And it would be in a general term. It wouldn't be trying to identify specific cases.
Okay. So as the state's motion is drafted, specifically the state requests that the defense not be able, during penalty phase, be able to discuss actual sentences in unrelated cases. So as to just the strict wording of the motion, it's granted. However, that does not preclude any of the defendants from arguing that the facts of this case, combined with their own mitigators, that does not rise to the level of worst of the worst, mandating the imposition of a death sentence. So generally speaking, you can argue that why it is your client should not be sentenced to death.
Thank you, Your Honor. As to the 6th penalty phase motion, I would have no objection. Would not talk to the jury about prior statutes regarding the death penalty.
Okay, so
not objection. As to the state's 5th motion, you're granting the motion as to the defense comparing or regarding the facts or sentences of other specific.
Correct. Okay. So there's not going to be specificity, but generally speaking, all of the defendants, if we get there, will be able to argue, generally speaking, why the death penalty is not appropriate for their particular circumstance. Okay, moving on, then grant the state's 6th motion for order in limine during penalty phase.
And Your Honor, the state also filed in each of the defendant's cases a motion to compel the defendant to provide penalty phase witnesses and evidence.
Right, and I issued an order setting a deadline for that. Has
that was met.
Okay, so the motion is granted, and Mr. Hernandez has indicated that he has complied with all deadlines established by the court for Mr. Murphy.
Thank you.
Okay.
I think the language of my response was that I reserve the right to be able to make amendments if so needed, but I don't have it in front of me, but I can tell the court that it was timely responded to.
Judge, I believe that did the court's order anticipate witnesses and expert witnesses penalty phase?
I believe it did. Let me pull it up.
And
that's my understanding.
We did provide that.
So the state's motion to compel also contemplates in paragraph 4 a reciprocal discovery as far as records, because I find typically in these cases, as we're progressing through guilt phase, at some point the state's provided thousands of pages of records. That puts us in a very untenable position to allow our experts to have time to digest that information before they conduct evaluations of the defendant. That's the type of information I'm asking for also.
Right, and in my scheduling order, I gave a deadline for the defendants to all identify any expert witnesses that they intend to call at penalty phase, including the provision of any and all supporting reports, documentation, anything that the experts relied upon.
Our doctor has been listed. He has not provided a report yet. In fact, I think he wants to see him one more time. And Mr. Harmon and I have talked about scheduling his deposition later this month.
Okay, well, I granted the motion. So there's an ongoing obligation for defense counsel to provide reciprocal discovery.
You know, I have 14 motions that I think I can go quickly through if the court would allow me, because I have them numbered a certain way. The first one is motion to declare sections 921.141 and or 921.1 subsection subsection 6, subsection H. Florida statutes. It's basically the hack motion.
Okay.
We're declaring that be declared unconstitutional facially and as applied, and I would rely on my memorandum of law.
Okay, that's fine. And just so, Mr. Hernandez, it will make my life simpler. When I was given a list of the pending motions by the state, and they were broken down as far as numbers and when we were going to hear them. So I have them broken down by the dates that we originally scheduled to hear the motion. So for example, it would be helpful to me, I'm looking at the motions that were initially scheduled to be heard February 26th. And as to Rashad Murphy, the motion to preclude the imposition of the death penalty.
Your Honor, I have them numbered my way. I didn't have them, but I can get to whichever one you want to get to.
Okay.
Which one is it?
It's the motion to preclude the imposition of the death penalty, and specifically that the retroactive application of a death penalty statute enacted in 2016 or 2017 violates Article 10, Section 9 of the Florida Constitution.
Judge, I guess I am having difficulty finding it.
Okay. All right. Okay. So hold on. Let's do this. Murphy. I'm going to pull out all of Mr. Rashad Murphy's motions that I have, and we'll go through those.
I apologize.
That's all right.
I did not have your numbering, and I just numbered them
worries.
separately myself. The first one was the heinous, atrocious, or cruel aggravator motion that I just referred to.
All right. Give me just a moment.
And Your Honor, before I forget, I would request to move orally to adopt any death penalty motions that were filed by co-defendants.
Okay, granted. We have about 60 motions, so just give me a moment. Okay, I think I have pulled out all of the penalty phase motions that were filed on behalf of Mr. Rashad Murphy. So tell me, Mr. Hernandez, which one you want to start off with again?
The first one that I mentioned, Your Honor, was a motion to declare. It's the heinous, atrocious, or cruel aggravator motion, asking that section, those sections of the Florida statute be declared unconstitutional.
What's the
facially
actual? Oh,
and
here it is.
applied.
Okay, just making sure. So you're arguing motion to declare sections 921.141 and or 921.141 Florida statutes heinous, atrocious, or cruel aggravator, and or the current 6H interim instruction unconstitutional facially and as applied. Correct?
Your Honor, and I'm relying on my memorandum of law that I've attached, so I don't have any further argument.
Okay, and state, you filed a response to that as well? You're relying upon that?
Yes.
Okay, I will deny the motion. Okay, what's
Your Honor,
next?
the next one on my list is titled Motion in Limine Precluding Improper Penalty Phase Argument. And Mr. Harmon has indicated that he does not object to it.
Okay.
No objection, Your Honor. We won't make any of the arguments in that.
Okay, that motion is granted.
Your Honor, number 3, I have motion in limine regarding reference to non-enumerated mitigating circumstances, and I believe the state does not object.
We do not object.
Okay, that one is granted. Okay.
Your Honor, my next one is number 4 is motion to allow testimony of the impact of defendant's execution on family members. The state, I believe, objects to this one. I think they object to the rest of mine. My argument, Your Honor, to this is the fact that mitigation can be anything. And the fact that he's greatly loved by family members should be something that I should be able to present to the jury. And I would rely on the Lugo case that's in the motion 845 Southern 2nd 74. It's a Florida Supreme Court case, 2003.
Okay, Mr. Hartman.
We filed a written response objecting to this. I can make additional argument for which is, but
What is it specifically, Mr. Harmon, are you concerned? I mean, you would concede that obviously the defendant can call witnesses to testify as to the, why it is that Rashad Murphy should not be executed, and that, you know, if he's a good brother or son or provider or whatever it may be, right? And so, but I guess where we're having an issue is whether or not those same family members would be able to testify as to their feelings should Mr. Rashad Murphy be executed, correct?
the impact of the defendant's execution of this is a future event that has not occurred. We don't know when it will occur. We don't know if the defendant will even ever be executed or if he would die naturally in the Florida State Prison. We don't know if the family members would still be alive when he was executed. It is such an unknowable fact for them to testify about. We believe that's improper. I have no objection to family members taking the stand to express to the jury why they believe his life should be spared.
Okay. Let me look at Lugo, and I'm going to take that one under advisement. So,
Yes, Your Honor.
okay, let you know.
Your Honor, the next one is titled Motion to Declare Florida's Death Penalty Unconstitutional. And in parentheses, it states unreliability. We believe that the argument, Your Honor, is that the fact-finding process cannot be deemed sufficiently reliable to justify imposition of the death penalty. And I would rely on the cases that are cited.
And just to make sure I'm on the same page, motion to declare Florida's death penalty unconstitutional as to unreliability. That's the motion
Yes,
we're
ma'am.
discussing. Okay, and state you filed a reply, which I have reviewed. Anything further?
No, Your Honor.
Okay, I will deny that motion. Okay,
Your Honor, the next one is the, it reads, motion to declare sections 921, 141, 6I of Florida statute. It's the cold, calculated, and premeditated motion. I'm relying on the memorandum law that I've listed. I'm arguing that the statute is unconstitutionally vague, overbroad, and it is applied in an arbitrary and capricious manner in violation of the 5th, 6th, 8th, and 14th Amendment to the U.S. Constitution, as well as Article 1, Sections 2, 9, and 16 of the Florida Constitution. And I would rely on the cases that are included in the motion.
okay, state filed a reply, which I have reviewed. Anything further? Okay, I will deny the motion.
The next one, Your Honor, is titled Motion to Declare Sections 921, 141, subsection 8 of the Constitution unconstitutional as requested for proffer of impact testimony and pretrial ruling on whether the danger of unfair prejudice of that evidence outweighs its probative value and or otherwise denies a fair sentencing proceeding. I am basically, I'm objecting to the use of victim impact evidence.
All right, and state you filed a response.
Yes, Your Honor.
Okay.
I rely upon that.
All right, so I will deny the motion as far as it's phrased that the statute is unconstitutional. Obviously, the case law controls how victim impact evidence actually comes in, which we will comply with. But just as to this motion that it's unconstitutional, the provision of victim impact evidence, I will deny that motion.
Thank you, Your Honor. The next one, which is my number 8, motion to declare sections 921.141 and or 921.141.6B of the Florida statutes and to be declared unconstitutional. It basically, the argument in this motion is the violent felony aggravating factor of this section should be declared unconstitutional as vague and overbroad and has been applied arbitrarily and in an inconsistent manner, and I would rely on the cases cited.
Okay, anything further from the state?
No, Your Honor.
Okay, I'll deny the motion. All right, next up.
In our number 9 is a motion to exclude evidence or argument designed to create sympathy for the deceased. I think I believe Mr. Harmon can correct me if I'm wrong. He agrees to paragraphs 1 through 4. I will not be, or that he would not be arguing the victim impact for the purpose of seeking sympathy for the deceased or in support of any aggravating factor.
Okay, Mr. Harmon, anything further?
Your Honor, we agree to paragraph 1 through 4 of the defendant's motion. The evidence designed to create sympathy for the deceased is inadmissible in the guilt innocence phase, and we certainly don't intend on getting into any type of sympathy evidence or argument in the guilt phase. Paragraph 5, we disagree with. The admission of evidence concerning the deceased or the circumstances is inadmissible under Florida law in the penalty phase. Well, that's clearly wrong. Circumstances of the case to support multiple aggravators in this case will be argued in the penalty phase. Evidence concerning the deceased would be victim impact. However, Mr. Hernandez did state as to what I told him that we would not argue victim impact is supporting the aggravating factor. So.
That's correct.
Okay. All right. Anything further?
No, Your Honor.
All right. So as to this particular motion, the motion is granted as to items in the motion identified in numbered paragraphs 1, 2, 3, and 4, and it's denied as to paragraph 5. Again, the state is entitled to present victim impact evidence in conformity with the case law.
Your Honor, yes, number 10, there's some repetition here, but it's a motion to limit victim impact evidence. And A through F are the very paragraph or the areas that we're asking for limitations, and we would rely on the case law that's in the motion.
Okay, state what your.
I'm sorry, Your Honor. What is that?
We're on a motion to limit victim impact evidence, and specifically, they're requesting only one witness may testify. The witness must be an adult. The state must proffer a proposed victim impact statement in writing.
So guys, this is the defendants are basically so we doing the motions, right? But I do see that we have some questions in regards to the DP. Let me show y'all this document so y'all can kind of see what we're doing here, and so we can all have an understanding on this. Let me show y'all, because we all about trying to figure this out, understand what we're looking at. They do have a DP in Florida, and this is the document. So they do have a notice out here to seek notice of intent to seek the DP. So the state of Florida, by and through undersigned assistant, blah, blah, blah. In the event that any of the named defendants are found guilty or plead guilty to a capital felony in this case, in any subsequent penalty proceeding, the state intends to prove and has reason to believe it can prove beyond a reasonable doubt the following aggravating factors. So they list the aggravating factors here. You see in 1 through 4 in regards to the murder of our guy, Julio Charles Jones. So they are going to seek the DP. Now, I don't know if it has been approved yet. And it does have it on here for the DP. We have Isaiah, Jermaine Chance, Rashad Murphy, Sean Andre Gaffright. Now, I don't think Davion Murphy was in custody at this point in time. He was still on the run. And this was October 7, 2024. Now, this right here, so the defendant's motion to preclude the imposition of the capital punishment. So the defendant, Isaiah Chance, by his counsel, Mr. Chance is charged with to commit free drum. So what they're trying to do is get the DP, I think, off the table for these guys. And I'm just in Isaiah Chance's file, guys. So that's what we're currently arguing now. So I'm going to take us back into the court just so we can understand what we are doing and why we're here in this current argument in regards to the DP. Because I see that we have different thoughts in the chat. So let me get that back up. I'm going to get us back in here and we'll finish listening to them argue who shoulda, woulda, coulda, and why not.
The court must hold a hearing on the admissibility of the evidence prior to its admission, and the court must consider relevant case law. The testimony must be limited to the prepared statement. No witness may testify if the witness is unable to control his or her emotions.
So Judge, we objected to the remainder of the motion, including that portion, limits on victim impact of one witness, that's not supported in the case law. There were cases where up to 12 witnesses have been allowed, 12 impact witnesses, even more in some cases. In this case, I'm not sure how many we would call. I know the court is aware we normally try to proffer impact through written statements by the family members. But there have been cases, I have presented impact statements in the past from the community to include friends, family, in-laws, things like that. So I don't believe that these limitations are.
Okay, so you object to only one witness, correct?
I do, and I object to limiting age, that type of thing.
So you object to the witness must be an adult?
I've never called anyone other than an adult in impact. I don't believe in this case that's an issue.
Okay. What about the statements proffer a proposed victim impact statement in writing?
We normally do that, Your Honor, just I believe it works better that way.
Okay.
The pretrial rulings on the admissibility, so I have no objection to that, I guess.
Okay, the testimony must be limited to the prepared statement, right?
Yes.
Okay.
Yes.
And you agree no witness, either for the state or the defense in penalty phase can testify if they cannot control their emotions, right?
I do agree, Your Honor.
Okay. So as to Rashad Murphy's motion to limit victim impact evidence, it is denied as to paragraph A, and that only one witness may testify. However, if we get to penalty phase, Mr. Hernandez, if you want to renew an objection, if the state you think is intending to call too many witnesses for victim impact, then you can renew your objection at that point in time, once we get down to the actual evidence that's coming in. But generally speaking, paragraph A is denied. At this point, I'm going to grant paragraph B that the witness must be an adult. Again, if for some reason we actually get to penalty phase and the state intends to call a minor, we just need to talk about it before you do it, Mr. Harmon.
Yes, Your Honor.
C, the state must proffer a proposed victim impact statement in writing. That's granted, and that victim impact statement needs to be provided at least 24 hours before the witness testifies. So that way, if there's a problem, we can discuss it. All right. I will agree to hold a hearing on the admissibility of the evidence if there's a dispute. Okay, so that's granted. Paragraph D. E, the court must consider relevant case law. I concur, I must, so that's granted. And the testimony must be limited to the prepared statement. That's granted, that's paragraph F. And paragraph G, no witness may testify if the witness is unable to control his or her emotions, so that's granted. Okay.
Your Honor, the next one, number 11, is a motion to preclude application of the most recent amendments to Florida Statute 921.141. In this case, as such application would violate Florida Statute 775.022, where our position is, Your Honor, that for the death penalty to be imposed, there should be a unanimous 12-0, and as opposed to an 8-4.
Okay, state you filed a response relying upon that.
Yes, Your Honor.
All right, I will deny the motion.
Your Honor, number 12 is motion to preclude imposition of capital punishment on the ground that the death penalty is presently administered is per se cruel and unusual punishment. And I would rely on the memorandum of law that is attached.
Okay, and state, let's see, you filed a response, are you relying upon that?
Yes, Your Honor.
Okay, I'll deny the motion.
The next one, Your Honor, number 13, is a motion to preclude the imposition of the death penalty. And again, I would rely on the memorandum of law that is attached.
All right, state you filed a response, are you relying upon that?
Yes, Your Honor.
Okay, deny the motion.
And then finally, Your Honor, a request for a jury instruction. It is our position that in order for an aggravating factor to be considered by a jury, it should be beyond all doubt, not just reasonable doubt. And we're asking for that jury instruction, and I would rely on the case law submitted.
Okay, state you filed a response, relying upon that?
Yes.
Okay, I will deny the motion. That's all I have for you, Mr. Hernandez, for Rashad Murphy. Is that all you have?
Yes, Your Honor. Thank you. That's all I have.
Okay, very good. Okay, so let's go back to Mr. Gathrights' motion is pressed. Mr. Wise.
Your Honor, which would you like to
You pick.
address first? Okay.
You tell me.
Well, I have looks like the traffic stop first on the pile, or the, not really a traffic stop. This is really multi-layered.
Right.
motion, of course. But this is a motion to suppress all the evidence that comes following the traffic stop of Mr. Gathright. And your first layer is that the stop itself was illegal. Obviously, everyone pretty much recognizes it's a pretextual stop. I recognize, of course, that pretextual stops are legal as long as there's an objectively reasonable basis for the stop. The problem here is that there was not. The two officers who conduct the stop testify that it's based on speed and intent. Now, they clearly have every intention to stop Mr.Gathright's car. Detective Barry is actually in the criminal apprehension unit, which apparently his main job is to conduct stops like this. Despite all of that, neither one have a dash cam in their car. No one has a radar gun or any kind of way of clocking the speed. They both testify as to the speeding, that they estimate the speed, but they've only seen the car for a quarter of a mile, approximately. Neither one of them, even today, can testify as to what the speed was on the road where they conducted the stop. They said 35 to 45, but neither one of them even knows what the speed was. And just the same, neither one of them knows what they thought Mr. Gathright was going at the time. So under the circumstances, Your Honor, particularly given that this was a plan all along to make the stop, this is not an objective, reasonable basis for the stop. And even though estimating speed can be a basis under Florida law, the Allen case that I discussed in the memorandum says the estimate has to be reasonable and credible. And in this case, under these circumstances, it's not a credible estimation of the stop. The second basis for the stop, the 10th violation, is also not an objectively reasonable basis. And I have a couple of statutes I had not cited in the memorandum, but I can provide. If you'd like me further, I can cite them.
Sure.
But it's really just two traffic statutes that pertain to 10th violation.
And for the record, you've handed me 316.2954 and 316.2951.
Yes, sir. And here, again, at least Officer Bear, I can't recall if Detective Griffin claims he sees a 10 violation as well. I think he may have, but neither one of them end up measuring the car. Someone else does. They don't know what the reading was, but in any event, Detective Barry issues a citation for a tent violation at some point, but he issues it, as he testified, for the tent being less than 15%. The problem with that, Your Honor, looking at 316.2954, it states for most cars, I guess you could say, that is the law. If it's less than 15% in the visible range, that's a 10 violation. And that's what apparently Detective Barry relied on. But it makes an exception for what are clearly SUVs, and the officers testified, and I think everyone knows a 4Runner is an SUV, but one of them testified to that fact, that something that qualifies as a multi-purpose passenger vehicle is allowed to have rear windows that have a light transmittance of at least 6%. So substantially lower threshold than the 15% that's most applicable. And then looking at the other statute, 316.2951, it defines what a multi-purpose passenger vehicle is. And I think that clearly is a sport utility vehicle.
Well, it says 10 persons or fewer.
Yes.
Does that include
The way I interpret it, Your Honor, it can be, it's 10 or fewer if it's constructed on either a truck chassis or has special features for occasional off-road operation. The statutes do not, as I see, define sport utility vehicle. I think that definition clearly would encompass a sport utility vehicle.
a 4Runner, a Toyota 4Runner can carry 10 people legally?
Well, 10 or fewer. I don't think that it has to be, if it were 10 or more, I think that'd be problematic, but it's 10 or fewer constructed on either a truck chassis or for special features for occasional off-road operation.
Okay.
So in any event, I think that encompasses what a 4Runner would be, and that pertains to when you read in conjunction with 316.2954, it allows for tent to be 6% or higher. So clearly, I think the officers, well, I quite frankly think it was a pretext. It was a case of stop the car and figure out a reason later. But in any event, it wasn't objectively reasonable because I believe they were relying on the wrong statute regarding the tent violation. Next layer, that would be the search of the car, of course. And I believe there really are two issues with regards to the search. Number one, Detective Griffin is the only one who allegedly smells the scent of marijuana. I don't believe that his testimony in that regard is credible at all, based on what you saw last week. So he stops the car. He's talking to Mr. Gathright at the car window for quite some time. Detective Barry also comes to the car window to get the license. Detective Barry never smells marijuana. Detective Griffin, after some time talking with Mr. Gathright, claims to have smelled the scent of marijuana. He says in his own words, it was a faint smell. Can't distinguish between whether it's fresh or burned, but he claims he smells marijuana. When the car is actually searched, there is a small amount of residue in a sealed mason jar. The quantity is too low to even be able to try to weigh it. There's no presumptive test performed on it, probably because it's of the small amount. It's in a sealed mason jar in a sealed backpack inside the car. There's no way that could be giving off any kind of odor of marijuana to be detectable from outside the car. And there's no indication, he testified he doesn't see any signs of impairment on Mr. Gathright. Can't say that it's a smell of burned marijuana that might have taken place, if someone smokes in the car sometime earlier in the drives. He says it's a faint smell of marijuana. The facts just don't support his claim that he smells that from outside the car. But number two, even if he did, the law has changed considerably in the last several years. And the Williams case in particular that was issued back in the fall recognizes that there are numerous forms of marijuana or of the cannabis plant that are legal to possess under state law and federal law. Anything basically that qualifies as hemp under state or federal law looks like illegal marijuana, smells just like it, and no one can determine which it might be just based on the smell. Aside from that, of course, under state law, medical marijuana can be lawful in certain circumstances. And for a time, it appears this Delta-9 marijuana was lawful to possess. But in any event, the hemp is lawful under both federal and state law. And no one can really distinguish between the two. And that's why the Williams case has now held, similar to Baxter in the 5th district, I think the year before, that the odor alone is not enough to support stopping. Now, what happened in Williams, and I'm sure the state's going to argue that, is that in Williams, they found that even though that's the law now, when the search was conducted, we had a different precedent. So they said that the officers acting on good faith reliance could do that. Here, the problem again, aside, just for the record, I would argue, saying that good faith reliance is okay really doesn't make a lot of sense in this situation because the laws that the DCA has recognized changed, happened long before this search was conducted. So I don't believe that it actually is reasonable to say officers should have been able to rely on prior precedent when the laws that legalize forms of marijuana were in existence. But the other problem in this particular situation is I don't believe officers were acting in good faith. We know very well they were looking for any reason to conduct a search of that car. I would suggest to you this is a classic case of we'll search first and we'll figure out justification later. I guess you could say luckily, but there was some little form of marijuana found in the car that they could rely on. But clearly, under the totality of the circumstances, this search is being conducted because they want to find evidence from this case and they're going to find a reason later. And they find a little bit of residue to justify it. It's not good faith reliance on prior case law. The next level, Your Honor, of this motion is assuming hypothetically that the smell of marijuana would give the reason to search the car. Law enforcement goes far beyond searching for potential marijuana and more importantly, in what they seize from the car. Law enforcement seizes these casings from the car. They're not unlawful to possess, just like the rifles. Now, there's a claim that handguns could not be possessed because of Mr. Gathwight's age, but there's no prohibition on possessing fired casings. There's no prohibition on, even if they're for a handgun, there's no prohibition on rifles. There's certainly nothing illegal about the laptop and iPads he possessed, but all of that is seized from the car based solely on this sense of marijuana. And we know very well why everything was seized, but there has to be an objective reason to do it. And there wasn't, especially for fired casings. I mean, he's not a convicted felon. There's no reason he couldn't possess those to begin with. Last layer of the search, or of the motion rather, is all of this evidence is then used to get the search warrant for Mr. Gathwight's house. I think everyone who testified about that agreed that search warrant would never be sought even. It certainly would not have been approved, but for the evidence that's found in the car. I recognize, and I'm sure the state will point out, that search is being conducted by Jacksonville officers regarding really, it would appear, I don't even think it was the earlier Charles Jones shooting. It was another shooting that linked to casings that were found. But what's significant is they still seize substantial evidence that they're trying to use now in this case. And that would never have happened but for the illegalities that occurred during the traffic stop. And I believe even though it's conducted by Jacksonville and the warrant is sought in connection with a different case, it's clearly a fruit of the poisonous tree because but for the illegal stop, the illegal searches, there would never been a search of the house. And I believe those cover all of the bases that I'd be relying on for this motion.
And you mentioned, and I just want to make sure we're on the same page, you concede that the second DCA at Williams, they actually affirmed the trial court, finding specifically that the law in our district at the time of Mr. Williams' arrest and Owens was the law in the second DCA at the time of Mr. Williams' arrest, and it expressly permitted the search based solely on the odor of cannabis. Thus, by following Owens, law enforcement was acting in objectively reasonable reliance on finding appellate precedent. We therefore affirm.
I certainly agree that that's what the second DCA.
Okay, and that the arrest in this case and the search of Mr. Gathwight's car occurred prior to the Williams opinion being issued, correct?
That's correct.
Okay. Okay, Ms. Wise, thank you.
And Your Honor, the state is relying on Williams v. Florida, that second DCA case as well. It is clear that there was a objective legal basis to stop that Toyota 4Runner in Jacksonville. You heard from 2 law enforcement officers from Jacksonville who were in separate vehicles, who both are trained and certified in estimating the speed of a vehicle. They both obtained that week-long class where they were able to demonstrate that they were able to accurately estimate vehicles within 5 miles, tested against a radar gun. They both had that training. They both passed that training. And with regards to Detective Griffin, he says that he still utilizes that training and makes that type of estimation 1 or 2 times a week as part of his duties in his present job. And they both estimated that the defendant was speeding. They chose to just give him a warning in that instance, so that there were 2 bases to believe that the defendant should be stopped. The other one was that tint, and you heard that he was actually given a citation for that based on another detective coming out there, they actually came and they measured the tint, and that was within the range that was not valid, so that he was issued a traffic citation stop based on the illegal tint that SUV had at the time. So there was a reasonable basis to do that. And you heard from Detective Griffin that he smelled the faint odor of marijuana when he was standing at that vehicle. Officer Berry had already taken the license at that point and had walked away. And based on a search of the vehicle, based on the smell or odor of marijuana, they indeed found marijuana, which again goes to support that that was a credible observation by Detective Griffin, that he actually did smell the marijuana and was able to conduct a legal search of that vehicle. In searching that vehicle, any place where you could find marijuana, he found a handgun. And the defendant was 21, under the age of 21 at the time, and the defendant was arrested for 2 bases based on possessing the marijuana and drug paraphernalia, as well as a person under the age of 21 possessing a handgun. Those were bases to arrest the defendant and conduct a inventory search of all of the vehicle. And you heard that it is protocol whenever not just a firearm, but any sort of ammunition or parts related to firearms, when they are found in a vehicle, regardless whether it's a search warrant or an inventory search, all of that gets put into NIBIN as part of their procedure. And it is the NIBIN results that lead to the search warrant, a properly executed search warrant of that house in an unrelated homicide investigation, which provides for all of the evidence then that is related in this case. It really does turn on the traffic stop, and there was a reasonable basis for law enforcement to stop that vehicle and then conduct the search that they were able to find all of the other evidence in the case. So, Judge, if there is a reasonable basis to stop, and we rely on the Williams v. Florida case, which was decided in October of 2025, where they said that no longer would you be able to use the smell to justify a search of the vehicle, but good faith reliance on binding precedent at the time, which was October of 2025, they're not going to suppress any evidence based on a search based on smell. And this search happened the year before. So we would ask that as well, Judge, that good faith reliance, that was binding precedent. That was the law at the time of law enforcement was able to conduct a vehicle search of Mr. Gathwright's Toyota SUV based on that odor and smell of marijuana. He went into his credentials, his familiarity with that smell, and that search did in fact lead to marijuana within the vehicle. So based on all of that, we'd ask you to deny the defendant's motion to suppress.
Okay, Ms. Wise, any rebuttal?
Just briefly. With respect, I recognize at least one of the detectives, I think they both talk about this, the class that they've taken. And they may be qualified at times to make traffic estimations as far as the speed someone's going. But the problem is it has to be reasonable and credible. That's what the case law says. You can estimate, but it's got to be reasonable and credible. And that's the problem. It's observing for a quarter of a mile. Can't even say what the speed limit is, even to this day. Can't remember how fast they thought Mr. Gathwright was going. So I would suggest, even though maybe they're qualified under some circumstances to make the estimate, we don't have the evidence here to support that, to show that it's reasonable and credible. Again, as to the temp violation, it's measured, but no one last week had even testified what the measurements came out to. And I believe, as I pointed out, I think they were relying on the wrong statute quite clearly when they were reasonably, in their minds, objectively determining that the temp was not lawful. Williams, again, before obviously reaching the point where Williams would come into play, there has to be a finding that the smell, that the testimony you heard was credible, that the officer actually smelled the marijuana. I don't believe that finding can be made given the testimony from last week. But even if it could be, I obviously don't agree with Williams and their conclusion that they should rely on it, but this isn't a situation, even recognizing that holding, where the officers are relying in good faith on Williams. They're trying to find any reason they can to justify the search. And they clearly, obviously it's a pretextual search. No one's really disputing that. But it makes no sense for them to come back and rely on Williams after finding this little bit of residue. With regards to casings being placed in the NIBIN and the various other firearm evidence being collected, that's a seizure. And I don't believe that there was a lawful basis, given Mr. Gathright is not a convicted felon, to seize casings from the car and put them in the NIBIN. That goes beyond searching for marijuana. It goes beyond even an inventory search. That,
Well,
that is a seizure.
What's your position on whether or not there was probable cause to arrest Mr. Gathright for the hand or for the gun that was found in his car and he being under the age of 21?
Well, they don't do that, I don't believe. And under the circumstances, I can't agree that that would give probable cause and under arrest him for that. We don't know to arrest him for that. The car, for what it's worth, is registered in his mother's name. His mother is a retired Marine. The handgun is not in plain sight. It's deeply concealed within the car. So I don't believe there was probable cause for that. Okay. Again, even then, the NIBIN hits, the last argument I think the state was making, the NIBIN hits didn't provide a lawful basis to search the house because there would never been NIBIN hits if it weren't for all these illegalities that led to the NIBIN hits.
Okay. I understand. Thank you. Okay, I'm going to take it under advisement. I'm going to do a written order. All right. So then we have Mr. Gathwright's motion to suppress evidence illegally obtained from the defendant's iCloud accounts.
So this is a much different motion, obviously, Your Honor. It probably became apparent last week that I was a little surprised by some of Mr. Ramos' testimony. That may not have been apparent, but I set out in the motion and I was intending to argue that what I believed was a date range, a temporal limitation in the warrant was overbroad. And from Detective Ramos' deposition, in all fairness to him, he couldn't really remember every search he conducted because he conducted many searches, but it was that if there was a temporal limitation, I would have stayed with that. Clearly, he did not. He testified last week. He had no intention at any point of limiting what he was going to search from the iCloud. And he clearly did not. He searched the entire thing. That's what he testified to last week. That, Judge, I don't even know that it can be questioned. That would not violate the particularity requirement of the Fourth Amendment. This is an evolving body of law, but the cases that have addressed this, several 11th Circuit cases, and then I think the Demons case is probably the most on point state of Florida case. They recognize you going in and searching someone's iCloud account is the equivalent of a general warrant. It's just rummaging through basically their life. In this case, it was rummaging through almost 4 years of Mr. Gathwright's life. That's why a lot of this goes back to the McCall case from the 11th Circuit, and Demons relies on that. But there have to be temporal limitations on what is being searched when a warrant is being sought for something like an iCloud account. In reading the warrant and the affidavit that Detective Ramos drafted, it could appear that there is a date range of June 1st, 24 to July 12th, 24, which I believe even that would be substantially overbroad under the current case law. But Detective Ramos stated he was not limiting the search to that date range, and he had no intention to do it. It sounds like it's somehow auto-populated that he did the affidavit. And when he submitted the request, and then the warrant that was actually signed, it basically provided free reign to review the equivalent of everything that was in the iCloud account. All emails, all instant messages, all iCloud data associated with backups, all contacts, all records and information regarding locations, all data stored in location services, all records pertaining to the type of service used, records of games, videos, other remotely accessible data, and associated IP addresses, all files, keys, basically anything you could think of that could be in an iCloud, he includes in this affidavit and in the warrant that he drafts. Even if that's problematic in itself, even if we have a temporal limitation of a month and a half, but there was no limitation whatsoever. It essentially went back to March of 2021.
Well, didn't he testify that Apple just gave him everything?
They did. And I think in the deposition, that's what he thought happened. And even if that's the case, Apple clearly did give him everything. And it's addressed in a couple of other cases I'll get into. But even if that was the case, then he would have a reason to limit it to whatever dates were in the warrant. So even if arguably this could be read in the warrant as a temporal limitation, which he apparently did not read it as, then he has a duty to confine what he searches to that. And I asked him about how, wouldn't it be easy to just click on the last access date and then organize everything by that date? You can search only things within that date range. But he had no intention of doing that. He looked at the entirety of the life of the account, almost 4 years worth of material, at least 3.5. So even if that was a limitation, and even if Apple ignored it, he made no effort whatsoever to limit what he actually searched. That, Your Honor, I think clearly violates the holdings in Blake, which I think is the probably the main 11th Circuit case that addresses this. In Blake, they addressed two different warrants. There was one to, I think it was Yahoo. There was one that they found was not problematic, although it appears in reading Blake that they were kind of, that was even a close call. But then there was a Facebook warrant in Blake that they found far exceeded the particularity requirements of the Fourth Amendment. This one is just like that. It really had no temporal limitations and it had no categorical limitations. It was what they found to be the equivalent of a general rummaging warrant. I don't know if the state, really can even argue that that did not violate the Fourth Amendment, especially the way the warrant was executed. But I think a big issue now that's addressed in the Demons case that I cite is, according to Demons, there can be an attempt to try to, I think, basically parcel out what was unlawful, what went outside the temporal limitations, and focus on what may have been reasonable. They did that in Demons, but they also said that it's not always going to be appropriate and not always going to be feasible. In that case, and unfortunately, Demons, they don't really say, they don't talk about why that warrant was overbroad. It appears the state agreed it was overbroad, but then they made an attempt to limit it to information from the time of a shooting that was being investigated and a few hours before and after. But in reaching that point, they noted, relying on a couple of federal cases from other circuits, one being Gulp and the other being Pilling, which I have a copy of. But they said that even when parts of a warrant may be valid and distinguishable, severance may be appropriate if the sufficiently particularized portion is only relatively insignificant part of the sweeping search, or where the warrant is generally invalid but has some tangential item that meets the requirements of probable cause. The problem here, Your Honor, is it's far from a relatively insignificant portion of the warrant, whatever might have arguably been relevant, because we have, again, 3.5 years worth of Mr. Gathwright's life that is collected in this iCloud. And really, based on Detective Ramos' testimony, there was no significant limitation that he could establish that might have been lawful. And even if there had been, he completely ignored it and went far outside of whatever limitation it might have been. I've been prepared to argue that June 1st to July 12th was substantially overbroad because it encompassed far more time than this conspiracy could have even arguably existed. And we went back and asked when was this first advertised that there would be a Charles Jones show in Tampa, and that was June 14th. So anything before June 14th could not have impacted this, could not have been evidence of the conspiracy, because there could have been no conspiracy. Nobody knew Charles Jones was going to be coming here until June 14th. The evidence or the facts set out in the affidavit are really pertained to actions that occurred June 22nd and June 28th. In any event, nothing before June 14th could have been relevant. Yet this goes 2 weeks before that and then goes substantially beyond the time the conspiracy was alleged to have existed. Under the circumstances, Your Honor, and I would I cite to most of the cases I'm relying on, but the one that I didn't cite is Pilling, which I have a copy of.
Okay.
It's referenced in Demons.
Okay.
It's a district court case from Idaho, so obviously not binding on it, but it's a very, very similar circumstance that they dealt with. And that one, and in Demons, I believe I said also relies on that, but in that one, basically it's the same thing. They get an entire Apple iCloud dump. Apparently there's some discussion about, there may have been some attempts to purge the information that would have gone outside the relevant limitations, but it states, and this is on, I believe it's the third page of the printout, that the government realized it inadvertently failed to purge the data, and essentially everything ended up being looked at. It appears that was done accidentally. Here it was done intentionally. But in any event, they go forward, find that the warrant was substantially overbroad, just as we have here. And then at the end of the case, the last 2 pages, they discuss why severance can't apply in that situation. And similar to what the court found in Demons, they're saying that you can't sever this because of the relative size of the valid and invalid portions of the warrants. And the portion that might arguably have had some relevance was relatively insignificant given the substantial size of the information that they had. Then they go on to conclude the opinion by finding additionally that the suppression was also justified because the government did not filter any of the unresponsive data before reviewing the defendant's entire iCloud account. And that's exactly what happened here. Even if in Pilling there was some attempt, there was no attempt whatsoever here. As Detective Ramos' testimony established, he had no intention of limiting anything. He was looking at everything that was going to be in that iCloud. And he did so. And I think the substantial portions of what he took out of that he finds to be relevant would have been far outside even the date range in this search warrant. But he didn't confine himself to that in any event. Good faith exception is obviously something that may be brought up. I don't see any way the good faith exception can apply here when the detective drafts a search warrant affidavit that he himself says he has no intention of limiting to any kind of temporal limitation. So even if the court arguably saw this to be a temporal limitation, it was essentially Detective Ramos deceiving the court because he said in his own words he had no intention of limiting what he was going to look at. And then even if the court did, issue what it believed to be a good faith warrant, Detective Ramos had no intention of following the limitation, and he didn't. He went far outside of it. I would suggest, Your Honor, even the date range of 6/1 to 7/12 in light of Blake and the other cases that we rely on, that's a facially deficient warrant. But regardless, Detective Ramos, number one, had no intention of the court limiting it to that date, and he had no intention of abiding by those dates. So I don't see any way the good faith exception could apply.
Okay, thank you, Mr. Wise. Ms. Ismer, why should the state not be limited to the dates of June 1, 2024 through July 12, 2024?
Number one, because the return was accurately complied with by Apple and Detective Ramos, but also because in the months leading up to the incident, several of the items of evidence that were discovered within the time frame that's listed in the original warrant date back to or in some way connected to evidence that's also located on the device in the months before. There were several representations by the defense that Detective Ramos nor Apple abided by the warrant. I believe there was some insinuation that there was misconduct or an ill intention by Detective Ramos. But if Mr. Wise has read the content of the search warrant, including the probable cause affidavit, what Detective Ramos requested was included in his request were the iCloud backups from both of these accounts from Mr. Gathrigh's devices. And that is exactly what Apple provided. When he backed up those devices between June 1st and July 12th, the information from the months prior were included in that backup. So yes, that is what was provided to Detective Ramos. There was also the reason for requesting such information also testified to by Detective Ramos, because oftentimes those items are either mislabeled, not labeled, and now with Apple's ability to actually change the date and time on photos and videos in devices, they make requests that specifically cover that type of occurrence happening. So it's not an overbroad warrant, but more specifically, the time frame from before the offense itself has several links to the temporal timeline that was provided of June 1st to July 12th. The specific example that we gave, or at least I asked Detective Ramos about, was in particular a photograph that depicted two separate rifles or assault rifles on the ground. The photograph, as it was discovered in the device of Rashad Murphy that had been previously discussed, was sent to Rashad Murphy's device from Sean Gathrigh's device within the temporal time frame that was listed in the warrant. But that photograph actually originated when you selected it or clicked on it in Mr. Gathrigh's device, having been received at a time in March of 2024. And so when you actually open the file and look to created by modified date, you could see the trail of where that photograph came from, and it would certainly be relevant to this case. Neither Apple nor Detective Ramos actually violated what was requested in the search warrant or what was actually disclosed or provided in the data that he received. So in looking through the data or the backup that occurred between the temporal timeframes that were listed in the search warrant, which again is also not overly broad, but what's been stated and the evidence that they had at the time of the premeditation leading up to the offense itself, and then ultimately the flight from and attempt to conceal their identities thereafter, it's an appropriate timeline of evidence that they were seeking. Several of the Jacksonville detectives also testified about their having seen visually several of the defendants or the defendants getting into it with the victim in this case in advance of his homicide. And so having a time frame which spans before the offense itself and thereafter not only provides a full picture of all of the data that's relevant to the case, but also the relationship of that device and if there are changes. Does this device typically stay in Jacksonville? Did it travel to Tampa on this weekend? You're not only establishing direct evidence from the date of the offense itself, but also the pattern activity for that device as well.
Okay, so if I'm understanding you correctly, so the photo of these firearms that was on Mr. Gathrigh's phone, it was originally received on his phone in March of 2024?
Yes, March 27th of 2024 from Isaiah Chance's cell phone.
Okay, so Isaiah Chance sends a photo of Mr. Murphy or Mr. Gathright?
Isaiah Chance sends a photo of two firearms on the ground, rifles on the ground, to Sean Gathright.
Okay.
That photo is then sent from Sean Gathright's device to Rashad Murphy's device in June.
June what?
June 20th of 2024 at 3:02 a.m.
Okay. Okay, and so if I'm understanding you correctly, so in the temporal time limit of June 1, 2024 to July 12th of 2024, so the subpoena goes out to Apple and then they send in everything that was on the phone during that time period, or that account during that time period, plus any backup. So anything that was backed up during that time frame also gets produced, correct?
Yes, they would not have what's on the physical device. They would only have the backups.
Okay.
Because it wasn't a search warrant for the physical phone itself. Only whatever went to the cloud, this, storage location. They would only have if the device was backed up, whatever that file was, and the dates of the backups. So they could only provide or produce backups in the timeline that they were given in the search warrant.
Okay, but that then kind of becomes a dragnet that brings in, even though you're putting a temporal time limit on this application for the warrant, and that's what the judge signs, and that's what the warrant says, nonetheless, because if the device or if the iCloud accounts are backed up during this temporal time frame, then everything that was in the accounts now gets brought back in, correct?
Correct.
Okay. Okay.
The reason it becomes relevant, Your Honor, is for several points. If a file is deleted or altered in some way, it would not have a time frame linked to it. So that would come with the backup. We would often be able to see it if it's deleted and not overwritten. But if it is, sometimes you can't see the file, or sometimes you can say where it says deleted and can't open it. But those actions are also relevant if files are deleted at or near the time of the offense itself. Then the files that link back to the prior incidents, if they are linked to the data that's provided to the offense in some way, that photo I'm talking about from device to device between the defendants being one of the relevant examples, that is an argument as it relates to weight and relevance for the defense to make. The fact that we can trace that photo back from before this temporal time frame doesn't make it inadmissible evidence as a result of what was disclosed to us. When you open the file, if created date, modified date, and last access date because you received the photo of guns 3 months ago but sent them 3 days before the murder, certainly those are relevant to the case. So selecting that image, just because the data is dated before the time frame included in the warrant, it's also relevant and related directly to the time frame that we have.
Right. I understand why the evidence would be relevant. I understand that argument. I guess the question I have is, if the state has the ability to acquire all of the evidence in someone's iCloud account because a backup occurred during the time frame, then it kind of makes the time frame meaningless. There is no time frame, because then if the backup occurred, now law enforcement gets everything just by virtue of the fact that the backup occurred during the time frame, and so then, which makes the temporal requirement then really irrelevant.
If the court is presented with those items that the defense seeks to exclude. So had the state presented to you photographs, which we could establish based on the electronic data that dates had been changed on to before the offense, or that had been deleted, the court would have to look to those items to determine whether they were within this time frame, whether there was something in those photographs which allowed us to date it, or there was some evidence of them having been modified, which is why we would not exclude all of the evidence, but instead the defense would have to at least specify which items they are indicating are outside of that.
Okay. Are you prepared to do that, Mr. Wise? Are you prepared to make the argument that specific items of evidence are outside of the time frame on the subpoena and therefore shouldn't come in?
I certainly would have been, Your Honor. One of the things I asked to take from was him with his demo. He claimed there are photos where Mr. Gafford is making what he believes are gang signs. In my review, I don't think any such photos would have been within this time frame. So I asked him again last week, which ones are you talking about? Because I'd like to try to identify. This has almost 14,000 photographs. So it's not something I can do easily, but I've parceled out the ones I think might have a gang sign. None of them are in that data. So the short answer is yes, Your Honor. Again, I don't think this is severable. I think the entire thing should be suppressed. But even
I understand.
Even if it's limited, yes. I mean, I'm gonna ask the state to establish a basis for every piece of evidence from that iPod to show that it came from whatever the court finds to be the appropriate date frame.
Yeah. Okay.
I can add my phone, but
Yeah, no, I hear you, and I'm probably asking the wrong person. So shouldn't it be your responsibility to identify what items of evidence, assuming I find the time frame of June 1 through July 12th to be appropriate? Just assume for the sake of argument I do. Wouldn't it be your responsibility then to identify what items of evidence the state would intend to admit at trial, and then I would hear argument on whether or not that would be admissible. Would that be your job to do?
Well, at this time, Your Honor, the state's position is that the items that have been received in the response are admissible items. If the court is limiting the state's date range, then the state would obviously assert that the dates that are provided in the warrant are more than satisfactory based on the probable cause that's stated in the warrant. The issue then becomes the images that can be connected to or dated back to the other evidence in the case. So there are ways that the state can articulately provide those items, meaning we just have an evidence view of those items sooner rather than later. And certainly we can do that as it relates to the iCloud account for Mr. Gathright, if that would be beneficial to Mr. Wise, but nothing about that type of evidence view would change the state's position specifically as it relates to the timeframe that's listed.
Okay, all right. Mr. Wise, any rebuttal?
Yes. One, I certainly disagree that Detective Ramos and Apple did not violate this warrant. I think Detective Ramos' testimony last week, he more or less admitted. I mean, he did admit. He said this basically auto-populated, and even if that was, which I think it's reasonable to read that as a date limitation, and I think Judge Smith likely did,
Right.
but Detective Ramos sure didn't, because he said himself he went far outside that. And with respect to the backups, if an account is backed up, it may be relevant to see evidence that it was backed up during that range, but that doesn't just open the door to look at everything that was on the backup. Because if we're doing that, I mean, what's the point of putting any limitations in this warrant?
That's my question.
Right. So I don't see how, again, the fact that it's backed up, sure, that's relevant. If you find that the warrant's severable, but that doesn't open the door to just look at everything in there. And that's what happened. And looking at the hard drive that I have, it doesn't distinguish that I can tell. And I'm far from a tech expert. What was the backup and what was not? It gives two accounts, which are the two that are in the warrant. And I don't see how it distinguishes between what was backed up and what wasn't. It's just everything. And that includes almost 14,000 photos, 400 and something live photos. I can't remember how many videos. I believe a few hundred, if I recall. It's his life for 3.5 years.
Yeah,
I'm
no, I
not
hear you.
exaggerating. One thing I would add, and I recognize if the court finds some temporal range to be appropriate, I agree that if there's a photo maybe that's older that is sent during that range, that may be lawful under the warrant. But the problem is, and it's very easy, by the way, to do that, as Detective Ramos testified. You've got categories. You can click last access, date created, last modified. You can sort them all that way. It takes a long time because of the data for it to populate, but it's as simple as clicking a button. So it's pretty easy, I believe, to determine what would have been at least accessed during that range. But that doesn't open the door to going down trails that take it far outside. I mean, if a photo is from 2021 and it's sent during, June 24th of 2024, and the court finds that appropriate, I agree that would be within the range, but you can't keep going down rabbit holes and going far outside the range. And I think that's the problem. One thing I would point out, because I know it was brought up that, there may have been something that Jacksonville detectives knew. Obviously, the search warrant affidavit is confined to what's in the four corners of the affidavit. So I don't believe that, if there's other evidence Jacksonville knows would give reason to go outside the warrant if that's not something that's included in the affidavit. I've given my reasons why I don't believe this is severable at all. But I think even if it is found to be severable, this date range, and this is what I was prepared to argue before last week, is overbroad as it is. Again, anything before June 14th, I think, could not be relevant. This has a 1.5-month range, far beyond what they found in Demons to be appropriate, which was just a few hours before and after shooting. So in no way am I conceding that this warrant is severable at all. But even if it is, the date range we have is substantially overbroad, and I believe it would be a violation of Blake in the many cases that it addresses.
Okay, interesting. All right, I'm going to take this one under advisement as well. But State, if I were you, I would start looking at the items of evidence that you would specifically intend to introduce. And if it was outside of the date range that was in the warrant application, which would be June 1 through July 12th of 2024, and the only reason law enforcement gets a hold of it is because the account was backed up. That's the only way they get it. You all need to start looking at what items of evidence you would actually intend to introduce, and you need to have an argument as to why. Okay, if I were you, I'd start doing that. Okay, all right, very good. I think that's it on the motions to suppress, correct?
Yes, Your Honor.
Okay, all right, it's 12:06, so let's go ahead and take our lunch recess, and we will reconvene, let's say 1:40, and we will continue on with the penalty phase motions. Move, I guess, back to the.
So I guess the one good thing that we can all look at is that I've never seen Judge Cisco ever put the state or the prosecution team up under any advisement. And she basically told them they better look at this evidence. They better make sure it's included in that warrant or what they asking for. Now, we probably won't get her doing that at any point in time when we get to the trial next month. But that is something different coming from Cisco. I'm surprised. She usually be down the defense neck, but looks like in this thing, she like, y'all better be looking and making sure that y'all got this evidence correct on the dates and things of that nature. I am looking at the documents to see if there's any documents that we should kind of go over from the motions and the pendants, but let's continue to see what we have got done. She's heard everything in regards to the motions to suppress. So now we're moving on back to the DP stuff. So let's go back into that. Wow. I've never seen her do that.
Penalty phase motions. And I did take a look at the scheduling order that I entered. And the defendants were supposed to have disclosed all penalty phase witnesses, including expert witnesses, by November 17th of 2025. For any expert witnesses, the defense must also disclose any and all records relied upon by the experts in reaching their opinions, as well as any reports issued by the same expert witnesses. And the state had until December 15th of 2025 to disclose all penalty phase rebuttal witnesses, including expert witnesses, with the same requirement to disclose any and all records relied upon by the experts. So I'm assuming everyone's complied with the court order.
Judge, we did list a witness expert, and I believe you wrong his name since we listed Dr. Myers. Yeah, we have been working on trying to replace him. He had to jump off because of volume of other cases. So we're searching right now. We've been searching.
Okay. Is he what type of expert is he? Mental health rebuttal?
Yes, he was a forensic psychiatrist.
Okay. And
that's for potential rebuttal testimony.
Okay. And then have any of the defendants listed a mental health mitigation expert for penalty phase?
If I could just ask a question regarding Mr. Harmon stated, I assume that was Dr. Myers as it relates to a particular defendant, Mr. Murphy, or?
Oh, no, it was Dr. Myers. I listed him and I believe all defendants.
Okay, I got it.
Yes.
Okay. So have the defendants identified mental health mitigation experts in their penalty phase witness list?
Jennifer Nicholson on behalf of Sean Gathright. I did list a doctor, and I indicated on there it was for mental mitigation. We are working on scheduling for deposition. I provided a couple of dates. I do not have a report yet, so I'm hoping she.
So just an update from what I can see, and what I'm hearing, DP is on the table. The judge is saying, hey, if this gets to DP, what witnesses do y'all have, or what would y'all like to present during the DP phase, if it gets there? And that's why she's saying, do y'all have any psychiatrists? Do y'all have people that's going to speak up for the defendants during this period of time? So it's also my understanding, just so everybody aware, that the reason why they didn't go to trial much sooner than what we are going now is because they were going for DP. When the state mentioned that they wanted to go for DP back in October. So yeah, I think that they're gonna be seeking the DP, and they talking. Yeah, I don't think this is just about the witnesses and stuff. But let's go back in. We can continue to listen.
Yes, that over to me. I spoke with her yesterday. That way I can get it to the state before the deposition. As far as records, there really isn't much, so I shouldn't have anything voluminous to send over.
Is the depot scheduled?
We talked about 2 dates. I sent over 2 dates yesterday. We don't have it yet scheduled, but we were looking at March, I think I said 25th and 27th.
Okay. What about Mr. Chance?
We listed 2 doctors, they removed one, but the other doctor we have scheduled for Monday.
For depot?
For deposition.
Okay.
She didn't do a report, and I'll verify. I don't believe she has any record themselves.
Okay, that's fine. Well, at a minimum, at her deposition, she needs to be prepared to answer if she relied upon any records and to bring them with her, so they can be disclosed. Okay, what about Mr. Davion Murphy?
Yes, so we listed one expert who has been disclosed. The report has been disclosed. The documents have been disclosed. There might be a potential for listing another expert
because we're waiting on an order, and I advised Mr. Harmon of this. We're waiting on an order, perhaps we're going to have it, for funding for a neurologist. And then funds to expend for potential brain scans.
Okay, and what type of doctor is the expert that you have listed?
He is a neuropsychologist.
Okay. This would be a different type of expert?
This is a neurologist. We need a neurologist and then a neuropsychiatrist.
But you have the person lined up, correct?
Yeah, we're just waiting on the orders.
Let me take a
I
look.
didn't file these motions, but I was in trial, but
Let me just take a look. There's something in my queue. I think I signed some orders a couple days ago
okay.
that were,
Order on neurologist, okay.
yep, I signed both those orders on yesterday.
Yes, sir, to the neurologist, and then the funding for the reading and scans.
Yeah, I'm not looking at the orders. I'm just looking at the title, but I signed 2 orders yesterday for your client. So I'm assuming that's what they are. So the fund's been authorized. So how quickly can you get this expert witness listed in discovery?
I would first have to get this, my client, potentially, well, first I need a script, then I have to get my client to the facility to get scanned, and I have to get the discs, then I have to send them to the other individual, and so it'll take a little bit.
Okay.
Part of the issue will be also working with the facility to get a date.
Okay.
And transport.
All right, so Mr. Davion Murphy still needs to identify his second expert that he intends to call. Mr. Chance and Mr. Gathright have identified their potential mental health expert witnesses. And then what's going on with Mr. Rashad Murphy?
Judge, don't quote me, but I believe the court might have had a colloquy with Mr. Hernandez this morning, and Mr. Harmon maybe can correct me, conversations with Mr. Hernandez about proposing his expert.
That he's listed him.
Yes, he said he had listed him. I'm not sure what type of documentation.
Sure, that's fine.
But yes, he's been listed.
At this point, I'm just trying to make sure all of the witnesses have been identified.
Judge, although I can't tell the court I was 1,000% listening, that's what I recall happening this morning, is that Mr. Harmon acknowledged that Mr. Hernandez had provided him the name of the expert.
Yes, Judge, just to put on record, all penalty phase counsel have been communicating, we've all been communicating by email about these experts, setting them for deposition, and it's been going very well. All of them have been in communication with me, trying to provide dates and get dates from their experts. Mr. Hernandez emailed me on the 25th of February about Dr. Collins, I believe. Is that correct? Brian, does that sound right?
Scott, I can't tell you.
Okay, so Dr. Collins, he emailed, he's planning on visiting Mr. Murphy one more time, proposing him in mid-to-late March if that works, and that does work for me, as long as I can, have time to get him proposed, get the transcripts back. So,
Okay. So let me just take a look at the calendar here. So Mr. Harmon, for all of the experts that have been identified, the defense experts, has a deposition date been scheduled?
not for all of them. I believe the only one I have scheduled right now is with Mr. Petridis. Is that correct, counsel?
We are scheduled for Monday. Yes.
For Monday, yes. Ms. Finkelstein's already indicated she provided dates, and hopefully we'll have that set up by hopefully the end of the day. Ms. Toomey has provided dates, is that correct? Yeah. So I was out yesterday. I know they both sent emails to me, so I haven't had a chance to review them.
Okay, so you guys have until today's Wednesday, close of business this Friday. I want you all to at least have dates agreed to, okay? For any outstanding witnesses, specifically the expert witnesses. And then as to the potential new expert for Davion Murphy, the neurologist, how much time do you need?
Judge, I'm gonna have to get with the doctor and see how quickly he can go out and see him so that I can get the script and then I can contact the facility. So I can email him now during this this afternoon and see when's the earliest he can.
And it needs to be rapido, not, because we had to start, I want this done before we start picking our jury, okay? So my preference would be on or before, at least gets identified on or before March the 20th.
Judge, back to the setting of depositions for all witnesses, including experts. I'm responsible for doing the penalty phase lay witnesses, and there are numerous ones, and I have not started to coordinate. Can I have by the end of the week?
Yeah.
Thank you.
By 5 p.m., March the 6th.
Thank you.
All depositions need to be on the books, okay? And then state, how much time do you need to get your rebuttal, penalty phase rebuttal expert identified?
I would ask for at least till the end of this week. I've been speaking with Ms. Toomey about a potential anticipated expert. I've already started looking for a rebuttal witness for that anticipated testimony, depending on if the PET scans or brain scans lead to what I'm believing they may or what they may present.
So are you telling me that you've got to for sure hear from Ms. Toomey regarding this neurologist before you can identify your potential penalty phase rebuttal
Well, she had
expert?
mentioned Dr. Wu, and I dealt with Dr. Wu before. You may recall Dr. Holder from the, I want to say the Ritchie case. He is now become medically incapacitated, so I'm trying to find another radiologist, neurologist to provide. But I started, she had brought that to my attention last week when we were all having discussions about where we're at in penalty phase with our preparation, and I started looking.
Okay, so Ms. Toomey, see if you can make contact with your potential expert this afternoon, and then we'll discuss this again. Okay?
Yes.
Okay. All right, so let's start off with the state's motions in limine. You all were present. So state's first penalty phase motion for order in limine. Is there any objection to that being granted? Okay, for Mr. Chance? What about Mr. Gathright?
No, Your Honor.
Okay, and Mr. Davion Murphy?
No, Your Honor.
Okay, so that motion will be granted as to all defendants. Moving on to state's second penalty phase motion for order in limine, having to do with regards to any argument or evidence concerning the actual method of execution or any description of an execution or the method of execution. Any objection by Mr. Chance for this motion being granted?
No.
Any objection from Mr. Gathright?
No, Your Honor.
Any objection from Mr. Davion Murphy?
No, Your Honor.
Okay, this motion will be granted as to all defendants. All right, next up, state's third penalty phase motion for order in limine regarding the individual beliefs of any person, organization, or religion on the death penalty. Mr. Chance, Mr. Petraeus, on behalf of Mr. Chance, any objection to this motion? Any objection by Mr. Gathright?
Your Honor, I don't have an objection. What I did advise Mr. Harmon, and I believe it's not stated in the motion, so it shouldn't be an issue. He said argument or evidence. Obviously, this comes up in jury selection. I just wanted to make sure.
Yeah, no, we're just talking about penalty phase evidence. Okay, all right, and then Davion Murphy, any objection?
No.
Okay, this motion will be granted as to all defendants. State's fourth penalty phase motion for order in limine. This has to do with any description of death, including any deaths depicted in any novel, motion picture, or television show. Mr. Petraeus, on behalf of Mr. Chance, any objection to this motion? Mr. Gathright, any objection? Excuse me, on behalf of Mr. Gathright. And on behalf of Mr. Davion Murphy, any objection? Okay, this motion will be granted as to all defendants. State's fifth penalty phase motion regarding comparing the facts of this case specifically to any other capital case. Any objection to me granting this motion? Mr. Petraeus, on behalf of Mr. Chance. As to Mr. Gathright, any objection?
No, Your Honor.
And Mr. Davion Murphy, any objection?
No, Your Honor.
Okay,
No, Your Honor. I was just making sure.
sure. This motion will be granted as to all defendants. State sixth penalty phase motion having to do with the changing the laws regarding the death penalty in the state of Florida. Any objection, Mr. Petraeus, on behalf of Mr. Chance, to this motion? On behalf of Mr. Gathright, any objection?
No, Your Honor.
On behalf of Mr. Davion Murphy, any objection?
No, Your Honor.
Okay, this motion will be granted as to all defendants. And as to all defendants, the state filed the state's motion to compel that the defendant provide penalty phase witnesses and evidence. And this motion will be granted as to all. And again, I have a scheduling order. And we will continue to discuss this. And as always, if there's an issue, just let me know. The sooner you let me know, the quicker I can deal with it. Okay, I think that's it for the state's motions. So let me just break down. Let's see. We're going to start with Mr. Chance. Hold on 1 second. Let me get all of Mr. Chance's motions in front of me.
Yes, Your Honor.
Okay, very good. I have them. Where would you like to begin, Mr. Petratus?
The courts. I know you have them in order.
I just will go in the order I have them right now.
Yes, Your Honor.
Okay, very good. Okay, let's start with the motion to declare section 921.141 L, I believe, Florida statutes unconstitutional and to bar state's use of hearsay evidence at penalty phase proceedings. Right? Any,
Judge, I'm going to rely on the motion and the case law contained therein and have no further argument.
okay. And Mr. Harmon,
Judge, we filed responses to all of Mr. Chance's motions and we'll rely on our written response.
okay. All right, I will deny the motion to declare statute 921.141, I believe that's L, unconstitutional, and I will also deny the request to bar the state's use of hearsay evidence. Hearsay evidence is admissible at a penalty phase proceeding, assuming that the defense is given a chance to rebut that evidence. So that motion will be denied. All right, next up, motion for findings of fact by the jury.
Yes, Your Honor. We would, Mr. Chance, we would rely on the argument and case law contained therein and have no further argument here today.
Okay. State?
Your Honor, we filed a written response. I'll rely on the state's response.
Okay. And just for the record, this motion would, is asking that I say that the jury's got to find additional findings of fact other than what the jury instructions require them to do in a capital case. So I will deny the motion. All right, a motion to declare 91.1416N unconstitutional.
Judge, we would rely on the motion, argument, and case law contained therein.
Okay, and this is the criminal gang member aggravator, correct?
Correct, Your Honor.
Okay, Mr. Harmon?
Judge, we filed a written response. We would rely upon that in the argument that the aggravator is constitutional, especially in light of the heavy amount of evidence of showing a nexus between the facts and the aggravator.
Okay, that motion will be denied. All right, motion to declare cold calculated and premeditated aggravator unconstitutional.
The same, Judge. We would rely on the motion and the case law therein.
State, you rely upon your response?
Yes, Your Honor.
Okay, I will deny that motion. Motion to declare 921.1412 and 3 Florida statutes unconstitutional. Mitigation must outweigh aggravation.
Same, Your Honor. We rely on the motion, the argument, and the case law contained therein.
Okay, Mr. Harmon?
Your Honor, we'll rely upon our written response.
Okay. We're going to stick with what is required currently under the law for the jury, so I'm going to deny that motion. Motion to declare Florida's death penalty unconstitutional based on violations of Article 1, Section 4 of the Florida Constitution and the First and 14th Amendments to the United States Constitution. Mr. Petratus?
No further argument, Judge. We rely on the motion, the cases and statutes contained therein.
Okay. Mr. Harmon, you rely upon your response?
Yes, Your Honor.
I will deny that motion. Motion to declare 921.1417 Florida statute unconstitutional and for pretrial determination of admissibility of all victim impact evidence. As to the, let's see, unconstitutionality of victim impact evidence, any additional argument, Mr. Petratus?
The only thing additional I'd say is I know the court had a specific ruling as to when Mr. Hernandez was up here. I believe you had said it to all defendants, so
Yeah.
other than.
So, yes, so any victim impact evidence has got to be in written form, and the state has to provide that letter, that written form to you all at least 24 hours before any person would testify. And at this point, it's got to be an adult. And at this point, the state's not limited to the number of individuals. However, at some point they may be, so you can always renew an objection if you feel that there are too many individuals that they intend to call for victim impact.
Yes, sir. No further argument other than that.
Okay, so I will deny the motion as to the unconstitutionality of section 921.141 subsection 7. And I will grant the motion with regards to pretrial determination of admissibility of all victim impact evidence, in that the state's got to disclose what they intend to have read to the jury, and then if there's a dispute or a challenge, I'll hear it. Okay?
Thank you.
So denied in part, granted in part. Okay. Defendant's motion to preclude imposition of capital punishment.
Judge, I'll just rely on the motion and the case law I cited in the motion.
At this point, well, any response, Mr. Harmon?
No, Your Honor, other than our written response.
Okay. So at this point, I read this as a wholesale motion to preclude imposition of capital punishment. So I'm going to deny the motion. However, you're not prevented in the future from, particularly assuming we get there, at a Spencer hearing, any arguments that are available to you, legally.
Yes, sir. Thank you.
But that motion will be denied. All right. Do you have any others?
I have one more.
Okay.
I believe objection to death qualification of the jury.
All right. I don't see that, but it may be here somewhere. And tell me what the motion is.
I should have it here, Your Honor. That's a
Oh,
long
wait,
one.
hold on.
If I could,
Well, it was when everything was in line, but I took it all out. So now it's good luck. Okay. Good luck putting that. Okay. Oh, here I've got it. Good luck putting that genie back in the bottle. All right. Let me just take a look. Okay. State, any further response?
No, Your Honor, we filed a written response. There are multiple grounds raised in the motion other than death qualification. We addressed each in our written response.
All right. The motion will be denied.
Your Honor, I believe that's the last one I filed.
Okay. All right. So moving on, Mr. Gathright, on behalf of Mr. Gathright. Okay. Do you have a particular preference as to order?
You can tell me.
Okay, all right. I'll
Whatever
just
you
go
have
in.
there, I'll go with you.
Okay, I'll just go in the order I currently have them. Okay. So, motion for victim impact statements to be read by a neutral party. State what's your response to that.
Is this the motion in the general procedure?
No, this would be Gathright, motion for victim impact statement to be read by a neutral party. I guess they don't want an actual.
I believe I filed a response.
Yeah, you did, you did.
And we object, obviously, to that.
Right. I mean, family members can read their statements, correct? Under the law?
Yes.
Can and they do.
And Your Honor, we would just ask for the same ruling or indication from the court as you did earlier, as far as if there's any minors.
Right. So same situation, any victim impact evidence, if there's going to be a written statement that's read, it has to be provided to defense at least 24 hours before the victim reads the statement. And at this point, it cannot be a minor unless we talk about it. And if there's any dispute, then I'll take a look at it and I will resolve the issue. So as to the specific request that the victim impact statements be read by a neutral party, I'm going to deny that motion. Motion to declare Florida Statute 921.1418 victim impact evidence unconstitutional.
Yes, Your Honor, we rely on our motion.
Okay, state you rely upon your response.
Yes, sure.
Okay, that motion will be denied. Motion to preclude any potential death penalty proceedings based on violations of the constitutional right to a grand jury indictment.
We would rely on our motion, Your Honor, indicating aggravating circumstances or elements of a capital homicide, which must be pled by the state attorney and unanimously found by a jury.
Okay, Mr. Harmon, you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. Motion to strike proposed aggravating factor number 1 from the state's notice.
And Your Honor, I think based on a conversation we had last week, we can withdraw that motion. My understanding is the state's solely relying on the facts of this case that would be heard in guilt phase.
A contemporaneous conviction, not anything prior.
Right.
All right, so that motion is withdrawn. Next up, motion to declare section 921.1416C unconstitutional on its face and as applied. This is the risk of harm
Yes.
aggravator.
Great risk of harm aggravator, finding it vague and overly broad. We rely on the memo in our motion.
Okay, Mr. Harmon, you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. And motion to bar imposition of death sentence on grounds that Florida's capital sentencing procedure is unconstitutional.
Yes, Your Honor, we have indicated in that motion that the procedure is currently unconstitutional, permitting a verdict of death on a non-unanimous vote of the jury, and would rely on the memo contained in our motion.
State, you rely upon your response.
Yes, Your Honor.
All right, that motion will be denied. Do you have any others?
We had, it looks like, motion to declare 921.1416I unconstitutional. Let's see, and that's for CCP.
Okay.
You see
And
that?
I've been saying I, is it I or one? I don't know. Okay.
And we'd rely on our motion.
Okay.
If you have it, you have it.
No, but if I mean, the motion is filed is to declare the CCP aggravator unconstitutional.
Correct.
Okay, that motion will be denied.
Let me just double check. We did have a few motions in limine. I think we can agree on most of them, but just, we did.
Yeah.
Both were denied.
There's a motion to eliminate as to general procedures, I believe.
Yes. Oh, and I'm sorry, Your Honor, there is one more we filed the motion to strike the aggravator that was withdrawn, but we do have a motion to declare 921.1416B, the prior capital or violent felony, the constitutionality of that. And we rely on that motion if you have it. That one was filed. Some of these are filed at different times, which would be, that one was filed early January. The state did file a response to that as well.
Okay, do you rely upon your response?
Yes, Your Honor.
Okay, that motion will be denied.
I think that was it for the constitutional and those motions. We do have a motion in limine for general procedures.
Okay, what does it state?
The first one, I believe the state didn't have any objection. Section A of that motion was reference to non-statutory mitigating circumstances and use of words such as catch-all.
Yeah, we have no objection.
Okay, granted.
The next one was section B, the presence of media, family members, and uniformed officers and shackling of the defendant.
Okay.
I know this, go ahead.
No, it's okay. Your Honor, I spoke to counsel about this last week. We agreed, obviously, to any kind of shackling in the presence of the jury during guilt phase. It's my recollection from Khrushchev, and I believe Richie possibly, that during penalty phase, we maintained that. So the shackling is outside, it's covered up.
Yes.
Okay. As far as the other matters in that ground, we would defer to the court as far as the media.
Okay. And tell me, I feel like I've seen the motion, but I can't find it right now on my desk. So,
Your Honor, essentially, we are asking that the court instruct the members of the media to not interview witnesses, family members, courtroom personnel, people involved in a place in the courthouse that could be subject to the jurors observing, seeing.
Okay.
I believe there's also a ground about use of cameras in the courtroom. If I'm just kind of looking at this from last week, there's an administrative order that deals with that.
right, there's only one camera that's permitted in the courtroom, and it's got to be out of the way. And I do have a whole discussion with the jurors that they understand that their faces will not be shown, their identities will not be disclosed. So, yes, the motion will be granted, and that they've got to, the media knows, and they've got to follow a certain procedure established by the courts, and I assume they will.
Perfect. The next section, we were asking C, names and addresses of potential jurors summoned to try the case and individual questionnaires I don't believe that's your honor's practice, but we were seeking to do individual questionnaires for the jurors.
Okay, that will be denied. And then as far as the names and addresses, we get those the day the jury is pulled. So, and I think I told you all we're gonna do 3 days of 150 back to back. So you'll get the 150 on the Wednesday, the next 150 on Thursday, the next 150 on Friday, the morning of.
Okay.
Okay. So you'll get them, but not before that.
Not now.
So I guess it's granted, but you'll get it the day of.
And we were also asking for individual and sequestered voir dire. My understanding is that the court does the individual or smaller groups as to hardship or media exposure.
Yeah, so individual voir dire will be done on anybody that thinks they know anything about this case. With regards to hardship, that will be done as a group for those that are claiming a hardship. And then on death penalty voir dire, that will be done again in small groups. That's not my traditional practice, but because of just the number of people that will be coming through for jury selection, I am going to break it down, the death penalty qualification questions into smaller groups. So probably the 30 to 40 range, we'll see whatever we think we can get through in a day. So, and I think I did mention this before, that normally I have a whole speech that I do before phase 2, which is death qualification. And I know the state has Mr. Harmon has a speech that I've seen him do before he begins. And normally I give the speech when we actually move on to phase 2. But in this case, what I'm going to do is I'm going to give my speech first thing Wednesday, Thursday, and Friday to the group of 150 as a whole, just because it is can be time consuming. And by the time I get done talking, by the time Mr. Harmon gets done talking, and then if the defendants wish to make a statement regarding penalty phase questions, it's, we're now into an hour and a half and we haven't even started talking to any of the jurors. So my plan is that Wednesday, Thursday, and Friday, the first week of picking the jury, I will give my speech to everyone there, but I will remind them that we're not going to be asking them any questions related to the death penalty in phase 1. And then if those that come back to go into phase 2, which are the death penalty questions, I will then just give them a brief reminder of what I said to them, and then I'll give Mr. Harmon a chance and the defense counsel a chance to give a brief reminder before we actually begin the questioning of the jurors.
Okay.
So if you all want to make a succinct speech regarding death penalty voir dire, you're welcome to do so. Okay. But you'll do it Wednesday, Thursday, Friday morning.
Once
of
we
the
pare
group.
down a little bit.
Well, you do it initially to the whole group.
Okay.
And then those that make it to phase 2, like I said, we'll do just a quick reminder of the points that were made when they first came in, but we're not going to do another wholesale intro for each of those small groups because it'll take forever. Okay.
Okay. Let's see, next was section E, objections being made contemporaneously with the occurrence of error to avoid procedural default. No, did we discuss that, Scott? I don't remember if you had an agreement to that or not.
No, I don't believe we did.
Okay.
So is there any objection?
Judge, I would just, so when I just tried to ask counsel for clarification on contemporaneous objections. Objections made at the bench, objections made from counsel's table.
Just so there's not speaking objections from the
Right.
council table.
Granted,
Thank you.
I don't like speaking objections.
No, I don't think anybody does.
Some people like them, or at least some people
That's
like to
true.
make them.
Yes.
They do, but
Or some judges, when you say, can we approach, and they say no, and then you have to do it.
right.
And the last one, I believe, is section F, which was miscellaneous matters.
That's what the attorney said,
And I
that
believe that the state is in agreement with that section.
judges don't.
Correct me if
I
I'm
know
wrong.
this,
But
of
she's
course,
talking about the last round, guys.
in the past, being in front of your honor, when the state asked for the record to reflect that witnesses identified the defendant. the record would so reflect.
Right. That's all they ever say.
Perfect.
So I guess it's granted.
Oh my gosh, is her face oiled up or is it just me on my screen, y'all? Y'all let me know. Put a one in the chat if y'all see that oil. Good grief, she need a towel. Can't tell if she's sweating or what's going on. Good. Oh, wow. Maybe the camera hitting her in the wrong way. She needed powder.
With the understanding that that's what I will say.
Okay. And I believe that is it. We handled the state's motion to eliminate. Is that all you have? Okay.
Okay.
That's all
all
on
right.
behalf of Mr. Gathright. Thank you. Your Honor.
Okay, thank you. Okay, and Mr. Davion Murphy. All right, you want to start off with defendant's motion to strike aggravating factor, section 921.1416N as unconstitutional, and that's the criminal gang member aggravator, correct?
Judge, you're talking about my motion to strike? I apologize.
Yes.
Okay, so my motion to strike the aggravating factor 921.141BN.
Oh, we're switching to a different, I was
Oh.
looking at 6N,
Okay.
but that's fine. We can start wherever you want to
No,
start.
I was going to start at the general procedures and work from there, but whatever Your Honor wants.
Okay, it really doesn't matter.
I think it's probably easier. Not that anything needs to be hard.
That's fine. So where do you want to start?
The motion in limine regarding general procedures. I spoke with the state. I think we're pretty much in agreement.
Yeah, the motion is very similar to Mr. Gaffrey's motion.
In that it appears the state agrees with paragraph A,
I do, the state does agree with that.
and that is in regarding the non-statutory mitigating circumstances. Paragraph B, if I recall, you left that up to the court's discretion, and that will be the presence of media, family members, and uniformed officers and shackling of the defendant.
I don't think we address family members as far as that goes. I don't think there's any limits to family members being in the courtroom. We always instruct them not to wear anything that's provocative to the jury, such as photographs or any kind of memorandum.
Wait a minute, they're gonna know. They're gonna know. Oh gosh, let me rewind it so we can see what the note is that he's trying to do. Oh wow. He said he putting up a note of SOS. Here we go. SOS. Wait a minute. Oh gosh, this is fun tea. He tried to tell her, he said he'd be a recording. He want to let her know.
And then
I don't think we address family members as far as that goes. I don't think there's any limits to family members being in the courtroom. We always instruct them not to
Hey,
wear.
wait a minute. I gotta see what it say now. Oh, this is crazy. He must can't get a phone now. It said, drives me crazy. Marshana Williams drives me crazy, but she my bae, my wife, and I love I don't know what that say right there. Her. Oh, wait. I love her so much. Oh, he say Marshawn Williams drives me crazy. So I want to say, I don't know if that's serious, but she drives him crazy. But she, my bae, my wife, and I love her so much. Oh, he said he wants the world to know how sweet it is to be loved by, I guess, him. I mean, shoot, he ain't got no choice but to be all in love with his bae and stuff. Like, okay. I'm assuming that he couldn't get it on the phone call, or why he wanted to know, want the world to know that his boo, she drive him crazy sometime, y'all. But she's still his bae. She his wife, and he love her so much. You ain't, hey. Oh wow! When he didn't get his phone call, he needed everybody to know this. Oh, this did tickle me to death. Oh, good grief! I thought he was sitting out like I didn't know what kind of letter he had in the back of it when you was telling me about it, Lynn. But this, he professing his love. He say he gonna let the world know he love his bae. She may drive him crazy. I don't know why he got to put that. He said, drives me crazy. I'm assuming this is sometimes. So wherever you at, I think it's Marshana Williams. You drive him crazy sometimes, but he said you still his bae, his wife, and I heart her so much. Because he drew the little heart Oh, that's what he over there doing. You better be working on your damn case, boy. You better be taking down some notes about this damn case and how you gonna get off doing some damn hearts and some letters. That's what you better be over there writing notes about. Over there writing love letters. You can write her when you get in your back in your personal quarters. But right now, you need to be writing notes to understand how you gonna get yourself out of this damn jam so you can get home to your bae, your wife, and showing everybody how much you love her. Because I tell you, if you go away and you get these football numbers, I don't care how many damn letters you put up here or how many times you profess to the world, she is going to be out, in my opinion. Shit, he need to be writing some damn notes. He's sitting up there writing love letters to post out. He confess his thing.
Right. And the defendants are shackled, but not obviously to the jury.
Yes, Your Honor.
And so I guess the motion is that paragraph B technically is granted with the understanding that there's an administrative order that deals with the media. Family members can be present. They just can't wear anything that might be considered inflammatory or sending a message to the jury. And uniformed officers obviously can be present in the courtroom, as you have to have security, and the defendant shall be restrained, but not so that the jury can see.
Yes, Your Honor.
So it's granted to that extent.
And then as it relates to paragraph C, names and addresses of potential juror or someone to try the case, I heard the court in addressing this motion previously. I guess we obtain or are provided the names and the addresses, I think, the morning of.
Yep. So no questionnaire, and then you'll get the names the morning of. So deny the motion as to a questionnaire, grant it as to the names and addresses. And again, that will be provided the morning of jury selection.
And then the individualized and sequestered voir dire. I also heard, Your Honor, as well. I have done it both ways. I feel as if it's more effective, at least to do the penalty phase portion of it individually, as opposed to like in sections of 10 or 15 or what have you. But
yeah, I'm not doing individual. No, we're not doing that. So we're doing, as I said, small groups, anywhere 30 to 45. We're going to see what's workable with the number of attorneys we have, but it's not going to be done individually. So as to paragraph D, that's denied.
And then E would be very similar to what the court has previously ordered with regards to objections. Obviously, there should be no speaking objections.
Right, that's granted.
And then F has to do with miscellaneous procedures, one of those being where the state wishes to identify.
Come on, cameraman, I'm about to do it again. He ready. He getting ready. He ready. He about to do it again. He said, come on, cameraman. Come on. Get this again.
Identify a defendant for the quote record. I would ask that that be done at the bench as opposed to the court commenting that the record has reflected that so-and-so, whatever witness has identified the defendant. If that's
you don't want to get
requesting that be done at the bench.
Don't do it again, I guess.
I'm going to deny that request. So the state can ask it just if the record reflects, and I will indicate if the record so reflects. Okay.
There's no longer the issue with the
okay
expert. Okay, so then the next one, if Your Honor may, motion to declare section 921.141B1, which is CCP, which I believe the state filed a response to. And I would just stand on my motion. Yes. 6I.
6I. Yep. Okay, that motion will be denied.
And then the next one would be motion to declare 921.101.6B unconstitutional as written at and as applied, and that relates to the prior violent felony aggravator. I believe the state also filed a response.
Does this defendant have an actual prior?
I looked, I thought that it was in the,
Does he, or are
In
you
the
just alleging
notice.
the contemporaneous conviction?
Judge, I can't speak to whether he does or not. I know all the defendants were relying upon the previous convictions for violent felonies. I believe this is Mr. Murphy, Davion Murphy.
Yep.
I think it said or. I'm almost positive.
You believe he does, counsel?
I believe that the notice said or.
Or, okay.
Yeah.
I believe that's the wording in the statute, so we utilize that wording.
Okay. Well, as to it being unconstitutional, I'll deny the motion, but
You
obviously
got it in
before we
paper.
get into a penalty phase, if the state is
just
gonna
didn't
rely
put
upon
it
a
in the file.
prior
There you
violent
go.
felony conviction,
Let me give a
make sure
paper
you've
together.
given them the defense.
He said, if y'all didn't get it the first time,
To
there you
let
go.
them know before to start
Ooh,
trial,
Papa,
okay?
we got you. We
And-
seen it.
Then the next one will be motion to declare 921-1418 unconstitutional and for a pretrial determination on the admissibility of all victim impact evidence.
Okay. So as to it being unconstitutional, I'll deny the motion, but I will grant it with regards to a pretrial determination of admissibility.
Yes. And as long, obviously, that we receive those letters
Yes.
in advance.
Yeah,
That should.
same ruling, at least 24 hours before anyone should offer the victim impact evidence in court before the jury. Has to be disclosed.
And then I would also adopt, I did not file, although I did tell Mr. Harmon that I was going to be adopting the motions that have been filed on behalf of the other defendants regarding the constitutionality of the new death penalty scheme applying to Mr. Murphy, not based on ex facto or anything of that nature, but based upon just general 8th and 14th Amendment rights. So I would adopt all of those motions and incorporate those
Okay.
in his argument.
Same ruling, be denied.
Okay, and then finally, we have motion to strike the aggravating factor. I think is that what you started with?
I have, defendant's motion to strike aggravating factor, Florida statute section 921.1416N, which is the criminal gang member aggravator. You're relying upon your motion?
I'm relying upon my motion. Yes, Judge. Yes, I am.
Okay. State, you're relying upon your response?
Yes, sir.
Okay, the motion will be denied as to the unconstitutionality of that aggravator. All right, Ms. Toomey, any other penalty phase motions?
The only other thing that I might add for the record with regard to this specific aggravating factor, specifically for criminal gang members or associates, that has already been enhanced, I guess, if you will, in the indictment. So it's almost like a doubling up of that sort of kind of enhancement. So I would just make a general constitutional argument against the doubling up.
Okay, same ruling, be denied.
I think that's it.
I believe so.
Yes.
The list I have. Your Honor, if I could readdress my motion to compel, so I can kind of let the court know where we're at as far as documents and records. Ms. Toomey has provided me with voluminous records, and I appreciate that. All types
Of what kind of records?
School records, I believe DCF records, other records, medical records possibly, in relation. Social Security records dealing with Mr. Davion Murphy.
Yes.
I know, Mr. Petridis, have you listed more than one expert? Is it multiple?
Yes.
I thought you had, okay. So I haven't received any records from any other penalty counsel. It's my understanding if there is any that will be provided, I just want to bring it to the court's attention.
Okay.
I've reached out to my experts. I don't have anything to send, but I told them to check if we were going to have anything. Obviously, I'll send it to Mr. Harmon.
Okay.
That jogged my memory, Your Honor. We have a small number of school records from Mr. Gafford. I did a notice of intent to rely, but now I think about it, I don't think I actually sent the records to the state, so I'll do that today.
Okay.
It's a very 10-page.
Okay.
And then I think that's it that we have for records.
Okay. And have you received any records from Mr. Hernandez for Rashad Murphy?
I have not, Your Honor.
Judge, I'm going to text Mr. Hernandez now, and I'm going to also make a note to speak with him after the proceedings.
Okay.
And judges, is there a deadline on those records?
Well, yes, the deadline is come and
Rapino,
gone.
I heard the court say Rapino.
Pursuant to my scheduling order, those dates have come and gone. But anywho, I tell you what, let's do this. We're reconvening Friday, correct?
We are, Judge.
So I want you all to just make sure you check to make sure you have disclosed or are disclosing any records that you're going to rely upon in penalty phase. and then let me know Friday what your status is. And then if they've not been produced, then I'll give you an absolute, like, I'm not kidding deadline. I know my scheduling order should have been an absolute, I'm not kidding deadline, but things happen, so. Okay, and Miss Toomey, I know you were busy, but have you heard back from your neurologist by any chance?
I emailed him.
Okay, that's fine. So we're reconvening Friday, so I just need to know by Friday when he's going to be able to get his evaluation done, so that you can determine whether or not you're going to list him.
And that's exactly what I said, but I'm not reading.
Okay, that's fine. That's fine. Okay. Okay. Anything else we can get done today? Any suggestions?
Judge, I did have a motion in limine to all defense attorneys to requesting that they provide us with any sort of drill rap videos that they intended to use to list them and provide them in discovery. I don't think we addressed that.
Judge, if the court will allow, I have a brief response on that.
Sure.
Somewhere.
Do.
Judge, if I may, while we're waiting.
Sure.
I did file a motion. I'm assuming that this is probably going to be put on Friday with all the other gang stuff.
Yeah, unless it's something we can get done today, relatively simply. No? Okay.
Not because of me.
No, I'm not. It's okay.
Judge, if they would prefer it be heard with the other gang motions, that's fine. I just thought that was something, because I was just asking that it be provided in discovery and listed.
Right, that's what she's asking at this point, not the admissibility, but just that if you've got any other drill rap videos other than what the state is intending, and if you disclose to the defense the ones you actually intend to admit at trial.
Judge, we will. I know we've listed probably more than we intend to use, but we will specifically list the ones that we intend to use.
Okay, yeah, by the time we reconvene Friday, you need to specifically identify the drill rap videos that you want to show the jury. And then if there are any drill rap videos that the defendants wish to show to the jury, they need to be identified and given to the state by Friday.
And Judge, certainly the evidence view, we on Friday are going to talk about getting together. It'll be, as the court can imagine, monstrous.
Yes.
There may be some non-testimonial issues that come out of that evidence view that may be need to be addressed by the court.
Sure.
But we can advise you of that. My only additional concern in this state's motion in limine is that it doesn't limit itself just to videos. It suggests that the defendants refrain from making any direct or indirect mention or introducing into evidence any non-disclosed evidence of the victim's prior gang activity or videos. And I would object, and I don't think it's appropriate to suggest at this stage of the game that we should not be allowed to either question or seek admission of evidence or mention or have argument to what is described as the victim's prior gang activity. Now, granted, the court hasn't ruled on any of these things yet, and I don't want to predispose or predetermine what that may or may not be. I agree wholeheartedly that we should be providing the state any rap videos we intend. But as it relates to argument or mention or questioning, I don't think that we can blanketly, as the motion is written, at least Rashad Murphy, agree to that.
Okay, and I'm not ruling on that motion yet. The sole issue that I hear Ms. Doherty raising is she just wants to know if there are any other in the universe of drill rap videos. Are there any other drill rap videos that any of the defendants are going to attempt to introduce at trial?
Understood, Judge.
Guilt phase. So you just need to tell her by Friday if there are. So once I've ruled on the other gang evidence and whether what's coming in or isn't coming in, then once I determine that, then we can start working on the motions in limine. So we'll kick off with the motion for me to determine how much of the gang evidence is going to come in, and then we'll go from there as to the remaining motions. All right.
Judge, there is one mention I would make. I've been working on when I can, and because of the late nature of the deposition of State Witness Robert Howard,
sure,
I've been working on what will be a non-testimonial motion in limine as to certain portions of what I anticipate Mr. Howard's testimony will be. And I just wanted to make everybody aware. I had spoken to the state some time ago. We just did get back last week the expedited transcript of Mr. Howard's deposition, although there was a previous proffer that we've been able to rely a little bit on. So I anticipate filing that motion as well, Judge, without significant argument other than those portions that we would seek eliminated.
Okay.
And Judge, I just wanted to comment on my motion to eliminate, because I did include gang activity. Obviously, I know that the court has not made any rulings about what will be coming in, but the state's concern obviously is bad character on part of the victim being inappropriately admissible by defense and last minute without us having the opportunity to fully vet and make any sort of arguments. So it does include not just the drill rap videos, but any gang activity that they're aware of that they intend to get into that's not been previously disclosed.
Okay. Okay. We'll start with the drill rap videos, and I don't know what that other evidence might be. I'm not really sure. So anyway, we'll see where we are on Friday. Okay. Anything else for today?
Mr. Gabbard had a couple of other motions that fit in the category.
Sure. Just tell me what they are.
One of them maybe we should have done last week, but he has a motion to sever count 6.
Yes.
I think we laid out our position in our memo, and I know the state off response.
I
Our
did.
position is it's a separate transaction. I know that the state's position is it's a causal link. But we believe it's sufficiently separated that the jury should be considering count 6 separately.
Okay. And remind me, what is count 6?
Judge, that's the tampering with physical evidence that is when Mr. Gathright goes back to his grandmother's house after the offense on the same day and wipes down the car and removes the car from Tampa and leaves it in Auburndale.
Okay. Oh, sorry.
And Judge, we did file a written response to that, again, saying that that is properly joined and requesting that it not be severed, as it specifically is connected and joined in an episodic manner, which I think is the case law, which says that that is properly joined.
Okay. Any response, Mr. Wise?
Only, Your Honor, it's a separate incident that's allegedly taking place. It's happening in Cook County. It doesn't involve anyone else in the room. I recognize the state's position, but it's separate time, separate space. It's two separate acts that should be tried separately.
Okay. I'm going to deny the motion to sever count 6. Okay. Anything else?
We had filed a motion to compel the location of all license plate readers along this path. That's
right.
We have hits from, we know where license plate readers hit. I don't know, and I know the state mission discovery, and maybe we missed it. I don't think we have locations of any license plate readers didn't hit. I know I addressed this in other, at least one other case, and I think there are some law enforcement concerns about disclosing it, but I think it's relevant if we're seeing evidence of where it hit. There could be license plate readers on these alleged paths that didn't hit. I think that's.
So you want the state to give you the universe of license plate readers along a
Yes.
travel?
Between here, Orlando, Jacksonville, yeah, along these routes of travel, which I know there's more travel in this case than a lot of cases where, we're talking about just someone traveling to Tampa. But I think it is relevant reading.
Huh, I don't know that's Brady. Okay, state, what's your response?
Judge, we have complied and given them all of the license plate readers where they hit. Judge, we don't know the specific path of travel, and I did specifically talk to the detective. If it is not captured on a license plate reader, it's not something that we can use in the particular case. It's a matter of timing and how the car passes. Some of these license plate readers are mobile. And so, Judge, there's no way for us to know. And there are different companies for different license plate readers. There just isn't any kind of, it's not exculpatory by any means. And without knowing the specific type of travel, when they got on, when they got off, if they took a break, there's just no way for us to be able to provide that.
But you have provided for the license plate readers that are going to come into evidence, the location of those has been disclosed.
Yes, they are disclosed by address, Judge.
Okay. All right. So I'm going to deny the motion as to any license plate readers that were not triggered during the course of travel of the defendants. Okay. I don't find that it's Brady. Okay. Anything else?
Yes, Judge, there were just, I think there was a couple additional matters. You asked us with regards to that Richardson case that occurred in Jacksonville.
Right.
What was the reason that there were 2 juries and that was a prudent issue.
Okay.
And I believe Ms. Ismore has a copy of the actual order that lays that out if you want us to forward a copy to you as well as defense
That's
counsel.
fine. I take you at your word that it was a brutal problem. I just was curious.
And then I did want to know, the court wanted to do a formal colloquy on the record. I know that Mr. Petridis had to step out for a moment. I think it was the last time we met for motions for a small period of time. We did go ahead and order the transcripts for what happened during that time period. If Mr. Petridis wanted to take a look at that or had any sort of additional argument to make, I know that there was additional counsel that was tasked with kind of asking questions, or was tasked with asking questions during that time period on his behalf.
Yeah, and I just want to thank you for reminding me about that. So I think the last two witnesses, and I think it was Drayback and was it Trey McCullough? Were
Yes,
those the last
those were the
two?
last two witnesses.
And I'm sure you were advised of this, Mr. Petratus, but Detective McCullough had no information related to your client at all. And then Detective Drayback, and this was done as a proffer to establish these detectives as gang experts.
Yes, Your Honor.
Okay, and I don't see Detective Drayback being declared an expert in this case, just because the gangs that he is tasked with, and I don't have my notes right in front of me, but there's a different gang or set of gangs in Jacksonville that he's focused on.
Yes, Judge, I believe we just listed him because he's not involved in a specific gang, but was the liaison and handled most of the matters as a general gang expert for Jacksonville gang activity.
Yeah, but you've got three other people to choose from.
Yes, Your Honor.
Right?
Yes.
So at this point, it'd be cumulative anyway. So yeah, here are my notes actually. His gang of interest is the 21st Street gang. And he testified he doesn't have any specific familiarity with 6 Block. And he's assisted other members of the gang unit with regards to ATK and 1200. But the 21st Street gang is his specific one that he focuses in on. So Detective Drayback is not going to be testifying as a gang expert against Mr. Chance or against any of the defendants in this particular case for that reason. The state's got 3 other people to choose from, and Detective Drayback's gang is not a gang at issue in this trial. Okay, so I did indicate that the state's ordered a copy of the transcript, and if for some reason you wish to ask any further questions of either Detective Drayback or Detective Trey McCullough, then we'll set up a Zoom hearing. So.
Judge, Ms. Ismer was kind enough to provide me with a copy of it, and we'll write no further questions. Otherwise, that's the questions I want to ask. I thank him.
Yeah.
I was present for the depositions of those witnesses in Jacksonville, so I anticipated
Right.
that would be the outcome.
Yes.
So I appreciate it.
Yeah. So just wanted to make sure I don't, just making sure. Okay, and anything else?
Yeah, Your Honor, I think that's all from behalf of the state.
Okay, anything else quickly we can do today? No? Okay, all right. I will see you all Friday morning at 9 a.m. and we will get through all of the remainder of the motions. Oh, also, I did take the motion to sever under advisement. Once I've ruled on the parameters of the other gang evidence that's going to come in, then I'm going to ask each of you to, with specificity, tell me what evidence is admissible in this trial that would not be admissible if your client was being tried alone. Okay, so just be prepared to answer that question. All right, okay, see you guys Friday morning. Do you need?
So in regards, okay, so that's all the hearings that we have and that were videotaped, but I can give you all kind of update. I know that the one of the biggest motions, and you just heard her talking about it, was the motion to separate the trials, the severance. The lawyers for Rashad Murphy, they definitely wanted that. Hey, Audie, welcome in. So, and they argued, and y'all should have heard these arguments. Evidence against one defendant could spill over and prejudice the others. Some evidence involves different, shootings and gang allegations. The jury might be confused on who did what, which is kind of true, right? But the judge signaled that much of the evidence may be intertwined, right, with the redrum itself. And why that matters is if the evidence can be intertwined, it can be used against all the defendants in one trial. So the judge did not grant a separate trial at this stage. So what I can tell y'all is that they all are going to be on trial together. I will, if I do see anything comes up for it, I will let you guys know. If we can, audit. Why I say audit? I must want an audit. I want an audit. Used to have an audit. Maybe that's what I'm thinking. I ain't even put the T on it. I just dropped the T. Sorry about that entire SD's message. Now, the next thing that they ruled upon, that was a really big ruling in this, the motion to exclude certain evidence. Of course, the defense tried to, what they doing what the defense is supposed to do is try to block some of this evidence from coming in. They challenge all things like the other shootings that may be tied to the group, that gang-related evidence that we seen where all the gang experts got up there and testified, and certain Florida statute enhancements. The judge ruled several of these motions were denied, as we seen. She just kept saying denied. Meaning prosecutors can still argue that the killing was part of a larger conflict, right? The gang wars that's going on in Jacksonville, and the defendants acted together as a plan. Last but not least, the major one that I seen was the victim impact evidence. And so the defense attorneys asked that the court limit victim impact material. They said, in regards to it being so emotional about Julio, it could unfairly influence the jury. And the judge did deny that. So meaning jurors can hear about the impact of Julio's murder. These rulings are real big because the defense tried to shrink this case before the trial. Remember, we go to trial next month. So we getting all the last details out. Instead, the judge did keep most of the evidence in. She allowed the prosecution broader theory. It kept the defendants largely tied together. So all for one for all is the way they're going to have to do this. And it makes the prosecution's conspiracy/coordinated attack theory very, very strong. Now, what happens in regards to now and between when we go to the hearing, I will definitely keep us updated in regards to that portion. And yeah, that kind of sums up everything that I have for you guys today. I wasn't even planning on streaming that much, but it kind of got real good. I was going to only do the first half and then do the rest later. But yeah, that got real good. And I'll touch base with y'all. We do have a hearing tomorrow on the 10th. Alicia Andrews' case is coming up for a status hearing. So we will look into the status hearing for Alicia Andrews come next week, early next week. Tomorrow, guys, just a reminder, we have a date, and don't be late because anything on Discord is not recorded, so I can't replay it. I can't get us all together. It does not go to YouTube. If you haven't had a chance yet, please make sure you sign up for the Discord. We are going to be watching the woman who died twice. We covered that trial, and they are now doing a 48-hour special on it on our Nick Casotas. If you didn't see the Nick Casotas case, please check out the channel. It's on the channel. It was a very good case. I'm down there in Georgia where he decided to dismember his wife's body and put her all over parts of Georgia. And the sad part about it is he said somebody else did it, this mystery man named Jim McIntyre. Who is Jim? We don't know who Jim is. Jim never showed up, but my guy, Nick, he believed Jim did it the entire time. Mind you, Nick had already told her parents that she passed away in the hospital. And that's why it's titled The Woman Who Died Twice. If you don't have a chance to check it out with us, definitely check it out. It's going to be premiering on CBS and Paramount. And Paramount. But if you have time and you want to hang out with us, we'll be over there on Discord at 11 o'clock a.m. tomorrow. And other than that, thank you guys so much. Thanks to all the new members, everybody that turned green. Thanks to the mods. Thanks to the chat. Thanks for everybody participating today. I truly, truly appreciate it. And I will see you guys tomorrow at our premiere. That is going to be so much fun. I'm going to have a whole bunch of popcorn and a movie, right? All right, guys. You guys have a wonderful weekend. And I'm going to play our outro song. That's what I am going to do for us. All right.
When Sweet Pea taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mars on patrol, chat is showing out. This little YouTube corner's what community's about. Therapist you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mind like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and true. Sharp as a gavel, funniest in the room. Dr. Rachel pops in while she's busy running lines. Speaks her mind every time, cuts through like a knife. And Paula brings the energy, jokes flying fast. Helping Sweet Pea backstage, making every stream last. Then Zach strolls and causing chaos just for fun. The resident cheater, but we love him, everyone. Here comes Maddie, handsome, quick with the line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. Squirrel Crew is everything we admire. Yeah, no matter what the case or file, we're forever taken to trial. Take it to trial. Shamrock keeps us trending, replay queen. Holding down the algorithm like a machine. Estes razor sharp, loyal through and through. And yeah, she adores chasing nothing new. Drunky the bear with the white cloth way, managing volunteers like she runs the whole land. Cynthia brings inside, would take sharp and steady. Donna keeps it real, 911 and always ready. Tilly Bird's the fat queen, receipts on tap. Easy's new, but she blends right into the pack. Tennessee, hard-lived, try support her with pride. Melly shows up for family for cooking for his dog. A steady carrying presence through the courtroom fog. In Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Baka loves her gram, speaks truth when it's time. Micrograms with metaphors straight up sublime. Barbara biggest supporter, heart kind and vast. Looking for missing kids, hope to truly last. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvio, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. Mods and shatters, yeah, this love is something rare. A courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taken to trial. Sweet Pea in the mods and the chat we adore. This isn't just a channel, it's a family. And we couldn't ask for more.
It says, hey guys, I know I'm behind on God. Is this current for the co-defendants? Which state and county? Yes, this is current for the co-defendants in the Foolio trial. We go to trial next week. Never mind, I read the description. Okay, you fine, MCR. That's what we're here to do. We are getting off now, but yeah, check out the stream. I'll be doing some cuts and clips of it. Very entertaining stuff, especially if you are into motions and what comes into court and what doesn't come into court and why things are ruled on, which is supposed to make our process go smoother. But I know we still gonna have our sidebars and blah 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 blah. Don't forget to check us out if you're on replay team. Don't forget to check us out on Discord tomorrow. We'll be doing our premiere special of The Woman Who Died Twice, and we are going to see if Jim McIntyre is going to show up for us. All right, guys.